Jurisprudence will come to order, and the clerk will please call the roll.
Chair Smithy?
Here.
Chair Smithy?
Here.
Vice Chair Wu? Representative Bowers? Representative Cook?
Here.
Representative Jones? Representative Little? Representative Louderback? Representative Money? Representative Moody? Representative Rodriguez Ramos? And Representative Verdell.
Money's here.
Oh, confirm Representative Money? Oh, 2 minutes out, okay. And then Representative Verdell. Okay. We have a quorum.
Okay. A quorum is present, so we'll go ahead and begin. Let me just do a couple of housekeeping announcements. Well, first of all, we want to welcome everyone here. We really appreciate you being here. I know a lot of you have traveled distances and you've taken time away from work, and we do appreciate your being here and participating in what we're doing here today. One other thing I need to mention is we're going to have members that are coming and going. Understand some of them have other committee meetings going on at the same time, and others have bills that they're laying out in other committees while we're meeting. So it's not from a lack of interest that they're not here. They just have other commitments. They're going to be coming in and out as they're able to do. So please understand that. We obviously have a number of witnesses here today. We have an overflow room next door in E2010, which is just to my right and to your left. If anyone wants to go in there, you will have access to the what's going on in the committee. And so we have a number of witnesses. On our posting, we announced a 3-minute time limit to witnesses, and we would ask that you, and the reason for that is we've got a lot of witnesses. We want to try to get everyone a chance to testify at a reasonable hour. I know many of you have places you need to travel and things, so we're going to try to get you out of here. And so if you would graciously hold to the 3-minute time limit. Some of the members may have questions of you, and if they do, that won't count against your time limit. But if you could try to give as concise remarks as possible and observe the 3-minute time limit. And we appreciate you doing that. And I know the other witnesses appreciate that as well. And the other thing that I was going to mention briefly, one thing I need to announce to the committee is that it would be the intent of the chair probably tomorrow to name a subcommittee from the committee. I've talked to most of you about that, and we're getting a lot of bills that deal with the creation of new offenses or to the alteration of the penalty or the punishment for various existing offenses. And I think all of us have the desire to make sure that whatever we do in a uniform and consistent way. And so that's the purpose of the subcommittee, is to develop some standards and make sure that we hold to those standards. And the chair needs to note now that Mr. Little is present, Ms. Bowers is present, and Ms. Rodriguez Ramos is also present. We thank you all for being here. One other thing I need to announce is that we have at least one bill that I think is ready to vote on that we heard last week. There's no substitute being worked on. It's Representative Bassout's bill. And so hopefully at a time when we have all of our members present, we can vote on that bill, but we'll kind of keep you posted as we go along. So I think that's probably everything. The last thing I need to announce is that if you want to testify today, we certainly welcome you to testify. If you intend to testify, you'll need to sign one of the electronic witness affirmation forms. If you haven't already done so, if you would please go ahead and do that on the kiosk. Now, the other thing I need to tell you that, and the chair also needs to recognize that Mr. Money is present. Can we go ahead and put that bill out? Okay. So if you do not wish to testify, but you want to make sure that the committee is aware that you are for or against a particular bill, you can also check on your affirmation that you are present here in favor or against, but you do not wish to testify. If that's the case, the committee will be aware that you were here and that you registered your position on the bill. So I think that's about all that I have. Members, we have that bill by Representative Basut that I think is ready. We've got everyone here at this point. Is there anyone who's not ready to vote on that? What's the bill? 307. House Bill 307 we heard last week. If everyone's okay with it, the chair will call up House Bill 307. And is there a motion on the bill? Okay. Mr. Cook moves that the bill be reported favorably from the committee and referred to the calendars committee with a regular calendar, general calendar, with a recommendation that it do pass. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers? Aye. Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money?
Aye.
Representative Moody?
Aye.
Representative Rodriguez Ramos? Representative Verdell?
Okay, so
It's unanimous.
by a vote of,
It was unanimous.
okay, by unanimous vote 11-0, the bill will be passed and referred to calendars. Members, if there's no other business, we'll go ahead and begin laying out bills. And I might just, for the audience and for the sponsoring members that are here, we're trying to go really by the bills that have the fewest witnesses to get those out of the way. And so we've got a couple of bills of non-committee members who are not on the committee, and we'll probably do those first. I think the first one is that we would call up would be Representative Capriglione's bill and then Representative Isaac's bill. So we'll do that in that order because they have the fewest witnesses. So at this time, the chair would lay out House Bill 166 and recognize Chairman Capriglione.
Great. Thank you, Mr. Chairman, members. Thank you for the opportunity to address the committee today. I'm here to speak to you about House Bill 166, which strengthens protections for children, elderly individuals, and disabled individuals by expanding the penal code for endangering these vulnerable populations through the use or exposure of fentanyl. Under current law, endangering a child, elderly individual, or disabled individual with the presence or use of methamphetamine is a criminal offense. With the rapid emergence of highly potent synthetic opioids, such as those listed in fentanyl and its derivatives, has introduced new dangers that require an updated legal framework. House Bill 166 ensures that individuals who engage in reckless or dangerous conduct involving those substances are held accountable when their actions place others at risk. One of the key provisions of House Bill 166 is explicitly criminalizing the act of exposing children, elderly individuals, or disabled individuals to penalty group 1B substances, which include fentanyl and its derivatives. These drugs are extremely potent, with even trace amounts capable of causing severe harm or death. Given the rise in accidental poisonings and overdoses, this legislation aims to close gaps in existing law and ensure appropriate penalties for those who recklessly expose vulnerable individuals to these substances. House Bill 166 also strengthens law enforcement's ability to address endangerment cases by clarifying what constitutes reckless exposure to these substances. This includes possessing or using penalty group 1B substances in the presence of a child, elderly individual, disabled individual in a way that creates a risk of harm. Storing or handling these substances in a negligent manner that increases the likelihood of accidental ingestion or exposure, and manufacturing or distributing these substances in environments where children, elderly individuals, or disabled individuals are present. By addressing these scenarios, House Bill 166 ensures that Texas law keeps pace with the evolving risks associated with synthetic opioids and other dangerous substances. This bill is about protecting our most vulnerable Texans and sending a clear message that reckless behavior involving highly lethal drugs will not be tolerated, especially when it endangers those who cannot protect themselves. Mr. Chairman, members, I'm happy to answer any questions. I reserve the right to close.
Any questions for Mr. Capriglione? I guess not. We've got one witness, so
Okay.
we'll go ahead and call her if that's okay.
Absolutely.
The chair would call Lauren Lawrence. And Ms. Lawrence, since you're the first witness of the day, I'll go ahead and advise you, as well as all the other witnesses who intend to testify today, we need you, when you begin, to state your name, and if you're representing someone or yourself, let us know that, and also your position on the bill. If you would, everyone would say that at the very beginning of their testimony.
Yes, sir.
Go ahead.
My name is Lauren Lawrence. I am here on behalf of Phil Sorrells, who is the elected district attorney in Tarrant County, and we are for this bill. As I mentioned, my name is Lauren Lawrence. Outside of being here and working with you all during the legislative session, I am a felony prosecutor at the Tarrant County Criminal District Attorney's Office, assigned to the 372nd District Court. I've been a prosecutor for the better half of the last 10 years. And in my docket, I handle everything from state jail felony drug cases all the way up to homicides. And prosecuting endangering of a child, including the way the law currently stands right now, presumption of danger based upon the use or exposure of methamphetamine, are cases that I have come across in my practice and cases that I have indicted in front of the grand jury. I wanted to give the committee a couple of examples of instances in where this offense has been used. And the first one is one I came across recently where officers engage in a regular run-of-the-mill traffic stop. Based upon information during that traffic stop, they conduct a search of the vehicle. They also notice that there is a toddler in the back seat, in a car seat, and they also notice in the vehicle that there is a diaper that they note is the appropriate size for the toddler in the vehicle. In that diaper was methamphetamine. And so we can imagine a scenario where, unfortunately, we are running short on diapers, and we, take the methamphetamine out of that diaper, place that diaper on that child, and we have now exposed that child to methamphetamine. These types of things can easily happen with fentanyl and other Group 1B substances, which is its derivatives. And as this committee is well aware, 2 milligrams of fentanyl is considered a lethal dose. And so if something like that were to happen, we would be in a situation where that child, is going to experience an overdose and potentially be fatal. And so our office sees adding this presumption as an opportunity to make our cases a little bit easier to prove, in the sense that instead of having to call a witness to testify to say what we all know, right, which is that fentanyl is lethal and it can cause bodily injury and it can cause death, that is a presumption. And I'm happy to answer any questions.
Thank you, Ms. Lawrence. Any questions, members? Yes, Ms. Rodriguez-Ramos.
Thank you, Mrs. Lawrence. Have you all found, or in your experience, that it has, because this law already exists for those who are in possession or manufacture methamphetamine, correct?
That is correct.
Have you all found that it deters individuals from making any reports or police reports when there is an overdose or anything, because they're afraid that they'll also be punished for somebody else possessing it within their vicinity and their child being present? Does it minimize?
No, it is not our experience that it in any way minimizes people from making a report. What we find is that it provides us an opportunity to protect children who are unfortunately in homes where these substances are, 1, found, and then 2, not kept in safe places. And unfortunately, what we also see with fentanyl is that they are pressing this powder into pills that intentionally look like prescription opioids, which is a problem for children. It's a problem for our disabled community, and also a problem for our elderly community, who may get a hold of that and think that's their prescription medication, and it's actually not.
All right, thank you, appreciate it.
Thank you so much.
Any other questions, members? Yes, Ms. Jones?
So what do you have to intend to do? I know it's not your bill, and maybe I'll ask Rep. Capriglione, but it says that you place in imminent danger death, bodily injury, physical or mental impairment, or we're just going to presume that if you deal with fentanyl, someone is going to presume that somebody's going to die? I'm trying to find the intent, that's all.
So the intent is simply to say that this legislature is stating that fentanyl is a substance that can cause death or bodily injury, and that is a presumption that we are going to move forward with, that this substance can cause death or bodily injury, just like the statute says for methamphetamine. So it doesn't change the acts or the behaviors that can be charged under this offense. Just that if we charge this offense and say that you have and that you've endangered somebody by exposing them to fentanyl, the legislature is saying, state, you get a presumption that fentanyl is deadly or can cause bodily injury. And as a presumption, it is, of course, rebuttable in an instance where someone could say that, that was being used for medical purposes or things of that nature, and that would, allow them to rebut that presumption.
Okay, thank you.
Okay. Any other questions, Ms. Lawrence? We appreciate you being here and bringing this in front of the committee today.
Thank you, Chair. I
very
appreciate
much.
your all's time.
Okay. Is there anyone else here who wishes to testify for, against, or on House Bill 166? If not, Mr. Capriglio, if you wish to close.
Thank you, Mr. Chairman. Members, as we talked about, what this bill does is we currently have laws related to methamphetamine and how that could, by proximity or by injection or other methods, risk the lives of the elderly, disabled, or young children. This bill simply adds fentanyl to the list of those items that would be considered controlled substances in those cases. So, no questions?
Any other questions for Mr. Capriglio? Okay, we appreciate you being here and
Thank you.
laying the bill out. And so if there's no objection, the chair will leave House Bill 166 pending at this time.
Thank you,
We'll-
Mr. Chairman. Thank you, members. I close.
Thank you very much. Okay. Next, the chair would lay out House Bill 1135 and recognize Representative Isaac to explain the bill.
Chair Smithy, Vice Chair Wu, and members of the committee. I come before you today to present House Bill 1135, the Taryn Solbrig Act, in honor of a young man whose life was senselessly cut short by a driver using a fraudulent tag. For too long, fraudulent paper tags have been a tool for organized crime, human trafficking, drug running, stolen vehicles, and other illicit activities. The only reason to use a fake tag is to avoid detection, whether by law enforcement, toll authorities, or anyone who might hold criminals accountable. While some may view fraudulent tags as a victimless crime, the Solbrig family will tell you otherwise. Their son, Taryn, was tragically killed in a car crash involving a vehicle with a fraudulent tag, a vehicle that should not have been on the road. Thanks to the work of Chairman Hefner, Texas will eliminate paper tags entirely by July 1st of this year. I also want to thank him for working with the family and I to name this act after their son in honor of Taryn. Instead of celebrating another birthday, another holiday, the milestone of adulthood, Taryn's family is left with only his memory. Through this bill, we can honor his life by ensuring no other family has to suffer the same pain. Naming this act after Taryn is a reminder that our laws have real-life consequences and that we have the duty to protect innocent Texans. I urge you to support House Bill 1135, and I stand with the Solbrig family in ensuring that justice is served. Taryn's mom, Tawny, is here today, and I think she would like to say a few words. And thank you for your time, and I'm happy to answer any questions.
Well, any questions? Ms. Isaac? Thank you very much. Okay. And so we'll call, the chair will call Tawny Solbrig. Ms. Solbrig, thank you for being here. And just a reminder, if you'll state your name and your position on the bill.
My name is Tawny Solbrig, and I am in favor of this bill, and I represent myself and my family. That was hard to listen to. As you can imagine, if you ever lost a child for any reason, it's heartbreaking, right? Just give you a backstory. October 20, October 4th, 2020, our son was in an accident and he was killed. He was 18 years old. He was hit by another car that was having fake tags. Consequences is what stood out to me with Ms. Isaac. The gentleman that was driving the car did not get any consequences. He had illegal paper tags. The car was not inspected, registered, any kind of tracking on it for years. It was sold at an auction, and it was just kept on getting resold. There was something wrong with the title. There was no way to get a title, so they just kept on issuing temporary tags to the new owner over and over for like 3 years. The DPS officer that was in charge of the investigation didn't issue any tickets. The gentleman didn't. I know y'all see y'all's look on your face. Imagine that, getting the news and then saying, well, it was an accident, we're not going to issue any tickets. He got to go away, go home to his family, and my son did not. He paid the ultimate consequences. We urged the officer to at least give some sort of ticket, some kind of consequences that was kind of be our justice. He did not do that. It was mine and my husband's investigation with Google to find out about the paper tag system that was broken. And then we met some amazing officers that are going to come up here and talk to you that fought the fight with us, and that started this fight. With that, I am honored that Ms. Isaac took this and was going to fight the fight with us, and urge y'all to maybe put our son's name on it. It would give us a little bit more comfort knowing that he got some kind of justice for this justice piece, since he didn't get it that day. So we really appreciate it. We really hope that y'all move forward to it. I'm a little frustrated that the state of Texas let this go for so long. I do have to say that I feel that Texas had hands in it because they knew of how bad it got, but this will help us. It really will. It will be an honor to our family, and I appreciate it.
Well, I think all of us in the committee understand how hard it is for you to come up here and even testify about this, and we appreciate you being here, sharing your story with us. Hopefully, it can prevent something like this from happening to another family. So
I appreciate it. And we do know that no matter what, the law is going to change, and that we do appreciate that. In the big scheme of it, that's what's important, to making sure that everybody's safe, So we do appreciate that.
Well, thank you for being here. Any questions, members, for Ms. Solberg? Well, once again, thanks for being here and sharing your story.
Appreciate it.
Hopefully, we can stop this from happening again.
Yes, sir.
The chair calls David Kohler.
Good morning, Mr. Chairman, Mr. Vice Chair, and honorable members. My name is David Kohler. I'm still in law enforcement over 34 years in Central Texas, and I'm here in support of HB 1135. So I don't want to go into the whole backstory of the paper tags, because we've come a long way with this legislative sessions. We've been dealing with this since 2017. This is the third session that we're still dealing with temp tags. So hopefully we're getting the corrective measures. We met Mr. and Ms. Solberg a few years back, learned of her story, and then she started coming up and testifying with us at various DMV meetings, House and Senate Transportation Committee meetings, criminal jurisprudence, et cetera. So again, I just wanted she did a solid for us and helped us with the fights and the progress that we've had, and that's our return to her. And I just respectfully request your guidance in voting this bill unanimously. Thank you.
Thank you, Mr. Kohler. Any questions, members? Okay, thank you for being here as well. Our next witness, the chair would call Jose Escribano. That's close. And let me just say at this point, the screen I'm reading is not very large, and I may mispronounce some names and misread some names. So if I do, you might correct me, and I apologize for doing that. Appreciate you being here today.
Thank you, Mr. Chairman. Thank you, committee members, for having me here today. My name is Sergeant Jose Escribano. I'm with the Travis County Constable's Office, Precinct Number 3, and I am for this bill. A young man's life was cut short. Mr. Taryn Solberg, and his parents are here. You heard from them. I'm not going to go into all of that. But I will tell you that the Solbergs were with us from the beginning. When we came to committees to try to get different bills passed, they were here. And I want to also thank, again, Representative Isaac for bringing this up. Also, I would like to thank Representative Hefner because these bills that we got passed through them and Representative Goldman will end the Texas tagdemic, like our unit used to call it, or is calling it. July 1st, they will be gone, which is a huge step. Also, the change in tampering with a governmental record helped us tremendously to be able to get indictments. And also, we in our unit were able to obtain 5 federal indictments and shut it down at a national level also. We started this in 2019. And the Solbergs were with us every step of the way, shoulder to shoulder. Anyways, I want to thank this committee for this opportunity to talk to you and Representative Isaac.
Thank you, Sergeant. Any questions for the Sergeant? Okay, once again, thanks for being.
Thank you, sir.
Thanks for coming. The chair calls April Aguirre. Aguirre. Sorry. April Aguirre.
Hello, my name is April Aguirre, and I am here in support of HB 1135. I just want to reiterate that paper tags for years have been used by criminal entities and to elude law enforcement. The majority, we have a huge problem in Harris County with jugging. People steal a vehicle, put a paper tag on it, and this is the way they make a living, by targeting individuals, leaving banks. So I urge the committee to also vote for this unanimously. This has been a tool used by criminals to harm innocent people in our daily communities. And unfortunately, sometimes they pay with not only their life, but sometimes are left alive with bodily injury. We had a lady in Houston who was left paralyzed after a jugging incident on her way back to the laundry department. That's all. Thank you.
Okay, thank you. And any questions for Ms. Aguirre? Thank you for being here. The chair would call Timothy Quinn.
Thank you, Mr. Chairman. My name is Timothy Quinn. I am not in law enforcement. I'm a private citizen. I'm a close friend of the Solbrigs. I've been a private investigator and a trainer for about 30 years. And to reiterate what was said, the past 6 years have been critical and impressive, with legislator and law enforcement working together to improve access, to improve the system by which paper tags are done. And so the platform that was built is fantastic. Personally, I'm sitting here to say that the Solbrigs and their name on this act will bring honor to Taryn's name and will establish a legacy of a young man who was a fantastic person and whose life was cut short, as noted by law enforcement and the folks who spoke here earlier. Thank you very much for considering changing this act into Taryn's name. Thank you.
And Mr. Quinn, I need you to state who you're representing. On your affirmation, you said on behalf of Quinn Private Investigations and self.
My apologies,
is that
Mr.
correct?
Chairman.
Okay.
My name is Timothy Quinn, and I do represent my company, Quinn Private Investigations, as a friend of the family.
And I also need you to clarify that you're for the bill.
I am for the bill. Thank you.
Okay, I just need to get that on the record.
My
Thank you.
apologies.
Thank you very much, sir.
Thank you.
Is there anyone else here who wishes to testify for, against, or on House Bill 1135? If not, Ms. Isaac, would you like to close?
Yes, if there aren't any questions, I close.
Ms. Jones has a question.
So I just want to be clear, so you're making tampering with a tag. First of all, it's not going to be tags after July, but do we know what degree do we know what the range of punishment is, or I'm not exactly sure what you're trying to do. Oh, that's it?
I tried to
Okay.
talk with you on the floor the other day, remember? I was gonna talk to you
Yeah, I
about
was
this. but-
talking too,
Okay.
to people.
Yeah,
Okay.
it just names
You
it.
just want to name it after him?
Yeah.
Oh, okay, all right, I don't have a problem with that.
Okay. Any other questions? Okay, okay. Chair recognizes Mr. Cook for a motion.
Yeah, thank you, Mr. Chairman. I know it's out of the ordinary to make motions to move a bill forward today, but I would like to do that if the chair would entertain it.
Well, it would be good to do it while the family's here.
That'd be great.
We don't
Thank
do
you.
this
Ms.
on
Bowers
every
is
bill,
a
so-
joint author on the bill as well.
Oh.
Ms. Bowers.
Ms. Bowers is, so Ms. Bowers, thank you. You've been a joint author and appreciate your efforts on that. So
Yes.
members, if that's, if there are any objection to the vote today? If not, clerk will, and I assume it goes to, would you want it to go to local and consent or general calendar?
Local.
Local and consent would be great.
Okay. Local, okay. So the motion by Representative Cook is that the committee report the bill favorably, House Bill 1135, that it be sent to the local and consent calendar with a recommendation that it do pass. Clerk will call the roll.
Chair Smithing,
Aye.
Vice Chair Wu.
Aye.
Representative Bowers,
Aye.
Representative Cook,
Aye.
Representative Jones,
Aye.
Representative Little,
Aye.
Representative Louderback, Representative Money,
Aye.
Representative Moody,
Aye.
Representative Rodriguez Ramos, Representative Verdell.
Okay. Thank you. So by a unanimous 11-0 vote, the bill passes and will go to local and consent calendar. And an outstanding young man will be memorialized in the Texas statutes for years to come. Thank
Right.
you all very much for being
Thank
here.
you so much, Chairman, Vice Chair, and committee members.
Okay. Okay. Mr. Moody, do you want to go ahead and go with yours? Are you ready? Okay. Well, you look ready. And so if you are, the chair will recognize Representative Moody to lay out and explain House Bill 799.
Good afternoon. Thank you, Mr. Chairman. Members, as we have this discussion about bail, I want to take us back to where it all started. It wasn't where we are now, which is talking about how to detain people pre-trial. And that's fine, and that's certainly something that we need to address, and I think we will be talking about later. We need to address those things for public safety when we're talking about dangerous felons. But this entire conversation began almost about a decade ago as a conversation about reforms to get poor people charged with low-level crimes out of jail instead of locked up on cash bail that they can't pay. So when you have someone who isn't dangerous stuck in jail on a minor charge, that does three things. First, it costs our counties for every single day that they're locked up, which means higher property taxes and less capacity to handle violent offenders. Second, it often leads those people who can't make bond to plead to things they're innocent of or have a good defense for, or that they might be guilty of but could get a diversion or a deferred adjudication on, simply to get out of jail. And those of us who have been practitioners have been in those situations where you're talking to your client and their only answer is, I'll do whatever it takes to get out of here, no matter what the facts of the case are. That sadly happens probably every day in courthouses across Texas. And third, it makes our communities less safe and less productive because time in jail leads to lost jobs, lost housing, and family instability. We're literally taxing Texans for outcomes we know are the exact opposite of what we want. House Bill 799 addresses this by making the default setting release on personal bond for misdemeanors and state jail felonies. With misdemeanors, we're talking about things like driving with a suspended license, or shoplifting, or a simple assault, or a DWI. With state jail felonies, we're talking almost entirely about possession of less than a gram of a drug and shoplifting with 2 prior convictions. I should also describe what a personal bond is, since there's often confusion about it. It's not what we sometimes call personal recognizance, even though PR bond is a phrase some people use. PR is a release with simply a promise to appear. A personal bond, on the other hand, has conditions and subjects the person to monitoring. Back in El Paso and in a whole lot of other places across the state, there's a personal bond office that monitors people who've been released, often requiring them to check in regularly, take drug tests, get mental health services, and so forth. It's almost like being on a mini probation. And with a personal bond, you're liable for the amount of the bond if you violate it. We get incredible results with this kind of supervision back home in terms of both court appearance and reoffense. And I'm happy to gather and share. In fact, I have that data from El Paso. I'm happy to share with you if you need it in terms of appearance rates. It's somewhere, I think, around 90% in our county. Finally, I'd like to point out that the bill just makes release the default setting. A court can always decide not to grant a personal bond under this bill if it finds that non-monetary conditions won't ensure the defendant's appearance or protect the safety of the community, law enforcement, or the victim. So if one of these low-level cases still calls for money bail, the judge can still do it even with this bill in place. I think that the default setting is important. Freedom should always be the standard in our society. With bond, we're not talking about punishment. We're not even talking about the guilt of the individual. These are people who haven't been convicted of anything, and on the low end, who often aren't realistically going to get jail time even if they are guilty of it. The consequences of an accusation shouldn't be worse than the consequences of a conviction. HB 799 is an important part of the overall bail discussion and will make sure that bail is handled appropriately at the lower end as we consider changes that we're going to make at the higher end. I do want to clear up, and we talked about the difference between PR and a personal bond, right? Because you may hear people talk about, well, what they do in other states, that they're just going to release people. That's not what a personal bond is. So I want to make that distinction up front. Also with personal bond, like I talked about, the type of monitoring that takes place, almost like a mini probation. Also what happens in those offices is that if an individual has, let's say, substance use issues, mental health issues, other things that are co-occurring with their interaction with the justice system, those services can then be linked up to those individuals. So we're not talking about simple release to street. That is not what we would do with this bill. So if that's something that's brought up as a concern here later today, I want you to know that those are 2 very different things, and I would not advocate for that. The personal bond is a structured system of monitoring and connecting people with services if they need them in their situation. I'm certainly happy to answer any questions, and after testimony would like to be called back to close as well.
Any questions for the speaker? Speaker Moody? Mr. Williams? Okay.
Sorry, I'm a lawyer, but I'm not a criminal lawyer. Can you give an example of some of the things that might be, quote, otherwise prohibited by law in here that would not allow for a PR bond for a misdemeanor or state jail felony?
Oh, and I'll get a list for you. There's carve-outs that we already have that you're not allowed to have this, that don't touch personal bonds. So it's just saying if those are already carved out, then they wouldn't be applicable. I'll get you a list of them, though.
Okay, and then it says, or the magistrate makes a finding that no monetary conditions of release are sufficient to reasonably ensure their appearance and the safety. So what would that finding look like? Let's say, I'm trying to think of what kind of an offense it might be. It might be a DWI or something where,
Sure.
where the magistrate says, hey, I think this guy might leave, or I think this person may still be a safety risk to the community, law enforcement, or whatever. What kind of finding are they going to have to do to ensure if they determine that a cash bond or something else is required?
Representative Money, I think it's as simple as what you just stated. I think you take the language from the statute, you have a form that the judge has, the judge is going to take certain testimony in these takes certain facts up during the hearing, and if I were that judge, I would have this verbiage in a fact finding based on the testimony taken. I find that this is not sufficient, and just list all of them, because it can fall into any category. You don't have to be specific about it. I think that's the way I would envision it happening in those court settings. The judge is going to have full discretion whether to do that or not. It just creates a default setting to liberty, and I think that's where we should start with, particularly with accusations on low-level offenses. And if the offense is one that that the judge doesn't find this is satisfactory or it doesn't fit, the judge has all the authority in the world to do something different. I just think it's important to enshrine that the default setting in our system is liberty.
Mr. Wu?
Yeah, so, thank you, Mr. Chairman. So just going on for Rep. Money's question, so like a situation where, like, let's say it's a simple assault, but like the person who was getting arrested yelled out when the cops arrested him, as soon as I get out of jail, I'm gonna come kill you, right? And the police officer would let the judge know, let the prosecutor know, hey, this person, by the way, threatened to come out as soon as he got out of jail to come and finish the job. Like, that would be noted to the prosecutors and to the judge, and the judge would say, okay, we probably need to put higher conditions on you. We probably maybe need to hold you for a little bit.
Yeah, I mean, those are the different nuances of every situation that comes in front of these courts, and in those instances, I would fully expect that a judge is going to do something a little bit more intense.
But like on these stuff, like robberies would not fall in this.
No.
You threaten somebody with a gun?
No.
A knife?
No. You're talking about aggravated assault. So
okay.
The way this is structured is it captures all misdemeanor offenses unless they're otherwise prohibited, and all state jail felonies.
So like, and
the bulk
state jail
majority,
felonies, like
the bulk majority of state jail felonies. I mean, we can get the OCA
writing
data, but it's the possession of less than a gram of a drug, or it's going to be your theft enhanced. I mean, there are other ones too, but those are the bulk majority of those cases.
Because I remember, I mean, like, when I was in DA's office in misdemeanor, I mean, easily a third of my cases were DWIs, another third were shoplifting, and
domestic violence.
Yeah, another third was domestic violence and simple assault and fights in bars.
That's about it.
Yeah.
Now, I don't have the 30 years of experience that Representative Jones has. I'm trying to get there, but yeah, that's been my experience.
And here, and kind of like what popped out to me, what you said earlier, is that keeping low-level nonviolent offenders in jail actually makes it more dangerous for society, because like if it overcrowds our jails, that means they're looking to potentially release other people.
Yeah, this is resource deployment. Like, how are you deploying resources, particularly in a time where I think resources are scarce?
Do you know how much it costs to like keep a regular person in jail?
It's going to depend on the county. Every county could probably tell you the cost per day.
I think like at Harris County, I think it's like somewhere between like $60 to $70 per day if they have no other issues, like no medication, no mental health issues, no behavioral issues.
Correct. If they're not being connected with other services.
And even for misdemeanors, people have the potential to sit in jail for months and months. Even on a misdemeanor case where they might have gotten like a 2-day time served, they could be in jail for like months at a time.
Yeah, I mean, certainly that can happen and does happen, and those are people that want. Those are situations where people are trying to figure out how to actually advocate for themselves and figure out how to fight the case, or try to put forward their information. The situation I listed earlier is the one that I think is equally as tragic, which is mostly young people that just need to get out. The answer is, I need to get out. I have to go to work. I have to do this. I have to do that.
Go back to my family, take care of my
I'd rather
kid.
take a hit on something. Yeah, I know that maybe the stop is something that there was an illegal stop, or there's a suppression issue, and you evaluate the case, and you can talk to your client till you're blue in the face. Their goal is that they need to get out, and that becomes very difficult for a lawyer, because your job is to advocate for them, and they're being driven by just purely I need to get out. And so whatever, and unfortunately, we see this, in my time in the criminal defense bar, you'll see defense attorneys are more than happy to walk them up there and sign the plea papers and not really give concern about how that's going to affect them in the future. So that's a sad reality.
Thank you.
Any other questions for Mr. Moody? Mr. Louderback.
Thank you, Chairman. Chairman Moody, let me clarify something, ask you a question here. Is it state jail felonies and A, B, and C misdemeanors?
Yes, that's the
All
way
apply to your bill?
way the bill is drafted. Yes, sir.
And for clarification purposes, you want to make that a default position where there's no bond? No bail?
A personal bond. That the default setting would be a personal bond. So with conditions for appearance and any other things that the judges feel is relevant. And if the judge doesn't feel like that is correct in that case, they can absolutely go to a money bail for that particular. They can do a split bond too. Do a personal bond and a cash bond. You can see that if they say, I want the conditions, but I also want them to have some skin in the game on the cash side, the judge can decide that too. Yeah, it leaves that discretion up to the judge, but it builds the default setting into a personal bond.
So the default setting now, is it your position that this is a widespread issue, that people are not able to get out of jail on misdemeanors?
I have seen it. I've seen it. I've certainly seen it in my jurisdiction out in El Paso. It's been the subject of massive litigation out of Harris County, Dallas County. This is where the conversation on bail started about 10 years ago, and it's morphed into a little bit different conversation. And the purpose of bringing a bill like this is, as we have this broad discussion on bail, and I look forward to that because there are certain cases that, and I don't want to get into talking about other bills, but let's talk about the system as a whole. There are high-end violent offenders that we absolutely need to work through how we give judges tools to keep our communities safe. And I am someone who has voted for that multiple times, constitutional amendment and bill. But at the same time, I don't think we should forget the beginning of this conversation, which is what are we doing for folks at this low level that are getting caught up in the system? And I think that has to be part of our solution too, and that's why I brought the bill forward.
So having run a jail, I fail to see the real problem here. I mean, bond, there's all types of reductions, there's all types of ways for people to get out of jail. So have you seen that in the rural settings?
I didn't tell you the experience that I've had out in El Paso and also in the litigation we've looked at in the larger counties.
Well, how about your smaller counties? 80% of the state's rural.
Mm-hmm. Yes, and so if these things are not a problem there, then this bill would not have an impact. I do think it is important for us philosophically to set the tone for what we expect in our criminal justice system. And we are talking about low-level offenses of which someone is merely accused of. And an accusation, as you know, is not a conviction. And I do think that if you're going to deprive someone of their liberty, then you should be making a finding like this. A judge should have to say a personal bond isn't good enough in this situation. We're going to do something different in this case. This enshrines in the law a default setting that is protecting the rights of the accused, and I think using our resources a little bit more wisely.
Thank you, Chairman.
No, I appreciate that. Thank you, Sheriff.
Mr. Wood?
And if I can just follow up on that just a little bit, I think going back to a point that you brought up earlier is almost all these cases, they're going to get probation. Like if they're taking conviction, a lot of them are they're going to be taking probation anyways. A lot of them are not going to serve any amount of time because almost always it's like a first-time offense, it's a low-level offense, and it's just like, why?
The likely outcomes in these cases, unless someone wants to go to jail, they're going to be on probation or deferred adjudication, or in some cases they're getting a pretrial diversion. I mean, those are the types of things that are going to happen with them anyway.
Right.
And so
we'd rather them be back home taking care of their families.
As the case progresses, they have an obligation to continue to show up. The judge has a tether into them. If you've got substance use in a case, let's drug test this person while they present, as they present through the process. let's monitor them for those things. What are other things? I mean, I've seen judges put various conditions on people that are on personal bond that are narrowly tailored to their particular case. And so I think it's a smarter way to do things, and I think it pushes the justice system to start at the right place. And if there is something that is abnormal, then it does nothing to touch the judge's discretion to handle it in whatever way they feel.
And if a judge in a rural area just wants to say, hey, you know what, I want all my cases to come in to have a cash bond, and I'm just going to make that my policy, and I'm going to make, and that's what I'm going to do. They can just do that.
Yeah, I think they just have to make a finding.
Yeah.
Let's see, I've got, Mr. Burdell had a question. Mr. Burdell?
Yes, sir. Thank you.
It's very
so
popular today.
I met a gentleman not too long ago, a few weeks back, that on a marijuana charge ended up sitting in jail for 2 years before he got out, and they dropped the charges on him. Is this something that would address something like that to prevent somebody from sitting in jail for 2 years?
Yeah, because what I assume in a case like that, and without knowing the facts, is that's someone that couldn't make bond and so is just sitting. You could also have, I mean, there could be a number of problems and why that case didn't come forward. That could have been one of them, though. Yeah.
Okay, Ms. Jones?
I think a lot of people presume things about the criminal justice system. The first of which is that it is efficient. I've practiced, have law license, will travel across Texas, in try cases in big urban areas and in small towns. And I think that the reason I know that the reason that this country was founded is because of what they did over in England, where the government was oppressing people and they didn't have a right to a trial or to defend themselves or anything like that. And that's why I believe the core principle, an American principle, is that you're innocent until you're proven guilty.
Mm-hmm.
I struggle when people want to do things in the law based on like the worst case scenario.
Mm.
Because the reason it's a worst case scenario is because it's the worst case scenario and there's only one. Most people, and let me be clear, if there's somebody who gets in trouble all of the time, right, chances are there are going to be a whole bunch of charges filed. Because it's my experience that the DA's office throws as much on the wall as they can and they hope something sticks. So if there's misdemeanors, they'll charge them with that. If they're felonies, they'll charge them with that. In cases where the only cases are misdemeanors, people presume that the law enforcement has their evidence. Harris County's pretty good about HPD having some evidence in the file for discovery relatively sooner than like small counties. Because I literally have represented people in small counties where the district attorney or the prosecuting attorney doesn't have any evidence in the file for 6, 7, 8 months. Meanwhile, back at the ranch, somebody is locked up through no fault of the person who's locked up, through no fault of the defense bar, and also sometimes through no fault of the prosecution, because law enforcement is maybe overmanned or whatever. In the case of body cameras, right, because cameras show what they show, in the larger counties like Harris County, those will be provided in maybe 2 or 3 months, right? And I cannot tell you the number of times the police made allegations and the body cam came back and said something different. I mean, I was in Hayes County. It's not the smallest county, but it's not an urban county, where the police officer literally said somebody didn't identify themselves, and the body cam that they released almost a year later had the person not only identifying themselves, but actually spelling their name because their name had an unusual spelling. So that's one problem, right? Evidence. The second thing is what you say is true. A lot of people who haven't been involved in the criminal justice system, they don't know. I mean, you take me and you arrest me for one night. I'm struggling. I got to go to work the next day. I miss work. Most people don't work for themselves. So if you depend on your job to, say, pay your rent, If you own a house, pay your mortgage. If you own your car, you pay insurance or gas or your kids' food or get your kids to school. You being locked up for one day for some hours is a problem. And people don't think about that, right? And so a personal bond, and it's also been my experience, whether I'm in Harris County, whether I'm in Fort Bend County, whether I'm in Montgomery County, whether I'm in Comal County, I can't even remember all in Trinity County. It's a whole bunch of counties I practice law in. A lot of times the DAs are overworked. So they literally haven't had a chance to look at the case. So I drive all the way, spend all my gas as a lawyer to go to the court, and they don't have anything for me. Not because they're evil or nefarious, just because they don't have the resources. I mean, we've had DAs come up here and testify that they need the state to allocate more money so they can do their job and be more efficient. And so, and also in misdemeanors, judges actually consider certain considerations for bond. One, the nature and circumstances of the offense. So the state is the prosecutor is gonna tell all the stuff, all the aggravating factors that happened in the case. The judge also, and these are constitutional requirements, by the way, that bail is sufficient to assure appearance, but not to be oppressive. I respectfully submit to you, if I'm locked up for a month, most people will lose everything that they own. And so you're not just incarcerating that person, you're incarcerating their families, their wives, their kids, their whatever. Now you got a homelessness problem, a whole bunch of problems. The state also, the seriousness of the crime. And on the state side, the state generally has more access to law enforcement, to the witnesses and things like that. At the first court setting, the defense lawyers most times don't have anything to work with. We just don't, because there's no discovery. They don't have to give it to us. And of course, our clients are mad at us. Like, why you don't have this, Miss Jones? I got to go back to my job. Dude, I don't have it, is what I have to tell my clients. So I say this, that I don't think that there's a harm in defaulting to a personal bond. A personal bond, at least in Harris County, and I've had some in other counties. Some small counties make the person, so say you're driving through some small town, as we do in this big state that we have, and you get stopped for something. You got to come back to that town, right? I mean, you're probably going to have to miss work. Hope you can miss a day's pay. But even in like Harris County or Fort Bend County, nobody wants a dangerous person out there. So the judge is going to consider the dangerousness of it. If the person was threatening people, they're going to look at their criminal history. So if they have a long criminal history, that's something to be taken into consideration. If it's a court-appointed lawyer, and I do some court-appointed work, I mean, that ought to tell you something. They ain't got no money. They can't afford me. So they're going to be locked up. What's the point? And then you end up having a system that puts somebody who maybe has never been in trouble before, where they've literally lost everything. They've lost their job. When I start thinking about some of the situations that I've had to deal with as a criminal defense lawyer, and I just feel like my hands are just tied when you know somebody's lying on somebody, right? And it's a swearing match. And the truth is, I've seen some people lie better than other people tell the truth. I've seen some people who get nervous. They're telling the truth, but they get nervous. Maybe they're not that bright. They get discombobulated when you're talking to them, and it looks like maybe they're not telling the truth. So there are all these things that have to work out to make sure that the state knows what their evidence is, and that it's, I guess, provable beyond a reasonable doubt. And then for the defense, we got to vet stuff. I mean, I've had clients tell me the truth, and I was like, yeah, that happened. But sometimes the truth is stranger than fiction, right? But I've also had my clients who did exactly what they were charged with, lie to me, but I have to have time to go investigate it. Right? So I just, just locking everybody up, and I would respectfully ask all of you here who are thinking about this, if your child got locked up, would you want the system to presume that they had to pay money to get out? And I don't know how much money you guys have, but my mother couldn't pay rent sometimes, right? I didn't have lunch. I didn't have breakfast. I ate free and reduced lunch. So if I would have got locked up, my mother couldn't afford to buy me out. So it's not as black and white as some people would have it be. And I think that justice we've got to make sure that we know what's going on. And I will tell you, most misdemeanors, this is what happens. They hold people in, and I have a ton of clients. I remember a case, I had a client who had never been in trouble before. And I thought I could show that, I actually thought I could prove her innocence. But trial wasn't set for over a year. My client wanted to get back to her life. And I begged her to, please, ma'am, let me fight for you. And she was like, I can't afford to stay locked up, Miss Jones. I can't afford, my mama can't watch my kid no more. CPS don't take my child. And she pled, and I was just torn. I was just heartbroken. Because there are all these factors that you just can't control. And everyone, great. If I could get charged with a crime, have my trial, even say within a month, maybe this might work. But there are people who don't have money. They can't afford $10. You say the bond is $100. Well, if you can't eat lunch, what lunch costs? $10? You can't afford to pay a bond. So I don't think there's harm in this, and there are tools in the toolbox for judges to be able to give cash bonds and sufficient cash bonds, because sometimes somebody's charged with a misdemeanor and they did a whole bunch of other stuff, and you can set it high where they actually have to pay. But there's no way that when you're charged with a crime, it should be a debtor's prison. Whereas you can be charged with something really bad, but if you got money, then you're going to bond out. That's just not right. It's not fair. It's not just. It's not American. Because if that's what we were going to do, we should have stayed in Britain. And that's all I have to say.
Okay. Ms. Rodriguez-Ramos, do you have a question?
Yes, sir. Thank you, Mr. Chairman. There was a comment just made, 80% of Texas is rural, but 90% of Texas population is urban. When I look at the chairs in this room, I think about beds and jails, and I would definitely prefer, no offense to our participants here, but I would definitely prefer the beds and jails to be taken up by violent offenders. Mr. Moody, Representative Moody, the conversations that you've had in your research with both urban and rural DAs. So the majority of the population, we know 90% is in urban areas. Although 80% may be rural, 90% of the people who live in Texas live in urban areas. That is a fact. So in your conversation with the DAs in both rural and urban areas, were they supportive of this overall in terms of what it meant to the overcrowding in their jails, in keeping the public safe, with minimizing the locking up those individuals who were more violent offenders? Was there what did they support this overall?
I mean, prosecutors across Texas are a diverse bunch, and they play a role in this. So the way this looks, at least at the time, when I was a prosecutor, and we'd go over to the county jail and we'd have these hearings, and you'd do dozens of them back to back to back to back, these bond hearings. And the way that looked as a prosecutor was I had the criminal history in front of me. I'd report that to the judge. I'd talk to whoever was assigned as the defense counsel that day at the jail, or if they had private, some folks had private counsel. But for the most part, it was the attorney on duty. You would converse with them. What is this person's living situation? Because that's what you're talking about. This is a flight risk. You look at, you have the police report, you have the basics of the you have the basic layout of the facts of the case. Obviously, it's early days, so that's just, you're looking at the base level information, and all that information is provided up to the judge, and then the judge makes that decision. So none of that really would change here. So I don't know. I don't know that I've heard. When prosecutors weigh in on stuff, and in the handful of cases where I went to go fight against a bond being reduced or to move to increase bond, we were talking about serious, violent criminals that were on the edge of trying to figure out how to get out. And so those are the cases that they spend their time on. The rest of it is managing and making sure that surely, they want to look at those cases, and you can't predict. Look, no one's going to know whether someone is going to reoffend. You might have someone that looks like an innocuous person on paper, and they go do something terrible. Some of that stuff is you can't prevent against. But those are the exceptions to the rule. Most of the time when people are putting these personal bond programs, talking to my DA out in El Paso, like I said, they've got a 90% appearance rate. That allows them to manage their caseload. It allows them to move the bulk majority of their cases in an efficient manner. If there's something that they can address with that particular individual, then they can do that as well. So in my experience, at least out in El Paso, it's a good collaborative relationship. Obviously, you may have differing opinions about how to do this best, but ultimately what this bill does is very simple, is that the judge still is going to have this discretion. Philosophically, I think it's important to say that liberty or freedom is the default setting, right? And I know that Representative Jones was talking about, founding of this country and some very broad principles and criminal justice philosophy, and I'm sure we can go into all of that if we'd like to. But it is why I love serving on this committee. What we say and do here is about what we believe is right and just for our society, and so this gets to the core of that, right? Do we respect those notions of freedom and innocent till proven guilty? This is a way to enshrine that and functionally put people in a better place to succeed when they're interacting with the justice system at what most of us would consider low levels. And so rather than ratchet people up into the system and create bigger problems for society, are there ways that we can handle it more efficiently and more in a more just fashion? So that's what this is aimed at doing.
Well, I'm not a criminal defense attorney either. So in this situation, we know DA offices and prosecutors have, the same 24 hours a day. Mm-hmm. So this allows me, a DA's office allows them to dedicate time knowing that statistically you're saying these offenders will come back.
I mean,
for their hearings.
I'll share with you the data that we receive from our county. We have a personal bond office that manages this population.
And so statistically, the percentage of them coming back is high. So
It's
then
something around 90%.
Okay, so then those that are violent offenders in my community, I want them to be locked up and held up in that space. So it allows the DAs in my office to dedicate their time to the true public safety of my community by, you use the term, allocation of resources, or you use resource
It was a really
deployment.
good resource deployment, yeah.
Yeah.
It was a good phrase I just came up with on the
Yeah,
fly.
well, that sounds, I wrote it down. That's a very good phrase. So it allows them to deploy their resources to the most violent people in my community to keep my family safe.
Well, and look, prosecutors across the state, if this is law, they're going to do the same thing they do every day. They're going to look at that person's criminal history, they're going to understand their background, and they're going to make a recommendation. And if they don't think it's the right thing for the judge to do, my guess is they're going to let the judge know that. And we'll probably have, in these environments, you usually have a fairly close working relationship with the court and the prosecutor. Again, this is, I believe, the best place to start, and doesn't take away the discretion of judges to be able to do something different if the case warrants it. But the bulk majority of these cases are better handled in this way. So let's start tracking them that direction. And if there is a reason to get it off that track, then the judge has that discretion to do it.
Yes, sir. Thank you.
Any other questions for Mr. Moody? Yes, well, let me.
I'll defer to Mr. Cook.
Mr. Cook, go ahead.
Thank you, Mr. Chairman. Mr. Speaker, I just had a couple of questions. I wanted to follow up, one on Representative Ramos's question about prosecutors supporting this. Do you have any prosecutors that are publicly supporting this bill?
I honestly don't know.
But none that you can tell us as of this moment, correct?
I mean, I'll look at the witness list. I don't know if anyone's here to testify for or against it.
Well, I just meant.
I mean, they're a player in this process. I would think that you probably have, much like other issues that DAs get involved in, there's probably various opinions on how to handle this. There may be some logistical things that they would be concerned about. I'm happy to hear the testimony. I honestly don't. I mean, as we've had bail conversations in the past over the last decade, I mean, like I said, prosecutors are essentially like on the side of that decision making. They're there, they advocate for what they want to do, but it more sits in the judicial space. And so they typically, not to say that they haven't weighed in on the various bills that we've seen over the last decade, but they almost sit to the side of this type of policy. And so, I mean, obviously, I work very closely with prosecutors from across the state, Republican, Democrat. So if there are concerns, I'm happy to take. I mean, I'm not afraid of that conversation. I just think, for the most part, when we've had the bail conversation, I mean, there's no role of the prosecutor has changed here. They can advocate for whatever they want to advocate for. So I don't think it really steps on them at all.
But I think it'll make it more challenging, which is fine to make their job more challenging. But
I think these. No, I don't. I guess I would respectfully disagree with that.
And I guess my thought on it is that it seems like it gives the judge less discretion. I mean, it narrows down the number of cases that the judges are going to have actual discretion on, because now it's going to be a legal presumption that they shall be entitled to personal bond. Do you agree with that?
Well, that's where they start. But every single case can go to a different track if the judge so wishes. So I don't think we're creating like a siloed group of offenses that go sailing off to personal bond. They all are going to come before the judge. The judge is going to start with, this is the default. Is there a reason for me not to go for the default? And that's the decision making.
Yeah.
That's the way it should work.
Yeah, my concern is that notwithstanding 17.03 language, and so maybe that's where we can talk offline and see if there's anything. Anything we can do to.
No, I think this is going to be one of the bigger discussions we have all session. So, and I've been a part of it for a decade now, and happy to continue having those conversations. I'm grateful for the chairman hearing this bill so early so it can be part of the conversation.
Yeah, because my concern is there's nothing in the bill that talks specifically about, if we're talking about someone that's previously been convicted of murder or sexual assault, the dangerous individuals that Representative Ramos was talking about earlier. There's nothing that I see in the bill that gives a protection there. I mean, I think.
Oh, if you've got prior convictions like that, I mean, I think we've touched that policy arena as a legislature before. But I can visit with you.
It just seems like there's a legal presumption now that you don't look into. You're not looking at that prior.
Oh no. The information that's coming to the judge, we've developed quite a bit over the time. Because if you remember, when Trooper Damon Allen was tragically murdered, part of the problem was the judge didn't have the information necessary to make a better decision. The information wasn't present. Had it been present, I don't think that the judge would have made the same decision. And so part of what we've done since that tragedy is improve the information that's being provided to the judges before they're making any of these decisions. And the more information we have before the judge, criminal history, all of those things, all the above, that makes decision making much better. So that is information is key when making these decisions. So nothing in here changes that whatsoever. I am for giving them as much information as possible so that when there is an aberration, when you do have someone there that is a problem, that they know that the default setting is not for that. Yeah, that's something that we've worked on for quite some time now.
Great, thank you.
Okay, Mr. Little has a question.
Thank you, Mr. Chair. Representative Moody, I'm struggling with an aspect of your bill, and
I've not worked as a prosecutor. I know that you have, so I've got a few questions for you. My understanding or my reading of Article 17.03 of the Code of Criminal Procedure dealing with personal bond is that the environment for obtaining a personal bond is currently permissive on the part of the magistrate. The magistrate has, the magistrate may, in the magistrate's discretion, release the defendant on a personal bond, except in certain situations.
Correct.
And one of those situations is it's a violent offense. Another situation might be that there's a two-tier system such that for certain offenses, only a district court may release someone on a personal bond. Am I reading that correctly?
Yeah, and part of the law that we changed in the last decade was to make sure that some of that decision-making went up to the district court that was going to handle those things.
And I think rightly so. My concern is that your bill kind of flips this permissive environment to one that is generally mandatory, subject to that magistrate entering a finding. And here's the part that I think that you as a prosecutor know that perhaps not everyone else knows, is that earlier when you mentioned you're doing 50 magistrate hearings at the jail at a time, generally a magistrate is not going to stop on an individual offense and enter a finding that no non-monetary conditions of release are sufficient to ensure that person's return. So I think, do you agree?
No, and I think it's a good question, because I think what people would picture is someone just stamping personal, like this is the situation you're talking about. They're not really individually looking at these. I can tell you in my experience, the judges in those situations are being given in a very exhaustive list of information. I mean, part of our job as prosecutors in that environment is to make sure the judge knows who is sitting in front of them, no matter how many we have in a row. So individualized look at these cases. In my experience, I can speak to my experience as a prosecutor and as a criminal defense lawyer who went into those same jails and was representing those folks that were trying to get out. And I always found, in my experience, those judges took an individualized look at each case. No, it is grinding, grueling work. I will tell you that. It's certainly a difficult job. But no, I've never found it to be a paper mill.
And Representative Moody, do you think that the existence of bail backed by cash or a surety serves as a meaningful deterrent to the commission of crime?
That you paid your fee to the bail bondsman?
Yes.
No, I mean their task is one task, and that is to secure your appearance. That's it.
Yeah.
So it really doesn't touch the others. When you're in a personal bond, now if you've got you've got drinking problems, drug problems, now we're monitoring a little bit that can maybe help curb your opportunity to reoffend, right? Or you've got to check in once a week with the personal bond office. There's a little bit more, so accountability is always part of the process. And that's why I want to be very clear, because in other states you just have like release to street, promise to appear. That's not what I'm talking about. There has to be accountability here, no matter the level of offense.
I understand that the release is conditioned upon certain events occurring, but my concern is not so much the situation that Representative Jones identified, which I would consider those situations to be on the extreme end of the spectrum, where there are certain offenses for which people are in jail way too long because of an inability to pay. I'm more concerned about the people who can pay, who are on a DWI first and second, for whom this is now the default position that they're going to be released on a personal bond. And while there are certain conditions that the magistrate can establish.
Well, there's mandatory conditions for some of those offenses.
I understand. I understand. But those are also misdemeanors that would be subject to this provision in your bill, right?
Correct. Yeah.
And the magistrate could impose additional restrictions if he wanted to. The magistrate could release that person on a personal bond today, even under the current situation, and even under the current statutory construction.
It's an option for them today. Now there's some statutory requirements on bond for certain offenses. Alcohol-related offenses have, depending on what offense you're on, there are certain requirements that that are going to be placed on that person if they're on bond.
One of my concerns, perhaps it's misplaced. You can tell me what you think, Representative Moody. One of my concerns is that someone on a DWI first and DWI second is going to be more likely to reoffend and drive while intoxicated if there are fewer consequences to their actions once they're arrested and detained, regardless of the question of their guilt. Okay, so I understand that not everybody is guilty of the offense they're accused of, but I do have a concern that certain people are going to be more likely to engage in that conduct if it is easier for them to get out of jail for having engaged in it every time.
Yeah,
Do you think I'm wrong about that?
I think the monitoring, particularly, and I worked in a DWI drug court, and so we worked on very intense monitoring for people that had significant substance use issues related to alcohol. So I've seen it run the gamut, right? Someone who made a mistake once versus the habitual offender. The level of intervention you have with someone is usually what dictates whether you have a good result. And so when you have a program that is actively monitoring someone and has conditions that they have to comply with, otherwise there is punishment for that, right? You violate the conditions of bond, you're back in jail. What you're putting at stake is your liberty. If you're just simply on a cash bond with no conditions, then, like I said, there's statistics on appearance rates, and I'm sure you'll hear from some of that, from some of the witnesses about that. But I think we do better when we have someone being monitored, even pre-trial, and particularly when you're talking about, and the bulk majority, like Representative Wu said, DWI, DWI second are a huge number of the misdemeanor cases that we're talking
It's
about.
a massive.
It is.
Do you have a way to estimate the percentage that might be in any county court at law?
I can get it from OCA. Yeah, I'm sure they have it.
I mean, it's the. Wouldn't you agree it's the bulk?
It is. Yeah.
Okay.
Yeah.
And so, the concern that I have is.
And we've changed the law drastically because of the concern that you just listed. Is what are we doing from arrest to trial to monitor? So the conditions on bond have now been, some are mandatory. They used to be discretionary. You have judges now implementing a lot of things to monitor those individuals. Because the last thing a judge or anyone wants is for someone who is out on an offense like that to go drive drunk and kill somebody, right? So the personal bond allows us to have those tethers into that individual. Now, as I've seen, at least in my experience, the more connectivity you have to that person, the more tethers you have to them, less likely they are to reoffend. But when you have those touch points with someone as they go through the criminal justice process, I think success rate gets a lot higher when you're able to have those tethers into them.
I appreciate your answers, Representative Moody. As I'm looking through your bill, I see this bill as very consequential in the sense that a magistrate is more likely to play to the default generally. If the default here becomes personal bond, that presumption becomes reality probably more often than not. Wouldn't you agree?
I do agree, and that's actually the
point.
That's the point of the bill. Is I do think freedom should be the default setting, not without accountability, not without requirements, but the default setting should be that you should have your liberty.
Thank you.
Okay, Mr. Louderback.
Chairman Moody, out of the 243 jails here in our state, I have yet to see a real problem on a misdemeanor getting out of jail. In fact, most sheriffs are more than happy to get rid of their misdemeanors as soon as they can, from reduction in bond to moving those folks out. That may be a little bit different in the urban settings, but in the rural settings where most of our jails are, this is standard operating procedure.
Mm-hmm.
Thank you.
No, and like I said in the beginning, there are kind of three things that we're trying to tackle here. Jail population could be one of them. The other is talking about how are we handling a population of folks in a fair and just way that is also promoting safer, stronger communities. And jails obviously play a huge role in that, and they're managing a myriad of issues. And so I do think this is something that to the extent that you have counties doing this proactively now, I think that's probably good. We can learn from those things, and if we find that is a successful path, then let's figure out how we can do it across the board.
Any other questions? Mr. Wood?
I know, I'm sorry, we spent quite a bit of time on
There
this.
are witnesses that are happy to answer questions too. I just want to throw that out for everybody.
No, but I think I want to follow up on your conversation with Representative Little.
Yeah.
And I think you guys were like really close to finishing that part of the discussion, but I think there needs to be an address, like what is the purpose of bail? Like what is the purpose of a pretrial, all the pretrial processes that we do? And on that, as a part of that discussion, Representative Little, is to make clear that bail and bond is not punishment and should not be, right? If we were saying that we have people who are getting picked up on multiple DWIs and they feel like those DWIs are inconsequential, that should be something that's addressed at punishment stage when they plead out or a jury finds them guilty, right? So if a person says, I got my first DWI, I don't really care, I'm just gonna get another one, when that person comes back to the court, when that judge says, you've been charged twice now with DWI in a very short amount of time, and this is your second conviction now, there are consequences of that second conviction, but only after that conviction or plea, right? So what happens, to say that bond should be used as a punishment, right, and not as a tool to make sure that the public is made safe, that the promise to return to court is maintained, right? If we say like those are the two goals of a bond system, to make sure the public is safe and make sure people come back to court, if what we're doing does not actually achieve those goals, then why are we doing it, right? And I think this is the point is, because, and I think what Representative Moody is saying is because most of these Class B and Class A misdemeanor cases, which is about the bulk of what we're talking about, it's petty theft, it's DWI, like a first-time DWI, the only criminal charge a person will ever get for a lot of times, and basically like just first-time offenses for a lot of people. And they're saying like because of the nature of those things, people, if they have a job, they have a home, they have family, you're not gonna run because you got a driving while license suspended, right? You're gonna come back to court, deal with your stuff, and get your license reactivated. And they're saying like for those people who are going to come back to court, they're not a threat to the community, what purpose does charging them money serve? And especially if they're poor, it's like poor people who need to work the next day, if they do not show back up to work on Monday, they're done. There's no like, you can take sick leave, you can do all this stuff. It's like, you're not here, gone, bye. And your family's out, and then now we have an entire family that's on services. So, and I know this is an important conversation, and I just for, there's a question asked about it, what happens in court? It's not just the judge. In Harris County, when they work on all this stuff, the adult probation system actually goes through while the person's in jail and does an assessment of their criminal history, their mental well-being, and does go through all this and hands that to the prosecutors and hands that to the judge, so that everybody that goes through, like where they're gonna get a bond of any kind, they're looking at those things and saying like, this is, right? And that should be happening everywhere, right? So.
Jones?
Chair Moody, what's the range of punishment for a Class C misdemeanor? You want me to tell you?
You're talking about fine-only offenses, $500?
And range of punishment?
$500.
Yeah.
0 to 500.
Okay, so for Class B, what's the range of punishment?
You got up to 180 days.
Say it again?
Got up to $2,000, 180 days, is that where we're at now?
So up to, right.
6 months.
You know what? Tell me if I'm wrong. For Class B misdemeanor, the range of punishment is up to 180 days.
Correct.
In the county jail and up to a $2,000 fine.
Yeah, 6 months, 2,000.
Right,
I just
so-
want to make, I didn't know if we had moved the fine up any. I don't practice in the criminal courts anymore.
So, but on a Class A
It was
misdemeanor.
4,000 or a year.
On a Class A, the most you can be locked up, if you're convicted, and
A
and
year.
you get the maximum penalty
365.
is a year in the county.
Correct.
On a state jail felony, if you
2.
get convicted of the maximum, what are you facing?
It's 2.
2 years in the state jail, day for day.
Yeah. And I have a whole lot I could say about state jail felonies, but we won't get into that right now.
And the fine is up to $10,000. Is that accurate?
Yeah, I think that's right. Yeah.
Okay, and in state jail felonies, you have these less than a gram cases. When you were a prosecutor, right?
Yes, ma'am.
So when you send off the alleged drugs, you send them to the lab. Do you know if you can even see with the naked eye the drugs?
You know, we've dealt with trace amount cases. We had a pretty significant problem, I think, out of Harris County, where the amount needed to test the drug to prove that it was a drug essentially destroyed it used up all the evidence, and so defendants have the right to independent testing, and so it was creating this issue of there's no ability to have independent testing because you're talking about what's left over, essentially dust. Right.
Well,
I mean, I'm not saying that's in all cases, but that's what we're talking about. You're talking about very small amounts.
But I guess the point that I'm trying to make is that for state jail and down, the maximum range for state jail is 2 years.
Yep.
Right? Class A, I said, a year. Class B, 180 days. Right? That's the most you can be locked up for.
Yep.
Is it your experience you were in the El Paso County DA's
Yes, ma'am.
office? Okay. For misdemeanors, like first-time defendants, did you guys give them time served, if you know? Because
If they wanted it, most of
it-
the time, and to Mr. Little's point, when we had DWI folks, I honestly didn't want to recommend jail time because I didn't think we were getting to the crux of the problem. You served your, whatever it is, 72 hours that's mandatory under the statute. Some people would come to you for that, and they're like, hey, you'll get your guilty out of it. And I was like, yeah, but I think I'd rather have this person monitored for a year.
I want you to deal
Because
with your
they're
problem.
doing something dangerous. I want them to have more accountability than just 72 hours in jail. So as a prosecutor, my philosophy was, if there's something, if there is a way that we can keep tethers into folks to make the community safer, that was our job. This person had made a decision, but by the grace of God, they didn't hurt somebody other than they got themselves arrested. And so I thought my job was to make sure the community was as safe as possible, which meant getting someone on probation, getting them connected to. There were some mandatory things when you put them on probation for DWI, but I mean, I think it was our job to figure out how to individually address each one of those cases.
So so with DWIs, did you in your practice make them, like on the regular, do breathalyzers, put the machine on their car?
Oh yeah.
So you know that the breathalyzers, they got it. You smile into the camera when you're blowing into it. So
Yeah, we had that, and then if people didn't have vehicles anymore, we had the unit that they'd carry around with them.
to make sure they're not drinking at home.
Yeah, depending on the severity of the case. I mean, yeah, absolutely.
Right, and was
Ignition interlock. I mean, if you want to stop someone from drinking and driving, slap that one in their car. Yeah, that was always a very good tool to use.
And was it with these misdemeanors?
You can require it on personal bond too.
With these misdemeanors, was it your experience that most people either got time served or sometimes dismissals?
I would do time served on real small, like drug cases, because some of those folks are not good candidates for probation, and so it'd be time served. But the bulk majority of things we saw were DWI and assault family violence, and in those cases, we were talking about conduct that is dangerous, that is very unsafe, and so I would always prefer to have someone being monitored in some way, shape, or form on probation. If that has to be deferred adjudication in certain cases, that's fine. But when you're a baby lawyer and you're a prosecutor, those are your big cases. It's domestic violence and DWI. That was 90% of what you tried.
So your bill doesn't prevent a judge to have the discretion. Well, actually, let me correct me if I'm wrong. Your bill says we will presume freedom and I guess the presumption of innocence, because this is America, But if there are other indicators, then, and whatever they are, then we can make you actually have to pay money to get out of jail.
Yes, you could do, if you make a finding, under this bill, you could make a finding under the different, what is this? You've got one, two, right, a couple of different considerations. And if you found that, you could do a number of things. You could do cash bail, up to, whatever the judge wants to do. Do a split, you do a split bond as well, because you want some of the conditions along with a cash bail, depending on the situation. So all those options would still be on the table. I just like starting with the default setting where we should have it. And if we're going to move off of that, then let's make a finding of that.
Thank you.
Okay, any other questions? You got on the hot seat, didn't
Is this why you put me now?
That's
You're
right.
wearing everybody out
I'm gonna wear
before you
them
have to
out.
go? Okay. I see how this works.
If not, we'll go ahead and call our witnesses and
Thank you,
certainly
Mr.
give you the
Chairman,
right to
members.
close. We have, anyone you want to call first, Mr. Moody, or does it matter? Okay. So we'll call Aaron Johnson, Chair calls Aaron Johnson. And just a reminder, if you will identify yourself, if you're testifying on behalf of someone other than just yourself, and your position on the bill.
You hear me? Okay. My name is Aaron Johnson. I'm the current president of the Texas Association of Pretrial Services. This organization was created 10 years ago, and it is serving the state of Texas in advancement of pretrial services within the state. We were recently awarded 2023 from our national affiliation with the National Association of Pretrial Services for our collaborative commitment to the advancement of pretrial justice and received the Partner of the Year Award. This is national recognition for our membership and in concerning our efforts to move pretrial forward here in the state. As far as HB 799 goes, we fully support, as local jails are already at capacity. With the passing of Senate Bill 6, which was the pretrial reform 4 years ago, local jail populations increased 5 to 10% statewide. If denial of bail moves forward as stated, as some of the other conversation that we'll have today, we're anticipating 20 to 25% of all felonies to be held initially to an already increased local jail population. Personal bond, as Rep. Moody had talked about, already covers 50% of all arrests in the state. They are already eligible for personal bond. However, across the state, it is only utilized 12% of the time. Since Senate Bill 6's inception, the state also only pays the counties $86 a day for paper-ready felons waiting for transport to the state, while most counties are incurring fees and costs of over $100 a day to hold them. Personal bond was created to help with the overcrowding issues the state went through back in the 80s and early 90s, and here we find ourselves on the same track again. What we, I had to write stuff down, sorry, now I gotta try to read it. Part of the issue with personal bond is that most of these charges are also cite and release eligible, and there are no statistics for cite and release across the state. However, most counties do not use, local law enforcement do not use cite and release in many circumstances. And we also have most of these cases, over 50% or more of the cases that we're talking about in this bill are also likely to be declined or not even filed. It takes somewhere to the tune of 2 to 6 weeks to get these types of cases filed. So when you're talking about having somebody sitting in jail during that time that's not able to post bond, when there are many studies talking about the how money has no effect on whether people show up and or stay arrest-free. So with that, I'll take any questions you may have.
Thank you, Mr. Johnson. Any questions? Ms. Jones?
You brought something up that I want to ask you about. You talked about some percentage of these cases were declined or not even filed. Can you explain what that is?
My understanding, as I'm not a prosecutor, is that if they decide that in the interest of justice, that they do not pursue these cases and/or there is not enough evidence for these cases, they will decline them at some point. But typically, that comes, again, 6 weeks down the road. On average.
So let me say this. I had never heard of a decline before I practiced in a small county near you in Texas. I had a client there that my client was arrested, and so I contacted the county because I didn't regularly practice there. And when I tried to get any kind of case information where, like it hadn't been assigned to a judge or the magistrate, so there was all this confusion within the small county. So I actually had to drive across Texas to get there. So when I tried to file a motion, again, no charges had been filed. And I was trying to figure out, why does somebody have to pay a bond and no charges are even filed? And what's the case number? So I ended up and I didn't know what to call the case. And so I asked for an examining trial so that I could get it going, because an examining trial is when the state hasn't indicted you in a felony to try to get them to move the case along. They couldn't even do that because they literally had not decided whether they were going to accept the charges. Meanwhile, back at the ranch, my client is paid a bond to get out. I then end up finding out later that they did a decline, like literally the document said a decline. I say, well, what's that? They say, we declined to accept charges. So my client has paid a bond, has been arrested, paid a bond to get out, hired a lawyer to try to figure out what's going on, and like 8 months later, the case is declined. That's in a small place. So I don't think that if you're in a situation like that where literally the lawyer can't call and get any information, doesn't know who a prosecutor is, the county that has incarcerated your client has no information for you, you can't figure out how to pay a bond. I mean, there are all these things going on, and people presume that justice is fair and it works. It doesn't. And so what do you do in this situation and why should you have to pay a bond if you haven't even had charges filed against you? Which is why I think Rep. Moody or Chair Moody, that your bill makes some sense for those situations.
And I'd also like to point out that when individuals do pay a surety agent that fee, that is non-refundable regardless of the outcome of the case. So in these cases that we're talking about that are declined or dismissed or not filed, you have individuals who get arrested, pay a bond, and that money's just gone. So I don't understand that myself, but I'll answer any other questions you may have.
Okay, any other questions? We appreciate you being here.
Thank you.
We have Ken Good.
Good afternoon. My name is Ken Good. I'm an attorney. I am on the board of directors of the Professional Bondsmen of Texas, and we oppose this bill. I want to set out just 3 reasons why we oppose the bill. I want to mention, first of all, there's been a couple of statements that I want to correct. There was a statement that courts can just say, require cash bonds at any time. That's not correct. The courts set bail. The defendants decide whether to do cash or surety. The courts then can limit bail after a failure to appear to cash only or after the bondsman files a 1719 affidavit. We also heard about El Paso using split bonds. That's the only county in the state of Texas that uses split bonds. There's a reason for that. They're not legal. There's case law on that. But El Paso uses them. They use them extensively because bondsmen are still writing a portion of that bond, and that explains why they still have a high appearance rate, even though they're using personal bonds in a split basis. The points that I want to make are the trial court still has the discretion under current law to grant a personal bond. So This changes that and says the court shall grant a personal bond unless it makes certain findings. And those findings are that nothing else will work. We've seen this language in other states, like in New Jersey, where the Attorney General interpreted that you had to use everything else before you could use a surety bond. In the first 60 days of that statute, only 3 surety bonds were written in the entire state. So I think that language is very harmful. And then the second thing I want to point out is there's a lot of data that we've used. You know, it was mentioned that this whole situation started with litigation in Harris County. True, O'Donnell versus Harris County. What wasn't said was the Fifth Circuit has ruled en banc that case should have never been filed in federal court. Nevertheless, the county is still following that settlement, and we have a lot of data from them using a default of personal bonds. The Harris County Police Officers Union reviewed 1 week's docket of personal bonds for misdemeanor courts and found a 75% failure to appear rate. According to HarrisCountyCourtWatch.com, over 2 years of data for Harris County found an over 80% failure to appear rate. Failure to appear rate at that high has 2 consequences. Number 1, you either need more courts to handle the same number of cases, or number 2, you dismiss more cases because that's what you do to keep the system from collapsing. I reviewed a docket. I mean, they do a report in Harris County every month saying here's how they resolved the cases. They resolved over 90% of the cases the month I looked by dismissing them. Then the last thing that I would say is that there was a study from Harris County as a result of COVID that said let's compare people that were released on nonviolent offenses. So all of it was nonviolent. 1 on a personal bond, the equivalent in California, and 1 on a surety bond. The study by a DA of Yolo County found that the person released simply on the equivalent of a personal bond had a 200% greater chance of committing a new violent offense in the next 18 months. The type of release matters. And I know, I understand some of the arguments being made, but you can make it where the courts can't even resolve their cases as a result of the failure to appear, because when someone misses court, the case gets put on hold until they come back. We can set up a system where we're being so kind and generous to people that we're completely destroying the court's ability to resolve cases, and as a result, nobody gets resolution and cases are dismissed. Caitlin Guajardo from Houston, Texas, was killed by her husband. He was already on a personal bond. He got arrested for domestic violence. He was released, and he killed her within hours of being released, stabbed over 30 times in her stomach because she was pregnant, and he didn't want anyone else to help raise her son. That was the case that started the bail reform movement in Texas. And I would encourage you to continue that movement in the right direction and deny this bill. Thank you.
Okay, any questions?
There's one real
Ms. Jones?
You said something, and I guess I didn't take good notes. You said something, you looked at something and you saw something where it said 90% of cases in Harris County were dismissed in a month?
Yes, ma'am.
Misdemeanor cases?
Yes, ma'am. Harris County releases a report every month on how they resolve their cases for that month. And the last report I looked at, over 90% of the cases were dismissed for the month.
Including pre-trial diversions.
Say it again. Oh. Okay, so the reason I asked the question is because I primarily practice in Harris County, although I do have law license, will travel around Texas.
Yes, ma'am.
That's not my experience in the courts, right? Even for low-level cases. I do have cases, and so I just want to be accurate. So I may have a client who's charged with 5 cases, right? A whole bunch of stuff.
Yes,
Let's
ma'am.
throw it all on the table. And my client has been locked up, and I will work a deal for my client where my client pleads to 1 or pleads to 2, and then in exchange for those pleas where he actually got TDC time, and he went to TDC, then we dismiss the other ones. And then, oh, by the way, my client has some misdemeanors too, right? Like I want to say 4 if I remember correctly. So in one fell swoop, one person who had, I think, 8 total cases.
Yes, ma'am.
3 felonies.
Yes, ma'am.
And however many misdemeanors, all but 2 of the felonies were dismissed and all of the misdemeanors were dismissed. I think that is, and again, went to prison for way longer time on much more serious stuff. So I don't think you can just look at how many dismissals there are, because I think it can be misleading if used in the wrong way.
Let me make 2 points on that. I agree with what you said in general, but I would also say, the comments being made on this bill today is we're protecting first-time offenders. The comments that you just made supports the point I'm making is there's a whole bunch of people that are not first-time offenders. And the second point I would make is, if you look at the statistics that Harris County reports to the state that are readily available on the OCA website, that data supports what I represented to the committee.
So the statistics that you looked at from Harris County, the 90% of dismissals were all for first-time offenders?
No, ma'am.
Is that what you're telling me?
No, I'm saying that I agree that part of them is what you're saying, but my point is, what was represented to the committee is the purpose of the bill to protect first-time offenders, and I don't think that's correct. I mean, you made a very good point about people being charged with multiple cases, and they're pleading to one and having other cases dismissed.
Well, I just wanted clarification that the majority of the dismissals, we just don't know where they come from. Like, we don't know if it's one person who has a whole bunch of cases or anything. We just don't know that.
Yes, ma'am.
Oh, you just don't know that. Since you
Well,
brought
I
that
mean, I
set
did a
up.
podcast with the DA, with the Yolo County DA from California, where they use this type of release statewide, and he said that they have an 80% failure to appear rate as well, and they have a Speedy Trial Act requirement overlaid on that, where if they don't come back within a certain time period, the case is dismissed.
Are you a lawyer?
I am a lawyer, yes, ma'am.
Okay. When you were in law school, remember how you learned how to distinguish cases?
Yes, ma'am, yes, ma'am.
So I guess the thing that's making me wiggle
Yes, ma'am.
and making me ask you questions is because when you take some statistics that you haven't looked at down granularly to see what it is, sort of like, on the one hand, you said first-time offenders, but then you said 90%. So somebody who's watching this could think, oh, 90% of first-time offenders, the cases are dismissed, when that's not at all what was said. So
No,
some,
that wasn't-
and I will also say this: do you ever do stuff with defense lawyers, or you only ever work with prosecutors?
I don't really work with either one.
Interview.
Interview on on my podcast?
On your podcast.
Everybody. I've
Okay.
had both criminal defense attorneys, judges, prosecutors. I think my next guest is scheduled as a prosecutor, but I mean, I'd love to have you as a guest.
Fantastic. Let my office know. I'm happy to do that. But I also think that perspective matters.
Absolutely.
Right? So I just want to be clear that you just can't look at dismissals in a vacuum and say they mean something.
Yes, ma'am. I understand your point.
And would you agree with Chair Moody that personal bonds and personal recognizance bonds are different things?
Yes, Texas doesn't really use personal recognizance bonds. They only use personal bonds. I think the point I would make is there's only very few counties in the state that have personal bond offices. So the supervision that he is talking about would not be available in the majority of the state. But as Ms. Ramos pointed out, that's geographically not the population numbers.
Okay, thank you.
You're very welcome. Thank you.
Okay. Members, any others? Mr. Moody?
What was the county that you cited? The county of the study?
Oh, Yolo County.
Yolo?
Yolo County
I
in
thought that's
California,
what you said.
yes, sir.
Okay, I just want to make sure. And that's where?
Yolo County, California.
California. And they don't use personal bonds like we do. They don't have the same system.
They do not have the same system.
That's
They're-
different.
No, sir, they're not. They're simple release. Texas calls it personal bonds. California
Okay, so
calls it one thing,
that's
New
why I want to
York
be
calls it
clear, when you're citing studies on non-appearance in California, in Yolo County, that is not apples to apples with personal bonds in Texas are. I mean,
And-
so
and-
let's just, it's like, let's just make sure that's level set.
With respect, I do not agree. They're both examples of simple release mechanisms, which is, they just use different names.
Personal bonds come with conditions and tethers and monitoring. And they have the ability to be, they're not simple release to the street.
They can be if there's a personal bond office, but not.
They can be, but that's not wholesale what they are, which is what that is in California. So when I look at the numbers out in El Paso, in our office, 91% court appearance for folks that are on personal bond. And these came from my district attorney's office. 84% no new charges. to me, these are very successful numbers. And this is the population we're talking about.
Yes, sir, and I mentioned that the reason for that is that El Paso uses split bonds, which no other county in the
So
state
you
uses.
think the level of success in El Paso has to do with the cash or surety portion and not the personal bond?
Absolutely. We've seen that in other parts of the state where they'll require a portion of a bond. I mean, I think Bear County used to do it. I mean, the pretrial bond office head would tell me, well, we would post 3 personal bonds, and on the 4th case, on the smallest case, we'd require them to get a surety bond. So if they didn't show up for court, we could call the surety bond company and say, you go find them because that's your job. So yes, we see that all the time.
But so you think that the appearance, so are all of these cases have surety bonds on top of them, the personal bonds in El Paso?
No,
or what
sir.
percentage do?
No, sir. You were the one that pointed out that California uses split bonds. I was agreeing that they do that.
No. I was talking about the data set here, and I think what you were trying to convey was because we also utilize surety in conjunction with some of these personal bonds in El Paso, that's why these numbers are so good. That's the difference?
I do believe that's
What
your
is the
explanation.
public safety? What's the public safety? What do the surety bonds folks bring to the table for public safety?
Public safety, they require that the defendant report to them once a week. If they feel like it's a higher risk, then they can require them to come into the office or report more often. If we see that they're doing something they shouldn't be doing, we can report that to the county. And the vehicle for that is a 1719 affidavit, where the court can grant a warrant for their rearrest. And in doing so, a 1719 affidavit grants the court new powers that it did not have, and the court can require any bond after that to be limited to cash only.
The level of interaction, you would agree with me, level of interaction in a personal bond office in terms of monitoring, in terms of other different conditions that can be placed on them, those don't fit the same surety bond system. The personal bond system is a monitoring system that is over and above what the surety bond system can provide. You're talking about an information flow up the channel, right? But if we're actually going to monitor and do these things and keep a close eye on people, then you have to have staffing around that. That's not what surety bond companies do. That's not their job.
No,
right?
we do, absolutely. We provide monitoring. And that's probably the primary job we do, is provide monitoring to make sure people will show up for court and that they're doing what they're supposed to be doing. And I would say that any court can oppose a condition on a bond, whether it's surety or
I just need to break
personal.
down.
I apologize. I apologize.
Because I want to get to each piece of what you're saying. Key thing is to make sure they appear in court. And you say you're monitoring them to be able to make sure they appear in court, which means you're talking to them once a week unless something tells you that you need to talk to them more.
Yes, sir.
What are the other types of monitoring?
Well, we do have situations where the bondsman requires GPS monitoring if they feel like it's a great risk, that's part of their contract with the defendant. And so anything that the state can require for monitoring, usually the bonding company in a contract, depending on the risk, depending on whether the family believes that there's concerns. But I would say the primary monitoring that we do is talk to them, and we set up, what do you call it? We set up a relationship with them where they trust us. I mean, the best example I can give is where the state is searching house to house for a defendant who failed to appear because they thought he was great danger. Mm-hmm. And the bondsman, because of his personal relationship with the defendant and the family, reached out to the family, and the defendant not only agreed to come back, the bonding company met the defendant at the jail to walk him in to cause much great public safety and to make sure that nobody was injured. And so that's the example of what the bonding industry does.
And so is it your position that type of relationship isn't built in the personal bonds office?
I don't believe that is. I believe that the trust that's built up, and with the monitoring that you're talking about, that can be imposed on any personal bond or surety bond. It's not tied to the type of bond that's used or posted, because the conditions set out under Chapter 17 are separate and apart from that.
All right, thank you for your testimony.
Thank you.
Mr. Louderback.
Thank you, Mr. Good, for pointing out clearly that the bond system right now in place is safe, great for public safety, and works well. Thank you.
Thank you, sir.
Mr. Wood.
Thank you, Mr. Chairman. And I kind of actually want to ask about that. So earlier you mentioned a a case out of Houston. And you said that a man was charged with domestic violence, he was arrested, he was brought to jail, he was eventually processed through, and because it was a first-time offender, and the nature of his condition, that he was given a personal release bond with conditions like don't go back to the house, don't go to her work, don't go near the school, right? And that person did not follow those instructions
Yes, sir.
and ended up killing his spouse.
Yes,
Right.
except
Wait, wait,
for
wait.
it wasn't a first-time offender like you represented. It was not.
Okay.
He was already out on a personal bond.
For what?
When he was out on a personal bond for leaving the scene of an accident when he was arrested for domestic violence.
Leaving the scene of, so
Leaving the scene of an accident, he got arrested for that, got a
Class
personal
B
bond.
misdemeanor.
And he already had a
Okay.
failure to appear at the time that he was arrested for domestic violence for failing to appear for that charge.
And, you know, when I was at the office, Harris County, your domestic Class A bond was $1,000, so he would have paid about $200, $250 to a bondsman. And you're saying that if he had been forced to pay $250 to a bondsman, then the murder would not have happened.
No, what I'm saying is that if he had not been granted a personal bond, he would have had a cooling off period in jail, which I think is very important in these types of cases because he would have had to have contacted somebody because he did not have the money on him. And so that would have required more time. Also, his wife, you know, her family was asking her to move, to not be there waiting for him when he got out of jail. And she said, he's not going to be released tonight. The criminal justice system will work and it will protect me. It did not.
How long does it take to set a bond?
In Harris County, once you're in jail, it usually, for posting a bond, usually takes 24, 48 hours to get out of jail. But on a personal bond, you get out much quicker.
Up to 24 hours.
No. at
48
least.
hours, if you're not charged, if you do not get charged within 48 hours, what happens?
Well, I mean, Harris County has immediate charges. The rest of the state, the majority of the state, is you're arrested on a probable cause affidavit. So 80% of the state, you're not charged at the time you're arrested. You're arrested and released on bail. So that's 80% of the state of Texas.
And again, you're saying that had that person, had any of those people, if they would be safe, the society would be safer if they give your clients, your members, money.
No, I'm saying that the public safety would be better. Yes.
Okay. So
absolutely.
On one hand, we can do all the conditions, all the requirements through the court, have them answer to the court, answer to the court staff, answer to adult probation, answer to release, and have the same conditions. On this other hand, we have the same conditions, but you pay money to one of your members.
I don't think that's the only difference, but I understand
Well,
what
it's
you're
the
saying.
same conditions on both sides.
No, there's not. It's a completely different situation. You're posting a personal bond. It's a surety. It's a bond without surety. And when you're you're contacting a surety company and they're asking you questions. What's your criminal history? We're doing our own assessment of whether they're going to show up for court, and we're going to be
The same assessment that the courts do.
Maybe, but we're going to be. But look, in Harris County, we're seeing situations where someone fails to appear 17 times on a personal bond, and what's the response? They keep getting another personal bond.
Yeah.
I mean, don't you think of around five times of missing court, she should say, okay, no more bonds, or at least no more personal bonds, not 15, not 10.
I get it. And, you know, it was like when we're dealing with like driving on a suspended license, petty theft, and those. I mean, it's very frustrating when I was doing it, and you know, when people didn't show up, and we would have to revoke their bonds, and then we'd have to wait till they get arrested again
Yes,
and
sir.
come back, and it's
Yes, sir.
very frustrating. I get it. But what I'm still trying to understand is, if the court imposes a set of conditions over here,
Yes, sir.
on my left hand, the court imposes the same set of conditions on my right hand. They're the exact same conditions.
Yes, sir.
Okay. If you screw up on any of those conditions on either hand, you're in trouble with the court, and there will be consequences. Fair?
Okay. I understand what you're saying. Yes.
The only difference on my right hand is that your membership gets a cut.
No, sir. That is not the only difference in that situation, because in the situation where the private industry is involved, he's going to have family members reach out to them. And then when the family gets involved, I think we cannot discount the involvement of the family, because when the family gets involved, they're saying, you have value.
Okay.
We think that you are capable of being turned around. And so when he gets out, he is confronted with family and a bondsman that says, you have value. Don't screw up again.
Okay. So on the left hand, we're not making the family come and support them and make the family pay a bondsman. And so because of that, the family won't care that their loved one is in trouble.
Well, the
And
family's
you're
not
saying that
involved.
on this other hand, if the family was forced to, everyone give up their lunch money, give up whatever they have, they pay the $500 to the bondsman, then there will be more invested, and they'll be forced to care and finally take care of their loved one.
I believe so, and they'll have a second guess about, they'll have a second thought. Maybe we crossed the line. Maybe we need to reassess what we've done. But I believe the personal relationships and the family involvement is the most important thing for the bail industry, and it gives people second chances to become productive citizens. And I think we're discounting that too much.
If someone's charges are dismissed, dropped, or they're found not guilty, should bondsmen refund their money?
No, sir. They're being paid a premium, and they're paying for all the supervision that's being given to them.
For someone who didn't do anything?
I mean, we've already talked about 80% of the people that are arrested in the state of Texas are admitted to bail and waiting charges to be filed, so we may be monitoring them for a year. It's premium on a bond where we're assuring their appearance. So, no, sir, they would not be, bless you, they would not be entitled to a refund.
Ms. Jones?
So are you that pretrial service, have you ever, where are you located?
I'm in Tyler, but I also have an office in Houston.
So you're familiar with, have you heard of pretrial services in Houston?
Yes, ma'am.
All right. Are you aware that pretrial services, when they're figuring out, well, let me ask you this. Who monitors defendants when they are given a personal bond in Harris County, if you know?
My opinion is no one is. I mean, defendants
Okay.
see that as a green light to commit more crime. When they get 17 failures to appear and keep getting personal bonds,
Okay,
that's a green light to commit more crime.
Hold up. You just give me information I didn't ask for.
I apologize.
Okay, no worries. I'm gonna work with you.
Yes, ma'am.
So I can tell you that in my 30 years of practice, I haven't had that happen,
Yes, ma'am.
right? Did you know that pretrial services ask the defendants to give them 5 family members that they can call and figure out what's going on with them? Did you know that?
I would not be surprised.
Okay, well, they do, right? Did you know that pretrial services finds out like where they're living, their living situation? Do you know that?
I would not be surprised.
Okay. Did you know that pretrial services finds out like where they're living, like if they don't live, I guess by themselves, like maybe they're struggling there with somebody.
But
Did you know
pretrial
that?
service has no ability to re-arrest.
May I finish, please?
Yes, ma'am.
Okay. So, did you know that pretrial services reports to the court about whether the person that they're supervising is doing everything the court asks? Did you know that?
I don't believe they're doing that. No, ma'am.
Oh, they absolutely are. Because guess who gets to notice that I got to come to court when my client isn't doing what they're supposed to be supervised with?
But the problem is, you told me yesterday that you do mostly all felonies, right? So we're talking
Yeah, but
felonies, and we're talking about misdemeanors.
I said
today.
I mostly do felonies.
Yes, ma'am.
I didn't say I only do
Yes, ma'am.
felonies. But, and oftentimes some of my felony clients have misdemeanor charges as well, right? So I get notice when my clients aren't doing, well, let me ask you this question. Did you know that the court is notified by pretrial services when the defendant is not doing what the court asked the defendant to do?
I think there are times in felony
Oh.
cases they do. Yes, ma'am.
No, it's in misdemeanors too. You, bail bondsmen, supervise what the court tells, I guess, orders the defendant to do. Is that accurate?
No, ma'am. No, ma'am.
So you don't supervise if they're supposed to blow into into an intoxilizer, you don't monitor that.
Well, and that's usually a separate condition of the bond, and that, I mean, we can perform that, but that's usually not something that the court, they already have someone else doing that, or they have to report to a third party.
So, for example, if it's a DWI, because there's been a lot of
Yes, ma'am.
testimony about DWIs, so somebody's making sure that the person is doing what they're supposed to do related to not drinking, but it ain't you. Is that accurate?
Can be. Yes, ma'am.
Okay. You cannot, as a bail bondsman, after finding out what's going on in somebody's family, make them do stuff to be better people.
We can report to the court, like if a family member comes to us and says, X is going on, we think they're going to run, or we think they're doing drugs again, we can absolutely report that to the court and request a warrant.
That wasn't my question.
Okay, I thought you said
No.
we couldn't do
You
anything.
want me to repeat it?
Sure.
Yeah. The question is, if you find out they're doing whatever from their family member,
Yes, ma'am.
can you, the bail bond, I don't mean going back to the court, because I'm going to get to that in a second. Can you, as a bail bonding company who's trying to insure their bond,
Yes, ma'am.
can you make them do anything? Can you tell the defendant, hey, you better stop doing this at your house, or you better not do what your mama say you're doing? Can you do that?
We can make them come in to the office to report, and then we can sit down and have a talk with them. And in our situation, what we would start with is say, you need to change your conduct, or we will have to report that to the court.
Did you know that pretrial services in Houston actually does that?
Pretrial services doesn't have any incentive to do that.
So I'm going to ask you again, did you know that they actually do that? Because I have to deal with it all the time. I literally am summoned to court on like less than 24 hours notice that I got to show up to court because my client ain't doing something my client is supposed to do, whether it's convenient for me or not. Because the judge wants to deal then with my clients not doing what they're supposed to do. So they do that.
I understand.
And you can call the court if they're not following the terms of whatever it is you tell them, like we tell you to come into our bonding office so we can lay eyes on you and to make sure that you're showing up or to give me payment or whatever. Did you realize that pretrial services can do the same thing?
I think they can.
And do you also know that pretrial services can call the court just like you and say, hey, judge, issue a warrant because they're not doing what they're supposed to do? Did you know pretrial services could do that?
I don't believe that they can. I do believe, I mean, bonds are held insufficient all the time where they file a motion to hold the bond insufficient.
I'm not asking you that question. So let me ask the question again. Maybe I'm not doing a good job of asking the question. Here's the question.
Yes, ma'am.
Did you know that pretrial can send something to the court, and it's in writing, where it tells all the bond violations? It's called a bond violation report.
Yes, ma'am.
Do
They
you
can
guys
report violations to the court, yes.
Hold up. So they have a whole thing where they,
Yes,
with
ma'am.
specificity, tell the court they did this wrong, this wrong, this wrong, this wrong. Did you know they do that?
Yes, ma'am.
Okay. And did
Wait,
you,
the counties, like 10% of the counties that have pretrial offices do that. 90% of the counties that don't have pretrial offices do not.
Yeah, but we've heard testimony that 90% of the people that live in Texas are in these big counties like Harris County. So that's where most of the people are locked up at. So you just
I'm not just saying that that's incorrect. I've already pointed out, as Ms. Ramos said, we're talking geographically versus population percentage. But I'm just pointing out.
would you agree with me that population matters?
Well, I'm not saying it doesn't matter. I'm just pointing out that that only applies geographically to 10% of the state. I'm not arguing with you. I'm just telling you what the geographics are.
10% of geography as opposed to 10% of actual people that are actually being locked up.
I don't know whether the 90% number is correct. I'm just telling you what the 10%. I mean, in Texas, especially in the House, large county versus small county makes a big difference.
Oh, we get whooped all the time. We big counties where we got out the most of the people, we get whooped by the rurals all the time because it's like Survivor. I was on that. I couldn't count when I was on Survivor, but I can count now. So while geography may be a convenient, I believe, not to be apples and oranges analogy, I think actual people affected, like those numbers, I think are important. So what I'm respectfully suggesting to you is that pretrial services in the counties that have them not only do what you do, not only do they ensure or try to ensure appearance, but they also deal with the breathalyzer if they don't have that, if the person has a GPS monitoring device and they go into zones that they're not to be in, they monitor all that. So pretrial services monitors things that you guys don't and can't monitor because you're not authorized to.
I think that they can, the court can order monitoring that is not provided by the surety, and then we provide monitoring to ensure they appear for court.
No, so
I think I agreed with you.
You guys ensure that they show up in court, or at least you try to. Is that accurate?
Yes, ma'am.
But all the other conditions, you got to go to AA, you got to do this, you got to do that. You guys don't monitor that. Is that accurate?
I would say we can, but I don't think that we are, I think that, well, I mean, we can do some of those, yes, like the one you just mentioned, AA. We can ask them when they're reporting, did you go to AA this week?
So, and you realize that if you have to stay employed as a term of your bond, you realize that pretrial services requires them to bring their check stubs. Did you know that?
I would not be surprised, no, ma'am.
Okay. So pretrial, at least in my experience, whether I've had a client in a rural place or whether I've had a client in an urban place,
Yes, ma'am.
or whether I have a client who actually paid a bond, pretrial actually does more than bail bonding companies because they make sure that the person, and let me be clear, there are defendants who I don't care what you tell them to do, whether you let them out for free or whether you make them pay you money, they're just not going to do what they're supposed to do, right?
I understand.
Right? I mean, so we agree there.
I mean, those people normally would not be bonded out by the industry.
I'm sorry, say it again?
I don't think those people would normally be bonded out of the industry. Those would be career criminals and they would stay in jail.
Because you guys wouldn't write a bond?
If there's
Or because the
nothing
bond
that
was
can
too
be
high?
done that they wouldn't show up for, then they've been through their whole family, their whole friends, and they have burned up all those, and we would classify those career criminals, and they would stay in jail.
But I'm talking about for people that are granted bonds.
Those are
I'm
well,
talking
they
about
would
for
be
the people
granted
that
a
are
bond.
granted bonds.
They would be granted a bond in that situation. It's just they wouldn't have any family, or they burned through all
Right.
them, and nobody would be. They would be saying, "This is the guy needs to stay in jail," and he would stay in jail.
Right. So, so what I'm just trying to ask you, or at least advise you of, because I don't think you were familiar with it, is that pretrial, at least the pretrial that I'm accustomed to dealing with, does all the monitoring of everything. And if the person violates, whether it's they blow wrong, they blow alcohol, they shouldn't have been drinking alcohol, or they're out past their curfew, or they go into an area that they're not supposed to because they've got GPS. Pretrial services actually does what's called a violation report. It's called and then they send it to the court, and then the court requires a hearing on the bond violation report. And at least it's been in my experience where most times the judges revoke them, and then they sit in jail till their case is over. So I'm just trying to help educate you on that.
Well, I mean, I would just say current law gives the trial court judge, the broadest discretion to do whatever he thinks is best. This bill limits his discretion. I think that's not good policy for Texas. But thank you for educating me.
Members, any other questions?
Okay, great.
Next up is Darby Good. Darby Good does not appear to be here, but the record show that he is here and against the bill. Michelle Chapa. She was the one who was here. She literally. Okay, well, Michael Nashby. please give us your full name, who you represent, and your position on the bill.
Hi, my name is Michael Nashby. Hello, Chairman, members of the committee. It is my privilege to be here with you today. My name is, like I said, Michael Nashby, and I'm a San Antonio resident and the Right to Justice community organizer with the Texas Organizing Project. I would like to take a moment to state TOP's support for HB 799 as written. In its current form, this bill establishes a presumption of release on non-monetary conditions for a range of low-level offenses, no matter one's personal opinions, political leanings. The presumption of innocence is central to our nation's legal system, and it must be protected. HB 799 is simple, forward-thinking. It's a bill that effectively creates presumption in favor of personal bond for lower-level offenses, shifting away from the standard process of financial sureties, which have done nothing more than increase mass incarceration throughout Texas, nor has it proven to keep our communities safer or reduce the cost burden on taxpayers who foot the bill for our state's mass incarceration problem. HB 799 is the kind of legislation that will increase fairness in our legal system, all while respecting our constitutional rights. Again, TOP is glad to register in support of HB 799 and would like to see this presumption of release applied to all offenses. Together, we can work toward building a legal system that better serves all Texans so that our freedoms are protected, communities are safer, and more people have access to justice they deserve. Thank you for your time, committee members.
Members, any questions? And Mr. Nashby, could you please clarify that you represent an organization and yourself?
Correct, yes. I am the Right to Justice organizer for the Texas Organizing Project, also known as TOP.
And you also represent yourself in this?
And I do, yes.
Members, any questions? Thank you, Mr. Nashby.
Thank you.
Next up is Michelle Chapa. Please tell us your name, who you represent, and your position on the bill.
My name is Michelle Chapa. I represent myself, and I highly oppose this bill. I wanted to support it. I did until Mr. Moody here started explaining it more, and things that were not written were said, and I absolutely not. I am a crime victim, and I firsthand know the devastating effects of violent crime. And here's why.
I'm sorry. Can I just stop you real quick? You had registered for the bill?
Originally, yes.
Okay.
I am pulling my support.
So
from
you're
it.
changing your position
Absolutely.
to against? Okay.
Absolutely. When offenders are allowed to walk out of jail for free, it sends the message that their actions and the harm that they've caused are not taken seriously and victims are overlooked. Certain offenders, especially habitual offenders, those with a history of violence or those who have shown that they are a danger to the community, should not be allowed to walk free without any financial responsibility or oversight. A PR bond is intended for those who pose little or no risk to public safety, low-level, nonviolent misdemeanor crimes. They should never be for weapons charges, any domestic violence charges. Most domestic violence charges are misdemeanors. When you're talking about myself being a victim of domestic violence, if this person is only out of the home for 12 hours, I've had victims I haven't been able to move out of their homes before their offender is back on the streets on a PR bond, and they're back, and domestic violence escalates. There's no conditions. We talk about pretrial. They do report bond violations. But if the judges are not going to revoke these bonds, or they don't even care, nobody's going to go look for them. They put out a warrant for somebody on a PR bond. Harris County, they're not bounty hunters. They're sheriffs and they're understaffed. Nobody's looking for these people. The only time they get picked up again on their violations or their warrants is when they've committed another crime. Now, you have surety agents that have bounty hunters that are willing to go pick up these people that haven't gone to court, and I would rather have somebody babysit my offender and make sure that they go to court than just assume that Harris County is going to do the right thing. What has happened in Harris County with the O'Donnell consent decree has been deadly. People are dying. because people are out on PR bonds and they're not facing the consequences or any kind of, when you talk about this hand and this hand, Mr. Wu, yes, you pay a fee on this hand, and that hurts your pocketbook. You're not gonna wanna do something that's gonna make you lose your money, right? So you have those same conditions, and then you paid a bond here. But guess who co-signed on that bond? Your grandma, your husband, your neighbors, people that are gonna assure that you're gonna go to court because they're gonna lose that money if you don't, right? Then you have over here, you have your pretrial set of bond conditions. Who pays for those? The offender, right? So when you're looking at your PR bonds that have these conditions that come with monitors and drug testing and check-ins and all that stuff, the offender's having to pay all those. The cost of those fees is more oppressive than an original surety bond would have been. And they have to do all these check-ins and drug testings, pay to go down there, pay to park, pay for the test if they miss the test. But then what happens if they don't? I have somebody who was arrested on a misdemeanor DUI and endangering of a child when she had her minor child in the car with her and she got in an accident. She was arrested for misdemeanor DUI and she was put on probation for 6 months. In 6 months' time, she had 9 violations. She failed 3 drug tests, didn't show up for 3, and her breathalyzer failed her 3 times as well. She had to wear one. We know what happened? Nothing. Her bond violations report went to the judge, who then dismissed her on probation. Unsatisfactory dismissal of probation. She never went to jail. She never, for violating her probation. This is happening a lot in Harris County. So the victims, we want to talk about offenders. They're in jail. They can't go to work. They can't provide for their family. Neither could I. Neither could I. I couldn't work. I couldn't provide for my family. I was violated in my job, at work. As a single mom supporting a 2-year-old, I went to work and became a victim of violent crime by people that were already out on bail. And it wasn't once, it was 13 times in 2 years. I didn't get to work. I didn't get to support my family, and I had to pay to go downtown and testify. I had to park, take time off of work, get something to wear. I have no idea where I'm going. There's nobody there holding your hand, and all of this cost me money while also not being able to work. I'm not even going to talk about the cost of therapy, of the PTSD and the anxiety that happened for me as a victim, knowing that my offenders were out of jail in less than 24 hours. And they never did a day in jail. They were given probation for aggravated armed robbery. Every day, these guys are out here with us, with you, with me, never did a day in jail. And I had to come out of pocket a lot of money. And I lost my sanity, I lost my peace, I lost my family, lost their peace. I can't have my child run up behind me when we're playing because I can't stand to have somebody running behind me. Freaks me out. I don't like being here in groups of people. I can't see all your hands, and that freaks me out. When you've had a gun in your face 13 times and you're protecting your employees, these are my kids. I spend 10 to 12 hours a day with the people that work for me, and they're laying on the ground and they're crying and they're bleeding. We've had stabbings, shootings, pistol whipped, my 6 months pregnant assistant manager dragged across the floor by her hair for some cell phones. 13 times in 2 years. Because of O'Donnell. They were back out on the street again. These are not first-time offenders. When we want to say that PR bonds are for low-level, nonviolent, that is exactly what they're for. That's why I wanted to say, yes, this is something we want to do. But there's no limit to them. There is a such thing as a second chance. What does a second chance mean? Second, right? Not 4th, 5th, 9th, 13th bond. The amount of bonds I see people on, at what point do you say, yeah, you didn't come back, and then you got out and you committed another crime, and then you didn't come back for that one, and then you got out and you committed another crime, and you're committing another crime? What limit is there going to be on PR bonds? I also am a minority, and I'm also poor. So why don't I matter? Why is the conversation about race and wealth only for the offenders and not the victims? Because nobody cared that I was Latina. Nobody cared that I was poor. Nobody cared that I had to take time off of work. Nobody cared that I had to go to therapy. Nobody cared that it ruined my family's first vacation. When my son wanted to see a white Christmas and we were traveling to Colorado and I got robbed the week before and stayed in bed crying for days. I still, to this day, any noise I hear outside, I'm looking, because these guys never went to jail. They were on probation, and again, and I'll show you the paperwork, they violated, they reoffended violent weapons charges over and over while on probation, deferred probation, and they were released unsatisfactory. What does that mean? Nothing. That means that if they get caught again and they want to ask for probation, the judge could take it into consideration that they didn't finish their first term. But what happens? Violence escalates. They've already committed an aggravated armed robbery, and I wasn't the first. I wasn't the last either. Somebody's going to lose their life again. How many people have died in Harris County alone by people that are out on PR bonds? These are not first-time offenders. These are repeat, habitual criminals that have 15 misdemeanors, and now all of a sudden they've got 6 felonies, and you hit felony court and you just keep going. And if you just get more and more felonies and you're never going to jail and you're being able to be released off of probation, unsatisfactory, and never have to do a day in jail, what are you telling the criminals? And what are you representing to the victims? We don't matter.
Absolutely, and I totally get you in talking about the crime victims, and like in appropriations right now, we're dealing with the loss of the funding from the Violence Against Women's Act, and the state is coming through and shoring up those funds, and that's been a really big priority. And I've said this before, that there are not enough services for crime victims. I think all of our counties should be given state support, that there should be an office of crime victims, that there should be people who escort you to court. There should be people who say, like, if you're a crime victim coming to testify, you do not pay for parking, and you should never pay for parking, right? And I think there should be...
You want to know how I met these people, these people, these people, these people? They're all victims. Do you know how we met each other? In court.
Yeah.
Walking into court. And I see these people that have lost their children. I didn't lose my life, but I lost my life how I knew it. These people have lost family members.
Absolutely. And I
There
think
needs
and
to
I think
be
the
a
state, we
limit.
end up re-victimizing people by not providing that support.
Yes,
and
and
I
then the
completely
system
agree with you.
victimizes me again when they just tell me to my face that it's okay. It's okay that you were robbed. We're going to put them on probation, though. That's fine.
Yeah,
they don't have to pay to get out of jail. That's
I
fine.
can't speak to that because I don't know what happened in that
This
case.
is a
and
daily
that's-
occurrence. This isn't an anomaly.
But
This
could I
happens
ask you?
every day.
Could I ask you this one quick question? If the bill just said that this only applies to true first-time offenders, no criminal history, no prior arrest, and it is a true first-time, low-level offender, non-violent. So if we can carve out domestic violence, let domestic violence go whatever route that it normally goes.
Even
If it's-
DUI is dangerous.
And DUI, but they're not dangerous if they're sober the next day, and we immediately tell them to put on an interlock. You come in for weekly urine testing, UAs, right? Breathalyzer, UA, hair, whatever drug, alcohol you're doing.
Who's going to pay for that?
We already pay for it. Our counties already pay for it.
So I pay for it.
Yes, we all as a society pay for it.
For my
It's-
offender.
because to keep them in jail at $50 to $70 a day is more expensive than to spend $6 to.
It is, but I
supervise them.
would sleep at night.
But I'm talking about true
But true
first-time
first-time,
offenders.
low-level, nonviolent,
Would you-
first-time, no crime, absolutely, 100%. People deserve a second chance. I have never said I don't want somebody to have a second chance, ever.
And I know you changed
It's not
your
second,
position
third,
on
yes.
this bill, but if the author changed this bill to say these are true first-time offenders, non-violent first-time offenders, true, what you would say are true, would you support this bill again?
If there's a limit.
True first-time offenders, that means
Your
that the
first-time
second
offense,
time they get
only
arrested,
100% I
you're
would
out.
support this bill. 100%, your first-time offense with no violence, no criminal history, 100%. But what we can see what happened with O'Donnell, this bled right into felony courts. There should never be. You're a felon in possession of a weapon. How are you eligible for a PR bond? You're a habitual felon, and you're carrying a weapon, at sometimes a machine gun, and you walk out of jail on a pinky promise. This cannot happen statewide. I don't know how things are done in El Paso, but Harris County, we got a problem.
I can't address every
Hold on.
situation. Can I tell you
I
just?
do want to be pretty clear here. The fact scenario that you just laid out is not eligible for this. So you're talking about
It should
violent.
not be.
And it's not. The bill is
It
not
is in
written.
Harris County.
No, no, no.
So
What
those are the protections
I understand that
I
we're going to talk about Harris County a lot, I bet, is my guess.
Oh, for sure, because it's
But,
crazy.
and I understand, and I've been reading up on that to prepare for today. I want you to know, as someone who has walked victims into the courtroom as a prosecutor, who has sat with them through difficult verdicts, who has sat with them in the hardest of all situations, I empathize with everything you've talked about here today. I want to be very clear that this provision here, while you may think it goes too far, and I appreciate the testimony, and that's something that we all have to take into consideration as we work on legislation, would not in any way, shape, or form touch the situation that you just talked about, nor would I ever advocate for that. And we're
Correct.
going to have a broader discussion about violent felonies later, and I assume that you're going to testify in that environment as well. I look forward to hearing your testimony on that. Thank you for bringing your concerns forward about this one, and I'm
I
very
would- like
grateful
I
because
said, I would
know
support
that, and I've read up on your story and your background and your advocacy, and I'm grateful that you are taking your time and your energy and your effort to bring a voice to some of these concerns. So I'm certainly very grateful for you being here today. Thank you.
Thank you. Like I said, for first time, absolutely. Beyond that, we need to have a conversation about how many chances you get.
We have another question for you from Mr. Little.
Thank you, Ms. Chapa. I do have a question, but to Representative Moody's point, I'm not sure that the bill doesn't impact the situation that she's describing. And I'm not aware of any place in your bill that limits the number of misdemeanors or state jail felonies in which you would engage.
But the conduct she was describing was aggravated assault with a deadly weapon. That is not eligible here.
I don't mean to.
It isn't now. It's not eligible now, but what is that when you have people that are out on bond and they already have 4 or 5 PR bonds, Harris County is very understaffed. And if you have seen a cop that many times, you're doing a whole lot of crime. But it escalates to felonies. And so it's the entitlement of getting it over and over and over and never having the consequence. It's like, what limit is there on your low-level misdemeanors?
And to your point, I mean, last week this committee heard bills impacting burglary of vehicle, which is currently Class A misdemeanor. And you can hit a vehicle over and over and over and over again and still be subject to a personal bond under this scenario. This I'll call it default scenario. But Ms. Chapa, my question really was going to be, what was it that you heard in this hearing that changed your mind about this bill?
It's too broad. It's way too broad. And then I hear about the conditions of bail, the conditions of this, the conditions of being on a surety bond, but nobody's brought up the conditions for the victims. And so I'm sorry, but if you were arrested for violence against me, I don't really care what your conditions are. You should have to pay. It should hurt, not just your feelings, but your pocketbook. And that's going to make me feel safe because I know that you're doing what you're supposed to do. If I look and I see a bond violation report and you've got 14 bond violations and nothing is being, how is that keeping anybody safe? It's not just about me. There's how many millions of people in Harris County that are going to end up being a victim just because we felt sorry for them. They're poor. They should get out of jail. I'm poor. I didn't want to be a victim. The victims are the only ones in the criminal justice system didn't ask to be here. We didn't sign up for this.
I don't think I could have said it any better myself. Thank you.
Mr. Louderback.
Thank you, Ms. Chapa.
Thank you, sir.
Any other questions? Ms. Jones?
I really want to thank you for coming to testify.
Thank you, ma'am.
Because I don't think people hear enough from victims. So I, too, am a survivor of domestic violence. I've been raped and strangled.
I'm sorry.
Shot at.
Mm-hmm. We have a lot in common, Ms. Jones.
Yeah, and I've also gone to a lot of therapy.
Mm-hmm.
Mental health therapy is important when you go through these things.
100%.
Because even sometimes when you think you're over it, something triggers you and you go right back to like it just happened.
A smell, a sound, a picture.
And you, in many ways, lose the ability to trust what you used to think you could trust, especially if it happens from somebody in your family, because your family's supposed to protect you at a minimum. And I was actually going to ask you if it was for first-time offenders. I was going to ask, would that, like someone who doesn't, I guess what, I mean, nonviolent, domestic violence, because I agree with you. It's a lot of, with DWIs especially, they're especially dangerous because a car is like a deadly weapon. And a lot of times people think there's no harm in a DWI if nobody actually gets hurt, until somebody does get hurt. So I just wanted to see if it weren't in those categories, and also with domestic violence is especially concerning, because especially if there's like stalking, and trust me, I got stalkers. If we could narrow it to that, and not have people who literally have never been in trouble before, this is their true first-time offense, and what I don't want to do is paint those people with a broad brush.
I agree.
Of the people who you know are gaming the system, because
We've all made mistakes.
There are those. And even with like the unsatisfactory termination.
Oh, that's horrible.
So here's what I'd like for you to know on that. Judges can't, even in a trial, unless a defendant in the state agree to have a jury trial. I mean, if they agree to have a jury trial, then a judge can make rulings on stuff during trial, but the judge doesn't get to say what the sentence is, right? The only time the judge gets to decide whether there's probation or something at trial is if they elect to have the judge do the punishment. But prior to that, like where there's a plea, it's only if the state and the defense agree to it, right? So if there's an unsatisfactory termination, what you'll generally see in front of the judge is, you know, maybe the defense lawyer saying, "Judge, can you just terminate them? They got one more month," or whatever, right? And then you'll have the prosecution saying, "Judge, but they haven't done this, they haven't done that." The prosecution is either saying, revoke them, which means stop the termination and sentence them to jail or prison, or extend them, generally like 1 or 2 years, because you may have the defense lawyer saying, "Well, Judge, they've changed," because that happened, where they say, "I've changed, I found Jesus," sometimes, if the state and the defense agree, they'll unsatisfactorily terminate their probation. So all I wanted to let you know is if there's an unsatisfactory termination, that it wasn't a decision that a judge made.
I mean, it's a part of the punishment.
right.
But the thing is, you know, typically when you revoke a probation and you have it on there, if you follow your terms, you keep up with your probation, or if you don't and you get your probation is revoked, you go to jail for the remainder, just like parole. You go back to jail, right? That's not happening. So they're not learning that there's any kind of punishment for their crimes. They can just be on papers and not follow their conditions, and then we're backlogged in Harris County, so it's just churn them and burn them out the door. And they're not feeling anything.
So I'll use my mother as an example, even though I'm the sister of the person. So my brother was murdered. He was shot 5 times, twice in the head. He was 19 years old.
Sorry to hear that.
We all have our crosses to bear. I've had therapy for that as well. The person that murdered my brother, or the person that they say murdered my brother, the streets said it wasn't the person. They went and found somebody who had never been in trouble before to take the case. I don't understand taking cases, but there clearly are people who do take cases. And I can tell you that my mother, to go to the victim part, has not been the same since May 31st, 1996, when my brother was murdered. And the fact that the person that was convicted for murder of my brother got 10 years probation was incredibly difficult on my mother. It was difficult on me too, except for I thought if you live in a life where you killing somebody, you're gonna violate within 10 years and you're gonna end up in prison anyway. Is what I needed to do to be able to deal with that situation, because why was my brother's life worth only 10 years probation? So I know that a lot of times those of us who are victims of crime, people don't hear our voices. And I want to thank you for sharing the victimization, but it is clear that you have turned it into a triumph. It is clear that you are using your voice to help people who are voiceless, because not all victims come and testify at the state capitol and try to fix the system that sometimes continues to victimize them. So I just want to thank you for that.
Thank you.
Thank you. Members, anything else? We certainly appreciate you being here, and I'm sure you'll be testifying on some other
I'll be back.
legislation as well.
Yes.
So thank you all
One more.
very much.
Thank you.
Okay. Next, the chair calls April Aguirre. I'm going to have, do you remember Mark Aguirre, who used to play for the Mavericks? They called him Aguirre, so it's hard for me to get out of that. But that was a little bit. Okay. Go ahead, if you will, identify yourself.
My name is April Aguirre. I initially was for this, and I am withdrawing that, and now I am against it. I want to first say that there is not enough out there to help people that are first-time offenders. And to have them mixed up with the batch of folks that are habituals is a mistake, because people in that realm most likely will rehabilitate and should be giving a second chance. But when you mix them with a group of people who are habitual offenders and are continuously in and out of the criminal justice system, it's wrong, and it puts people in danger. I have here a list for the last 30 days in Harris County of PR bonds, and I'm going to give you, if you guys are familiar with Harris County, it's the largest county in Texas, and that's why it's talked about so much, and it holds a lot of the population within our state. And it goes, this is the problem with PR bonds. It's not necessarily for nonviolent offenses. We have a big problem with shooting deaths in Harris County, and to my anger, a felon in possession of a weapon is granted a PR bond every single day in Harris County. That's just normal. So here you are having an individual who is clearly has a criminal record and should not have a weapon. And if we care about gun violence, then why is it that we're taking so lightly laws that are already in place and we're not implementing them? And it's a slap on the wrist. On top of that, you have violence against families, you have assaults, and so this bill, unfortunately, loops in everybody, and it puts in language into the penal code that says shall. So magistrates would go based on this and use it as a blanket approach versus saying, you know what, we're going to strategically use this only for first-time offenders. And I would agree with that, and I honestly thought this is what this was about, and it wasn't that way. And unfortunately, they've tried this in Harris County, and it's failing miserably. Criminals are taking advantage of this. Another thing that we've had a lot of deaths is people that are fleeing from law enforcement in their vehicles, right, evading arrest. Those things are also getting PR bonds in Harris County, but we are in an uproar when there is a death when police are chasing suspects. However, if a suspect knows that he can run from the police and knows he might get away, and even if he doesn't, he gets a PR bond. So there's just so much risks with public safety. A lot of the deaths that have happened in Harris County are from police chases that have been suspended. However, just because the police is not behind them anymore doesn't mean that they don't continue to drive dangerously. I want to say that this is just not right. Victims are immediately put into a position of loss property crimes are the highest crimes in Harris County, right? And these crimes usually get a PR bond as well. The issue with that is that crime victims in that moment are also low income and minorities for the most part. They're losing that vehicle means that they may lose their ability to be able to make money, to be able to provide for their family as well. So there's not enough focus on crime victims also in this bill. So that is where I lie with that. My father's car was stolen when I was a young girl many years ago. We walked for a year. My father walked to work, rode the metro, we walked to school. Luckily, it was close enough. So for the people to say these are nonviolent, victimless crimes, it's just wrong. And people need to face consequences just like victims do immediately after a crime is committed against them. Thank you.
Thank you for being here. And so let me ask you this. Do we have your permission to change your
Yes, please.
your witness affirmation to against the bill instead of for
Yes.
the bill? Okay, thank you very much. Any questions, members? Mr. Wu?
No, thank you. And Ms. Aguirre, thank you for being here. I know we've worked in the past a lot in Houston on multiple cases. I always appreciate your advocacy, and thank you for always standing up for everybody. And I just want to make sure I clarify a couple of things. I understand what you're talking about in terms of the felony cases, but this bill doesn't deal with that, like, at all. And in fact, I absolutely 100% agree with you that there's not enough attention being paid to victims. But the problem is, in this bill, this bill wouldn't be able to do that.
Didn't they say state felonies?
I'm sorry?
Didn't they say state felonies?
State jail
included?
felonies, which are like
2 year
trace
180.
case, and look, I mean, we can discuss. I mean, I think everything within the bill is negotiable. Like, if that's too much, if we want to carve out domestic violence, I don't really disagree with that, right? But I want to be clear that this bill would not affect anything that's happening in felony court, because what those judges do is what those judges do. Now, I get the felon possession thing. I actually was a part of one of those cases, and it was a person, the client was a person who had a felon conviction from 30 years ago, and the gun that they were busted with was his grandpa's antique musket. And it's still a firearm, he's still a felon, but they kind of said, like, we told the judge, like he was given the gun as a part of the inheritance. He didn't even know it worked, or that muskets counted, and they got a PR bond for him. All right? Whether that's right or wrong, I mean, I'm not gonna say. But look, I think there may be some. I very, very much understand a lot of the anger that's out there. And that there's some very, very frustrating type of decisions that are being made. And I think a lot of those people are now gone as well, right? And I want to make sure, two things. I want to make sure we, one, have a continued conversation about resources for victims. And I would implore you, and I think, like, whether you're for this bill, against this bill, I think we are all for providing more resources for victims. And I think we as a state and we as a body should be demanding that, right? That, again, I'm saying, like, we should be helping counties, support services that say, like, we want to make sure that every victim of a crime, when they come to court, there is somebody, if they want somebody to walk with them, there is somebody to walk with them. That if they say, a victim says, I need help filling out my crime victim compensation form, which our offices have to help do that, pick up that job a lot, right? That there should be somebody in a county office that says, come on in, we'll talk you through it. We'll figure out what the right thing to say is. We'll figure out what to sign, and if there's a problem, we'll call the state and say, we'll fix this, right? Absolutely, 100%. We should be funding those things, and I would beg you, let's have that conversation. Let's have the conversation, like, let's pay for this stuff.
So right now on this bill, we have domestic violence. We have evading evading arrest in a motor vehicle.
This is, that's a third-degree felony.
Felon in possession of a weapon.
That's a third-degree felony.
And so in Harris County, we're receiving these things already using for PR bonds.
But what I'm saying is that's a totally different system disconnected from this bill. And what this bill is, I mean, we're talking about if you want to get rid of first-time domestic violence for like a slap or a push or whatever it is, you want to get rid of that. I understand your point because, yeah, that's domestic violence is especially dangerous. We want to carve that out. Happy we can talk about that if we want to. But the rest of it, shoplifting, driving with a suspended license, first-time DWI with restrictions, right? I don't know, criminal trespass because you got yelled, you refused to leave the bar. If it's just like those things,
Yeah, it is.
you're okay. You would support this bill.
Yeah, I would, especially if it's their first time.
Right. If we say like this is a true
But
first-time offender
versus
bill.
like PR bond, PR bond, PR bond, PR bond, PR bond,
Yeah.
at what point would the bill limit it, you know?
And so what I'm saying, offering is actually if you don't like what's happening in Harris County right now, if you pass this bill and you put into this bill that says, hey, by the way, your second and third and fourth, you cannot use this and the judge must do X. You would do this.
That sounds good. But right now, it's just a blanketed approach, and it doesn't specify first-time offenders. It kind of gives it to everybody. So first, second, third. So if
But
it was a
I-
first-time approach, I honestly feel like we do need to keep beds open for real violent offenders.
Absolutely, and I appreciate your candor in this, and I just want to make sure like we're so close, like if this is the only hangup, if like saying like making sure that it says point blank, this is for first-time offenders only, right? If you are a second-time offender, the judge must set a bond of some kind, right?
That
Must,
would
and the judge must
eliminate-
review it, and must bring you in.
That would deal with the habitual offenders.
Okay.
Mr. Louderback has a question.
Thank you, Ms. Aguirre. How is soft on crime going to help us?
It
How is that?
doesn't.
What happens
so.
to first-time offenders right now in the system?
They
Right now,
graduate to
I'll tell you.
felons.
I'll tell you what happens with first-time offenders. First time with no criminal history whatsoever, misdemeanor cases, they're handled lightly. They're handled lightly by our judges here in the state. But tell me, how is soft on crime going to help us at all in our state?
You know what? It really doesn't, because we've seen this in Harris County play out. If you look at the dashboards, they're actually really great in Harris County. It actually shows you how many people reoffend. Now,
Thank you.
we are common people. You know, we don't always get it 100% right, but I can tell you that reading just the records for people that were given a PR bond on felonies that are different from state felonies, it's a lot of people and it's a lot of charges. So the PR approach has been used, and unfortunately criminals, habitual criminals, use this to take advantage of the system, a system that's attempting to give them a second chance.
Well said, thank you.
Is that all, members? Okay, thank you
Thank
again
you.
for being here. Next, the chair calls. Ms. Chopper, are you still? There you are, you're right. Can you come up for 1 second? I need to ask you one thing, and if you would, identify yourself again. And
These chairs really stick to the carpet, huh? They don't slide. I'm Michelle Chapa. I am representing myself as a victim of crime from Houston.
And I know this sounds picky, but we're trying to protect the record, which we have to do because the bill can be killed on the
For sure.
floor on a point of order. But you had indicated that you were changing your testimony
To
from
oppose.
for to against. And as a result of that, I have to ask you the same question I asked a moment ago. Does the clerk have your permission to note that change of position on your witness affirmation?
yes.
Okay, I just had to do that, and I apologize for
Fair enough, that's
making you
okay.
come back up. Thank you very
Thank
much.
you.
At this time, the chair calls Nick Hudson.
Thank you, Chair and members. Y'all have covered a lot of ground. My name is Nick Hudson. I'm with the ACLU of Texas. We're here in support of the bill. Nearly 40 years ago, the Supreme Court held that in our society, liberty is the norm, and detention before trial or without trial is supposed to be a carefully limited exception. And we see this bill as an incremental step towards getting us closer to that standard. Our pretrial system's key obligations are to minimize unnecessary pretrial detention while maximizing public safety and court appearance through a rational and fair pretrial release and detention process. Money is an irrational and random way to make decisions about release. This bill would move Texas closer to a system where we're dependent upon legitimate assessments of flight and safety. And that's what we should all be striving for when we're trying to retool our bail system. Texas County jails detain more than 53,000 people on any given day who are presumed innocent. It costs about $1.2 billion a year, $62.41 a day, according to the Office of Court Administration. And I just want to be clear that money bail is the norm in Texas. It is set in 83% of cases, according to the Office of Court Administration. And actually, the Vera Institute of Justice did a report. It's set in 77% of drug possession cases, excluding marijuana. And marijuana cases, it's 74% of the time. The bond amounts are normally north of $1,000 in these types of cases. And so if you don't have access to money, this creates an absolute barrier to your release from jail, whereas a similarly situated person who has money is able to buy their release. And so as we're trying to think through how to retool our bail system, our goal is to help this committee and be a resource to try to minimize unnecessary pretrial detention, maximize public safety and court appearance through a rational and legal pretrial system.
Any questions, members? Mr. Little.
Why is the ACLU not more concerned with Ms. Chapa's civil liberties and her rights to life, liberty, property, and the pursuit of happiness?
Thank you for the question. What I felt, and I've talked to Mr. Khan about this before, folks from Crime Stoppers, I actually think that it is often the case that the ACLU and crime victims organizations, once you have a full conversation about what bail reform looks like, they're on the same page, because everyone kind of recognizes that you don't want decisions about release being made based upon money. And so what I would say is we're very concerned about safety and would love to have a conversation about how to make sure that all of the pretrial release and detention decisions are being made in a rational and legal way that can pass constitutional muster.
Just to be clear, for the record, are you going to be testifying on bills later today as well?
Yes, sir.
Okay. To be clear for this committee's record, the ACLU is principally concerned with safety, right?
We are concerned about safety, yes, sir.
Is that your principal concern, the safety of the people of Texas?
We are concerned about balancing safety and liberty. When Texas was founded, in our founding documents and the Declaration of Independence, it actually criticized the Mexican government for holding their citizens, incarcerating its citizens. What we are trying to do is make sure that we embed in these bills a presumption of liberty, because that's what we think the Constitution requires. And we also want to try to get to a system where release and detention are made in rational and legal ways so that we can get to the outcomes we all care about.
But that presumption of liberty terminates at the point when someone is engaged actively in violence against the people of Texas, right?
Well,
You'd agree with that?
I would agree that everyone is engaged, is entitled to a presumption of innocence before there's a conviction, as I know you agree with.
Thank you.
Thank you.
Thank you, Mr. Little. Any other questions? Okay, thank you for being here. Our next witness is Sylvia Escobedo. Go ahead.
Excuse me, AJ.
Good afternoon. My name is Sylvia Escobedo. I am here in 4 different capacities today.
Before you go any further, let me get you to, you're here on behalf of yourself.
I'm here on behalf of myself.
And what is your position on the bill?
Against.
Okay, go ahead. I'm sorry to interrupt you.
No problem. I've been a criminal attorney for 30 years. When I graduated the University of Texas School of Law, I went to work at the District Attorney's Office of Harris County, Texas, in Houston, where I prosecuted crimes, the worst of the worst, for 14 years. I was a felony court prosecutor, chief prosecutor, tried hundreds of cases. I became a criminal defense attorney in 2009 and opened up my own shingle, so to speak. And I have been a criminal defense attorney ever since. I am also a citizen of Harris County in Houston, also a single mom. I also have to live there and I want to be safe. I'm also today here to say that 10 days ago I was a victim of jugging. I came down today really to watch these proceedings and become better informed, and I started reading up on some proposed legislation that's not going to be addressed here today. But while I was watching the discussions on proposed House Bill 799, there are so many things that I have to say about this that I ran to the hallway and put my name in the queue. So thank you for hearing me. And I'm sorry this is all out of order because I've been making my notes. Burglary of a motor vehicle is currently a misdemeanor offense in the state of Texas. In 1994, they changed it from a third-degree felony to a misdemeanor offense. In the first 2 months of this year alone, the Houston Police Department has opened investigations for over 2,000 burglary of motor vehicle cases. Everyone considers BMV, as we call it BMV, to be a victimless crime. They say BMV is a property crime. You should have insurance, have it covered, that. Like I said, I've been a victim of BMV at least 3 or 4 times. On March the 8th, 10 days ago, for the first time in my life, I went to go meet my elderly mother at her request. She just moved into independent living. My sister came into town, and for the first time in her life, she says, Sylvia, girls, I want to go shopping with y'all. I want to get some new shoes, and I want to buy my first luxury handbag. We go to the Galleria. If you're familiar with the Houston Galleria, Jolanda Jones probably is. There is open parking outside of Neiman Marcus. There's open parking outside of Neiman Marcus where you actually have to pay. So I always choose to park in paid parking because it's super well lit and super well trafficked. So I went to meet my mother and my sister, and it was the first time ever we did some shopping, okay? I told them to leave a few minutes ahead of me. Thank God I did. Thank God I did. Because we were meeting other family members down the street for dinner in Uptown Park, which is about 1.5 miles down from the Galleria shopping mall. When I left the Galleria, it was about 6:30 at night. And so it was getting dark, but I always park under the lights, and that place is super well lit, and people are coming and going, because that's the main entrance to that shopping mall. So when I leave, I am literally looking left to right, left to right, left to right to make sure nobody is watching me, to make sure that nobody is following me. Because I do what I do, and I know what I know, I'm hyper vigilant. I never get gas at nighttime. I don't own an ATM card. I never physically go to a bank. Some people only, they call bank juggings bank juggings.
If you could kind of move forward, because we've got a lot of more witnesses, so.
Well, the purpose is, a burglary of a motor vehicle would fall under this proposal. I am adamantly against this proposal, okay? BMV, burglary of a motor vehicle, you have a victim, okay? I did not sleep for 8 days after this, and I have personal reasons why, which I will happy to not waste your time with, but discuss with you at a later time. I did not sleep for 8 days. I did all of my own investigation before it was ever assigned an investigator. I tracked down the surveillance videos. I created a file and sent it all to law enforcement. Once they saw the evidence I had collected before it had even been assigned an investigator, they said, your case is being transferred to Auto Crimes Task Force because you were a victim of jugging. Because I got surveillance video that shows them following me, literally. They get out of their car. But it's a BMV on the books, that's it. That's a misdemeanor. How is this something where that offender is entitled to walk out of jail with no consequences? When I've spent a full week calling insurance adjusters, getting property repaired and whatnot. So I'm against it for that. We didn't talk about BMV being a misdemeanor, but it is. And it's a misdemeanor that is not just a property crime. There is a victim who can't work while they get their car fixed, while they call the insurance adjuster, while they call the claims adjuster and do all of the things they have to do. Not to mention, what if they work out of their car? What if they had something very personal stolen out of their car? There is a victim. The other things I want to address are that everyone here has only talked about, because the bill places state jail felonies. And everyone keeps saying, well, we're just talking about less than a gram. I can tell you in Harris County, if you're just charged with less than a gram and you're a first offender, you're going to get a PR bond anyway, okay? Let's talk about the crimes that are state jail felonies in the penal code that have not been yet mentioned. Where's my list? Unauthorized use of a motor vehicle. That means you have stolen someone's car or you are knowingly driving a stolen car. That is a state jail felony. I don't care if that person is a first offender or not. That person should be able to have more consequences than getting a PR bond and walking out of jail a few minutes after getting booked in. Criminally negligent homicide is classified as a state jail felony in the state of Texas. Criminally negligent homicide.
Okay, I think we get the point. Does anyone have any questions, members?
No, but.
Okay.
Well,
We're trying to keep all the witnesses to a time limit, so.
I understand that.
Okay.
The bill includes an automatic PR bond for state jail felonies. I want to quickly list the state jail felonies that have not been mentioned here, because we're not just talking about PCS less than a gram. We're talking about interference with child custody, state jail felony. Animal cruelty, state jail felony. Forgery of a check, state jail felony. Theft or fraud, $1,500 to $20,000 is a state jail felony. Improper visual recordings or photographing other people, like they do in the bathroom sometimes, that's a state jail felony. Endangering a child is a state jail felony. Driving while intoxicated with a child passenger is a state jail felony. Making a false report is a state jail felony. How are those people entitled to a PR bond even if they are simply a first offenders?
Okay.
I feel like we've left out half of the penal code when discussing this particular proposal, 799.
Okay, I think we get it. Any questions, members? Okay. Thank you very much for being. Oh, Ms. Jones.
I just want to say, hey, Sylvia.
Hi,
We've
Joe.
known each other
Hi, Joe.
for a very long time.
Yes, very long.
I knew her when she was a prosecutor, and I know she's a defense lawyer. So
Yep. I didn't even get prosecutor, defense attorney,
I
all
was
of it.
surprised, all of it.
Single mom,
And your
all of it.
kids and your ex-husband. But anyway, that's another story for another day.
Don't hold that against me. He's X for a reason.
Anyway, thanks for coming up here. I appreciate it.
Thank you for your time.
We thank you.
If y'all have any questions, let me know.
Okay, and if you want to communicate with any of the committee members, feel free to do that.
I will. I just
Thank
wanted
you.
to highlight some things that hadn't yet been mentioned, just
Okay.
not trying to be repetitive. Thank you.
Thank you. Next witness is Leslie Matthews.
Good afternoon, committee members. My name is Leslie Matthews. I started my professional career in law enforcement at the Fort Worth Police Department in the Special Victims Unit, the real one, not the TV show. And the reason that I started there, my best
Let me
friend.
stop you and say you're here on behalf of yourself, and you're for the bill?
Yes, I'm
Okay,
in support
all right.
of the bill. I'm an attorney. I have my master's degree in social work. And the reason that I'm in favor of this bill is my best friend was murdered by her husband. And that happened 20 years ago, July 31st of 2005. She was stabbed to death over 40 times while she was fleeing for her life. And if you would have asked me if I would have supported this bill 20 years ago, my answer would have been a resounding no. But I've had an opportunity to work in law enforcement for quite some time. I've also, after I left the police department, I obtained my master's degree, worked with children in education, and it was my students in education who inspired me to go to law school. And so I got accepted a lot of different places. I went to law school in Hawaii. I served as a deputy prosecuting attorney, a legislative attorney, and I want to center these comments on crime victims. Crime victims absolutely need the services, and I think that when we have too many people that are being detained and when the state is paying for their housing in custody, that's funds that could be reappropriated to survivors of violence. As a deputy prosecuting attorney for the state of Hawaii, I wanted to be able to have the conditions that are being talked about. I firmly believe, and my best friend was murdered here in Lubbock, Texas, when we were sophomores in college. I firmly believe that if her murderer would have been given the services that he needed, that perhaps my best friend would be here and she would be raising her daughter. And we would be reminiscing together than just honoring her memory. So I believe that conditions should be uniquely tailored to the people that are there. I believe in the presumption of innocence. And sometimes when people are having to fight for their freedom and also fight their cases, it's incredibly problematic. I prosecuted misdemeanors and felonies of abuse, a family household member of domestic violence. I want for people to have the services that they need and have those monitored by pretrial, those that are particularly and uniquely tailored to monitor those things, those in pretrial services. I want those monies that we're spending to be reallocated to survivors of violence so that they have the services that they need, that our crime victims compensation is adequately funded, so that we center the voices of survivors of violence so that we can interrupt the cycle of violence and heal the harm that crime causes. I appreciate, and in closing, I appreciate the testimony of the brave survivors that have come up here and said, where is our voices in this? And so I think that it should truly be for first-time offenders of nonviolent offenses so that we can have those persons monitored, so that they are encouraged to get the mental health services that they need, that they are encouraged to stay with their jobs, that they are encouraged to check in. And I don't think that that's something only implementing cash bail or bonds companies, and that was just demonstrated in some of what we heard today, that they're not aware of the pretrial services that are there. And I think that we need to reinvest those funds into pretrial services, diversion, so that we can interrupt the cycle of violence, and that my hope would be that we don't have this happen anymore. And I'm happy to answer any questions, but I think that the bill probably could benefit from some revisions, but I'm very thankful that the conversation is being had, because I want to see the voices centered on survivors, and that people can have an adequate opportunity to fight their cases from a place where they're being monitored.
Thank you.
Yes.
Okay, any questions for Ms. Matthews? Once again, we appreciate very much you being here.
Thank you.
Okay. Is there anyone else here to testify for, against, or on House Bill 799? Yes. Okay, have you filled out a witness affirmation? Yes. Okay. We can't find an affirmation for you. You can come up and testify, but I'm going to need you to fill one out as soon as you testify.
She needs to do it before.
Okay, you're going to have to do it beforehand then. So if you will, head over to her and.
What's your name? Okay. It wasn't her. We skipped Darby Good, but I don't see a Joy Davis. If we could get her to go outside to a kiosk.
Oh, could you, yeah, go outside to a kiosk possibly. So there's really not much we can do. Before she comes back, let me just ask, is there anyone else who wishes to testify on House Bill 799? We're sorry for the delay, so the committee will just kind of stand at ease for a moment here. Generally takes about 90 seconds or so.
So if you will, I will go. Yep, just let me use.
You'll come back to order, and at this time, the chair calls Joy Davis. Thank you, Ms. Davis, for registering.
Thank you. All right, let me know when you're ready. My name is Joy Davis. I am representing Pure Justice Action Fund and myself today. There are 9,212 people held pretrial in Harris County.
Well, first of all, I'm going to have to get you to identify who you're here on behalf of, and it says on your affirmation, the Pure Justice Action Fund
Yes.
and yourself.
Yes,
Is that right? And also your position on the bill.
I'm in favor of the
Okay,
bill.
all right, now go ahead, I'm sorry.
Okay, so there are 9,212 people who are incarcerated in the Harris County Jail today. 6,228 of those people are pretrial. 23% have an average pretrial risk. 21% have lower than average pretrial risk. Our jails have been overcrowded. Our people who are incarcerated have been moved to other jurisdictions, other states.
I believe in second and third chances. I'm also a survivor of multiple things. Some I really don't want to discuss right now. But I also believe people can be rehabilitated. I don't think continuous incarceration is going to change the problem that we have in society. Diversion programs are needed, community programs are needed. Even before people have to face the judicial system, there should be access to services and funding for those services. Incarceration doesn't always deter the crime. I know someone who has a family member, and the family member is jealous of him and the relationship that he has with his mom. And because of that, he filled out a false police report to get this person incarcerated. The average jail time stay in Harris County is 191 days based on today. So just that false allegation alone could take someone from their family, their homes, their jobs, they could lose their vehicles, everything. There was a case where somebody had wanted custody of their child. Neither one of them had custody, so the parent accused the other parent of a crime. The other parent was incarcerated, lost custody. And these are the kind of things that we're seeing. So I absolutely believe this bill is necessary. Surveillance footage, just trying to get surveillance footage for crimes takes months in Harris County. And then another thing that leads to the incarceration is the number of times that cases are reset. So I support Joe Moody's bill, and thank you so much.
Thank you, Ms. Davis. Any questions? Ms. Jones?
Yes, ma'am.
I just want to thank you for coming down here, but I can also say something. A lot of times, and again, I'm speaking directly to Harris County, prosecutors will like request a reset because they're just not ready. They're switching, and let me be clear, this affects the victim and the accused because the victim they want finality, they want it to happen fast, and I've pushed for us to go forward on things like a hearing or something, because my client is like, Ms. Jones, I didn't do it or whatever, or maybe they did, but I want a hearing. And so the resets, it's just sort of all over the place,
Right.
whether it's from the state or not. And again,
it could take years.
Like I say, Harris County tends to be better in getting evidence faster, but it's been my experience in really small towns that it takes a really long time to get the evidence. And I've had clients flat out lie to my face, swear on their mama that they didn't do something. And then when I finally do get the body cam or whatever, the body cam shows they did exactly what they were accused of doing, right? So actually, if we could figure out a way, and maybe I'll think about it, how to get these things faster, that would cause the slow wheels of justice to churn faster. But again, there are a lot of things that will cause, like truly first offenders, to have to sit in jail for a really long time and lose their life for the most part. And I can tell you the best deterrent to crime is a job. Mm-hmm. And if you lose your job because you're locked up, sometimes you're creating people in situations. And I'll end with this. I had an uncle who had been locked up, and he did his time in TDC, and he got out, and he learned his lesson, and he just was not going to ever do anything again because he did not want to get locked up anymore. And he literally went looking for jobs every day. He would catch the bus. He got a bus pass. He would catch the bus. And like the fact that he had gone to prison really did prevent him from being able to get a job. And so in a situation like that, I was actually very impressed with my uncle because he was way more patient than me. And if I go to try to get a job every day and I'm literally living a law-abiding, productive life because I do not want to go back to prison, some people will become criminals because they can't get a job, all because something like that happened. So I would just ask everyone to sort of think about not just the worst case scenario, but also there are really innocent people who are proven guilty.
That's right.
There are innocent people who are proven guilty, and that is a core belief of why this country was founded.
That's right.
And to take all situations into consideration does not make you soft on crime, right? I don't believe that makes you soft on crime.
Right.
I think that justice can sometimes be tricky. There are people that do make mistakes and actually commit crimes, right? And the question is to try to figure out what we do with them. Do we try to figure out like why they're doing stuff? Because some people will learn and the experience will be so uncomfortable that they will never get in trouble again. And I have some people that are hard-headed. You give them an inch and they'll take a mile. So I think that justice can't be looked at from one extreme to the other. I think justice needs to look at everything and try to make sure that whatever laws we pass are, try to minimize the unintended consequences. And so I actually want to thank everybody that came, because as I was telling Sylvia, and I'm gonna call her by her first name because I've known her for as long as I've been practicing law, we've gone against each other, we've helped each other. I thanked her for coming here because we did sort of left out some things, and I too believe having my car broken into, it ain't victimless. I had to pay a whole bunch of money. I didn't file my insurance because I didn't want to have a ding against me and have my insurance, premium go up. And so I'm almost certain that Representative Chair Moody is probably willing to carve out some stuff for this bill to truly address first-time offenders, some of which will have actually did what they were accused of some of whom will be innocent, right? So anyway, but I want to thank you for coming and sharing.
Thank you so much.
Okay, members, any other questions? If not, we appreciate you being here. I've already asked this question, but if anyone is here that wishes to testify on this bill, if you'll let us know now. Otherwise, the chair would recognize Representative Moody to close. Okay. Oh, Ms. Bowers, you got a question? Yes, Is it for Mr. Moody or?
It is for
Okay.
Mr. Moody.
I didn't even say anything yet.
I didn't want you to close before I said this and shared this. And, I appreciate the discussion that has been had here. I do have worked alongside Vice Chair or Chair Moody. He's probably still my chairman from, with all due respect, Chairman Smithy, he's probably still my chairman from last session. On criminal jurisprudence. I really do appreciate the discussion. I do believe that that Representative Moody will be okay with making those proper clarifications. But I think there was a little bit of confusion on what this bill is actually about. I don't think that anyone in here is not standing up for the victims. I think that's probably where we started to go wrong, and I don't think this type of bill reform would make us at all soft on crime here in Texas. I just wanted to add, and I'm thankful, Chair Smithy, for a moment, that about 53,000 folks are in jail awaiting trial. Half of them will be found not guilty. Essentially, people are being criminalized for being poor. This bill offers the necessary balance, and I thank you, Representative Moody, for bringing it. And there are quite a few other ways that this bill will do some great things. When you look at the pros, it will reduce the jail population, it will increase fairness, and it will improve transparency and cut local jail costs. So I thank you. I'm looking forward to signing on as a co-author, a joint author if you'll have me, but I'll certainly sign on as a co-author. So thank you for bringing this legislation.
That's very kind of you. Thank you. I want to review just a couple of things and ask you all to kind of conversation migrated into certain conduct that isn't eligible for personal bonds. I just wanted to make sure that we're all talking about the same thing. And so I know that, we'll have the opportunity to go dig back into the code. But when a bail decision is made, right, if you go to 17028 of the Code of Criminal Procedure, there's three things. Three things can happen with you. Granted personal bond with or without conditions. You can get surety or cash with or without conditions. Or we can deny your bail pursuant to the Texas Constitution. I know we're going to talk more about that later. That's it. Those are three options for you. There are a series of things that we've done in 1703 that houses the personal bond section. There are a series of things that we have said are not eligible for personal bonds. They're out. They're out. Right? So we're talking about, and then who makes the decision on personal bond? We've also defined that here, right? We're in 1703 B2. If that person is charged with an offense involving violence, now we've defined that. Murder, capital murder, kidnapping, aggravated kidnapping, trafficking of persons, continuous trafficking of persons, continuous sexual abuse of a young child or disabled individual, indecency with a child, assault, if it's a second degree or higher, or if it's a family violence assault that can be charged as a felony. So that'll be your strangulation or an enhanced family violence. Continuous sexual assault, aggravated sexual assault, injury to a child, elderly individual, disabled individual, repeated violation of certain court orders or conditions of bond in family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, trafficking, continuous violence against the family, aggravated robbery, taking or attempting to take a weapon from a peace officer, federal special investigator, employee or official or correctional facility, parole officer, community supervision or corrections department officer, or commissioned security officer, aggravated promotion of prostitution, compelling prostitution, sexual performance by a child. Right? Those are crimes of violence. Cannot have personal bond. Right? All of those categories of offenses. Or if you're on bail or community supervision for any one of those crimes of violence that I just listed, and then you are additionally charged with any felony, not eligible for a personal bond. Or these other offenses that are categorized as misdemeanors: assault, deadly conduct, terroristic threat, disorderly conduct involving a firearm. So if you're on bail for any of those and you commit any other felony or these misdemeanors that I just listed, you're not eligible for a personal bond. You are out. So when we talk about repeat and repeat and repeat and repeat and repeat, right? This is, I understand what those folks are talking about. I know we're going to get into it later because it has to do with complying with this, right? So I understand what their concerns are, but I want to be very clear about what this bill does and what it doesn't do, because something I have done since I got here, coming out of the district attorney's office, is I have worked to progressively amend victims' rights in this state. In fact, some of the biggest bills I've carried have been advancing victims' rights and giving them more status and authority in the criminal justice system, because they deserve that seat at the table. So I want to make sure my position on this is very clear. So these are things that are out. You don't get this decision. What this bill does say is, for things that are misdemeanors that don't come under this, that don't have all these issues going on, or state jail felonies, that the judge starts with personal bond. And when we go back to the decision we talked about, 1, 2, or 3, the judge starts with number 1. And then if that judge has information that says something else about someone's ability to show up for court, their the sensitivity to maybe reoffending, or any number of things, threats to law enforcement, all of those things can then be considered, and then they can move to number 2, right? And then number 3 is very narrow. That is preventive detention, denial of bail until face trial. So those are very, very narrow cases. We're going to talk about that later. But so you're essentially deciding between 1 and 2. The bill says, I'd like you to start with 1 unless you say there is some danger here. There is some problem here. then we can move in another direction. That's it. And all the rest of these types of situations, they shouldn't be in the conversation for a personal bond anyway. And if they are, then someone's not doing their job correctly. So that's what I wanted to clear up. And I apologize for going through the law school dissertation, but you know, I'm always happy to look at whatever we want to look at. You know, we have this huge litany of things that we said aren't eligible for personal bonds. There's ways to weave other exceptions in here. If we want to talk about it, we can get creative with it. But ultimately, I think there is value in setting a philosophical space that what we're talking about here is not punishment. Bail is not punishment. These are people that are not convicted of things. If they're convicted of stuff, they're going to have all sorts of other denial issues because the code is replete with ways to keep them from getting this type of relief. So that's my concern. That's a concern we're trying to address here. This topic, this language was part of a broader conversation last session on bail, and so that's why we brought it back as a standalone to continue to have that conversation, because I know we're gonna have a bigger, broader bail conversation as well. So I appreciate the time, and I'm gonna escape now. No, I'm happy to take any questions.
Member, any questions for Mr. Moody? Yes, sir. Wes?
So is the intent of this bill is basically to help those who could be innocent that are unfortunately stuck in jail for a long time? Is that what we're looking at here?
Well, I mean, their guilt or innocence, it really kind of it kind of sits on the side of this. These are accusations, and unless we find otherwise, unless the court finds otherwise, then the default setting would be to be given a personal bond with conditions, and that's where I'd like to track people to. It is, in my opinion, when it comes down to it, it's not really about, you know, these decisions come down to whether you got money or not. And if we have a system that is preventing people from, because like take the burglary motor vehicle case you just heard about, tragic situation. Does it make anybody more safe if that person could cough up $500 on a surety bond? Do our victims feel safer because they cough up $500 on a surety bond? Because that's the only other thing that's going to happen. It's personal bond or the other.
Copy that. Appreciate it.
Yeah.
Thank you.
Any other questions for Mr. Moody? All right, unless there's any objection, we'll leave. What's the House bill?
I'm happy to have you all voted out like you did with Kerry's bill.
I'm not going to make that motion on this.
No, not right now. Thank you.
799.
No, thank you all very much.
Otherwise, we'll leave House Bill 799 pending. Thank you, Mr. Moody. Next, we'll call House Bill 36, Ms. Bowers.
I'm actually scared to sit in this seat now that Joe has just been here. I was tempted to sit over there, but I feel good about this piece of legislation. Before I start, we do have, HB 36 does include a committee substitute that will strengthen its impact by replacing Section 5.
Let's let Mr. Cook lay out committee substitute to the bill.
Absolutely.
Okay?
Thank you. She's bringing it over.
Okay. The members will have a copy momentarily. Go ahead, the members
Sure.
will have a copy.
So once, Mr. Chairman, once Mr. Cook has the committee sub to lay out, then do you want me to proceed?
Yes.
Okay.
I don't think you need to do anything. Well, Mr. Cook lays out the committee substitute, so, okay?
Thank you so much. So the committee sub will strengthen the impact by replacing Section 5, subsection B1, 2, by changing it to the use of firearms outside of professional, sporting, recreational, or hunting context with criminal conviction involving the unlawful use of a firearm. And this ensures that the law applies with precision and directly addresses dangerous offenders. So thank you, Chairman Smithy, Vice Chair Wu, and the members of our esteemed committee here in criminal jurisprudence for this opportunity to lay out House Bill 36 today. This bill is named after my dear friend, Sharon Radabaugh, who lost her life due to a domestic dispute in 2023. And members, it happened just after we all arrived home after session was over. I received a text with this news. Sharon was not just a name on a piece of paper. She was a mother, a community activist, and a true friend. She stood for justice, and today we honor her legacy by fighting for the safety and security of every Texan impacted by domestic violence. And I happen to be a member of that population. I too am a survivor of domestic violence. Domestic violence is not just a personal tragedy, it is a public safety crisis. In Texas, 1 in 4 women and 1 in 7 men will experience domestic violence in their lifetime. These are not statistics. These are our sisters, our mothers, and our daughters. These are our neighbors. House Bill 36 does what common sense and basic decency demand. It strengthens monitoring of high-risk offenders and gives victims the tools they need to protect themselves. Courts must require the use of global positioning monitoring systems for offenders who pose an ongoing threat to their victims. This isn't about punishment, it's about preventing the next attack before it happens. Governor Abbott has said Texas is a law and order state, and we will not tolerate violence in our communities. HB 36 delivers on that promise by making sure abusers are held accountable. We will not let dangerous individuals slip through the cracks. HB 36 ensures that victims can receive immediate alerts if their abuser comes too close, providing real-time protection for those at risk. This bill ensures that law enforcement and the Department of Public Safety have access to updated real-time data and protective orders and bond conditions, closing dangerous gaps in communication that could cost lives. As I mentioned, I am a survivor of domestic violence, and this morning before I headed to the Capitol, I thought about my own experiences, thought about the fact that I am here today. I am a survivor. I got out of that relationship and got a divorce. But that's not the case for everybody. There are too many people that are not here to tell their story. And Sharon's story affected me personally and my community when this happened at the end of last session. This bill was passed, a bill like it was passed last session in Tennessee. And it was said that, Retta, maybe you should carry this legislation here in Texas. And because of what happened to Sharon, I knew, in my own personal story, I knew that I had to bring this before our legislative body. Our laws should reflect our values. We value freedom, but no woman is truly free if she has to live in fear. And we value family, but no family can thrive when it is living under the shadow of abuse. And we value justice, but justice means nothing if it comes too late. This is not a red or blue piece of legislation. It is merely about doing what is right. To abusers, your time is up. Texas will not allow you to terrorize your victims in silence. The silence that victims largely live under. To victims, I want you to know you're not alone, that the law is on your side. And to my colleagues, it's time to stand up. So I hope you'll join me and support this legislation. It's time for us to act. It's time to pass the Sharon Radabaugh Domestic Violence Protection Act, and let's send a clear message across the state that you don't mess with Texas women. With that, if there are no questions, Chairman Smithy, I reserve the right to close, and I do have witnesses that are here to testify.
Thank you, Ms. Bowers. Let me see if there's, Mr. Little has a question.
Thank you, Mr. Chairman. Representative Bowers, thank you for your bill, and thank you for telling your story. I very much appreciate it. I have some questions, some of which have been resolved, I think, by the committee sub, which I now have a copy of, but I have mixed feelings about the presentation of section B-1. So if you have do you have the committee sub in front of you?
You know, I do, and I want to say, Representative Little, that is exactly why we went and changed the language. We did receive an email asking us to look at that, and so if the committee sub answers your questions, it does not.
It doesn't fully, so I've got a few more questions for you, if that's okay. So if you look at the provision in the Code of Criminal Procedure that this seeks to amend, so it says a magistrate may require as a condition of release on bond, et cetera, et cetera, et cetera. So there's already a structure in the Code of Criminal Procedure that gives a magistrate the authority to preclude someone who's engaged in family violence from spaces that the victim is in. So there's a mechanism to do that. As I understand your bill, it provides an electronic monitoring means for the magistrate. I have a couple problems with it. In B1, so if we're on page 3, bottom of page 3 of the committee says a magistrate shall require as a condition of release on bond that a defendant wear a GPS monitoring system. So I have a little bit of concern about the word shall, the requirement by the magistrate. But the larger concern that I have, Representative Bowers, is that the triggering events that are enumerated below that, it's parentheticals 1, 2, 3, and 4. It says a defendant is considered to pose a continuing threat to the victim if the defendant has a history of, and it says item parenthetical 1, conduct violating a provision of Title V Penal Code. This is a variety of assaultive offenses, and it's unclear to me whether it's designed to target conduct for which that aggressor has already been convicted or charged, and what constitutes that history under parenthetical 1.
So can you tell me exactly where you are?
I'm on page 4, lines 6 and 7 at your parenthetical 1. Okay. So this is designed to give the magistrate guidance about what constitutes a history for purposes of determining whether this person is a continuing threat to the victim. And so parenthetical 1 says a history of conduct violating a provision of Title V Penal Code. Are we talking about a conviction, someone who's been charged multiple times? And I think the answer is we want to know if this person has a history of violence. And the question I would pose to you for purposes of your bill is, what constitutes that? Is it a conviction or something broader than that? I want to suggest to you it probably is something broader than that. Parenthetical 2, a criminal conviction involving the unlawful use of a firearm. In my understanding, that can be a lot of things, some of which are violent, some of which are not. And so if there are particular penal code provisions that could be cited there, I think that would be helpful. So let me zoom out for a second and say my broader concern is that regardless of whether someone's been convicted of an assaultive offense or an act involving a firearm, a husband or spouse can absolutely still be a continuing danger to that spouse. Like if you had a spouse who's He had a husband who beat his wife to a pulp with a lead pipe. I don't really care what his history is. Do you understand what I'm saying? So I think the way that I would structure this, or the way I would structure it in my mind, is to make the GPS monitoring permissive based upon the facts and circumstances presented to the magistrate, regardless of the criminal history, because sometimes it can just be your first time or second time abusing someone, and you can be an ongoing danger to the point of death.
And I agree with you, and I think I hear what you're saying. I think the part of it that is of concern for me is that one time is just too many, right?
Right.
And so I think we're saying the same thing. I think when you were sharing, my question to you was, have you ever been a victim of abuse?
Even if I were, I don't think I would share that here. So I would just say that in that circumstance, the question of whether I've been a victim of abuse is irrelevant. I think what we're dealing with is trying to protect women who, or primarily women, who are a victim of abuse. And so I think that making it permissive and subject to the magistrate's determination of the facts and circumstances will actually help more people than fewer. Because if I want you to, I'm imagining in my mind as a lawyer a circumstance in which a woman is a victim of domestic violence and it's severe, and her husband has never been convicted of an assault before, has never done anything, has never violated protective order, has never done anything wrongful with a firearm. Magistrate goes, I can't monitor him. I can't use this system.
And let me say this to you, because I appreciate what you're saying, and I think we actually agree. I think you sit right behind me on the floor, so I'd love to continue this conversation. I do have people here to testify, but I want to share something with you, because I don't mind sharing in this very public setting that I am a survivor of domestic violence. The situation you just described was my situation. My husband was that abuser, my ex-husband, okay? And he was not turned in at all. I did. I will share those very scary and terrible incidences that I incurred, that I underwent. My ex-husband couldn't even deal with me being gone to the grocery store for very long. He was already putting his handgun in his pocket and asking me, what took you so long? Just because I went across to the grocery store. He cocked that gun behind my back, and I heard it click. When I finally got fed up was when he had my face in the kitchen floor, and I got up with every bit of my strength and grabbed a knife. Those are things that I don't often talk about. But as I stood up for the race that I won to get here, I finally started talking about it. And I became that voice. And so whatever it is that I can do to help clarify what you're asking, I will certainly do that. But today, I'm telling you that I am here to stand up for a life of a friend, in addition to my personal experience. Sharon Radabaugh did not deserve what happened to her. And I think you're actually saying the same thing that I am.
I am, and those situations are truly terrible. My concern with the bill is that it will only touch a very unique lane of people for whom their victimizer has engaged in a very narrow set of activity. And so...
And if we need to broaden it, I certainly will take every note that I can and make sure that happens.
Sure.
The people that have worked alongside me and served alongside me in this body, they know that of me and my work, that I will take everything you're saying into consideration. However, I would like the people that have traveled here for a very long time to be heard today.
Of course.
So please, let me take those notes. Let's sit down and talk about it. I sit right there on the row in front of you. And I
course.
promise I will hear you out. And if you can help me, then I certainly will take all that into consideration.
Yes, ma'am, thank you.
Thank you.
Rodriguez Ramos has a question.
Okay.
Then Mr. Louderback.
Mhm.
Representative Bowers, thank you for bringing this bill forward. You're saying the existing monitoring systems have proven insufficient, essentially what you're saying. So what resources quickly can you tell us about? Nothing long-winded, just what's this going to take us to get something like this through? What's it going to cost our counties?
So there is a fiscal note, and, you know, I want to again say that it certainly, in the state of Texas, will be worth the money. So
Sure.
the fiscal note, it says, you know, as introduced, is a negative impact of $2,153,360,000. But what I have to say, and certainly Representative Louderback, I do believe that it really will not, like, the DPS officers will not be monitoring, they will not be left, they will collect that data, and they will go ahead and put those numbers in their final report. So I'm not at all saying that the current situation is wrong. I just think that those offenders need to be monitored, certainly to protect victims and their families if they're getting close to them. So that is what I'm saying. I'm not saying, and it is just in addition to what we already have in place.
So in probation, we're already using this system. That's what you're saying, move that over into this other area?
Yes, sir.
Okay, all right, thank you.
Thank you.
Anything else? Yes, Ms. Jones.
I got a question, Rep. Bowers.
Mm-hmm.
So I know, for example, in some counties, they're using GPS. What is your bill gonna do differently? Do you understand what I'm saying?
I do. And this bill will require that they go ahead and wear the GPS monitoring system, that information is tracked by DPS, and then it will make sure that they report that information at their annual report. That law enforcement does.
But so I read somewhere where it talked about real time.
Yes.
So when you said alert, so you didn't mean like a silver alert or an amber alert where the victim gets an alert if they're in where they're not supposed to be, if they're close to them. You're not talking about that. You're talking about alerting law enforcement of where they are.
It will alert law enforcement. However, that real-time data, to my knowledge, and with this piece of legislation, will alert that victim and their family. It will not be an amber alert or a silver alert.
Right, I just use those as examples because I literally just had a GPS case, and I had to get the records from the GPS monitoring
system or
company. They give me a gajillion pages of stuff, and then I actually have to sift through the GPS monitoring, I guess, business records affidavit, and see where, like, literally get the addresses of the victim who has the protective order or whatever, and then try to match them up. So I was just wondering if there's technology that you can put it into the GPS monitoring system that's going to do something.
As I read Representative Bauer's bill, my understanding is the victim will be able to download an app on their phone, and if her aggressor, abuser, is within a certain range, she's going to get a notification on her phone.
He or she. He or she.
Fair enough.
And so thank you, Representative Little, for sharing that. The victims will receive real-time data alerts if an offender enters a restricted area, giving them time to seek safety while law enforcement responds. So the bill also provides access to the victim services and legal protections.
So do you know if there's technology that already does that, or is that technology going to have to be developed? Do you know?
There is, to my knowledge, technology that does that. I think with this legislation, what is happening is, while it's giving the victim that alert, it in addition, as you said, gives law enforcement the time to respond. So they're alerted as well, but it gives that victim time to go to safety, to find safety.
No, I understand what you're trying to do, and I think it's great, because I'd like to know if somebody who's not supposed to be around me is around me and I just don't know it, i.e.
Right.
stalking.
Right,
And
correct.
I also know that stalkers are more likely to kill their victims.
Yes.
And stalking is stalking, because most times you don't know they're stalking you, right? So I'm just trying to figure out, because if I knew that there was technology available to do that, right? Because sometimes we can, when we're at the bench arguing what the conditions of bond or whatever are, we can sometimes say, Judge, I know this program or this app that can help do this. Can you make them do that? And then that way, so I just wonder if there's not technology available to allow for real-time notifications to the victim and or law enforcement. And I think to the victim is better, right? Because they're the ones who are in danger of dying or whatever. I wouldn't imagine that there'd be a physical note to the state because most times, at least when I've practiced, the defendant has to pay for their monitoring device. They've got to pay for everything.
And so the bill does explicitly prohibits offenders from tracking victims' vehicles or electronic devices without consent, and further strengthening those protections, as you said, against stalking as well.
Right. So I guess the cost of the state is for DPS or whatever law enforcement to get the technology that will allow that to happen for them.
For them, right? Because this is just it's using a GPS monitoring system. So it is the portion of it that I think speaks to the change you're talking about, is so that law enforcement gets that alert, that they are able to track that information, collect it, and then make sure they are reporting it in an annual report. And that's where the fiscal note comes in.
Thank you.
I think
I've got, yep.
So who is this an additional law enforcement duty?
so. That's a good question, and thank you for that, because we anticipated that question, if there would be an extra burden on law enforcement. So law enforcement enforces violations, as you know, right? But does not actively track offenders. So that's the part where the change is. Violations must be reported to a statewide law enforcement database, and ensuring that officers respond when necessary. So that's the piece where it does give law enforcement some extra duty. But I would not say that is so much of a burden, like an extra burden. They're collecting information that is necessary so that those that are the victims are able to get to safety. And I do believe that it will save lives.
So something at the local level, like this would go to dispatch? Would go to the jail information would be transferred to dispatch?
Yes, and I'm making a note of that, because.
So who would be ultimately responsible, I guess? And we can talk about this offline.
Yes, but thank you. And so I'm going to make a note of that, who would be. But I do believe that when we've looked at it, when we've talked to those that have supported the legislation, it would be local law enforcement, getting that extra alert, tracking that information, putting it in that database, and making sure that they're reporting that on an annual basis.
Okay, thank you.
Thank you. Okay.
Rep. Bowers, thank you so much for this bill, and you started off in your hearing, you started off in your testimony sharing your personal experience. I've known you for almost 10 years, and we've never discussed that. So thank you so much for sharing it in this open forum, and you talked about 1 in 4 women being survivors and of domestic violence, and I think on this committee, we've all shared, or, in different spaces, you have 3 of 3 women up here who have been survivors of domestic violence. So this is a real issue, and it's not just a hypothetical but this affects several of us on here. My question to you is, the electric monitoring, you talk about, what are some of the fees associated with it? Because I know in a lot of spaces, people talk about whether individuals can afford this or not. And before, as you're gathering that information, in terms of like what the average fees are for the offender, I wanted to touch a little bit on Representative Lauterbach. Yes. Sorry, brother. I've worked in community spaces and different community revitalization projects, and it seems to me something like this is really helpful for the survivor or the victim, because although police might say they have limited resources or it's not a priority call, that somebody is around their victim, right? And like, I'm in the Dallas area and worked a lot with police in different in community revitalization project where we've had cameras monitoring the community to make sure that it was safer. And it was taught to us, we were informed that the Dallas police would not necessarily respond to every call or every what have you because of the priority calls. And so I imagine an alert to the police dispatch or whatever would be like, okay, that's not a priority call that he's within 100 feet of you. We have a murder going on over here. We have to go over there. But it really helps the victim or the survivor, right, to really be aware. So it's almost a double whammy in terms of what it allows for that space and that protection to happen if there aren't any priority calls happening where police can go to that area. But more than anything, it helps the victim. And I think we've talked about victims in the past in our hearing here. And so I really, really appreciate what it does for victims that we talked about earlier. We often overlook the empowerment of the victims. But going back, so thank you for that. Going back, what are some of the fees associated with this monitoring? And we talked about the DPS covering their ability to heighten their technology to be able to gather that information. But what is the average cost?
So that is information, Representative Ramos, that I'm going to have to get my staff to get, and hopefully, while we hear from the witnesses that have come all this way to testify, that they'll have that information. If I could use that in my closing.
Okay, yeah, and I understand that there's some also waivers or sliding scales for those indigent. Okay, you're going to say something. Indigent offenders, but I do want to just really once again express my gratitude and that it prevents harm for those victims who to prevent them from being victimized once again. So thank you.
And thank you, Representative Ramos. And as you said, we have known each other. We're classmates. We came into the legislature together. And it is something, as I mentioned to Representative Little, that I do not talk about a lot. And some of the witnesses that are here, we have family members here, but we have other witnesses that know that I have suffered from domestic violence, and I have been fighting alongside them for years. So I will certainly get my staff to get that information. If I don't have it at my close, I will certainly share it with you on the floor.
Anything else?
Yes, a couple of quick things. One, thank you for the committee sub. That was going to be my first question. I think you've addressed that. My second one, and it goes to I think what Mr. Little was talking about, but the idea is to, I would think, make sure that we are capturing. I'm almost say capturing, but we are monitoring any defendant that is what this says considered to pose a continuing threat to the victim. And then we limit it by if the defendant has a history of these things. And I'm with Mr. Little saying if the court finds that the defendant is considered to pose a continuing threat to the victim based on, any number of factors or considerations or the court's good judgment, I would not want them to be limited and not be able to impose this monitoring as well. So, to me, the monitoring system is a way to ensure the safety, or not ensure, but to improve the safety of the victim while still allowing some manner of liberty to the defendant as they go through the legal process. So it should be something that kind of has broad support, I would think. And I would like to give the judge a little more leeway in deciding when. And maybe we say in these cases they must, but in other cases they may. There may be several ways to fix it, but I would hate for there to be somewhere that our net doesn't catch.
And I so appreciate Representative Little and your comments, Representative Money, and I would love to talk to both of you so that we can work on language that will make sure that that doesn't happen. I think in both cases that when you all are describing the scenarios that you are, it is a little bit sensitive for me because I am a survivor. And as I said to Representative Little, one time is too many, and I think you agree with that from what you're saying. I just know that as a survivor, the first time it happens, you definitely don't think that it's going to happen again, right? And I think as a victim myself, I know I didn't report my ex-husband. You see what I mean?
Right.
I didn't report him. There was no protective order because I didn't say a word. And half the time, I want to be honest because I know there are victims, other victims in here. You don't, you sometimes believe that you're part of the problem. And it took me a while to get past that it's not me that is making this happen. And so I really want to work with both of you to make sure we do get that language right. And I appreciate y'all for bringing this up and for the discussion about it because it is a serious problem. And this is a crisis that men and women are facing, and they're suffering in silence. So as I sit here and discuss this with you all and think about the many fights that we had, and I didn't say a word. You see what I mean? Really didn't even want my family to know, right? That I was allowing this kind of repetitive, negative behavior in my life. So thank you for that.
And then the last question, and I'm not familiar, but these systems, do counties already have these for their probation and for this is something that counties already have and do, correct? This would just expand
Yes.
the types of offenders or defendants that would be.
It will expand what we already have in place, and the part where the change comes in is making sure that the information is tracked, making sure that law enforcement is alerted, and then certainly that they're asked to report that information.
Right. And so I do think it's important if we understand, even though there may be no fiscal note for the state, I think it is important to understand what kind of financial burden this may place on counties. And then in addition to that, I know that there's provision in here for the defendant to have to pay back some or all those costs, depending on whether they're indigent. But there's going to be some upfront costs just to make sure that we have enough monitors to handle these cases. And it would be helpful to have a little more of that information.
Okay, so your question is just what costs there will be, right?
Right.
What kind of costs are there? And I think that's the same question that Representative Jones had, or Representative Ramos. It was Representative Ramos.
Okay.
So I certainly will make sure that if I do not have that information at closing, that I will get that to you all as soon as possible. Thank you.
Thank you.
For your time and your interest in this legislation.
Okay. Is that all members? Okay. Thank you, Ms. Bowers. And I understand that you Do you have anyone particularly you'd like to call as first witness?
If we can, the family,
Certainly.
I do believe that Eden Radaba is here and her
Well,
family.
She registered as Eden Casey, so we're going to call her up right now.
Thank you.
And we'll reserve your right to close, okay?
Thank you, sir. And thank you, committee.
Thank you, Ms. Casey. Come on up.
Thank you. Hello, members of the committee. Thank you for allowing me to be here today. My name is Eden Radabaugh Casey, and I am here on behalf of my mother, Sharon Radabaugh. Also with me here today in support are my husband, Michael, my sisters, Erin and Jamie, Sharon's 4 grandchildren, Ava, Austin, Romy, and Margaret, and my best friend, Justina Whitlock. I'm here speaking in favor of the bill in front of you, the Sharon Radabaugh Family Violence Protection Act. On June 3rd, 2023, my mother, Sharon Radabaugh, was shot and killed in her home. The man that murdered my mother was a man she had been in a relationship with for 5 years. She had ended the relationship a month earlier. He continued to harass and stalk her. She eventually told him she had moved on and was in a happy new relationship. That day, he chose to drive 3 hours from his house to hers, entered her home, uninvited and unannounced, carrying a shotgun, walked in, and according to his confession to the detective, he asked her if she was seeing someone else, and when she said yes, he shot her twice, once in the stomach and once in the chest, in her own living room. I cleaned up my mother's blood. This passage of this bill is imperative to protect the lives and provide resources of so many Texans living with domestic violence in the name of Sharon Radabaugh. If possibly my mother had this resource or these resources, perhaps none of us would be here today. I would personally like to thank Representative Bowers for authoring this bill. Thank you for your time and consideration.
Well, thank you for being here. Members, any questions? Ms. Casey? We appreciate you being here. We have, the chair would call Molly Voiles.
Hi, good afternoon. My name is Molly Voiles. I'm the Director of Public Policy at the Texas Council on Family Violence. We're the statewide coalition of domestic violence programs here in Texas, many in your district. I want to start by first thanking you, Representative, not only for authoring the bill, for what you shared, because so often people don't talk about domestic violence. And for survivors to sit and hear this and hear what you've done, I just want to thank you for that. And I want to thank the family. To lose anyone is something you never don't hold. And to come here today, I just want to thank y'all for doing that on behalf of all survivors.
And we want to, if you would, tell us where your position on the bill.
I'm very much for it.
Okay,
Thank you, Chair. Thank you so much for the time. I want to kind of just explain a couple pieces. I know y'all have talked some about it, but as we see it, for many years, there's been the ability to have GPS, particularly at probation here in Texas, but it has been what we call passive GPS. That means it pings off at periodic points. It is not active. For the true safety of a survivor, what this bill does that is huge is it changes it to active GPS. So all too often when we tell survivors, hey, here's this safety feature that's going to be available, there can sometimes be holes in it. And right now, the passive nature of GPS sets survivors up to not have that real-time information. So we're very appreciative of this bill switching it from passive to active. It utilizes current systems. So I think to some of your questions, much of this is in place in the probation level. There's even a grant program through the Criminal Justice Division to allow for support on this at the county level for probation. So you've got some setup already. It also utilizes an existing database, which is critical and available to law enforcement, because certainly I stand here with the grace of having stood with survivors for many years, but it is also the most dangerous call for law enforcement when they arrive at the scene. And so they need to know that there is an active GPS situation, active stalking, or active domestic violence. Particularly, y'all mentioned firearms, which raises the risk of domestic violence homicide by 500%. So we need our law enforcement officers to know that when they're arriving at the scene. We really appreciate that it is a closed database to law enforcement and other professionals. Sometimes we see more public ones that can cause some danger for survivors. So I think the setup of this and looking at the active versus passive, ensuring that survivors have a real-time safety mechanism. When you leave, it is the most dangerous time. 52% of survivors who were murdered in 2023 by their intimate partner, primarily women, it was done when they were making steps to leave, when there was a protective order, when they had told a friend maybe and not made a report. And so giving this at that critical time could quite frankly save a number of lives. I'm happy to answer questions, but I just want to say again, thank you, Representative. We're very supportive of this, and thank you again to the family.
Mr. Little?
Ms. Voiles, thank you so much for your testimony. I'd like you to elucidate a little bit the difference between active and passive. As I was reading Representative Bauer's bill, what I was envisioning is a wife gets an alert on her phone that her husband has followed her to the grocery store. He's violated whatever the order is. Is that what you mean by active, that you're getting the information in real time as opposed to it's just simply being captured somewhere that the victim doesn't know?
It's a great question. Thank you, Representative Little. Typically with active, it means you have the ability real time to see a violation of the zone. A passive, it could be delayed. It could be that you have to check in and look online to say, oh, okay, they did and I didn't know. So I think that's what's been in place for quite a long time, is that I would have to proactively come in to see, was that violated? The setup in this legislation would allow for that more real-time pinging, which would bolster safety. And we've been here 3 sessions in a row talking about passive versus active, so we're really excited to see this shift.
And Ms. Voiles, were you here for my questions to Representative Bowers?
Absolutely.
Okay.
We made sure to be here the whole time.
Okay, so the thing I'm trying to, did you understand the question I was asking about which situations this bill would capture?
I think so. I never want to say for sure, but as I do, I wondered, Representative Little, if and to what, thank you again, Representative Bowers, if that I haven't seen the sub, but in the original language, there is a piece around threats being made to the victim, and I wonder if that would get to what you were thinking and to what Representative Bowers was saying around maybe not always making a police report. And we know y'all have heard a lot today about the criminal justice system, so there could be great reasons why someone has chosen not to engage. So I liked that it included that language in the non-sub bill for threats,
So,
to your point.
as an attorney, I've had the displeasure of representing some women who were victims of, I'll call it hellacious abuse, like the worst you can imagine. And I'm putting them through the rubric of the bill. And I'm like, her husband had never had any contact before violating an assaultive offense under the penal code. He had never used a firearm. He didn't make threats. He just beat her. And so I'm wondering, what is the broadest possible way to capture a truly ongoing threatening situation under the code? And I pose that question to you and ask you if you've thought about it yourself, and I'll ask you, do you think this is broad enough to capture every situation you want it to capture?
I think first and foremost, we don't often mark a threat when it's made, because sometimes we're looking for something a bit more explicit. So if we were to prepare everybody from law enforcement advocates to judiciary to ask questions, because I think I heard you even say, Representative, I didn't note that at first, and so often I was a former advocate, although always in my heart, and all too often a survivor would say, well, that was not domestic abuse, or that was just emotional. So I think part of it is coupling it with the training to understand those threats were there. That survivor absolutely knew. And it may be that we don't have everybody ready and trained to identify it, but I also love that you and the representative would talk about that to get to that point. I appreciate that you're looking out for survivors in this.
Well, and my concern is I want to make sure that the magistrate when the case is being, or when the case comes in front of the magistrate, that the magistrate goes, red flag, I want to put something on this guy or on this woman to make sure that we know where he or she is, because this has the classic signs of an ongoing threat situation. Whereas instead of a magistrate going, well, I can't check boxes 1, 2, 3, and 4, so I can't do that yet. And so I'm imagining that a more permissive environment for a magistrate to go, this has the classic hallmarks of an ongoing threat of domestic abuse, and I want to use this tool, so now I have the authority to use it. Does that make sense?
It does, and one thing y'all could consider is putting some training in place for the magistrates to identify those threats. Because I think, I do get where you're going, but so often it's about that last line, how do I know that threat has been made? And what questions am I asking of the survivor to understand that? And am I doing it not in front of their partner who used violence?
Thank you.
Okay, any other questions? Okay. Thank you
y'all
for
so
being
much.
here.
Yes, ma'am.
We have Angel Carroll. Ms. Carroll, thank you.
Hi, how are you all doing today? My name is Angel Carroll, and I'm here in strong support of HB 36. I have the honor of serving as the Director of Advocacy for Measure, a research nonprofit. I'm
And
also
so,
a member.
Let me interrupt you. Your affirmation is you're testifying on behalf of Measure and yourself, correct?
Measure myself.
Okay, great.
Yes, as well as a member of the Austin Travis County Family Violence Task Force, as well as an executive board member and public policy chair of Safe Alliance, a pillar in the Austin
Now,
community.
let me stop you there. So,
Yes, sir.
on your affirmation, I'm sorry, I just
No,
don't want to
you're
endanger
fine.
Ms. Bauer's bill, okay? Unnecessarily. I know you don't either. So, I've got to get you, your affirmation says you're just testifying on behalf of Measure and yourself. Is that accurate, even though you hold other
Yes,
positions?
yes, sir.
Okay, I just wanted to clarify that. Thank you.
Of course. And executive board member for Safe Alliance, seeking to stop abuse for everyone in Austin. In these roles, I've collaborated closely with survivors, advocates, and policymakers to prevent family violence, support survivors, and hold offenders accountable. It is my firm belief that family violence is a public safety crisis in Texas, and the statistics are staggering. In fact, in 2023 alone, 205 Texans were killed by intimate partner violence, 179 women, and 26 men across 64 counties in the state. Firearms were used in 72% of the cases where women were killed by their partners. Family violence offenses have increased by 26% since 2018, with 247,896 incidents reported in 2023. HB 36 offers a critical alternative. By requiring GPS monitoring of high-risk offenders and providing real-time alerts for survivors, this bill allows survivors to stay in their community, maintain their employment, and remain connected to their support networks without having to uproot their lives of protection. For many survivors, this means they no longer have to choose between safety and stability. HB 36 is more than just a monitoring tool. Again, it's a life-saving measure, and I ask all of you to vote yes for it. It empowers courts to protect survivors, again, prevents repeat offenses that we see, and ensures that accountability measure. And as Rep. Bauer stated earlier, we need to prove a point, that Texas will not tolerate family violence, and Texas supports its women and men that are affected by domestic violence. Thank you.
Thank you very much. Ms. Carroll, any questions, members? Okay, thank you for being here. We have Aaron Johnson.
My name is Aaron Johnson. I'm the president for the Texas Association of Pretrial Services. I'd like to say we also support HB 36. Family violence is the #1 issue in Texas. Being consistently the highest charge for the past 2 years, this group makes up 10% of all arrests in the state. We feel high risks needs to be defined and assessed, which we think is what the representative is trying to do in B1. The association has partners who utilize these kind of assessments. There are danger assessments, domestic violence assessments, that can give some more guidance to who we feel like these high-risk individuals are and identifying them. And it also takes the victim's point of view into account because it's an actual assessment of from the victim's perspective and with the victim. We would welcome the opportunity to work with the other agencies to implement these across the state if they're not already. Ordering GPS devices is problematic on some fronts as far as who provides the supervision. Probation in the state of Texas does not receive funding to supervise pretrial populations, and we've already heard the surety agents do not provide this as well. Respectfully, any fees assigned to the case should be set at the end, and I'll explain that a little bit more. A couple of things with domestic violence, unfortunately, many of these cases are not filed and declined, and having someone pay for fees that maybe they were not found guilty of on the back end. Most importantly, this is also a tax on the victim and the family. Because these are domestic violence cases, the person you are assigning these fees to, it also affects the victim and the family because they're the ones that are also having to go and figure out how to pay these fees in order for the GPS device to be utilized. We feel trying to legislate the technology requirements may not be viable as technology changes very quickly. And we might not be able to, it might put us in a position where we're not able to utilize better services as it comes along because it would require a legislative fix. So leaving some kind of opening for better technology and being able to use something better that comes along versus what's only available in the bill. And we believe Section K also provides a mechanism to report these requirements from the magistrate. But there are already legislative pieces in place, and it might be better left for the counties to make that decision for the reporting system, only because this might actually be more restrictive than what they're currently using or the current process. We work with a lot of domestic violence agencies in my current jurisdiction, and we actually have a high risk, what we identify a high risk domestic violence cases, and we work with many different agencies, and we work back and forth with the court. So just not being so restrictive that you can't do anything else outside of that. But other than that, no, we absolutely, yeah, I'd be more than happy to take any questions.
Okay. Any questions, members? Okay, thank you for being, I'm sorry, Ms. Bowers has a question.
Thank you, Mr. Johnston. My staff is here in the committee hearing and watching from the office, but would you please come by our office too to share all that you have? My chief of staff is right there. He can get you his information.
Perfect.
Thank
Okay,
you.
thank you.
Okay, thank you very much for being here. We have Heather Bellino. I hope I'm saying it right.
Heather Bellino, Chief Executive Officer, Texas Advocacy Project 4. Did I cover all the bases?
Well, now your affirmation says neutral.
I know, I just changed it on you, I'm sorry.
Okay, that's fine. So, well, does the clerk have your authority to change
Absolutely
your
has my authority.
affirmation
Thank you
to-
very much.
for the bill, okay?
Yes.
And you're here on behalf of Texas Advocacy Project and yourself, is that
Yes.
correct? Okay, I didn't mean to interrupt, but go ahead.
No, wonderful, thank you, and thank you for having me, and Representative Bowers, thank you very much for this bill and for what seems like everybody's spirit of wanting to make it as broad as possible to keep victims as safe as possible. I, again, am the Chief Executive Officer at Texas Advocacy Project, and for those of you that don't know, we provide free civil legal services for victims of dating and domestic violence, sexual assault, human trafficking, child abuse, stalking, all of those atrocities that might need a court order for long-term safety. And the work we do is only as good as the laws that you make. So thank you for this and for this consideration. Last year, we closed over 5,000 cases. That's 5,000 of these victims sitting in this room. This year, we are on track to close more. And that's going to affect over 10,000 and nearly 15,000 victims were primary and secondary victims in the state of Texas. So we see firsthand how victims of abuse navigate the legal system and all the challenges they face in seeking the protections. And survivors who attempt to leave an abusive situation often encounter those barriers to safety, especially when monitoring and enforcement mechanisms fail to prevent continued harm. And as it was already stated, when somebody is trying to leave, it is the most lethal. Can you imagine when you get the most courage to go? It is the most dangerous moment, and what you must overcome to do that. So, one of the things that we just hear over and over again is when survivors say, I don't know if he's in the room. I don't know if this person is coming after me. And let's face it, the criminal trials last for years. Most recently, I was on a call with a victim yesterday, and 3 years before her criminal trial even occurred. And for those 3 years, the only protection she had was a lifetime protective order, but she still didn't know if he was in the room. We have to find a way to stop that. As Molly said earlier, going from passive to active, this will make the difference. Yes, we do have to find ways to keep up with the software and with the technology as it adapts, but it is absolutely our responsibility to the members of our communities, our sisters, our aunts, our brothers, our cousins, the people you're in the grocery store or the church with. It is our responsibility to make sure that they feel safe in their own community. I had one person who went to join a gym, and she walked in and he was there. Had she known he was there, she never would have tried to join that gym.
Yeah.
So it's about knowledge and about empowering victims to have safe measures and to control their own safety. I could go on and repeat the things that are on my piece of paper about what we love about the condition of bond, the victim notification of violations, the provisions addressing unauthorized tracking of victims, because when that technology flips, it's horrific. Establishment for that victims assistance program, and of course what I love is data collection and annual reporting, because if we can give data-driven, evidence-based information, we can continue to make better laws, which is what you all are doing here today. So thank you very much, and thank you for allowing me to change to 4 instead of.
Thank you, Ms. Boyd. Any questions, Mr. Wood?
Thank you. And I know you were here earlier for other bills and stuff, and you heard a lot of people saying like who will think of the victims? Why don't we provide more protections for the victims? And I want to make sure this is what domestic violence advocates and victims have been asking for decades.
Decades.
For just let us know, because even with my own life, with my friends who have gone through this, I've had calls where we say I know that's his truck. He keeps driving by the house and over and over again, and we call the cops, and the cops say, well, did you get a license plate? Can you see the license plate? I know that's his truck. I said, well, unless you have it on camera, we can't do anything, right? And if he had an ankle monitor or she had an ankle monitor, you would know for certain, yes, you were not supposed to be within 1,000 feet, you were within 200 feet driving by, right?
Mm-hmm.
And this is this, and like we talked about earlier, if you don't deal with people as they escalate, then they will escalate higher and higher and higher until we end up with another assault or a murder.
Absolutely.
Right? And the fact that if people are not following what they're supposed to be, like the judge says, hey, I don't know if you're guilty or not, but for the sake of everyone, you need to stay 500, 1,000 feet away from X, Y, and Z.
Yeah.
And it's that's all there is.
Yeah.
Right? And instead of leaving people in jail to rot, we say, look, we don't know if you did this or not. We don't know if this is a he said, she said kind of thing. But until we figure that out, we're just asking you to stay away.
Yeah.
That's all we're asking you to do instead of putting you in jail, instead of leaving you in jail. And this is just let the victims know.
Yeah.
Right?
And the secondary folks around the victims, the police, the law enforcement, the advocates, the shelters.
Yeah.
It's important.
Yeah. I mean, it's just information.
Yeah. Thank you.
Okay, anything else? Yes, Mr. Little?
This may be a stupid question,
Oh,
so I
no
apologize.
stupid questions, but I don't know if I'll be able to answer it even if it's not.
Does the abuser who's being monitored know when he is within X number of feet of his victim? I'm envisioning an ankle monitor. I'm envisioning the victim with an app on their phone going, he's at the same grocery store, or he's now at a restaurant you're at, does the person who is being monitored know that they are violating it?
I'm not 100% certain on this, and I think that you can have offline conversations with it, but I do not believe that the perpetrator gets notified when they're close to the victim, because that would be a way for them to track the victim.
I could see that, but also I'm wondering if he goes to the movies, if the person who's the abuser goes to the movies and happens to be at the same movie theater and doesn't know, now she's terrified, and he didn't mean to be there, or vice versa.
But at least
so
she has the option to get up and walk out safely.
that makes sense to me. I'm thinking
Yeah.
that the data is going to be used as evidence of a violation of the protective order as well, and I'm wondering how you establish intent. Maybe you'll have thought through that. And
Well, I'm not an attorney, and I'm not allowed to play one on TV. I just run the shop.
Of
And all the
course.
attorneys do the heavy lifting.
Mr. Wu,
But-
No, but can I help you with that? So, like, in my time in the office, we've dealt with this a lot. So, what you're talking about is a secondary charge called violation of protective order, right? It's an intentional violation. You have to intentionally violate it, right? And we've had cases where, like, the person who was not supposed to be near the other person showed up at the same grocery store. And they said, we showed up at the same grocery store. And then what happened? Well, I saw the person I was not supposed to be, and I left. The judge says, okay, no problem, right? And the judge, in fact, in every single domestic violence, or every single case where a protective order was issued, the judge says point blank, you're not to go within 1,000 feet of X location, and here is the exact address. You're not to go within 1,000 feet of second location, and this is the exact address. You're also not supposed to be where you know the victim to be. And that's the key, that you know where the victim to be. If you don't know where the victim is and you just happen to be same place, once you know, the judge will in fact admonish you and say, if you just happen to be at the same place and you know that the other person is there, you have the obligation to leave. I'm sorry, that's the rules. Okay.
And on the passive side with GPS, they can still go back and look at that and say you were there. So it would work whether it's the passive or the active in the way that you're thinking, but you're right without that intent.
So it's like, they see this GPS tracking, and it's like, she's going from her house to the grocery store, and he's going from her house to the grocery store, and they ended up having the same place. Like, I'm not sure that was accidental.
Right.
Right? But, you know, they just happen to come from different places and end up the same time. Like,
yeah.
Anything else, members? Okay, appreciate you being here.
Thank you. Thank you all.
Chair calls Keith Maples. And let me just say right here, I know we've still got more bills to do. We've got a number of people who are here to testify, and we are so sorry to keep you waiting. And I wish we could avoid that, but we do appreciate you staying and being willing to testify on these bills. Mr. Maples, if you'll identify yourself.
Keith Maples, and I'm here to testify for House Bill 36 on my behalf and on behalf of the Texas Family Law Foundation. We're for this bill. I'm for this bill. I do believe that the discussion here today from Representative Little and Representative Money on the subject of giving discretion to the magistrate or to the judge in the family court context would be a great addition to this, so that they don't feel like they don't have the ability to do that. The way I have read the bill, I don't believe it is actually going to be tracking whether the person with the monitor is near the victim, but near places where they're prohibited from going. So I don't think there are provisions in the bill that would let the victim know that they're near them if they're not at those places. In years of practice, being in front of courts, I've heard judges say, this protective order is a piece of paper. It's not going to stop violence, but it's going to bring attention to the situation, which is a deterrent. I it's not going to stop every perpetrator, but I do believe knowing that you're being monitored and that the court will know, and there won't be these swearing matches about whether you were at that place or not, the evidence will be there, then they are going to get found to have violated protective orders, and that is going to have real-world consequences. And I believe that this will protect victims and hold people accountable, and I think it's a great improvement to existing law.
Right, thank you. Mr. Maples, any questions? Mr. Little?
Yeah, Mr. Maples, I have questions about the overlay here with family law. We have an excellent family lawyer in Representative Cook on our committee. He may already know the answer to this. I do not. Typically, what I see in very high conflict divorce cases, there will be from time to time a protective order entered at the beginning of the case. Do you envision a family court judge having the ability to order this degree of monitoring? Because I read through the bill and I did not see that. Unless I'm missing something.
I believe that the bill is also amending the family code protective orders in exactly the same way. It is amending, I think it's section 85.022 of the family code, which is the part of the family code dealing with protective orders. So if the court believes that it is appropriate to issue a protective order, then this is one of the things that could be a part of that protective order. On page 7
Of the sub.
it is implementing it virtually the same provisions as you would be done for emergency protective orders under the penal code. And in fact, ideally there, you've got a court hearing a lot of evidence that they could gather to make that discretionary decision on whether or not to issue these, the monitoring as part of a protective order. If they don't grant a protective order, I don't think they could issue the monitoring.
Okay, then I'm just going to leave a mental note here. The sub on page 4 modifies the firearm language, but that firearm language still exists on page 8 of the sub. So unless I'm
7 and 8.
No, I'm sorry. On page 8 of the sub, the previous firearms language is carried over into the family code. The subbed language from page 4 does not.
Yeah, it's repeated twice in the bill, so if it was changed in one place, it should have been changed in both, probably. I don't have a copy of the sub.
I certainly wouldn't suggest anybody's intent one way or the other. I just noted that, as Representative Cook pointed out to me on page 7, that it amends the family code, 85022 as well. So I'm having been a part as a lawyer of some high conflict family law cases, I could see this being used. I mean, it would not be uncommon. But I also see a family court judge having to go through the same funnel that we discussed earlier, and having his or her authority limited to only those criteria. So
Yes, I agree with you. I think broadening it to give the discretion in other situations to the court would be improvement, both under the emergency protective order and the family code protective orders.
Okay, so I'm not the only person on earth. All right, thank you. Appreciate you.
Anything else, members? Okay, thank you for
Thank
being
you.
here, Mr. Maples. Leslie Matthews.
Good afternoon. My name is Leslie Matthews. I am speaking on behalf of myself, and I'm in strong support of this bill. As I previously mentioned, I'm a practicing attorney. The main theme of their main tenet of our law firm is to end violence against women and children in my lifetime. I shared that, and I'm okay to share very personal parts of my life as well, being a survivor of domestic violence, getting launched into this work after the brutal murder of my best friend. I went on to work at the Fort Worth Police Department and trained by the Department of Homeland Security Federal Law Enforcement Training Center as a domestic violence advocate and sexual assault and human trafficking. Teach TCLOS certified classes here in Texas and have chaired the Tarrant County Council on Family Violence. This bill is incredibly important as it requires, under certain findings, that we enable survivors to know where their abuser is. There was a period of time when I worked at the Fort Worth Police Department. I worked 6 suicides in the course of a summer. One of the ones that I was called to work on, the woman had just gotten her paperwork for the finalization of her divorce. Her abuser followed her to a Kroger parking lot in Fort Worth, Texas, and shot and killed her as she was driving and died by suicide there in the parking lot. I can't imagine if we would have had this type of legislation then that she would still be here, that my best friend would still be here. I help survivors as an advocate before I was an attorney, and I wanted to become an attorney because I was the social worker that continued to refer, and we don't have enough civil legal attorneys to help survivors that are seeking these types of protections. So to have it in a different vein is really, really strong. To know where your abuser is. There's a film called Telling Amy's Story that I think that a lot of people should watch. We go back for just that one last thing, a baby bottle, some Pampers, and women and persons who are surviving violence end up losing their lives seeking very basic necessities. And this matters because it strengthens the monitoring offenders, provides necessary resources to the victims, and enhances data collection. So as a researcher, and data is important as we look to improve the state's response to family violence. Domestic violence does not just affect the individuals, but affects our entire community. Because of the work that we were able to do, we started the largest family justice center in the nation, which is there in Tarrant County, which is One Safe Place. In closing, it went from this isn't my issue, this doesn't happen, or I'm not okay to talk about it, to us looking at how does this, as someone working in law enforcement, saving law enforcement officers' lives and knowing where we're responding. Domestic violence it impacts our property values and everything else, and so this really does impact everyone here. And so, Representative Bowers, thank you for introducing this legislation. Last thing I will say in closing is I think some people have already mentioned this, but we do have the global GPS monitoring systems that are already in place so that something like this could occur, and funding that is already in place. And the last thing I'll mention is that when to one of the representatives' questions, when we look at how do we look at who may be a threat, as a prosecutor and then as an advocate, I can look at things and work with our amazing victim advocates to say, what were the threats? What else is there? And can bring those things forward to help the magistrates to be able to see who may benefit from having such a tool as this. So thank you.
Thank you. Ms. Matthews, any questions? Thank you very much.
Thank you.
And we have Chesina Whitlock. Thank you.
Hello.
I hope I said your first name right.
You did. You said it perfect. Yes, so my name is Chesina Whitlock, and I appreciate the opportunity to speak today in favor of the bill 36. As someone who also knew and loved Sharon Radabaugh, I felt it was important to come and speak not only for Sharon, but for many other victims who no longer have a voice. I've been a hairstylist for 28 years. In my career, I work very closely one-on-one with many people on a regular basis. And all too often, I hear stories of family violence. I've listened to family members terrified for loved ones who experience abuse by their intimate partner but are too afraid to leave. I've listened to friends who are scared for their loved ones who did leave their abusers only to be faced with stalking and harassment thereafter. And unfortunately, it's not uncommon for many of these stories to end the same way as Sharon's. Just 3 short months after Sharon's murder, a precious friend, client of mine, lost her childhood friend, shockingly in a similar way. I've been given permission to share her story by her family who are in favor of this bill. On September 24th, 2023, 34-year-old Victoria Lynn Anderson was shot in her home in Kingwood, Texas, with her 3-year-old son present at the crime. After an hours-long standoff, Victoria's husband was arrested and charged with murder. There were previous reports of violence, and Victoria had filed for divorce a few weeks before the shooting. Fearing of what he may do, she had removed all guns from the home. As in Sharon's case, if Victoria had known that he was nearing her location, it is possible that this tragedy could have been avoided and her son would not have been so cruelly robbed of his mother, much like Eden, Aaron, and Jamie. The bill is an opportunity for Texans to have resources that could save families from facing predictable tragedies. Texans should be able to file a protective order without the fear of retaliation. No one should have to live life preparing for a possible ambush. I see this bill as a chance for the state of Texas to show that it will go to great lengths to protect families from these violent offenders. I hope that you will choose to pass this bill so that victims can stop living in fear, wondering if there may come a day where the abuse might someday turn fatal. Thank you for your time, and thank you, Representative Bowers.
Thank you. Any questions for Ms. Whitlock? Thank you for being here. So is there anyone else here to testify for, against, or on the bill? I'm sorry? Oh, have you filled out an affirmation? I'm sorry?
She did online.
Online? Okay. We don't have it. Tell me your name.
John Rich Newton.
Can you spell your last name?
Newton.
Okay, 1 second, there's a lot of witnesses.
We can't find you on our list. We've had one other that didn't register, that didn't get registered on here. If you don't mind, the clerk will assist you to go to the kiosk and sign, so we'll stay at ease for a moment while you come back, about 90 seconds, hopefully.
genres. Thank you. Good evening. My name is Genres Newton. I am for House Bill 36. I thank Representative Bowers for including me in this session, and my new family here.
I'm going to ask you, you've registered on behalf, that your testimony on behalf of the Tapestry Ministry.
And myself, yes.
I just want to make that clear. Is that correct?
Yes, that's correct. I am a 31-year survivor of domestic violence. We usually count survival time for diseases, but I count it for domestic violence because it is truly a survival. Tapestry Ministries is a nonprofit in Dallas, Texas. We provide safe hotel stays for women that are fleeing domestic violence, and the shelters are full. We take them, keep them safe, so they won't go back into the fire. We also have a program called MADA, M-A-D-A, Men Against Domestic Abuse. This helps us to spread the news, encourage men to also be advocates for domestic violence victims. I also wrote a book called Healing Voices, Women of Faith Speaking Out Against Domestic Violence. It's a collection of 11 women's stories that have endured domestic abuse because of their faith. As a 32-year survivor, the most dangerous words I've ever heard is, if I can't have her, no one else will. When that is an imminent threat. My life has been threatened because of that. Even though I was married, I was, like Representative Bowers said, I didn't tell anyone. I didn't tell my family. It was our little secret, me and my 3 kids. So when I finally had enough and decided to leave that relationship, that's when the danger came. When you get your nerves to leave and you walk out, your life is in danger. I had no idea where he was. They took me to a shelter. They said, we're going to put you here because when he gets out, he's going to look for you. And that's all the information I got. So I lived in fear for years, not knowing if he would kick my door in, I would run into him at a store. I didn't know. This system like this would have helped a lot. This would have really eliminated my fears. For years, I would get up every night and go to every door and make sure the doors were locked. Every night, every day, for years because of that fear. So I hope that you all consider this bill, pass it, so that other women will not have to live in fear and other women will not have to lose their lives. Thank you.
Thank you very much, and I'm sorry about the mix-up.
No
Ms.
problem.
Newton. And so, members, any questions or comments? Mr. Little?
Ms. Newton, I just want to say I'm familiar with Tapestry Ministries. I live in the Dallas area, and
thank you.
very thankful for the work that you're doing. Thank you for being here to testify.
Thank you. We overhelped during COVID. We helped so many women because women were coming out from those situations, being locked up with those abusers, and it emptied all our funds. Yeah. so we're always actively trying to replenish that because we don't want anyone else to have to endure that.
And I know for all these bills today, pretty much every bill we're hearing, that our witnesses are having to share some very personal stories and some very emotional stories.
Yes.
And the committee understands that, and we want to tell y'all how much, again, I've said it before, but how much we thank you for coming up here and exposing yourself and telling your story, because it's very helpful to us who haven't heard some of these things.
It's Healing Voices. That's why I named the book that. My story is in there as well. And when women share their stories, they have power and they begin to heal.
Well, thank you very much for being here.
Thank you.
So anyone else here to testify?
I can just.
Oh, go ahead.
Thank you. No, ma'am, it's okay. Thank you. No. I just want to thank you for your courage. I know, like, for every person that's out here and speaks up, there's hundreds and thousands of other victims who do not have, who cannot speak up, right?
because it's still too fresh for them, it's because it's still too painful. So thank you for speaking up for them, and appreciate all the victims who are here and their families to share their story. And just, you know, the best thing we can do is try to stop it in the future, right? Thank you.
Anyone else here to testify for or against the Ryan House Bill 36? Not seeing anyone. Representative Bowers, if you want to close.
I think I'm gonna switch seats. I want to address a couple of things. I really do appreciate Representative Little and Representative Money's questions, and we will be addressing those things. I think there was a witness that shared that some of that will only help to strengthen this bill once we do some clarifying of the language. So I'm always going to be open to that. I do want to say that, you know, we all know that abuse is verbal, emotional, and physical. And unfortunately, I suffered from all of that. I've taken note to training for the magistrates, if that can be one thing that would be helpful. Also, going from passive to active GPS, I think, is where we're going with this piece of legislation, and I know that is going to really make a life-saving difference. In all that we've shared in the discussion, I do believe that with this type of legislation, Sharon would still be here. I have to share another personal story. You know, when it comes to standing tall for and strong for victims and me being a survivor, you know, when I had enough, as I call her Minister J.R. Newton said, and I was ready to move. So I was moving, but at 29 years of age, I was moving in the doggone same apartment complex. Stupid enough to think we can do this in an amicable way. We can do this in a friendly way. I think I even remember talking to him about our bank account and like, let's just, you know, work this out. And the craziest thing was when I moved just down the parking lot to my single one-bedroom apartment, the day I was moving, if this type of legislation had been in place, it really would have helped me, because as those guys were helping me move my furniture from one apartment to the next, the door was open. I'm 29 years old. I'm just thinking I'm handling this, right? He appeared in my apartment. So I know this is life-saving legislation. I will take to heart the things that you all have shared and make the changes necessary, because I want us to all be able to get on board with this. This is for Sharon Radabaugh. And so, Mr. Chairman, I want to thank you. I want to thank you, members, and really say that this is about real people and real lives and the real impact that strong policy can have. We all know someone who has been affected. My sister in the fight, Representative Ana Maria Rodriguez Ramos, I say your whole name. She said it. The three women that are up here, we have all suffered. Jolanda, my heart goes out to you, Representative Jones, and for all that you have suffered. And, you know, whether it was a friend, a family member, or a neighbor, this is our chance to say we hear you, we see you, and we will fight for you. So together, we can make Texas a safer place, not just with our words, but with action. So let's stand on the right side of history and ensure that survivors have the protections they deserve. And with that, Mr. Chairman, I close.
Okay, any last-minute questions for Ms. Bowers? Well, we really appreciate you and our other colleagues sharing their stories with us. I think
This is the safer seat to be in.
Oh, I know. Thank you. So if there's no objection, the chair will withdraw the substitute for now, and we'll leave the bill pending. Thank you very much. Ladies and gentlemen, let me just make a couple of comments. The last four measures on the agenda today will be things that I've authored. And so I'm going to surrender the chair in just a moment to Vice Chair Wu to preside, and we're going to switch places, I suppose. And anyway, I just wanted to say that all of these relate to bail, but they all do something a little different, and it's very important that you limit your testimony to just the measure at hand. And all I'm trying to do is protect the legislation when it gets to the floor. So even though these are related and they're very similar in a lot of things they do, I would just ask that you confine your remarks to the measure that's actually being done. We have to do them all separately. It would make a lot of sense just to lump them together because many of the same witnesses have registered on all the bills. But that creates a situation that almost guarantees the bills could be struck down on the floor of the House. So we're just trying to protect the bills. So we'd ask that you would bear with us on that. So with that, I will turn it over to Vice Chair Wood.
You step here.
Yeah. I'll just stay up here.
All right. Chair calls up, XJR 16 by Smithy.
Thank you, Mr. Chairman.
Chairman Smithy.
And I would just say, this, as I mentioned before, this is a first in a series of legislation. This is actually a JR that has already been passed in a slightly different form, I believe, by the Senate. And it's fairly simple. I would just say that, since the Texas Constitution was written in 1876, that we've had a bail provision, essentially the same bail provision we have now in Article 1, Section 11, which is part of the Texas Bill of Rights, and it's patterned to some extent after the United States Constitution Amendment 8 to the Constitution of the United States Constitution, which simply provides that in most cases, a person is entitled to have a bail set and be released from confinement prior to their actual trial. Of course, it's based on the presumption of innocence until proven guilty. And so over the years, we have, the legislature has proposed several amendments to that original provision. And so by virtue of that, we've had some additional provisions put in. Section 11A of Article 1 was passed and approved by the voters in 1956, which created a special rule for defendants with multiple convictions. And then in 2007, we passed and the voters approved two measures, 11B and 11C, which dealt with a defendant who had violated a condition of release, and 11C provided a special provision for violation of an order on family violence. And so over the years, we have created these new rules. And so HJR 6 would amend Article 1, Section 11 by adding a new Section 11E. And so this amendment does a couple of things. One, it defines the term illegal alien in a fairly specific way. And then it provides that an illegal alien who has been charged with a crime shall be denied bail pending trial if a judge or magistrate, and this is conditioned on, after a hearing, finding probable cause exists to believe that the person engaged in the felony punishable by the offense's conduct. Now, what this does is it creates an exception to the general rule in Article 1, Section 11 that would provide for the denial of bail in these situations. And so then we will follow, and we do that in House Bill 75 and 76 with with legislation that is designed to implement the constitutional provisions. And so, members, this is something that I have become convinced, and I think the witnesses will emphasize this, so many personal stories, so many heartbreaking stories. But if we can pass this with a minimum intrusion on personal rights, and yet we can protect innocent human life, it's so important that we do that, because we have innocent lives that have been taken needlessly, senselessly, and in a very tragic way. And I think that's what all of us would like to prevent. So I've mentioned to several of you on the committee that I think there may be some things that we need to iron out with this bail legislation in general, but particularly with some of the wording, and as I'm speaking to HJR 16. So I've always felt like we need to work together to collaborate on these things and try to reach the best legislation possible that will accomplish the goals that we're all trying to accomplish. We've got so many witnesses. I think I'll stop there and just say, if anybody has any questions, Mr. Moody or Mr. Wu will be glad to answer those for you. So, actually, Mr. Moody's worked on this similar legislation for several sessions, and he knows more about it than anyone.
I'm going to hopefully not prove you wrong. I do have I have comments before we take testimony, if that's okay, Mr. Chairman. Thank you. Because I certainly understand what we're trying to get to here. As witnesses come up, if there's some folks that can opine on this, I think it would be helpful. Because I think in a situation like this so it's automatic denial of bail if probable cause is found, and this is an individual who's an illegal alien. So that's all felonies. And I think you're probably going to hear some stories about some fairly horrific cases is my guess. What about those instances and that's where I want people to think about. Typically, if someone has an ICE hold on them or is subject to deportation, the way or they have federal charges pending, the way we handle that is you essentially give them a personal bond and they are remitted to federal custody for deportation or to face federal charges. This is where I want it, and I don't know the answer to this question. Is that possible under the way that the JR is drafted? Because what I don't want to have happen is there's certain cases, and prosecutors are going to have to make this decision. Do I want this person housed here and we're going to try them for what they did? Or is this a level of offense where they've got federal charges pending or they're facing deportation, and that's the better route to send them? So you bond them, they go to federal custody, they're either deported or they're charged in the federal side, and they handle them that way. And when you do it that way, the case itself remains pending, right? It still exists as a state level charge. So if they come back, charge is still pending, or if something doesn't go the way it's supposed to go at the federal side of the prosecution, charge is still pending. We still have a charge at the state level. The thing I get concerned about is if we don't have that flexibility with some of these, the only way to discharge them to federal custody is to dismiss the charges. That's the only functional out to the feds. So I just don't know. I want to get to where you're going on this, and I don't philosophically don't have objection to what you're doing. I want to look into the nuts and bolts of those cases where maybe the best decision is to remit this person to federal custody for whatever charges or for deportation, and to give, as long as there's some flexibility in those matters, because those are going to be decisions. Because I can imagine when you're looking at these level of offenses, I can imagine a prosecutor is going to say, no, deportation is not what I want. I am going to hold this person here, and we are going to prosecute this crime right here to do what's right for the victims in our community who were harmed. Yep. And so that's it. I just want to make sure that we're not binding people to those other decisions they could make, which we do currently with the feds. So those aren't questions more than as people come up to testify. That's just, I want to make sure that we're not tying people into where the only way you could do that is dismiss the case. Because I'd rather have the case pending if you're going to remit them for deportation or for federal charges.
Well, and I think you've raised a really very important point. And we've discussed that as, you know, I think it's fair to say that over the last few months that ICE has taken a much more aggressive policy toward dealing with people who are in the country illegally, who have committed crimes. I think over the weekend there was a plane load sent to an El Salvador prison, and which I think, as far as I know, is unprecedented. And there's been also talk of housing some at Guantanamo. And so I think that that's a very important policy issue is how do we decide who needs to stay in a Texas prison? How do we decide who needs to go somewhere else? Now, one of the concerns with sending them back to whatever country, whether it's Venezuela or wherever, is they may show back up here again in just a matter of weeks. And so I think to some extent the answer to that is going to depend on what is our reciprocal policy with these foreign countries that are the country of origination, to make sure that if we send them back, that they will be detained in some way when they get to those places. That would be my idea, but I would like to hear some of the witnesses discuss that.
Yeah, I think that's just part of what I want to discuss, because I think it's to your point, you know, there are some very serious high-level felonies that could come into play here, and I would anticipate that any prosecutor with those sitting on their desk, unless there's some massive federal charge waiting for this person, they're going to want to prosecute at the state level and hold those people accountable under our laws. However, if you're talking about low-level felonies, the answer in those cases could be to remit them for deportation, and then the case is still alive. If they do come back, you can arrest them. And so, I don't know, that's just one of the topics I wanted to go over.
And that's going to be a hard decision for the committee to make, I think, is which way we go on that.
Yeah, because I think there is probably a way you could make, and like I said, we'll see how the testimony goes. I think there's a way you could make the prosecutor the gatekeeper, you know, but on that. But anyway, it's just one of those functional topics that I think we need to kind of flesh out.
Members, any questions?
For the
Mr.
committee, for the committee's education, there is a very defined role in the handoff between an illegal alien that is arrested, and the process has been worked out for some years now exactly how that takes place. So it is cataloged. There's such a thing as secure communities situation that goes on. So there is I'm very familiar with the process on up to and including the 287G program, which is a better handoff between a local charge or a state charge and how it's handled through the federal system with an illegal alien. So very, very knowledgeable about that.
Well, we want to work with you for sure to make sure that we're consistent with the procedure that's being used.
Members, any other questions? Okay.
Mr. Chair, I've asked that you call Ms. Nungery first, Alexis Nungery, Jocelyn's mother, and I know that the Senate voted to add Jocelyn's name to one of these pieces of legislation. She is obviously somebody who was very important to all of us, and so I would ask that she be called as the
Chair
first
calls
witness.
Alexis Nungery. Please tell us your name, who you represent, and your position on the bill.
Good afternoon. My name is Alexis Nungery, and I am for this bill. Obviously, my daughter's pretty fairly known. Unfortunately, she was 12 years old. She decided to make a childish decision that would forever change the rest of her life and our life. She went to the store to get a soda and was encountered with two illegal Venezuelans who crossed paths with her at that time. She should have came home that night. They were both apprehended by Border Patrol and were released individually the same days they were apprehended. They should have never crossed paths, but they did. And they somehow convinced Jocelyn to go with them, and they walked over to the nearby bridge at the gas station, and they were with her underneath the bridge for 2 whole hours. What happened that evening, I don't know. Only my wildest imagination can go off. She was strangled to death. She was bounded her ankles. She was bounded with her wrist. She was left with no pants on to rot. She was found hours later, luckily, by a Samaritan who just so happened to look over at the bayou to see how high the water went from the rain. I had to go to a bond hearing for these individuals before I could even identify my daughter at the funeral home. I had to look these men in the face to make sure an adequate bond was applied for the charges that were presented without even being able to physically see it was my daughter, already picking a funeral home, already picking a casket, already picking stuff for not even knowing for sure if it's my daughter, but just being told that it is. I shouldn't have had to go with my family to go see these individuals before I could see my own daughter. The pain that me and my family have felt, the anger and the rage that my family has felt by being able to see these men before being able to see our girl is not okay. They had no business being here in the first place, and that was our last administration's fault. Catch and release was a horrible policy we had in place. I appreciate the administration we have now, and they are trying to make a difference. And I appreciate the Senate hearing me here the last time and passing it through and hearing my pleas and hearing my cries to help make change. Victims shouldn't have to sit in bond hearings to make sure that their loved ones' killers don't get out on a $500K bond, don't get out on a $1,000 bond, because we will forever have this pain. And we will forever have this hole in our hearts of a loved one we will never get to see again unless we're in heaven. I appreciate y'all for hearing me and taking the time to listen to my story, and I say it over and over again, and it never gets easier. It really doesn't. No matter how many times I do it, it still hurts. And it's still hard, but I choose to be brave for my daughter because this was her dream, was to be famous, and it wasn't supposed to be this way. But I promise I will make a name for her, and I will continue to let her legacy live on through me. Thank y'all for your time.
Members, Mr. Lauerbeck.
I'm very sorry for your loss. We have met several times, and it's a painful story, and I apologize for that. I'm very sorry. Thank you.
Thank you.
But Mr. Chairman, thank you again for, I know it's having to come to the Senate and then again to the House has been kind of a double thing, having to do it twice, and we apologize that that's been necessary, but we just really appreciate you and really so many people we've heard today sharing these very, like I say, very personal stories and very emotional stories, and I know hurtful stories, but hopefully your testimony today will make a difference, and we appreciate you waiting and testifying and being here. Thank you.
Thank you. I hope so too.
Members, thank you very much.
Thank you.
Chair calls Eric Martinez. Okay. We're going to change that to registering against, but not testifying. Chair calls Amon Blair. Hi, Mr. Blair. I have you shown as Amon Blair. Hope that's pronouncing it correctly. You're representing the Texas Public Policy Foundation. Is that all correct? And you're for the bill?
Yes, sir. Correct.
So,
All right, thank you. And if just for future reference, if you think of ham and eggs, that's how you pronounce my name, Ammon, instead of the H, just ham and eggs. Yeah, it's just Ammon. All right. Thank you for having this opportunity to testify to you today. I'm a senior fellow at the Texas Public Policy Foundation. And before that, though, I served as a U.S. Border Patrol agent in the Rio Grande Valley sector. And I want to apologize because I was part of the group that released illegal aliens into the country. Okay. I'm here today in support of House Joint Resolution 16, which amends the Texas Constitution to deny bail to illegal aliens charged with felony offenses. As a Border Patrol agent, I operated under federal law, specifically the Immigration and Nationality Act, which establishes clear detention mandates to certain categories of illegal aliens. The INA already mandates detention for certain individuals who enter the country illegally and commit additional crimes. However, in practice, criminal illegal aliens have been released by Border Patrol, and unfortunately, as a Border Patrol agent, I saw it firsthand. And also ICE, or have been granted bail and released, who should have remained in custody or removed. For example, nearly 650,000 criminal illegal aliens right now have been released and are on ICE's non-detained docket, including over 14,000 charged with homicide, 20,000 charged with sexual assault, and 105,000 charged with violent assault. These individuals should have remained in custody under federal law until removed, but due to prosecutorial discretion, lax enforcement, and bail practices within the courts, many have been released back into our communities. This amendment ensures that Texas law aligns with existing federal law, closing gaps that allow individuals charged with serious crimes to be released when they should remain detained. The 10th Amendment is clear. The powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people. Among those reserved powers is the authority of states to enforce their own laws related to public safety, including pretrial detention. The Supreme Court also recognized this in New York versus Milner. Every state in the Union has the unquestioned right to provide for the exclusion from its territory of any person or class of persons whom it may deem dangerous to its peace or welfare. Felony criminal aliens are a flight risk due to their unique circumstances. Facing severe penalties like imprisonment or deportation, they have a strong incentive to flee to evade both criminal prosecution and immigration enforcement. Consequently, these factors collectively justify stricter bail or detention measures to ensure accountability. I therefore ask this committee to support House Joint Resolution 16. This amendment represents a necessary proportional response to a genuine public safety crisis, one that falls squarely within Texas' sovereign powers while contemplating federal enforcement efforts. And then to answer Representative Moody, if I could just for a second. We don't have 100% domain awareness on the border. That means we still don't know who, what, where, why, how, or when anything is coming across, not just the land border, but also our coast. Therefore, if we do release, Representative Smith, if we do release them back to their home country, whether that's going to be Mexico or any other country, then for the most part, if they want to return, they're going to pay the Mexican cartels who own the pipelines into every single one of our communities. They're going to pay them to get there, regardless of the cost. And then they're going to wreak havoc once again on the communities within our United States. And that is one, because we do not have domain awareness of the border to include operational control of that border. And then two, based off of the administration and policies under each administration. Look, we are only going to have this administration for this 4 years. There may come a time where, due to prosecutorial discretion and other guidances and policies, that myself as a former agent or Border Patrol agents like myself currently are going to be forced to do catch and release, are going to even see right before them that they are criminal illegal aliens. They've already been charged inside the United States or have a criminal record in other countries. And yet, based off of prosecutorial discretion, we were told as agents to still release them into the United States. That also includes those that are U.S. citizens, in fact. U.S. citizens that are smuggling. Myself, I've had to, we weren't going to charge them. The AUSA was not going to charge them. So they told me to take this person in the vehicle and then drop them off at a gas station. So I'm here based off of our leadership and their guidance, and then based off of whether the Department of Homeland Security and the Department of Defense can first and foremost gain domain awareness along the southern border both of the coast and ours, and then to include not just ours, but other states, to include the northern border in Canada. Until that measure can happen, I strongly suggest that the state of Texas take its right and obligation to then put them in custody.
Members, any questions?
Chairman Wu.
There's a little.
Mr. Blair, thank you very much for your testimony here today. My supposition is that should we pass this joint resolution, should it go to the voters on the ballot and it subsequently be approved, that there will likely be constitutional challenges in the federal court system, probably at a district court level, and then up to the Fifth Circuit, and then presumably on to the United States Supreme Court. My understanding is that the question of the constitutional protections that illegal immigrants enjoy at least has been pretty well settled by the Fifth Circuit last year in the United States versus Medina Cantu. To put a very fine point on it, that illegal immigrants do not enjoy the same constitutional protections that American citizens do. And I'd like for you to just kind of briefly walk us through your understanding of that issue, as I know it'll be one that'll be of great interest to the committee and the members of the House.
Sure, that's a great question. So as we know that immigration law, if we go back into history, I mean, first and foremost, the states created the federal government, or the United States of America. And so when Texas, or the great country of Texas, became a state, with it came certain inherent sovereignty, or duties and responsibilities. And inherent in that was to exclude and also to remove those that they deemed that were a public safety and a public nuisance threat within the state of Texas and other states like that. This was also codified in the U.S. Constitution, like you just mentioned, and also through case law, specifically this recent case law, this case that you just mentioned, where and then that's going to go to, everyone talks about the U.S. versus Arizona, where the certain provisions within U.S. Arizona was stricken down, but it was only certain provisions, and the reason why it was stricken down is because Arizona wanted not to make in parallel laws enacting their own immigration laws, but they wanted to supersede or make greater cases for that. And so this is not the case here. It states nowhere, except for in certain terms, whether the states themselves, not just Texas, but every state in the United States, can actually can pass immigration law so long as it is not preempted and so long as it does not go above and beyond the current federal law. And so that's what this does. This law itself, it makes sure that based off of our current AUS code, our detention methods, whether that's 1226 and then also 1227 under AUS code, that we maintain that same level of detention for criminal illegal aliens, that as a state we have that same right and responsibility for immigration as the federal government. Now there are certain things that is exclusive to the federal government, which was brought up in that case that you mentioned, but also U.S. Arizona, and that is of naturalization. The federal government has determined what is and is not admissible, where that person is supposed to go, which is at a port of entry at a time and place, which is that port of entry. But every other case, the states can enact laws that are in parallel or right next to the federal law. And so that's what this does. As it stands, the last 4 years, and once again, I'm sorry, the last 4 years, I wasn't, as a Border Patrol agent, as a federal agent, as an immigration officer, I was not allowed to uphold the Constitution. I was not allowed to adhere to current immigration law. And so by passing this, the state is like, okay, if the federal government is not going to do it, we now have laws on our books where we are going to. And really, that's what this is.
Thank you, Mr. Blair.
Thank you, Hammond. It may be beneficial to the committee and to the people listening out here to kind of start off at the arrest site. So if you'll permit me to ask you some questions where we can outline to the committee exactly how the arrest procedures have taken place and actually what the law is now. Notwithstanding the 4 years that we've gone through of lawlessness in that area, but really these laws have been in effect, and Texas jails have been working with it for some time. Correct.
Correct. So
as we move through almost any situation where an illegal alien is arrested for a state charge, just walk through the areas, exactly what's going to happen when that person is booked in and fingerprinted in a jail.
Sure. Automatically, what they're going to do is they're going to send out a detainer request. And so, as myself, as a Border Patrol agent, we also scour, because some jails do not want to work with us. And so either a Border Patrol agent in that area, so the person up in the TALK system, usually a supervisor, or ICRO, what they'll do is they'll scan jails and look at and see if someone was apprehended or arrested that is not currently an illegal alien. And what they'll do is they'll reach out and be like, hey, I'm going to put a detainer on them. So as a Border Patrol agent, that's what we would do in Stark County and Rio Grande Valley. We'd sit there and say, oh, okay, this guy's been booked. We see that he's an illegal alien. He also has a current immigration record. We're going to put a detainer on them. In a lot of cases along the border.
Hammond, hang on just a second.
Sorry.
Let me back up just a minute. So in the booking process of an arrest, so everyone is fingerprinted.
Everyone's fingerprinted.
So at that point in time, those fingerprints go to a DHS database, which houses the A files, the alien files, correct?
Correct, yeah. So
this would bring in the secure communities part of it, which is a notification for DPS, FBI, and DHS, correct?
Yes, sir,
Now
correct.
they start over and you kind of work it from that area there, so they'll understand the process that we go through here.
Yeah, sure. So it's really difficult. So if they were a got away and they get their fingerprints, then they're not going to be inside of our system.
Which they would have no A file at that point
Correct.
in time.
They wouldn't have an A file.
Right.
An A file. What an A file is say like you come across the border, and you're an illegal alien. You came between the ports of entry. You are at the port of entry, and you go to an immigration officer, whether myself as a Border Patrol agent or Customs, and you go through the process. We get your biographical data, and you're given a number. And that number is associated with you for the rest of your life here while inside the United States, and it's called an A number. That A number is also based off of your biographical information, like you said, your fingerprints. If you are 14 and over, that is the case. If you're 13 and younger, you're not going to get fingerprinted. And if you do not have fingerprints on file, like you said, if they are a got away, if they did not get caught by any immigration, then it's going to be very difficult to ascertain who that person is or was. That fingerprint itself then will go through our systems, and you can check through various systems, whether that's NCIC, IDENT, or IAFIS. Those that are, go ahead.
Well, one thing. If they haven't been encountered by any law enforcement agency and the fingerprints are there, this also invokes ICE under the Secure Communities Act to arrive at the jail in most cases, unless they have bonded out or unless they have been released under some other terms. Yeah. So the system is supposed to work under the Secure Communities Act. That's the way it's supposed to work. It doesn't always act that way, and this is one of the reasons why we promote 287G. But from that point, if they have never been encountered by law enforcement anywhere in the United States, then leave on from there.
Can I just pause 1 second? Just make sure that whatever, I know this is public testimony, this is on the record, so be careful if we have information that needs to be confidential.
Okay, yes, sir. Thank you, sir.
Just don't want to get anybody in trouble.
Yeah,
please continue.
Yeah, so all this is open source intelligence. You guys can Google it if you'd like, or go on Grok if you guys are onto Twitter. But if you guys, so like you said, a lot of times this also can happen right at the point of detention or arrest. So a lot of times an officer will come and put someone in detention, whether they're speeding, they have another traffic violation or whatnot. And they'll end up calling the Border Patrol agent, depending if you're on near a border county, or they could call the local ICE office. And so there, a Border Patrol agent will go and then verify the identity of the person. If they do not have documents, then as a Border Patrol agent, I have direct access through our TALK system. Like I said, IAFIS, NCIC, and IDENT, where I can then identify whether that person is illegal or not. And if they're not, then typically we'll take custody. We'll actually talk with law enforcement based off of, to be honest, whether the Attorney General's office, not Attorney General's, the AUSA's office will prosecute, or whether they want to take the case and want to prosecute. We'll determine there with local law enforcement who's going to take the subject. If the local law enforcement takes the subject, then we'll just place a detainer on him, so that way he goes and he does his time, or he goes through that process, that due process, and then goes to that pace. But at the exact same time, they have a detainer on them. But if he's at the jail portion of it itself, like you said, the Secure Communities Program, or also 287G, then they also at the jail, with the jails program, if they have someone that's part of that 287G, then they don't have to contact me. They don't have to contact ICE. They themselves are able to have access to the same systems that I have access to. And that's why the 287G program is so important, to include task force model as well. So that way you're not waiting on all of this, or waiting for a Border Patrol agent who may or may not be able to come to that site of detention or arrest. And then so from there, depending on what the Border Patrol agency or ICE, they'll determine what is going to be best for the community itself, whether that's going to be us as a federal agency to then take them in custody right there and then place them through our proceedings. And then our deportation or our expedited removal process, or whether that they should go and remain with that county or police station or whatever entity, and then they go through the charges that way. So that is actually determined at our station with our watch commanders. They determine that with law enforcement, sheriff's departments, and whatnot, and they determine that case. If they do then end up staying in the community, whether that's at the county jail or whatnot, then the Border Patrol and ICE at that time period will allow them to stay for the term of whether that is going to be 2 weeks in jail or whatever the judge has decided, and then we'll just wait. And so once that waiting period is done, once they have done their time, then that agency will contact Border Patrol. That agency will also contact ICE, and then from that time period, us as a federal agent will go and then take custody and do that transfer of custody.
In the event that we have a murder case, but this is about bail here. So in the event that we have a murder case, can you quickly step through some what's going to happen in a murder case?
Yes, sir, you can. That's under
a state charge of murder.
Correct. Under 8 U.S. Code, it allows us to do expedited removals. It allows us to take certain cases of that type of felony and immediately bypass all that process and expedite them to their home country. Now, like you saw, right now some of the countries are not taking them, and so that's where they're going. Like the worst of the worst, either going to Guantanamo Bay or they're going to be housed in El Salvador with Bukele.
So, is it in this process of can the county hold the person there awaiting trial, and after trial, if sent to prison, then can they work with TDCJ at that point in time? And upon any release date, decades down the road, would that person then be given to ICE and for deportation at that point in time?
Hopefully.
So they're never allowed to go free. They may go to a federal holding facility for a while and then come back to withstand trial.
Correct. Yes, sir. Correct.
Okay.
Chair recognizes Representative Rodriguez Ramos. I'm sorry.
Thank you, Mr. Chair. Now, how long were you employed with the Border
Patrol? Yes, ma'am. It was 10 and a half years. Yes, ma'am.
10 and a half years. And what did you do before that?
U.S. Army. So 22 years in the military.
Okay. It sounds like you're very passionate about this subject, and you're currently a fellow at TPPF?
Yes, ma'am.
Okay. And you also recently were a guest speaker at a neo-Nazi conference where they were claiming there was a war on white America. That was in July?
No, ma'am, I did not speak. That was with the True Texas Project. I did not speak.
Were you scheduled to be a speaker
I was
at that
scheduled
conference?
until we found out what they were going to be talking about, and then there was a few of us that pulled out. Myself pulled out, as well as Todd Bensman and a few others. When we found out that the topics that were also going to be addressed, so I was going to be addressing the same thing here as border security. When we found out what was going to be discussed, I no longer spoke at that event.
So you
Always
signed
wanted
up to speak to that event, and their biggest topics were the Great Replacement Theory, and you're saying you didn't know.
No, ma'am. Well, I did not know the topic.
Okay, thank you.
Members, any other questions? Thank you, Mr.
I do. I just, as you were going through, and
Rep. Moody.
thank you. Sorry, I
Good.
appreciate that. I got to get used to being called on. I appreciate you going through that process. 'Cause I think it helps us kind of crystallize what it looks like going through there. In the murder example that you brought up, and there's an expedited deportation proceeding or whatever, at any point in there, is the prosecutor brought in? Like, can they put a halt on that? And they're like, I don't want this person deported. I want to move forward with the state charges. Like, has there become a tension between the feds and the state at that point? Or can there?
There can be, yes, sir. There, all the way from the ground, all the way up, we saw tension between Border Patrol agents, DPS troopers, local law enforcement, to the point of physical altercations based off of who is going to take custody of what. So all the way from the point of apprehending the person or the point of what the crime that they committed, all the way until whatever crime they've committed, they've been whether they've been found guilty or not, is a constant tension between state and federal, and that all has to do with the leadership. It all has to do with policies. If the current policy is that we have supremacy over all things related to immigration, we don't want state support, then when the state tries to get involved in that process, then there's lawsuits, and that's what we saw in the last 4 years. And unfortunately, that happens all the way down at the ground level, where you have it officer versus officer. Go ahead. Oh.
What? So going back to that question, so arrested state level charge, they're brought in. If they're going to get, if they're part of the system, they're going to have a detainer placed on them once they're at the county jail, right? And so can that deportation decision be made even if the state wants to move forward with prosecuting a high-level murder charge?
Yes, sir. The federal government at that time has preemption.
Thank you.
Rep. Bowers.
Thank you, Mr. Chairman, and thank you. Is it Amon?
Ammon, yes, ma'am.
Ammon Blair. Thank you. My question has to do with, and this may be a question for the author, and I know we don't have Chairman Smithy here. I guess I wanted to hear more about what you feel HJR 16, the definition of illegal alien. Is, looking at the Texas Pretrial Justice Coalition, it's saying that SJR 1 and HJR 16 define illegal alien broadly and in a manner that could potentially include naturalized citizens. And my father was an immigrant from St. George's, Grenada, and he received his citizenship as I was 2 years old. And so, part of my question has to deal with how can this affect individuals who might have been in the country legally. And so I need to hear what your interpretation of illegal alien is, because if people are over here legally, they would have the right to due process and could get caught up in a more broad definition of that.
Yes, ma'am. Thank you for the question. So my interpretation really is straight from the U.S. Code. And that is that, one, coming across the border is a crime. So we've designated under U.S. Code where you can come across the border at a specific time and place. And that's going to be at the port of entry at a time and place. Anything outside of that realm, you are then illegal. You're creating a crime. And it is codified also in U.S. Code, the term of foreign nationals that are coming into the United States as an alien. And therefore, anyone who is inadmissible based off of U.S. Code is an illegal alien. So my interpretation really is just straight language from U.S. Code.
So thank you. And I mean, you know, my father's situation was different, coming definitely across through a point of entry. He definitely came for his education. But my concern has always been saying that anyone coming across the border is automatically a criminal when they come across. I think that, you know, we are criminalizing people when we should be helping them. When they reach our borders, if they are coming over here to seek asylum or they're coming over here to find a better way of life, we should be figuring out a way to help them, not harm or hurt them. And it always takes me to the dehumanizing of those people. So automatically, to me, right off the bat, we're in the wrong if we say they're a criminal and start to criminalize them, to me, the first just coming across. And I'm not saying everybody is coming across for the right reasons, but what I am saying is it's almost like, what would Jesus do? That's the way I feel about it. And I want to say that what I do in this legislature, it is somewhat of a ministry to me. And I do believe that we have to figure out a way to receive people and help them to a better way of life. So thank you for your definition, and I appreciate your testimony. Thank you.
Thank you, ma'am.
Chair recognizes Representative Ana Maria Rodriguez Ramos.
Thank you, Mr. Chair. As we're talking about the term illegal alien, what this section does is it criminalizes, or it includes people, I guess, the definition's so broad that it also includes people who entered any time without inspection. So that could be those individuals who were, who obtained status through Reagan's amnesty plan. So somebody who in the 80s obtained status. And so as you're discussing and advocating for this bill, you understand, having worked 10 years in Border Patrol, that there are individuals who entered without status who are now are citizens, and they would fall under this provision.
No, ma'am. To be honest, if you wanted to make the provision even stronger, all you would have to do is just copy and paste straight from U.S. Code.
No, I'm asking you, under this provision, what it's saying is anybody who was admitted as who came as a non-immigrant at any time or place. So there are many U.S. citizens who entered that without status, who are now U.S. citizens. That's what this includes.
No, ma'am, because they're currently citizens now. So it includes those who have...
If you read the bill, it says those in this section means anyone who entered the United States without inspection or at any time or place other than designated by U.S. So there are people, you probably ran into some of these people in your work at Border. I know people who've come without status. They're victims of violence, and now they're legal residents. There are people who got married with U.S. citizens. I mean, Trump is deporting a lot of U.S. citizens now. So there are individuals who actually have status that may have entered. And so this bill says we're going to include all of those, lump everybody together, even though you're a U.S. citizen now.
Well, I'm not the writer of the bill, but no, in my interpretation of the bill, it only includes those who are currently not in status. So a current non-citizen, those that are currently still inadmissible, not that have gone through the process and become legal, whether that is also a LAPR. My mother is not a citizen. My mother is also an immigrant here from the UK. And so I understand that she's still going through that process of becoming a citizen right as we speak. So I understand where y'all are coming from, those who do have immigrant parents or those who are immigrants themselves. I do get it and I understand.
Well, and the difference is your mother's probably not racially profiled, while other people that fit what is the description. We know in SB 4 that was a very common theme in SB4 last cycle. People were being racially profiled. People are currently being racially profiled. And so the concern is that there are individuals who are now U.S. citizens, legal residents, like fit all the requirements necessary, and that this is so broad that it lumps everybody and denies all of these individuals bail who are also U.S. citizens at this time, but may have entered without status, but followed whatever pathway there was to obtain their status. So thank you, I appreciate it.
Thank you, ma'am.
Could that not be addressed?
Chair recognizes Representative Money.
I'm sorry.
No problem.
Excuse me. Could Ms. Rodriguez Ramos's issue be resolved? And this may be a question for the author and not for you, but by just saying in this section, illegal alien means a non-citizen who, and these things, or is person defined elsewhere? I'm not exactly sure, but certainly we're not intending to get citizens who entered without inspection.
Yeah, if we need to clarify that, we can, and we'll work with you.
Chair recognizes Representative Little.
Thank you, Mr. Chairman. I think the question of who is in the country illegally is really preempted by federal law. It's not controlled by Texas statute, or certainly not this joint resolution. Federal government decides who's properly in the country, to include the Immigration Act that Reagan signed in '87. So the definition, while the definition I think that's in the resolution is helpful, the people who are American citizens is purely a question of federal law. The resolution is helpful in that it deals with the question of how we treat them as a state once they are here illegally. But to Representative Rodriguez Ramos' point, I don't think Texas really gets to define by statute who is and is not a citizen.
Mr. Chair, if I may. No, you're absolutely right, but that doesn't mean it doesn't preclude, it doesn't stop it from doing it. So the state of Texas already does it with SB4. They're having these magistrates make that determination. Now, whether it's constitutional or right, it's not the point. The point is that they're actually doing it. So no, they don't get to decide, the federal law does, but what I'm saying is in this bill at any time, that's the concern that we have with this bill and that we've had with SB4. When you're talking about somebody who enters without status, they were undocumented at that time, but there may not be undocumented now. So the concern with this bill is there are people who do come in or who have come in without status, who were undocumented according to the federal and state, according to the federal law, because that is who decides, right? However, my concern is this bill says at any time. So if I came in without status in 1980 as a kid, but I got married with a U.S. citizen, now I'm a U.S. citizen. So then you're going to ask me for my information, where I was born, right? Okay, I'm saying Mexico. Well, did you come in with it? How did you get here? Well, I came without status, but that was when I was a kid at 8 years old. Okay, well, you still came at any time without status, and that's my concern. It's so broad that now I'm a citizen. I vote. I'm productive, whatever.
Yeah.
But yes, I did come out without status.
And Representative Rodriguez Ramos, I don't want to be dismissive of your concern, but what I'm envisioning is someone gets arrested for a violent felony. The state of Texas is going to ask the federal government, is this person a citizen? And the federal government's going to say, yes, they are, or no, they're not, and then, or are they properly in this country is probably the more specific question. The federal government goes, no, they're not supposed to be here, they're not on a green card, they're not a citizen of the United States of America, and Texas says, okay, no bail. But I think that process has to happen. Texas has to ask the United States government, is this person properly here? And I don't think that someone who's supposed to be in the country is going to be lost in the shuffle by virtue of how they got that status.
Well, we know right now there's U.S. citizens being deported, but no, I am not saying that that the federal government is not, I'm not saying that. What I'm saying is the at any time part of it. They came in without status at any time. That's the concern. I'm not saying if they're without status now, then 100% move forward. But the at any time part, if they came without status 20 years ago, but they have legal status now, or 40 years ago, that's the concern.
Let's
They
move
have
forward.
status
We
now.
still have a witness up here. I mean, I think he made a good point earlier. We just said, and I think that's the point Representative Little is making, which is there is a definition. So, and
Let me
Chairman
clear-
Smithy has already made it clear he's willing to work with everybody, and we can do that offline. We've got over 50 witnesses, I believe, that we still have to go tonight. So let's move forward. Any other questions for Ammon Blair? Yes,
Well,
make
So
the-
Hammond, isn't it really a right to stay here? And if you're arrested for a felony here, or if you're picked up somewhere else, it's going to come down to ICE agents saying, ICE ERO is going to determine whether or not you've had a right to stay here. Those are the people being deported today. Those are the people that have been deported for a long time. And to Chairman Moody's question earlier, I have never seen a prosecuted office here in the state of Texas that has released someone to federal custody. If they have a murder charge, then they keep that person and they try that case there or come to a final determination on that case, and then they're released to the federal government.
Yes, to that point, even in the 287G program, whether that's a local law enforcement DPS trooper on the road wanting to determine alienage, whether that is in the jail system or whatnot, everything is all federally led to determine the citizenship. Whether you're part of the 287G program, whether that's task force model, the jail model, or any model, you are led by the SAC or the ICE, I can't think of the name right now. The ICE supervisor over that area. So it's not like your local law enforcement, your state agencies are going out there rogue. They're actually being led under this task force model by the federal government. The systems that the state agencies are utilizing are all federal systems. So everything is still federally guided. And to Representative Little's point, in that, yes, preemption and exclusion, the states do not determine who is or is not inadmissible. That is the naturalization process. The federal government has proudly proclaimed, not just through the Constitution, but also through jurisprudence, that they do have exclusive authority over that, over the inadmissibility. And in that point, Representative Ramos, in terms of any time or place, maybe the author of that or whatnot, because in current U.S. Code, it states that they have to be at a time or place. And so maybe they thought, I'm not the one who wrote it, but they're like, oh, in order to be illegal alien, it has to be any other place or time other than that designated spot by the federal government. And so maybe added clarification could assist in that bill, ma'am. But yes, thank you.
Thank you, Mr. Blair. Appreciate your testimony. Next we'll call Andrew Hendrickson. Mr. Hendrickson, we show you are with the ACLU of Texas and that you're against HJR 16. Is that correct?
That's correct.
All right. You may proceed.
Thank you, Mr. Chairman, members of the committee. I just wanted to raise a few constitutional concerns with the automatic denial of bail in this situation. I want to make one thing really clear from the start. There is a completely different line of cases when we are talking about a immigration removal proceeding and the denial of bail in that circumstance and a state criminal proceeding. Big differences there are that deportation is not a criminal proceeding, and therefore the case law is entirely different about whether you can hold someone pre-trial or not. It's not on a presumption of innocence. That's not the basis in an immigration hold. And so, when we're looking at removal and when bail is for a criminal charge, there are constitutional law issues that are under the 14th Amendment that are problematic here because you're treating folks differently based on their national origin in violation of the 14th Amendment's Equal Protection Clause. Someone in a bail proceeding because of their national origin is going to be treated differently under this bill than they would be if they were a U.S. citizen. And just by virtue of being present in the country, they are entitled to 14th Amendment protections. More importantly, I think, is the due process concerns. This is not a narrowly tailored automatic denial of bail. Flight risk and danger to the community have all been recognized as reasons to hold someone pretrial with and deny bail. But simply looking at someone's immigration status is not a proper determination of whether they're a flight risk or not. Someone who just arrived in this country recently, has many ties to their country of origin, is back and forth a lot, versus somebody who's been here for 20 years and has, 3 kids in local public schools, a job that they've held down for a long period of time. These are the kind of individual determinations that judges should be looking at when making bail determinations. Those individualized determinations where you look at the whole scope of factors are what is really required when we talk about keeping someone in custody who has a presumption of innocence. I also would mention that I think there's a coercive element to having an automatic denial of bail and setting it at a felony. If you are trying to get someone to plead to a lesser charge as a prosecutor, one way to get that done, if this bill were to pass, is to charge the felony and have the person understand that they have no chance of being released pre-trial because of the felony charge. But if they plead to a misdemeanor, well, then they might be released. On top of that, I think, I would just end with the mentioning the Salerno case. In our society, that's quoting the Supreme Court, liberty is the norm, detention prior to trial is a carefully limited exception. This is not a carefully limited exception. A single factor should not be the basis of deciding that someone is automatically denied bail.
Thank you for your testimony, Mr. Henderson. Can you confirm that you are Andrew Hendrickson?
Yes.
Okay, thank you. Members, any questions for Mr. Little?
Mr. Hendrickson, you're reported to be working with the ACLU of Texas, is that right?
That's correct.
Do you do so on a volunteer basis?
No.
Are you an attorney?
Yes.
Okay. If this House Joint Resolution 16, if it passes and it goes to the voters and the voters vote in favor of it, it becomes law in the state of Texas, the ACLU going to challenge it in court?
I can't comment on any future pending litigation. I do not work in our litigation department. That's not up to me. And also, we would have to see through the process how it passes. Things change.
You are registered on behalf of ACLU, not here on your own behalf.
No, but I am not in charge of making litigation decisions for the organization. I work in our policy and advocacy department, despite the fact that I am a lawyer. I am not involved in the decision whether or not to bring litigation.
I just really have a simple question for you. Do you think that the 2 Venezuelan nationals who raped and killed Ms. Nungare's daughter should enjoy the same protections of the United States Constitution as her daughter does?
Yes. Every single person who is present in the country is subject to the protections of the Constitution. Those constitutional rights wouldn't mean a whole lot in the 8th Amendment if they didn't apply to folks who committed crimes. Due process only applies if you are in a criminal proceeding. Simply because you have done something wrong, and I am not suggesting that that is not a horrific crime, but that does not mean that you are not subject to our system of laws and the constitutional protections that apply to all Americans and all folks who are present in this country under the 14th Amendment. And it is very clear in the 14th Amendment, it is based on whether you are present in the country, enjoy the protections of the Constitution. That is not always a popular thing. We've
It's extremely unpopular, is it not?
It is extremely unpopular, as was defending the KKK's right to free speech. When we did that, we will defend all sorts of unpopular opinions. But the point being, we have defended all sorts of...
Mr. Little's got the floor.
Absolutely.
Yeah. What does the A stand for in the ACLU?
American.
Why?
Because we defend the United States Constitution.
Is it the official position of the ACLU of Texas that the 2 Venezuelan nationals who murdered Jocelyn Nungare should enjoy the same constitutional protections as she did? Is that the official position of the organization?
I think that would depend on the constitutional protection, but when it comes to due process and the rule of law and the prosecution of criminal cases, yes, I think that those protections definitely apply.
Thank you.
Remember, any other questions for Mr. Hendrickson? Mr. Money?
What other constitutional rights should illegal aliens have in the United States equal with citizens?
I think that's a broad and wide open question. I think a lot of constitutional rights apply. I would be.
What about the right to vote?
No.
Why not?
Because that right is not extended. Well, first of all, the right to vote is actually not enshrined in the Constitution. It's not necessarily as explicitly stated as that, as it is in the 14th Amendment, where it is explicitly stated that the right to vote is, or that the right to due process is based on presence in the United States. I think really this depends on the context here and what the actual words are. I mean, you know, I think a lot of the conservatives on this panel would identify as strict constructionists, or long have identified as strict constructionists, and the word presence is very clear in the 14th Amendment.
Okay, this is narrowly tailored, though, is it not? It's not saying that we will detain anyone that is found to be. It's only someone who is accused of committing a felony, not even a misdemeanor, but accused of committing a felony. Is that not narrowly detained to protect an interest that the United States has in protecting the life, liberty, and property of its own citizens, like Ms. Nungare's daughter, in order to continue to give due process to the accused? That accused will still have a trial in front of a jury of American peers. It will go through all of the due process, but we're only saying we're not going to give you the right to be to live free until that due process is completed, because number one, you don't even have a right to be here, and number two, while you were here, you have been accused of committing a felony in addition to, to get past Ms. Bauer's point, this is not about whether or not it was criminal activity coming in to the United States. We're saying we're not even dealing with that. We're not even dealing with that. We're dealing with a further crime after you're already here uninvited.
I think the key here is what I said at the beginning, which is that this is a criminal state court, not a federal immigration court. The person is not being held because of their immigration status. They're not being afforded different rights because of their immigration status. That is a factor that is leading to the denial of bail in their criminal case. As Representative Moody pointed out, if, especially under the Lake and Riley Act, which was recently passed at the federal level, if they were to be released, they would be put into federal custody. That would be related to the immigration status. The court that we're talking about here is holding them based on the idea, and as it was laid out in the Senate, and as this proposal laid out in the Senate, and as it's been discussed a lot, the idea here is that there's something inherent about them being a flight risk in this status, because that is one of the things that is permissible. I would suggest that simply looking at immigration status is not enough of a narrowly tailored provision to assess whether someone or not is a legitimate flight risk, or without looking at the individualized circumstances of their case. Now, that, without commenting on any of the constitutionality of the Lake and Riley Act or any other federal law, because that's not what we're discussing here, but if they were being held under federal custody, under an ICE detainer, that would be related to their immigration status. But this is about a denial of bail where the only charge they're being held on is not a charge related to whether or not they entered the country illegally. That's just about a denial of bail. But what they're being detained for is exclusively the crime for which they were charged. And so in this instance, what you're doing is, what I believe this HJR does, is it takes a single factor and it makes a determination about whether to hold you on those criminal charges, not hold you based on your immigration status or not. That can happen at the federal level. That can happen via an ICE detainer. That is possible, but it is not the same to say that because that would amount to punishing someone or imposing a criminal punishment at the state level based on someone's immigration status. That's not what they're charged with.
So I want to make sure I'm getting this clear, and I might not be. Do the people of the state of Texas have a right to change their constitution to just say generally classes of crimes we are or are not going to give bail? Do we have the right to do that?
Personally, I believe our position would be that regardless of the crime, and I would argue that regardless of the crime, we should always be looking at the individualized circumstances. There are instances where perhaps we might find that factor, the heinousness of the crime, but again, along with the
But could we just say
probability the
capital
probability
crimes?
that
Could we
they-
just say capital crimes? Do we have the constitutional right to say capital crimes, we're going to deny bail?
Well, I would argue that you would still have to look at the strength of the evidence.
I'm
in the
not
case
saying what
and-
you want. I'm not saying what the position of the ACLU is. I'm saying, do the people of Texas have a right to say we're going to deny bail in these circumstances?
As it relates to the crime in this instance, I would say that possibly. But I would say that in this instance, what is radically different here is that everyone charged with that crime, regardless of some characteristic unrelated to the crime, like their immigration status, would be treated the same. In this case, you would have an equal protection problem because two people charged with the same crime are being treated differently in a bail determination based on a single factor, which is related to their national origin.
No, because not their national origin. Not their national origin. Their citizenship status. You can have a national origin in Mexico, Japan, Iran. We all know people who are that and who are U.S. citizens. They have come here through a legal process. They have gone through a arduous legal process. They have taken a citizenship test. They have sworn an oath. People who have come here illegally have not done any of those things. They are here. In some cases, we don't even know who they are, why they're here, whatever, and we encounter them in law enforcement. Who are you? And you're saying this person, they could be an enemy combatant that came here just to do harm. We intercept them burglarizing a car, and we say, whoa, you're not here legally. They have the same legal rights as you and I do? The same due process rights?
In state criminal court, yes. But if that person were to then be released, particularly under the Lake and Riley Act, they would then be picked up by ICE under an ICE detainer. That ICE detainer would proceed to give them rights.
We're not here to talk about...
But the point here being that the federal government may have the right to hold someone on an immigration hold like that. That is not the same as holding someone under a state criminal charge and denying them bail where they're not being held because of their immigration status based on the single factor of their immigration
And
status.
some of us up here have lived through 12 of the last 16 years where the federal government was completely disregarding of our immigration laws. And we want to make sure that Texas has laws that will protect Texas citizens regardless of who's in the White House, regardless of a Lincoln-Riley Act. That's great if that's there. But we have Texans to protect here, and Texans have a right to amend their constitution and say, when someone is here illegally and they commit, allegedly, a felony, while we wait and give them due process, they are not allowed to leave. We see that as a flight risk. They have already demonstrated their willingness to break the law and go somewhere where they are not allowed to go. And so I'm belaboring the point, but I disagree with your position, as you may have discerned.
Plenty of people do.
All right, thank you.
Thank you, Mr.
Chairman.
Money. Chair recognizes Representative Rodriguez Ramos.
Thank you, and thank you, Mr. Hendrickson. You mentioned that they'll be, if they're detained by ICE, and they'll be looked at, evaluated by an immigration attorney, by an immigration judge. What level, what's the difference between an immigration judge and a state judge? somebody that
First of all,
operates in Texas?
they're federal judges. It is a completely separate system, and it is a civil law system. It is not a criminal system. Again, this is not. We do not treat the deportation and removal process as a criminal law process. It is a civil proceeding. It's part of why the rules about it are entirely different when it comes to the Supreme Court jurisprudence. So the other thing is, I find this to be one of the many bills, like SB4 was, like some of the proposals we've seen recently about elections and proving citizenship status there. We were asking all sorts of local local officials to make complex alienage determinations. That is often the first and quite long part of a federal immigration case, is to work out the alienage status of the person. That's not as easy as it sometimes is made out to be, that someone can just, figure out right away what someone's legal status is. It is part of the process. There is specialized, complex training that goes into that. And so I would say that when we are looking at the appropriateness of removal, when we're looking at deportation, it is, and the other thing with also the timeframes here is that part of the idea here is with bail, which is mentioned in the 8th Amendment and the due process issues under the 14th Amendment, is that Congress has plenary power over immigration. That means that their determinations regarding immigration policy, they have broad, the Supreme Court has long recognized that they have broad authority when it comes to setting immigration policy. That doesn't apply to a state level judge. They don't have that authorization granted by Congress based on the plenary power of the federal government to deal with this issue. And getting to the point of, I would harken back to Senator Birdwell's comments on SB4 when he was the lone Republican who voted against it.
We need to stay on this bill.
Absolutely.
So, so what with the federal judges, you mentioned training, extensive training, and I recall in previous discussions. Are you aware of any additional training, or because you just mentioned it's not that easy to determine somebody's status, to see whether they're here with or without status. It's not something. It's not, you can just not make. It's not just making a phone call. They're through many processes, so they could be have some kind of waiver going on right now where they're waiting to hear from some final determination. So they're technically in a holding position where they're not necessarily. They may be here without status, but they're waiting to hear a final determination, so it's a full immigration process, correct? And so those judges, those federal judges, are the ones who are making those determinations through that process. And I assume they have lots of training to do that and to identify where they're at in the process, the individual.
Correct. Training, experience, they have worked within that system longer than, a state judge, and also tend to work pretty exclusively within that system. State judge who deals with criminal law cases is not going to be making an alienage determination in the majority of the cases that they hear. And certainly not when we're talking about the bail setting process and looking at magistration, where oftentimes bail is being set by someone not represent. Well, first of all, the defendant might not be represented by counsel, and the person who's actually setting bail might be just the piece who doesn't even have a law degree. These determinations being made without anyone in the room being present who is an attorney.
So it's your understanding we're asking for the local magistrates to make those determinations, that federal judges have extensive training, extensive expertise within the space. Now we're giving it to a local magistrate. So it's like saying, I've gone to court in different spaces where the judge is like, I don't do criminal, I just do civil. I mean, some of us up here are struggling. We don't do criminal, we do civil. So I imagine it would be a very difficult and huge room for errors for a local judge who doesn't work in this space, is not an expert, to make those determinations, and then the snowball effect of the rights that are being violated because they're not experts in those spaces would be a huge challenge.
That's correct, and I think there's also probably a pretty substantial possibility of error.
Right. Thank you, sir.
All right, thank you, Mr. Hendrickson. We appreciate your testimony. Chair, next call is April Aguirre, and next is Selena Bray. You'll be next. April, we show you as registered as April Aguirre,
Yes.
Aguirre. Aguirre, and you're representing yourself, and you're testifying in support of the bill. Is that correct?
4.
I'm sorry?
4?
Yeah.
Yes.
Please proceed.
Okay, so I became a crime victim advocate after my niece, Arlene Alvarez, was murdered. We have a soft spot for children. We can't focus on all types of murders because there's just too many in our county, but we like to help the families of murdered children. I came across Mr. Gonzalez, a migrant father who only spoke Spanish, and his daughter was murdered in their own home. She was 11 years old. She was also a migrant child who was very excited to start her American dream. She was about to start school in just a week before she was murdered in her own apartment. Her father is exactly the type of migrant that we want in this country, hardworking, law-abiding, and he went to work that morning. A neighbor who had only been in this country 3 weeks learned the father's schedule. He watched them leave that morning, and he had a plan to attack that little girl. He knocked on her door. She knew him from living in the apartment complex and seeing him. It was a neighbor knocking. She didn't hesitate to open that door, and he pushed his way into that apartment. He closed the door behind him, and Maria fought for her life. For hours, we know that he was in that apartment based on camera footage. That apartment looked like it had been ransacked by 10 people. I helped Mr. Gonzalez clean up and move out of that apartment and gather Maria's things. There was glass, pillows, furniture, everything was a mess. It looked as if so many people had gone in there and just ransacked it, but it was Maria fighting for her life. He tried to get rid of the body and put her in a plastic bag. When he was somehow spooked for some reason, he put her body under the bed of Mr. Gonzalez. Mr. Gonzalez came back from work when he couldn't reach his daughter from work, and he came home early. They looked for her and they called the police, and the police and him found her under the bed, deceased. She was bruised so badly that we had to find her a communion dress that covered her neck from all the bruising to her body. It's just a reminder that it's not just citizens that are being harmed by bad people, and bad people can be citizens or migrants, but this individual was only here 3 weeks. After he did this to Maria, he fled to Louisiana within those couple of days. So my point is that it is important that we don't hold illegal immigrants to the same standard that we would hold a citizen to, just because they don't have the community ties to ensure that they return back to court. And on top of that, if we were to try to put capital murder, they have to prove that there was a sexual assault committed, not just by assumption, but by either a medical examiner's report or by DNA evidence that could take up to a year with the backlogs in our country that are happening right now here in the state of Texas. So it is important that we are able to hold these individuals before they flee. If he was able to be here 3 weeks and kill a little girl that was also Guatemalan just like him, he has no sympathy, not even for his own people. And it's just frustrating to me that we want to sit here and defend our people, my people. We came here to avoid the way our state is, the way Mexico is. We left Mexico for a reason. People flee here and they migrate here for a better life. Why? Because there's no criminal justice process in our countries. So if we're going to treat everybody the same, then we're just replicating the same places where we came from. And we came here to the United States because we want law and order. And even Mr. Gonzalez was a migrant himself. It was difficult for me to explain to him that this guy was still entitled to a bond. He just couldn't believe it, but it's true. You torture, you strangle an 11-year-old little girl, a Guatemalan little girl, which Guatemalan people are very small. So even for an 11-year-old, she was so tiny. To me, she looked like my 8-year-old. I just want to remind everybody that this is not a race issue. It's a bad people issue that have the ability and have proven that they're willing to cross borders to leave. And on a fun fact about the murderer of Maria Gonzalez, when he left, the murders of little girls stopped in his town. So we all suspect that this wasn't the first time that he had struck. You don't just become a murderer overnight. So let's get back to what this bill is about. It's about giving Texans
We got like 60 more people, so if you can wrap it up. Yeah,
let's give Texans the ability to choose. Do we want this? Do we not?
We do.
When we wrote our Constitution, this was not a problem. It's a problem today. We have people coming here into this country and committing heinous acts. Thank you.
Thank you for your testimony. Member, any questions? All right, thank you so much. Next, yeah, thank you. Selena Bray, we have you testifying on behalf of Pure Justice and on behalf of yourself, and you're against HJR 16. Is that correct?
Yes, and I would like to let the record show that it will be Pure Justice Action Fund that I am representing as a policy organizer, if that may be corrected.
So, but are you also representing yourself as well?
Yes.
Okay, you may proceed.
Thank you. So I am here today to oppose HJR 16 on both principled and pragmatic reasons. First, as it pertains to principle, as Mr. Henriksen said, pretrial detention should not be our default by default. It shouldn't be an instinctive gut-wrench reaction to detain people and lock up the key without doing the proper due diligence to make sure that, one, as Representative Bowers was talking in relation to the definition of an illegal alien, one, that we have the right to detain them in that way, but two, why would we make our default option purposefully worse, more restrictive? Is it really the best way to ensure and promote public safety and address the tension and legitimate conflict in our changing communities? I agree that the crimes that we have heard testimony about are horrific and should never have happened. I also acknowledge that there are tensions within our communities all across Texas, and I don't know that detaining people and in furthering mass incarceration is the way to ultimately bridge that divide. Ultimately, for principled reasons, this would erode our fundamental national and Texan values of liberty, truth, and continued opportunity for all. As it pertains to the practical reasons, again, I point to the instance of blanket criminality that we're putting upon people who would meet this jurisdiction. But I also ask what sort of accountability or safeguards would be in place. As Mr. Henriksen from the ACLU elaborated, this would be taking place in a state criminal court that is fundamentally different than a federal immigration court, not only with the judge's expertise, but also the resources and the information and the synergy between systems that we have available. I want to point out that there was an instance, I think within the past 2 weeks, of a 10-year-old girl being deported from Houston. Obviously, this is a different situation. She was coming to seek medical care, and her parents, I believe, were undocumented, and the entire family unit, the household, was deported back to Mexico. And obviously, I'm not trying to say that this is a guaranteed instance with this legislation, but I am concerned about the synergy of information and the working between government groups to be able to make sure that there is no miscarriage of injustice or that injustice does permeate as well. I also want to just ask about the overcrowding concerns. From the smallest counties in Texas to the largest counties in Texas, Representative Lauterbach, you helpfully pointed out earlier that 80% of the state is indeed in a rural area. I come from and grew up in a rural area myself, and so I'm very sympathetic and empathetic to the resource crush concerns, the staffing concerns, the manpower concerns that we have from all corners of the state. Thinking about a larger area, Harris County, as we've talked about today, the Harris County Jail is extremely overcrowded, and we're currently outsourcing people to other areas like Louisiana and Mississippi. I'm hesitant and scared to see what will happen to other areas with less resources that are already overburdened. And I also point to the increased costs that we would see as a result of having to mass incarcerate so many more people. And I ask that the value of our dollar is changing every day, and our fiduciary concerns are changing every day from the local, state, and federal level. And I ask, is this an investment that we're willing to make, this uphill battle with these legal costs and potentially hurting people who are here legally? Is this what we're willing to do? And is this the best way to ensure that we have community safety across Texas? Thank you.
Thank you for your testimony, Ms. Bray. And I did want to just clarify, you said that you registered as Pure Justice, but it's actually Pure Justice Action, and we
Yes,
have your
sir.
permission to update the record?
Please.
Okay, thank you. Member, any questions? All right, thank you for being here. Next is April Ageti. Did they already testified? Yeah, she testified. And then Virginia Raymond. Is Virginia Raymond here? All right, next one is Jennifer Tharp. Ms. Tharp, we show you registered as the Comal County Criminal District Attorney, and that you'll be testifying on behalf of that office and on behalf of yourself in favor or for HJR 16. Is that correct?
Yes, sir. Thank
All right,
you.
you may proceed.
And for the record, my name is Jennifer Tharp. I'm the elected criminal district attorney for Comal County, and I'm testifying in support of HJR 16. October 24th, 2020, at about 10:30 p.m., Sacramento de Jesus Martinez began his night of devastation and violence that encompassed 3 cities, left multiple people injured, 2 people dead, and 3 children effectively orphaned. Fueled by jealousy, rage, cocaine, and alcohol, Martinez was losing control of his estranged wife, Marisol, age 33, who had attempted to end their relationship due to domestic violence. You've heard a lot of testimony tonight. I'm not going to belabor the point. But she had just gotten away. And that's what upset him. That's what set him off this night. She got her own apartment, she got a protective order, and she got her 3 children into what she thought was safe housing. She got a protective order because he had previously strangled her, raped her, assaulted her, and threatened to shoot her with a taser. This happened in this town. When he was arrested by APD, ICE was not notified, therefore no detainer was put in place. He was bonded out and was on bond the night of August 24th, and she had a protective order in place, supposedly to protect her and their children. I don't have enough time to go through all the facts of this particular case, but just know that she was taken from her apartment, in which the 3 children were there, while they were asleep. When their teenage daughter woke up to look for their mom because she had heard some sort of weird noise and couldn't find her mom, she called her mom's cell phone numerous times because she just knew something was wrong. And she wasn't wrong. She called her dad's cell phone because she was nervous too. And about 1 o'clock in the morning, phone records indicated, and we were able to prove this in the capital murder case that my office tried, that her father did answer the phone. And that teenage girl's last memory of her mom was hearing her mom crying in the background. That was right before he murdered her. After murdering Marisol in this town, he then went to 2 different locations in Austin. One, he shot his drug dealer in the face because he thought he was sold bad cocaine, and the other one he shot at a group of individuals in this town. He then left Austin, headed south towards San Antonio where his sister lives, with Marisol deceased in the front of the vehicle. His car had trouble. It broke down in my county, in my town, New Braunfels, went to the nearest truck stop, and approached an 18-wheeler truck who had just arrived, a man by the name of Daniel Seeger, age 45, first night on the job as a truck driver. Went right up to the front right to the front driver door, shot him 4 times, shoved him over, jumped in the 18-wheeler car, went on a reckless spree. Wrecked that out. Ultimately, he was captured. You had great questions. Thank you for the questions as to how that interacts with prosecutors. We filed capital murder charges. We had no issues with him being deported. They allowed us to try our case before we were successful. He's now serving life without the possibility of parole for capital murder. But I've tried plenty of these cases for felony offenses. We try our case. Once they serve out their time in TDCJ, then ICE is notified and they're deported. It is, quite frankly, a fairly seamless process. The only time I've had someone that was on state charges taken out of our jail was when there are also federal charges that are more serious and more violent. And yes, there's some understanding from a state prosecutor's standpoint on that, but we work with that. That's not really a particular issue. I don't have time, but I will, for those of you who had questions about the constitutionality aspect, I have a whole bunch of case law that talks about the ability to have that amended.
I want to start with Speaker Moody, and then we'll go to Representative Little.
Thank you. Ms. Tharp, thank you. I appreciate you kind of leaning into the functional parts of things. And it's good that there's this cooperation there. And there certainly should be. If the prosecutor decides that this is something that's important, needs to be tried in their community, you do want to be able to hold on to those. And that's what I just didn't know how that tension resolved itself. So the way that this is written, right, it's all felonies.
Sure.
It's all felonies.
And I can appreciate some concern as to that aspect.
So that's what I want to drill down onto, because the situations you are talking about, I cannot speak for other members of this committee. I understand why we would want to make this change. We've only gone back into the Constitution 3 different times to give permissive authority to judges to deny bail. Right? We've done that 3 different times. In the original Constitution, that we covered capital offenses. And even then, you had to prove up something to deny bail. The reason this one is different, and that's why I'm wondering about the legal construct, is it is shall This is not permissive. This is not a judge making a decision. This is a judge essentially just doing it. In the cases that you've talked about, I think everybody can understand that if given those, if given the opportunity to deny bail to someone, I think that judges would certainly take that path. State jail felonies, bulk majority of those are possession under Graham. This bill, as I read it, this resolution, if passed and adopted by the voters, I'll be technical, would mandate a denial of bail in possession under a gram of cocaine. And my question is, if you as a prosecutor, you're looking at what, 2 years maximum you can hold them for, right? Could someone, I mean, look, people left their country for a reason, I guess, and they can say, I want my trial. I want my trial. And they can sit out on our dime for less than a gram of cocaine, 2 years in our county jail. They can ask for investigators, they can ask for independent testing of the drugs, they get all those things that they would be able to do as their case proceeds to trial, and they clock out 2 years, and then they're handed over to the feds for deportation. The way I read this, I don't think that and this is where I want to drill down into, and I'm not talking about violent felonies. I think I want to separate those out because we are grabbing a lot more than that. I want to talk about the bulk majority of these are going to be these drug crimes in the state jail world, and maybe enhanced theft and some others, right? That's the majority that we're talking about. Will you have the discretion here to say, we want to release to federal custody, we don't want to prosecute this if it's mandated that no bail can be given in those cases?
Yes, sir.
How do you functionally?
You reject charges.
So then you wouldn't have a charge sitting. So that's the option. Okay, that's what I want to drill down into.
So
the option you're given is, I don't want any state charges pending in this county. I'm going to just decline it, let them go to federal custody and be deported.
A prosecutor could absolutely reject charges, file a non-prosecution affidavit, and understand too, when a non-prosecution affidavit is filed, depending on the language within it, if it's still within the statute of limitations and that prosecutor decides at a later point in time, let's say there's additional evidence, let's say there's a lab result back now from DPS, that prosecutor could at a later date then choose to file charges, i.e. indict on that felony, because we would be required to do an indictment for a felony.
But, and I guess my question is, you can land back at that point later, but if you've got the charge and you can release to federal custody and the charge is pending and active, they get deported, they come back, case is still alive, it's already there, it's already in the system. What functionally would be wrong with permitting the prosecutor to take that path rather than decline, they get deported, they come back, now we can charge them, now we can do all these other things. I get that you can land at the same place, but why wouldn't we want to give the prosecutor the discretion to do either in those low-level offenses rather than have people game out the system sitting 2 years in the jail, in the county jail, and you're going to have hundreds of these people.
Sure.
Thousands.
We can sit here and talk all night with different hypotheticals because I will tell you, I've seen what you're discussing, and then I've seen obviously the complete opposite and extreme. With regards to whether or not there's opportunity to kind of drill down on HJR 16 and being very thoughtful on the application, that comes down to the author's standpoint on that. I think you've already heard in the original layout, there's opportunity for some tweaks to it. And I will just tell you, for all practical purposes, there's a difference in my testimony on the case that I just talked about, or an ag assault, or a murder. I mean, I can give you case after case where I've had individuals here not legally. And what I will tell you is individuals charged with a felony and that are also here illegally are very often flight risk.
No, and it's something that's considered. It's
everything that you talked about, understand too, I've got a case on my trial docket where that individual committed the offense close to 10 years ago. We filed the cases. They were granted a bond, and they have been MIA. And when you talk about justice for the victim, because I think we can all agree, I mean, the scales of justice are two-sided, right? There's the defendant's rights, and then there's the community's, law enforcement, and victims.
Safety, yes.
And when you look at both sides of the equation, there's got to be some balance and some common sense application. And so understand, too, that individuals that are not here legally that make bond are really hard to bring back to court. Now, your low-level nonviolent offenses, sure, those may be easier, but that's not always the situation. And so I can appreciate some tweaking of the language to make sure that there is potentially discretion. I've filed 11A, 11B, and 11C no bonds, and I've been successful on getting no bonds on particular cases. It is an affirmative action that we do. We file motions for that typically. And HDR does spell out and require a hearing. It says shall, but it's after a hearing where the judge decides that it meets that particular standard.
Yeah, and in this one, we have what, probable cause?
This one is probable cause,
So
which
I know
is
we're not
different from
talking
the other ones.
there. So that's what I'm saying. So this is the functional stuff.
I'm
that
not the drafter,
No,
but
I
I
know,
do
I know.
see a lot of value with HJR 16 in protecting this state, not only the citizens, but also individuals that are here.
No, and I want you to not misinterpret what I'm asking as a pushback on this JR as a concept. I'm trying to drill down into the finer points of some offenses that I don't think we would, in our mind, when we're hearing the tragedies that we've heard about, there are a number of other things that don't fit into that category. So I think that's kind of the conversation. And having you here, I think, is extremely helpful. So I know you've been sitting here all day and waiting, so I don't want to take too much of
May
your
I
time.
add one aspect is in being thoughtful and how any of HJR 16 is adjusted. What I will tell you, because I have done cases with an under 11A no bond, and the thing that you need to realize is when a prosecutor files a motion,
Those are multiple.
it's typically for
multiple
multiple felonies. And if the prosecutor goes for no bond and under Article 1, 11A of the Constitution, I have to have them arrested and I have to have a hearing within, I believe it's 7 days from the date of their arrest. It is incredibly difficult to get that hearing set, and I have to call witnesses to meet a standard that is higher than what is in this. And I will tell you, 11A is very rarely used because most prosecutors don't have the case within that time period. Additionally, if I file for an 11A, I have to be ready for jury trial in 60 days. And I'm telling you, it is very rare that I have any cases. So I have done it, but it is an extreme measure, and it's all hands on deck from law enforcement and prosecution, and I have to have a court cooperative to give me those hearing dates. 11A of our Constitution is helpful, but not in a world where, as I believe you talked about earlier, we have body cams, we have DNA, we have forensics. I don't get any of that evidence within that time period. So 11A is not a fix, and maybe there's some opportunity and some additional language with a committee sub on this.
Yeah, and as I said, those are dealing with, you've got multiple felonies. Oh, it's got different.
But in terms of
different
the
ways to get
process
there.
and procedure, there's
And
got to
so-
be balance.
And I think the way that we've always built this over time, right? Because the default setting is if you're going to deny, right? Because we have bail, we have the right to bail enshrined in the Constitution. So if you're going to, and these are some of the constitutional law questions that we get into, if you're going to go down that route, it's why you have a fairly spelled out process, because you are now moving into a space where otherwise someone would have had a constitutional right, and you are taking that back to give an opportunity to a judge to say, no, not in this case. So under HJR 16, we are saying that in a fairly broad array of cases, and I think I'm to a point of comfort with a multitude of those, but I think there's some that we probably need to drill down into to understand that there is some discretion that needs to be maintained at the prosecutorial level with some of these lower level offenses. That's really my main concern. And having you here, you've always been so giving of your time and your expertise, and I can't thank you enough for kind of putting some of the legal structure around how this works for the committee. Thank you.
Representative Little.
Thank you, Chairman. District Attorney Tharp, thank you for waiting so patiently. I've really a two-part question. One, I know you've been sitting here a long time. You've heard some of the testimony and the questions from the committee, there has been a suggestion that the question of whether an individual properly belongs in this country is very nuanced and subject to intensive training about how to determine whether this person should be in the United States or not. So in a ground truth reality for you as a DA, how do you find out whether somebody's supposed to be in the United States or not?
It's really simple. They're flagged in our system because our sheriff's office has already reached out to ICE. ICE has already put a detainer. I have paperwork that's showing from the federal government that they're not here legally, and they've already placed their hold on them.
Okay.
It's very simple.
Second question. Okay. You presented a very bleak situation when you started your testimony. Very violent case committed by an illegal immigrant. Something kind of caught my ear when you were speaking. You said he was arrested in Austin, correct? And then he was released because no one at the DA's office called ICE. Is that right?
Not DA, the sheriff's.
No one at the
Law
sheriff's office?
enforcement. And there are certain, and Representative Lauterbach probably knows more about this than I do. Our sheriff's office, we notify the ICE anytime we have anyone within our custody. We are not trying to skirt any federal law in any regard. But there are other jails where that cooperation, that communication is not in place.
So let me ask the obvious question. What is to simply keep the Travis County Sheriff or any other urban county sheriff or rural county sheriff from saying, you know what, I'm just not going to ask? Then I don't have to know. What do we do about that? What do we do about that? I ask sincerely.
Yeah, I was going to say, I do believe there's some provisions out there. I think there is more of an effort from top administration in the federal government to looking at that aspect and making sure that states, cities, mayors, governors are in full cooperation with the federal government and the laws that are out there in place. It is a problem. Monty Soul and Daniel Seeger should still be alive.
Well, in a perfect world, what would have happened is Travis County Sheriff would have called ICE and found out this person's on a detainer, they cannot leave, correct?
Even if the DA's office in Travis County, and I'm not making any comment on whether they would have prosecuted her case that happened in this community, but at a minimum, if ICE was notified, he would have been deported.
Okay. Thank you for your explanation.
I'm simplifying the
I'll
process.
yield my time to Representative Lauterbach. I think he has some things he wants to say.
Real quick, D.A. Tharp, appreciate your testimony, but in your horrific example, in the crime that was committed there, a person fled to Austin and was arrested there. And so for the purpose of the committee, the Secure Communities Act would be intact, but that does not mean that the fingerprints were not there and transmitted back to the sheriff's office before the bond was set, before a person was allowed to get out. But in this particular case, if this was to pass, this is a great example of how this could become very, very effective. Because if any one person would have noticed, and one of the things said, I think we need to check the immigration status of this. They could have called. There's ICE ERO here in Austin, based out of San Antonio, but they're here. They have an ICE contingent here. They're very close to the jail, and they could have come and checked status, prohibiting, and then they could have immediately prohibited that release on bond. Correct?
Yes, sir. In my fact scenario, I would not have been able to, from that first incident, go for a no bond hearing on Martinez had I been in Travis County. It does not meet in 11A, 11B, or 11C of the Constitution.
And that's how HCR could really help us.
Yes, sir.
Thank you.
Any other questions for DA Tharp? Thank you for your testimony. Okay. Next, we'll call Daniel Woodward. Not here. Next is Crystal Gomez. Ms. Gomez, we have you registered as Crystal Gomez with the American Immigration Lawyers Association, Texas chapter, and on behalf of yourself as an immigration attorney, and you're testifying against HJR 16, is that correct?
That's correct. Thank you.
You may proceed.
Thank you. Good evening, committee members and Chair Smithy. As stated before, my name is Crystal Gomez. I'm here representing myself in the Texas chapter of the American Immigration Lawyers Association. I have serious concerns about HJR 16, and I'm testifying against the resolution. I've been an immigration attorney in Texas for over a decade, working with the complex and often contradictory definitions of lawful status in the INA. And state involvement in these matters is both dangerous and legally fraught. In addition to the constitutional and humanitarian issues that others have raised, this resolution also fails to achieve its stated goal. Mr. Hammond from TPPF gave his federal definition of illegal alien and also stated that he reads the bill as limited to people without current status, but that's not the definition that's used in HJR 16. The definition of illegal alien in the resolution is deeply flawed and overbroad. Representative Little suggested that the federal government would decide if the person was undocumented, but the definition in this bill isn't limited to undocumented people in the US, and it encompasses even US citizens. And it isn't just as simple of a fix as Representative Money offered earlier by changing the name to non-citizens from people either, because this bill would then encompass people with lawful status, people with pending applications and in periods of authorized stay, lawful permanent residents, DACA holders, people with military parole in place, victims of domestic violence who hold U visas or VAWA authorization. We've also heard testimony that determining lawful status is very simple. A detainer request makes an allegation that somebody is deportable or inadmissible. It doesn't make a determination of that because only an immigration judge can do so after hearing evidence. In the Senate, very similar bill, SJR 1, they purported that this bill complements the Lake and Riley Act. But contrary to what we've heard here, this resolution doesn't align with federal law. Instead, it conflicts with it. And this goes to Representative Moody's question earlier before we began testimony and the testimony from the district attorney just a second ago about balancing public safety concerns. The Lake and Riley Act expands mandatory immigration detention in a federal detention center for certain non-citizens. The folks that we've been talking about here are covered under Lake and Riley. So anyone who commits serious bodily harm on somebody, theft, larceny, all kinds of other enumerated crimes would be subject to Lake and Riley. If a person is subject to Lake and Riley and they're arrested for a felony in Texas, they wouldn't be released on bail. They'd be transferred to ICE custody for mandatory detention there. But under this resolution's categorical denial of bail, that same person would instead remain in Texas criminal custody for months or years while their case plays out in criminal court. It's not common practice for ICE to take custody of a person until their criminal case is either disposed of or they're going to be released from custody. Thus, this resolution hinders ICE's ability to take custody of the person and effectuate their removal, and it also shifts the financial burden of the costs of detention from the federal government to the Texas taxpayers. Additionally, Representative Money discussed flight risks. This is an important point to remind the committee of. Judges and magistrates already have the authority to consider flight risks and potential flight risks when they're discussing or when they're doing an individualized assessment of somebody and what kind of bail to set. So this resolution doesn't do anything to enhance that. Ultimately, I urge the committee to reconsider this resolution. It's unconstitutional, overly broad, and risks ensnaring U.S. citizens. It places an undue burden on Texas judges and magistrates to make complex determinations about lawful status, and ultimately, it forces Texas taxpayers to cover the costs that the federal government is already responsible for. Thank you for your time.
Members, any questions for Ms. Gomez? All right, thank you for your testimony.
Thank you.
Next, we have Alicia Castillo. And after that will be Travis Fife. So Alicia Castillo, are you here? Yep. All right, Travis Fife. Okay. So Travis, we have you registered twice, actually, and just wanted to confirm whether or not one says staff attorney for Texas Civil Rights Project, and the other says just Texas Civil Rights Project. So
I think I've exposed myself at bad at technology.
Okay.
Those are both accurate. I am a staff attorney at Texas Civil Rights Project.
Do we have your permission to remove the second entry, the one that does not say staff attorney?
Yes, sir.
Okay, so based on that, we have you registered as Travis, is it Fife?
Fife.
Staff attorney for Texas Civil Rights Project, and you're testifying against HJR 16, is that correct?
Yes, sir, that's correct.
All right, you may proceed.
I wanted to first of all thank the committee members for the thoughtful conversation we've had today. Like we just clarified, my name's Travis Fife. I'm a staff attorney with the Texas Civil Rights Project. You'd be surprised how many people say FIFE. And I'm testifying against HJR 16. I first want to just acknowledge the powerful stories we've heard today. I think we can all agree that the family members of victims and the story told by the Honorable District Attorney all deserve a serious response that both respects their rights as Texas residents and also protects the rights of the accused. The Honorable District Attorney from Comal County talked about the scales of justice and how we have to balance both the rights of the accused to due process of law and the rights of victims to an efficient process that leads to accountability where appropriate. In our view, this joint resolution knocks the scales off the table. It flips the historical tradition in Texas that dates back to 1876 of a right to bail of those accused, and it does so on shaky grounds that will disrespect the due process rights of folks going through our criminal system. And it's because of this that I want to highlight three principal objections, hopefully quickly. I know this has been a long day. The first is I want to pick up on some of the comments made earlier about immigration being a complex process. I think that that is absolutely true, and for those of you who have been prosecutors or attorneys or defense counsel, you'll know that the magistrations where these are happening are low information proceedings, not because of bad faith or anything like that, just because they usually last under a minute. The person is unrepresented. And frankly, I've talked to people who have been told not to speak at magistration at all because they don't have an attorney. And so you are making hugely consequential decisions in terms of individual liberty in less than a minute. Second is that this bill paints with too broad of a brush. Representative Moody, I absolutely love the questions you asked of the district attorney. Any prosecutor knows, no prosecutor would think to move for no bond on simple drug possession or aggravated theft. And for those two principal objections, we strongly oppose this bill.
Any questions for Mr. Fife? All right, thank you for your testimony. And again, Alicia Castillo is not present, is that correct? All right, that concludes all of the people we have registered to testify on behalf of SJR 16. Is there anyone else that's intending to testify that has not been called? All right, Chair recognizes Chairman Smithy to close on HJR 16.
Thank you, Mr. Chairman. And, in light of the time, I'll go ahead and close and just remind everybody on the committee that I'm willing to work through these issues, and particularly some of the issues that have been raised in the testimony, and we'll continue to try to work through those and get a good product in the ultimate end. Yes, ma'am.
Any questions for Chair recognizes Representative Jones.
So, Mr. Chair, I'll just tell you, and we can talk offline, that I do have concerns with identifying a class of people based on immigration status. I think that's on shaky constitutional ground, and we can talk about it off.
Okay.
Line.
Anytime. Okay, thanks. So with that, Mr. Chairman, I'll close.
All right, unless there's objection, we'll leave HJR 16 pending and pass the gavel to Vice Chair Wu at this time.
Can we do 15?
All right. Chair comes up, House Bill, HJR 15. Chair calls up HJR 15.
Thank you, Mr. Chairman and members. And once again, I'll try to speed through this without compromising the description of it. But this is the other constitutional amendment, HJR 15, which has, in substantially the same form, has already passed the Senate. But it adds a section, another section to Article 1, another subsection to Article 1, Section 11 of the Texas Constitution, and it provides that a person accused of committing a sexual offense punishable as a first-degree felony. I'm not sure what that list is. Some of you may know, but I mean, I know it includes aggravated sexual assault, Chapter 22 of the Code. But as that definition, the definition is a sexual offense punishable as a first-degree felony, a violent offense or continuous trafficking of persons. And I might say the violent offense is as described elsewhere in it's defined elsewhere in Section 11, and so we just pick up that it refers to that definition that's already in the Constitution. A violent offense or continuous trafficking of persons may be denied bail pending trial if, after a hearing, a judge or magistrate determines by clear and convincing evidence that requiring bail and release conditions do not reasonably ensure the person's required court appearance or the safety of the community, law enforcement, or the alleged victim. So you would have a mini pretrial based on clear and convincing evidence, which of course is somewhere between the preponderance of the evidence and beyond a reasonable doubt, and there would have to be a finding. And then if it's determined by the judge or magistrate that bail or other release conditions would not protect the public, then the judge or magistrate can order that there's no bond to be allowed in that case. You can hold the defendant without bond. This is to try to address some cases that have arisen. I don't have any real specifics, but in general, I would just say that there are a number of cases where we've had individuals who have been charged and who are out either on bail or some other release condition and have committed violent crimes, actually killing, murdering, raping other innocent people. And so this gives another tool to the courts to be able to hold these individuals to try to protect our citizens from that type of behavior. If there's any questions, I'll be glad to address those, but we've got a number of witnesses again. Yes.
We're still in HJR 16?
No, 15.
Chair recognizes
Okay.
Rodriguez Ramos.
Okay, no, I withdraw.
Okay.
Thank you.
Thanks.
Members, are there
Uh,
members? Are there any questions?
If not, subject to closing, I'll. Okay.
Rep.
I
Jones.
have one quick question
Okay.
for you, Mr. Chair. So this HJR is trying to keep people detained pre-trial because if they are charged with a certain type of offense, there is some kind of presumption that they'll commit a violent crime. Is that because I just have seen situations where, I don't know, bad breakup, somebody knows they can use the criminal justice system to get the person that they're mad at, and they make false allegations against them. And I've had cases where down the line, it was proven that the person, I guess the complaining witness, was just flat out lying. But serious charges were alleged against them.
Well, I would say this, that what this has basically two conditions. One is that they're committed, that they're accused of a certain class of crimes, which are the more serious crimes involving injury or death to another person. The second thing is that the judge or magistrate has to make a finding by clear and convincing evidence. And I think clear and convincing would take your situation out of it, where you just have if you have a case of a he said, she said allegation, where you have conflicting evidence that you very likely you have not met the clear and convincing standard. Clear and convincing is defined at least once or twice in statute, essentially, I think substantially the same way. It's also defined in case law as, I don't know if I can recite it. I'll do the best. That's evidence of a sufficient level to create the firm belief that the allegation is true. And so it's a higher standard than the preponderance of the evidence in a civil case, but it's not quite as high as your standard of beyond a reasonable doubt, because we're not trying the case in terms of whether we're going to deny or allow bail. But you've got to have some evidence, and it's got to be at least meet the clear and convincing standard.
So clear and convincing is actually the standard that's required to terminate a parent's right to their child.
Right. It's
so,
the
so
family.
it's pretty.
You know.
I practice family law too. You do too, don't you, Mr. Cook? Rep
And
Cook?
for exemplary damages,
but-
Chapter 41 of the Civil Practice and Remedies Code as well. Yes.
But so if this, like DA Tharp said, like early on in the case, you just don't have a lot of evidence. So what I would envision and what I've seen is that the DA has way more evidence than like the defense side. And the witnesses for the DA are generally law enforcement. They're the ones who investigated it. I generally don't see in bail hearings, I mean, Rep. Wu, or I guess Rep. Chair Moody can tell me if they've had this, that you don't even see, not early on, not at the preliminary determination of bail, you don't even have witnesses there to be able to testify to anything. So I don't understand how at this process you would have enough time this early on to actually be able to get the quality of evidence that you're suggesting to be able to make a determination.
Well, even if the defendant doesn't have any evidence or doesn't come forward at the hearing with any evidence, and very likely they will possibly have some evidence that they will not want to use at that stage, or they probably won't let their client, the defendant, testify, for example. And so, but still, the prosecution is going to have to prove at a heightened burden of proof that the act that's alleged probably occurred. And that's not always that easy to do.
We can talk.
Okay.
Members, any other questions? That will call our first witness. Eric Martinez. Let's show them neutral on the bill and not testifying. I'm sorry. Against the bill and not testifying. Okay. Sorry. I was looking at the next one. Aaron Johnson. Hi, Aaron. I show you as the president and representing the Texas Association of Pretrial Services, and you're neutral on the bill. Is that correct?
That's correct. I think there's a lot of confusion still as far as when this actually takes place, and it's specifically confusing because of the new clear and convincing piece that we're trying to talk about. This amendment, as stated, would fundamentally change the nature of the 1517 hearing, because it's only to make a determination of probable cause. As we've, again, as Representative Jones has talked about, you're talking about two different standards and two different evidentiary pieces. And most of the time in the state of Texas, individuals who are accused and arrested do not have an attorney present for this initial hearing. That is not the case in some places, because some of us have gotten sued and we have those pieces in place. But I do know that other places are looking at having appointed attorneys at that time. let alone trying to get your own attorney and being able to even present to that level, that standard. I'm just kind of confused as when this is actually supposed to take place, because that's not set forth in the bill. In the bill, it just says at a hearing. And so it would help if we could kind of get some sequence to what's actually occurring when, and when this is supposed to actually take place.
I might just respond to that and just say that, so this is a constitutional amendment. It's a JR. It simply amends the Constitution to permit the denial of bail in this particular fact situation. So that's all it does. And it doesn't get into the mechanics of how it works or anything like that. That has to be done through legislation in the form of a House bill or Senate bill. Now, there are other bills that have been filed, which I really can't get into in the discussion of this resolution, but I will say that what you're talking about belongs in the statutes, either in the probably in the Code of Criminal Procedure. So you're not going to have that detail in the constitutional amendment.
Understanding that, the other pieces of 11, that the previous pieces, there's actually sequence. There's actually when this occurs, how it occurs, but this new piece, this new different standard, again, I don't foresee an individual being able to defend themselves, let alone the prosecution having the evidentiary pieces that they're going to need to meet this standard within any reasonable amount of time. So on its face, what this is doing is basically saying anybody that is charged with these crimes are to sit in jail until basically the prosecution's ready for their case. Am I misinterpreting this?
I think you are. And like I say, this isn't really doing anything other than just authorizing the legislature to pass legislation that would prevent a release in certain situations. Without legislation, there's not going to, there's really no, in other words, we don't put all that in our Constitution, okay?
Understand that.
Yeah.
I do understand that.
Okay.
But the effect of what this would allow would be to hold somebody until basically the state is ready to proceed with the case. And that, on average, 60 to 90 days.
It might allow the legislature to pass a bill to that effect. But once again, that's part of the political process. And I don't think the legislature is going to pass that.
Okay. I think that when you're talking about making this kind of change, fundamental change to this process, that before something would be brought legislatively, that there would be a study done about how it would actually affect what would happen at the county level. That's why it's a neutral. There's still too much here that needs to be pieced together to see how this would actually work versus just allowing for something to happen or to go to the voters. Because if we don't understand the small pieces, the voters are not going to understand what you're trying to do legislatively. So I'll take any questions.
Members, any questions? Thank you very much.
Thank you.
Next up is Krishnavi Gundu. And we'll show them as against, but not testifying. Nikki Presley. Hi, Nikki. I have you showing as representing the Texas Public Policy Foundation, and you're for the bill, or for the HJR, is that correct?
Yes.
Thank you. Please proceed.
Well, as you stated, my name is Nikki Presley. I represent the Texas Public Policy Foundation, and we are in support of HJR 15. Thank you, Chairman and committee members. I know it's been a long day. Thank you all for being here. I am the Texas Director and Chief of Staff for Right on Crime, which is a national campaign of the Texas Public Policy Foundation. In Texas, the accused have a constitutional right to bail, meaning unless a defendant is charged with capital murder or meets a certain criteria for repeat violent felonies, the judge cannot detain a defendant and must afford them bail, no matter how dangerous they believe that defendant to be. This creates a system in which high-risk defendants who can afford bail can buy their freedom despite the public safety threat that they pose. Allowing judges to detain high-risk defendants before trial is not unorthodox across the nation. Many states allow for the denial of bail for a variety of offenses and circumstances beyond capital murder, and 9 states do not have a constitutional right to bail. Furthermore, in 1987, the Supreme Court ruled that not everyone has the right to bail. The ruling affirmed that both court appearance and public safety should be considered when determining pretrial release conditions. If there are no conditions that would reasonably ensure the safety of the public or appearance in court, then bail can be denied pretrial. Providing judges this discretion in serious violent cases will help keep our communities safer. Furthermore, to Representative Moody's point, which he has brought up a lot on the lower end of the spectrum, our recommendation to improve this bill would be to include the least restrictive conditions language that we have in current statute under 17028 Code of Criminal Procedure. Thank you for your time, and I'm happy to answer any questions.
Members, are there any questions? Thank you very much. Next up is Michelle Chapa. And I have you as representing yourself.
Just me.
Okay. And you're for the bill, is that correct? Or for the HJR, I mean, he's saying bill.
Correct. It's okay, we'll call it Bill or we'll call it Bob if you want to. So yes, I am Michelle Chapa. I am a crime victim again, as we've stated earlier, and I know all too well the feeling of looking over my shoulder, constantly wondering if I'm truly safe. Even now, every sound outside my door, every unfamiliar face sends a chill down my spine, and these moments remind me that the people who hurt me still walk the streets, free to inflict pain again and again. It's devastating to think that habitual violent offenders are released without any real accountability, putting our entire community at risk, especially when they have no ties to it. They have shown us their capacity for harm, yet the system allows them to remain free while awaiting trial. This leaves us, the public, in a terrifying position. How many more people are going to suffer because they're allowed to roam freely? How many more victims are there going to be? And this is also an extra burden on law enforcement as well, as they're forced to have to confront the consequences of a system that fails to protect the victims. Just this week, we had in Harris County an intimate partner homicide defendant who was so violent, the CERT team had to extradite him from his cell to bring him into his court hearing. His bond amount was set at $250,000, and her family had to fight to have that amount raised to $500,000, as this man is a menace to society. He also abandoned her dogs on the Katy Freeway after murdering her. Victims and families should not have to do this. We should not have to fight to have a reasonable amount set for a violent offender, especially someone who's habitual. Our judges need the discretion to set bond amounts that keep the community safe from these limited sets of violent criminals. This is not applying to everybody, these limited, habitual, very violent people. Stricter bail laws are not about denying rights, they are about ensuring our safety. This isn't about punishing someone before they've been tried, it's about protecting those of us who have already suffered. We need a system that seriously considers the risk to our community. And I'm not asking for everyone to be held without bail, but I urge our magistrates and our judges to weigh the potential danger to public safety. This is not about wealth. The most violent crimes aren't committed by the wealthy, unpopular opinion. But we deserve a change. Our justice system must prioritize the protection of victims and public safety above everything else. We cannot afford to wait until it's too late. We need to empower our judges to safeguard the innocent and ensure that our communities can heal and then thrive. I'm hangry, y'all, so
Thank
I'm
you.
ready for
Members, are there any questions?
I'm ready. I'm hangry
Thank
and
you
I'm
very
ready.
much.
Thank you, guys.
Next up is Nikki Presley. I'm sorry. Sorry. Stuff is getting shifted on the screen as I'm reading it. Thank you very much. I appreciate that. Emma Stammen. I hope I got that right. And my laptop just shut off. Somebody, can you log in? I don't. This is laptop. log in. This is what we call womp womp. You want to just read it, Mayor? I'll just come up with it. Emma Stammen from the Bail Project.
Correct.
And you're against, wait,
Against.
against the bill. Is that
Yes.
correct?
Correct. Thank you for the opportunity to speak with you all today. My name is Emma Stamen, and I am the policy strategist with the Bail Project. I am here today in opposition to HJR 15. HJR 15 is a proposal that would undermine public safety while stripping legally innocent Texans of their rights and freedom. This legislation threatens to fill overcrowded jails with thousands of Texans for as little as a potential missed court date. But research shows us that unnecessary incarceration is dangerous to the public, undermining HJR 15's very purpose. HJR 15 would create a broad expansion of pretrial detention that would allow judges to detain someone if they simply believe they may miss a future court date. Missed court dates may be inconvenient, but they are often unintentional and are hardly reason enough to keep someone in jail. Our work shows us that with the right resources, most people will come back to court. Pretrial detention already costs Texas taxpayers over $1 billion every year. Rather than throwing away taxpayer money on unnecessary jail stays, we should identify people who can be safely released and invest in evidence-based programs to prevent crime in the first place. HJR 15 will also worsen racial disparities in the criminal justice system. People of color are already disproportionately represented in Texas's jails. Research consistently demonstrates that Black people are detained pretrial at a higher rate than white people with similar charges and histories. The dangerously low standards in this amendment will only exacerbate this issue. A drastic increase in pretrial detention will result in more crime rather than prevent it. Being held in jail is destabilizing. It causes people to lose their jobs, homes, custody of their children, and can harm physical and mental health. After 1 day in jail, people have a 24% chance of rearrest. After 3 days, that chance jumps to 45%. Policies like HJR 15 ultimately threaten public safety. HJR 15 disregards the presumption of innocence by allowing legally innocent people to be jailed pre-trial without a chance to adequately defend themselves. Changes to the right to bail must ensure pretrial detention remains the exception, not the norm, and clearly separate cases of intentional flight from those where someone misses court by accident. Pretrial detention has already doubled in the last 25 years, yet Texas is no safer for it. We can improve public safety without opening the door to unnecessary incarceration. The solutions do not lie in HJR 15. Thank you for your time.
Members, any questions? Representative Rodriguez Ramos?
Thank you for testifying today. Could you tell us what are some reasons that people might miss a court date that aren't intentional or willful flight, and what solution would you propose?
Absolutely. So there are many different reasons why someone could miss a court date, and like I mentioned, they are often unintentional, and they're often due to everyday challenges that any of us could face. It could be not being able to take time off of work, not being able to get transportation or secure childcare. It could be due to illness, injury, emergency, having to care for a loved one. And also the court system can be really difficult and confusing to navigate for people. Court dates can change, the times of hearings can change, and people may not always be adequately notified. But what we've seen with our work is that really simple interventions like simply sending someone a text message or ensuring that they have transportation reduces those failure to appear rates. Even just the text messages alone can reduce those rates by 30%. So that's why we encourage the change in language in the draft.
So in the scenarios that you just expressed, in some of those cases, somebody might be later declared innocent. They never made any violations, but because they weren't able to show up, they are presumed guilty. Could the expanded authority to deny bail lead to prolonged pretrial detention for individuals who may later be acquitted?
Absolutely.
Might this resolution inadvertently increase jail overcrowding?
Yes.
Okay. Would you agree that without clear guidelines, the discretionary power to deny bail could be applied inconsistently, leading to unequal treatment of defendants across different jurisdictions?
Yes, I would.
What type of jurisdictions would be most impacted by this denial?
I'm not sure I'm the best person to answer that question, but maybe another witness could.
Okay, all right, thank you.
Thank you.
Members, any other questions? Oh, Representative Jones?
I've got a few questions similar to Rep. Ramos. Have you had where people are poor and they can't afford to have a phone, so they don't have a phone? Have you had people have children and some courts don't allow children there? So if you don't have childcare, then you can't come to court.
Yes, that's absolutely a problem. If people don't have access to phones, they might not be able to get their hearing date, and even if they have to bring their child to court, it's not a good environment for the children.
And some courts just don't allow kids.
Exactly.
They'll be like, you got to leave.
Yeah.
And also sometimes they just don't, so they don't have transportation and they don't have money to even afford the bus. And there's some places, like in the Harris County area, where there's not bus service in the part that you live in to even be able to get to court. And I mean, there are a bunch of explanations for missing court that don't have anything to do with you trying to shirk your responsibility. But
Absolutely.
All right, thank you.
Members, any other questions? Thank you very much.
Thank you.
Next up is April Iguri. Oh, sorry. I saw her. Please, and I apologize if my laptop is down. Could you tell us your name, who you represent, and your position?
I'm
on the
April
bill?
Aguirre. I represent myself, and I'm for the bill. Since the writing of our Constitution, things have really shifted and changed. The word even serial killer didn't exist. Criminality has evolved, and our Constitution needs to evolve with it. I'm not asking you today whether you believe in this or not. I'm asking you to give Texans the ability to vote for this. I want to say that John Whitmire, from the Houston mayor, has written a letter of support for this. I want to say that Adrian Garcia, Precinct 2, Harris County, has written a letter of support for this. And Ed Gonzalez, the sheriff from Harris County, has also written a letter in support from this, and we agree that unfortunately criminality has changed. We have seen things happening now that just didn't exist back then, and we have to evolve with the times. I feel like things that don't get passed to here that we want Texans to have a vote on is a form of voter suppression. Let Texans decide whether you and I believe in it or not, or whether it gets struck down by the Supreme Court if it goes that far, if it doesn't meet the legal standards. Give it the ability to go through the channels, through the proper channels, but give Texans the ability to vote for this. Recently, we had an individual who was indicted for shooting and killing a Harris County deputy, Officer Escada, and he was given a $500,000 bond for capital murder of a law enforcement officer, and he bonded out. His family was able to come up with the money. Now you have this type of individual that there was 42 shell casings recovered at the scene of Officer Escada's murder. This is a type of crime that is very concerning. And this is why we need to give judges, to deal with the worst of the worst, the ability to deny bond, regardless of your financial abilities. It should be based simply on the community safety and also on the ability, whether you're gonna come back or not. This guy has a death penalty on the table. He has a very high risk of flight risk. So let's give judges the tools that they need to do their job, and this is only for the worst in our community. And I urge you to give Texans the opportunity to vote for this. And if you don't think it's legal, and it may not be, let it go through the proper channels. Give it a chance. Thank you.
Thank you very much. Members, any questions? Appreciate your time. Thank you.
Thank you.
Letitia Ibarra, I have you as representing yourself, and you're for the HJR.
Yes, sir.
Thank you. Please, please
Hi, thank
proceed.
you guys for having me and hearing me out. As you said, I'm representing myself. In August of 2020, my beautiful daughter, Jessica, was brutally murdered in Harris County. And since then, I was thrust into the world of navigating this criminal justice system I didn't know anything about. You know, I tell people I have more than a traffic ticket. I didn't know what was going on. And all the while, you're trying to navigate this, you're just unimaginably traumatized by all of this. none of us chose to be in this situation, right? None of us chose to be in this community. And so what I want to highlight is the effect on victims that these offenders of these violent crimes, when they're let out on bond, the effect on the community, the effect on the victims when the judge has no choice but to grant them a bond, right? So every day I'd wake up in the morning not wondering whether this guy got out and I didn't get the Vine alert, right? Is this guy going to come after me? Is he going to come after my family? And some may think that that's, you know, kind of an irrational fear, but you know what else was irrational? My daughter getting brutally murdered, right? And we're talking about an individual. He beat her over the head with a skateboard to the point where her brain matter was exposed. He went back, discovered that she was not dead yet, and finished her off by stabbing her in the neck. So we're talking about super violent criminals, and we want, again, like April said, to give Texas voters the chance to allow our judges to make those informed decisions, the discretion to do that by following the rule of law and everything. Let the voters decide, and judges that we elect, right? So then it's kind of give power back to the people. We get to decide whether they get discretion, and we vote them in or not based on their action while they're in, right? So I see a judge, I don't like the way his discretion, good, I'm not going to vote for him, right? But it gives us the opportunity to do that. We have to think about the victims and what we go through, right? It's not fair. We shouldn't have to. We didn't do anything wrong. My daughter didn't do anything wrong, right? And if that could help somebody's Jessica from being victimized and murdered, then, you know, we're going to do it, and we should have the right to decide that. Thank you.
Members, any questions?
Thank you very much. Appreciate you.
Thank
Appreciate
you.
your testimony.
Thank you.
Thank you very much. Next up, Charles Cook. I have you as representing yourself, and you are for the HJR. Is that correct?
Yes, excuse me, let me grab the smoke. If you'll allow me. My name is Charles Cook. I am here in favor of HJR 15, and I am representing myself and also this lovely lady right here.
It changed.
It changed. Oh, my goodness. Thank you. That lady there is the mother of 3, and she's mine. She's the grandmother of 6, great-grandmother of 5 and counting. Let me tell you a little bit about her before I talk about how I feel about this. She was a hard worker, and when I was a kid, and we grew up in the Hiram-Clark area of Harris County, for those who know about that area, and we were humble. We didn't have much. We had 1 car, and so Mom would get up, and she'd make breakfast for Dad. She'd load us all up in the car, wake us up, load us up in the car, take Dad to work, come home, get our breakfast ready, send us off to school, get herself ready for work, go to work, come home in time for us to get home from school. Then we'd go pick up Dad, then she'd cook dinner, 5 o'clock every day, and baths, a sitcom, maybe the news, and that was wash, rinse, repeat, and she never complained, not one time. Not one time. She was the most loving, caring, and affectionate woman I've ever known. She was a hugger, quick to tell you that she loved you. I always felt loved unconditionally, and I still do today. She was my best friend. She was unpretentious, humble, simple. She didn't require much. She wore very little makeup. Never in her life had a manicure or a pedicure. Rarely spent money on herself, and the occasional hairdo was always what she might do. And that's what she had here for a Christmas picture.
And so really, at the age of 80, she was what you would picture if you were asked to describe the little old lady that are in storybooks. She was 5 foot tall. She walked with a slight hunch, with a cane or a walker. She always had her eyeglasses down on her nose, and you'd find her in a rocking chair, reading books or knitting. She was a widow. She lived alone, and she was determined to be independent. But what this did is this made my mom the most vulnerable of the vulnerable. We've talked a lot about children today who are innocent and vulnerable, but we've got elderly that are the same. So to my point, not quite 5 years ago, she left her house on a Saturday morning to run her Saturday errands at Walgreens, just around the corner where she's been for decades. At 10 a.m., she parked in the handicap spot closest to the entrance, shuffled into the store with her cane, got her things, chatted up with the elderly clerk that she's known for a long time, got caught up on grandkids and such, as you know. And completing the conversation, she grabbed her cane, shuffled back to her car that was parked not more than 8 foot from the door, where she was approached by a man and with no warning stabbed. Not once, multiple times, and all he wanted was her purse and her car. The tragedy here is that this man, a career criminal with 67 prior arrests, 67, in case you didn't hear that number. And he was out of jail on 2, not 1 but 2, PR felony bonds. 1 for felony theft, a little bit. So, please, Mr. Lewis, go out there and don't do any more crime. Just promise you'll come back to court for us. He goes out, assaults a public servant, back in jail, felony public servant charge, PR bond. Please, this time, go out there and behave yourself. 2 weeks later, he stabs my mom. My mom died on the hot asphalt of a Walgreens parking lot because some idiot, some 67 prior arrest career criminal, was not held accountable. You know, the best predictor of the future is to look at history. We all know that. And this certainly applies to human behavior. Randy Lewis certainly proved that saying to be true. He had no business being on the street again. His past was a clear indicator that he had no respect for persons or the law. As I said, she died a lonely, painful death on the cold asphalt of the Walgreens parking lot, drowning in her own blood. The system is supposed to be designed to protect the public and, most importantly, the most vulnerable. This system failed my mother, and unfortunately hers is not an isolated incident. There's a saying that goes, if nothing changes, nothing changes. Or put a different way, if we keep doing what we're doing, we're going to keep getting what we're getting. It is high time for change, folks. Long overdue. Not only to protect the innocent children, but the innocent elderly people like my mom. And anything that strengthens or gives some teeth to the magistrates and the options available to keep these guys behind bars is a win. Yes, there may be a few who are imprisoned improperly. But that can't be the reason why we don't strengthen our judicial system. So my hope today is that you consider the benefits from these measures that brings to victims and the broader community and vote yes for this resolution. And as you consider these regulations or these legislations, did it go off? Bummer. That you picture my mom's face as you think about it. Because God forbid it happens to other ladies or your own mothers or grandmothers or great-grandmothers. And because I'm out of here, if you'd allow me, I am for all Smithy's bills and HJRs. I am 100% behind Representative Bowers. I am completely against 799. That's it.
Mr. Cook, I just wanted to say thank you for sharing your story here today. I know that probably wasn't the easiest thing you've ever done, but
It makes me mad every time I got to tell it.
I know. When did that occur?
Not quite 5 years ago, May 19th, 2020.
Okay, well, we're sorry it occurred, and we appreciate you being here.
Thank you.
Rep. Bowers.
There. Thank you, Chairman Wu, and thank you, Mr. Cook. So sorry for your loss. Thank you for sharing. I grew up in Houston as well. I represent in Dallas, but I grew up in Houston. So I know Hiram Clark very well. My uncle and aunt and uncle go to Brentwood right there. And, I grew up in Third Ward, but one thing that I know that Representative Jones knows, because she serves near the community that I grew up in, that Houston has changed. And it breaks my heart. I go home every Thanksgiving. It breaks my heart to see the difference. I think Ms. Chapa, who is not here anymore, talked about over in the Galleria area. And the crime is out the roof. So I thank you, for using your voice to share your story about your mom. And my mother's still there. She's out in Pearland, and I do know that the crime rate at Houston is out of control. And I have to say thank you for your 100% support of my bill. Thank you for being here.
Thank you. And I might add, there's not one decision I ever made that I didn't suffer a consequence for. And being from Hiram Clark, I understand the criminal mentality. I get it. They don't think in terms of right and wrong. They think in terms of, can I get away with it? And that's what PR bonds do. They embolden those people. Get rid of them damn PR bonds. Excuse my language. And don't try to dress it up all sexy, Moody. It's not sexy, man. You can't put enough lipstick on that pig.
Members, any other questions? Thank you very much. Next up is Paul Castro. And I have you as representing yourself, and you're for the HJR. Is that correct?
That is correct. Thank you. Thank you, Chairman Wu. Thank you, honorable members. My name is Paul Castro. July 6, 2021, my sons and I were driving back from an Astros game when a twice convicted violent offender felon who was out on parole, still within the window of his parole, got mad at me and shot at us during a roadway incident, hit my 17-year-old son, David, in the head. I had to drive him to the hospital holding his brain matter inside of his skull. So that wasn't something that I ever thought would happen to me. And so because of that, I'm here today to talk to you about what we can do to solve problems. My son was amazing, amazing kid, 17 years old, ready to start his senior year. I have a picture of him from the rotunda back there. He wanted to be one of you one day. He was studying hard so that he could be a leader and write policy because he believed in us. I still believe in us. So today I'm going to speak with you the way I would have spoke to him, and that is, I want you to remember who you were. At some point in your life, you decided you wanted to be a leader, and you thought, I'm going to solve problems, I'm going to make my community better. And I'm calling upon all of you, Republicans, Democrats, to figure out how to fix things, because things aren't working. We need to solve a problem, and we're here. I have to exhume my son every time I come here and bury him again when I go home. We pay a high price, and what we're trying to tell you, what I hope you hear from us, is a lot of us suffer from a failure of imagination. You think the worst thing that's ever happened in your life is the worst thing that ever will happen in your life, and I'm here to tell you that that's not true. Worse things can happen. They can happen to you, your loved ones, your neighbors, and you'll reset entirely. You know, the worst day ever, you know, whatever it was for you today, it will pale in comparison to what it could be. And I'm asking you to have that in mind when you think about the people who don't care about that, the people who are out. The person who killed David, twice convicted felon, got locked up, turned himself in, had the audacity to wear a shirt that had George Floyd on it. He was trying to engender sympathy from the community that wasn't there, thankfully. The community turned against him. Turned against him so much that 100 people had called in against him to try to identify who he was and what he had done, killing a young man. He wound up getting released from jail about a month after he was arrested. He was released on a Friday, and because it was on a Friday, pretrial services wasn't open at the time he was released, so he was released without an ankle monitor, free, you know, twice convicted felon, accused of murder, no monitoring whatsoever on him until he returned to court on Monday. For 481 days, he was free. He even violated bond while he was out on bail. Nothing happened. Not a slap on the wrist. He had to come in and talk about it. We found out 4 weeks after he violated bond, we were told, oh, by the way, this happened. And when I asked why did it take so long, the response was, that is not information that you have a right to have. That's personal information. That belongs to him. This is not something you can request, because I asked again and again and again, has he violated bond? I was told, this is an inappropriate question. You can't ask that question. It's a problem. Okay, it's a problem that we're facing in our community. It's a problem that can be addressed, because what happened when he was released, before he was released, Judge Mark Brown, who was a visiting judge at the time, set a bail that was pretty high. And because at the time Harris County and its messed up bail system allowed him to be released on essentially a 2% bond, he got out for killing my son for $7,000. He put on a credit card. They falsified records. He's now sitting in federal lockup for falsifying and wire fraud, falsifying records. Again, a failure of imagination allowed him to go free. Okay, and while he was free on falsified records for 481 days, every day I had to wonder, is this the day that he's going to wind up on my front step? Is this the day that he's going to exact revenge for me calling him what he was, a child killer? And the answer should have been that was not even a possibility. I believe that if Judge Mark Brown had had the opportunity to hold him without bail, knowing his record and knowing the danger he presented to the community, he would have held him without bail. HJR 15 is the tool that you can provide judges that they can judiciously use in cases like this to keep people like him out of our communities and away from the people they've hurt. I'm asking not for your sympathy, but your empathy. We are here for others. None of us, we don't get anything for being here. We're paying out of our own pocket to be here. We're here because we want our community to be safer, and we're asking you to help us do this. Remind yourselves of that person you were. Figure out how to fix the problems you have with the bill of the JR, and fix it, right? And come together, fix it, for your fellow Texans who are asking you to do something, because the world is way different from the one I grew up in. And I know that you want to make this work. I'm asking you to drop the letters after your names and come up with a solution. Thank you.
Members? Thank you, Mr. Castro. I'm sorry.
Thank you.
Appreciate it. Representative Jones.
I want to thank you for telling your story as well. We met back at Discovery Green.
We've met 3 times.
Yeah, but the one I
You- oh,
remember
oh, yeah.
was at Discovery Green, talking about weapons and stuff. But I'm sorry about, you should be able to go to an Astros game, that's back when they were winning, without having to worry about that.
Thank you, Representative Jones.
Representative Cook.
I just want, and I apologize to get back into details. I'm sure it was hard to tell that story, but can you tell us more specifically what you were told by pretrial services?
Yeah, so all I needed to know, because I kept asking the same question. The question was, has he violated bail, right? And what I was told is, in order for that information to be provided, that has to come through the judge. The DA has to request it. And without the DA requesting it, the DA has to be able to prove to the judge that there is a rationale for that request. So there has to be some reason.
Like
and
your
with
safety?
Yeah, well, yeah. I mean, to me, this is a no-brainer. To me, I should be able to monitor that guy on my phone the way I monitor my kids, right? It should be like I should be able to know exactly where he is all day, every day. And that's what I was told. So I'm not an attorney. I have opinions on them on TV, but that's it.
Were you told that it was not subject to open records?
That is correct. Because I tried everything. And by the way, open records, don't get me started. I've tried so many times to get open records out of Harris County, and I think I've had one request fulfilled, and it was a spreadsheet, or it was a stack of papers of a spreadsheet that was like 200 columns long. It was there's not anything that breaks in the favor of victims in Harris County, for sure.
Were you made aware of his court dates and things like that?
Oh yeah, I showed up to every single one.
And even at those court dates, you were not able to get any of that type of information?
What would happen is they would put in a request as to whether he was still adhering to his bail restrictions. And what I was told is yes, 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 until we were told, oh, by the way, this happened 3.5 weeks ago, and we just thought we'd let you know. And I found out while I was at a court date, but that was within that 60-day window between hearings.
Thank you.
Mm-hmm.
Members?
Yeah, I'm head scratching too.
Yeah,
Moody. It made no sense to me. I'm just telling you my lived experience.
Mr. Chair, thank you. I'm sorry, I'm going to get stuck on this too, because there's certain information that victims, families of victims, are supposed to be provided with for the purpose of knowledge, right, and their own personal safety. We've gone back into the code a number of times and done that to strengthen victims' rights. I'd like to visit with you offline if I could get your information.
Sure.
Because I want to drill down into why exactly that information wasn't being provided, because I have a hard time understanding what the rationale would be. It doesn't, to me, just doesn't add up. And so I appreciate it. It's obviously there is a lot to your story that is important for us to hear, but.
I can give you an anecdote. I became very interested in pretrial services as a result of being told no. I listened in the commissioner's court when their budget came up, and when the leader of pretrial services was presenting his budget, he said, we have an X% satisfaction rate from our clients. And I thought, well, who's a client? Then I realized, the people with ankle monitors are the clients. They're the ones who are satisfied. And to me, if that's the level of, nobody ever, told me to say, like, hey, how are you doing?
Were you connected with a victim advocate at the prosecutor's office?
That's a long story. Yes, and the person was on FMLA when it occurred, so they went radio silent for about 3 weeks. And so we didn't hear anything, and I could go on about there's no way for you guys to understand unless you've been through it, what it's like to be on the victim side. So the first email I got has the email title is Murder: Gerald Williams, case number this. So that's all caps. That's what shows up in your email box. Mm-hmm. And then in lime green, magenta, and other colors, and a 10-point font is just an indescribable amount of text about all the things that have to happen. Then we're given a PDF form to fill out where it asks you to quantify all kinds of things that are unquantifiable. and you have to fill it out in PDF. You know, who has printers these days? It's not, you know, so all those things happen. And then if you file it the incorrect way with the OAG's office, you get put in this stack. And if you file it electronically, then you don't have access to certain things. But if you fax it in, then you can't access anything online because that's not how it works there. So there's not one thing that works right for victims, starting with, you know, of course, the crime.
I'm sorry, I won't belabor the point, Mr. Chairman. I know that is not the particular topic of this bill, but the bureaucracy that you drown in as a victim it's insane. I mean, I know in my time serving as a prosecutor, I mean, we were victim-centric, we were victim-forward. We had people in our offices that were, no one's going to live that experience that you went through. And our job is to sit with you, is to hear you, empathize with you, and try to walk you through what is probably the most difficult legal proceeding that you're ever going to be a part of. As you grieve, as you mourn, you're also dealing with the mechanics of the legal system.
Correct.
I am shocked. I am shocked.
So a lot of the things that were discussed earlier today need to be addressed. One of them being, you know, you're not told, I wasn't told, that I was going to be standing in the hallway. I look up and there's
he's going to be
Gerald Wayne Williams across, and then his defense attorney showed up and they fist bumped, and it was all I could do to not get arrested.
Yeah, I'm going to connect with you offline. Thank you very much. I appreciate you being here.
Representative Jones.
Just want to say one more thing, Mr. Castro. Is it not everything related to your son's murder, you received that information from the DA's office? Is that accurate?
It starts off with HPD and then it shifted to the DA's office.
Right, but once they accepted charges.
Yes,
So,
sir. Yes, ma'am.
So, because I do know that I'm sometimes retained to make the criminal justice system work for the victim. And as a lawyer, I've contacted the DA's office about the status of a case and trying to get information for the family because they want to know about the family. And in more than just Harris County, I've been told by the DA's office that they're worried about, I guess, the integrity of the investigation and the prosecution. And so they can't give us certain information for whatever reason. I'm not going to get into that. So I would imagine that pretrial would report to either the judge, would report to the judge. And I can recall getting, as a defense lawyer, emails from pretrial, you know, telling me my client violated. But I think that's the extent of it. So I think that, have you had to deal with this new DA in Harris County?
I've had the opportunity to meet Mr. Tier, and he has engaged me along with another victim in terms of helping to inform his office as to how to better improve interactions with victims.
Because that's one of the things I spoke with him about.
Yeah.
Because of experiences I've had representing families that were trying to get some modicum of justice. Thank you.
Thank you very much for your time. And Paul, I'm sorry, Mr. Castro, you're in my district, and I appreciate you being here, and you've represented crime victims in Houston a lot, and I would appreciate that. And I just want to say that I totally agree with you. I think we should drop the DNR or whatever it is behind our names, and like this is, crime victims don't, I mean, criminals don't care about what your party affiliation is before they commit crimes against you, right? And so this is a issue that cuts across the board, but like we talked about with Representative Moody and everything else, is like it's not just bail bond. It's also the bureaucracy and the fact that the courts are still operating like their computer systems are from the early 2000s, right? And we are not taking advantage of the technology that we have available to us today to make sure that victims are informed of what's going on, what's everything. And I think, you know, not just to reiterate my point from earlier is like we should have county and state investments into victim services. And just saying the DA's office, you guys take care of it, is, I don't think is good, because, you know, I've talked to a lot of victims where they said, well, I don't want to call them because they're busy and they have like real cases to prosecute. I don't want to call them and ask them what's going on. And I said, like, if we had an office in the county that worked with victims and said, hey, you want to know what's going on? Call us and we'll go through the paperwork and we'll tell you what's going on. I think that would be a lot easier. And that's the way it should be. And I think along with all this, I hope, and I know you've been part of this conversation, we should have a discussion about why a felon had a gun. Who sold it to him, and why don't we prosecute the people who gave him that gun, right? And all those things. And the point of this is I want to talk about that public safety is not one thing. Correct. Public safety is not one little sliver of a thing. Public safety is everything. It's everything from, we talked about earlier, mental health issues, dealing with mental health issues. How do we deal with jails? How do we deal with victims of domestic violence? What kind of protections do they get? And it's not one thing, it's all of the things included. So thank you so much for not only being an advocate on this issue, but being an advocate in many, many other issues as well.
Thank you, Chairman. All right, appreciate it.
Next is Selena Bray. Or Brahi, I don't know. Hang on. Hi, I have you as Selena Bray, and you're representing Pure Justice and yourself, and you're against the resolution.
All of that is correct, except I, again, like before, want to amend that it's Pure Justice Action Fund instead of just Pure Justice.
Can we have permission, your permission, to make that change?
You may.
Please proceed.
Thank you, chairs and the committee at large. I understand the intention behind this HJR and the perceived positive safety outcomes that potentially would result. However, even if putting this JR on the ballot might make people believe that they're safer, the reality is that the legislation would open the door for even more households and families to be destabilized and placed in new, dangerous situations because of involvement with the criminal legal system. This may check the boxes of being tough on crime, but it will ultimately be really tough on all Texans, their communities, their liberties, their opportunities. In my daily experience at Pure Justice Action Fund, working with system-impacted people and understanding how safety is cultivated and how it's not, this path of automatic bail denial is ultimately a distraction. I want to uplift the experiences of someone who was here earlier but had to leave for different reasons. It was Mr. Edric Wilson, who was denied bond for 12 years at the Harris County Jail for a crime he would eventually be proven to have not committed with DNA evidence. Eventually, he did have his bond set very high at $850,000, but in the interim time, this was his situation. He was stuck. His lack of bond meant he had no options to get unstuck. He had no access to his senior father, who had cancer at the time, to connect with his daughter, who had just gone off to kindergarten, and most importantly, no way to get out and use any resources or opportunities to seek more active justice with a better attorney, to seek employment opportunities that would have helped him and been an ultimate deterrent, as we've seen here, be a real deterrent against offense and crime. And I remind you, he was very much innocent. But with this sort of abandonment, blanket assumption of guilt, and treatment of him as a guilty person, it would be pretty hard for us to tell. He spent 2006 to February 28th of this year incarcerated pre-trial. The insistence that bond denial is a crucial step to public safety is wrong. This component of the HJR isn't running on justice. As it's currently written, it runs on fear and progress. It runs on the fear of progress and each other, not a desire to remediate the societal ills and even curb the individual actions or risks that correspond to heinous violence of all varieties. Again, blanket pretrial detainment should not be our default. It's just too vague. I want to rely and lean on my attorney friends at the ACLU, who have said that HJR 15's proposed expansion of pretrial detention without bail is just frankly too broad. As drafted, it authorizes the denial of bail for those who are accused of offenses that do not necessarily implicate public safety. For instance, second-degree aggravated assault does not require any actual evidence showing physical harm caused and can be charged when someone makes a threat with anything that could be considered assault with a serious deadly weapon, like a high-heeled shoe. We encountered a community member in Harris County within the past year whose son was detained for a very long time due to alleged assault with a hair comb. To have these hearings when defendants lack counsel, which would surely be necessary to make sure that they understand and properly navigate this constitutional amendment and may not be extreme safety risks, is wrong. I urge you to oppose this legislation and, at the very least, consider adding provisions that would curb its impacts and perpetuation of systemic harm and mass incarceration. Thanks. Again.
Thank you. Members, are there any questions? Thank you very much for your time.
Thank you.
Paul Castro again. Andy Khan. Yeah, he's right there. I'm keeping an eye on him.
Too many people stepping out. Okay? I don't even know what.
Andy, I'm sorry, Mr. Khan, I have you as Andy Khan with Crime Stoppers. Did you want to add that as Crime Stoppers for Houston, or is that?
Sure. Crime Stoppers of Houston. Sounds good.
I'm sorry. Did you want to keep it as Crime Stoppers, or did you want to? I wasn't telling you to do it. I'm
No,
asking.
I know. I
Okay.
get it. I agree with you. Crime Stoppers of Houston.
When we have permission to change it to.
Yes, you do.
Okay. And you're for the HJR.
Correct.
Please proceed.
I'm Andy Kahn, Crime Stoppers of Houston. I also serve on the board of Parents of Murdered Children and Surviving Family Members of Homicide, which is the only organization in this country in which someone else writes out your membership for you. And you've heard from several of the members here earlier today. I've been a victim advocate for over 30 years. I was in the mayor's office for 18 years. I was with the Houston Police Department for 8 years, and with Crime Stoppers since 2018. So I've seen a lot, been a lot. I'm going to read you something that was posted on a hearing on the same bill in 2023 by a Harris County Democrat judge. Normally, judges don't actually offer comments on legislation. For whatever reason, this particular...
I'm sorry. I ask to admonish the witnesses that they have to keep the testimony to the bill itself.
This is the bill. I'm testifying on the bill. I'm testifying, what I'm going to say is what a particular judge posted about this bill.
This bill that's on from, okay. So
It's the same language.
I can only admonish the witnesses, but
Well-
again, the issue is that our rules require it, and it could cause a point of order in the bill.
All right, I will rephrase that. I will just forget what I just said, and I will just take it from here, okay? Are we good?
Okay.
Thank you. Good. Public safety is a factor that is always taken into account when setting the amount of bail and the appropriate bond conditions for a case. However, in the event a judge finds there are no bond conditions sufficient for the protection of alleged victims or the community as a whole, there is no mechanism in our law to deny bail. Furthermore, case law has prohibited judges from setting bail in an amount specifically to keep a defendant in custody. Therefore, even if a judge believes beyond all doubt that a defendant is a danger to the public and alleged victims, the judge must set a bail that does not violate the defendant's right to liberty. By allowing judges the ability to hold a defendant without bail after a hearing based upon specific findings, judges would have a tool to address that shortcoming in our law. Now, some may be concerned that prosecutors could arbitrarily use this provision to seek denial of bail to all individuals where this resolution allows, but I believe this is unlikely to occur. The reason is a hearing is required to deny bail, and evidence has to apply in denying bail. I, like many other Texans, am always skeptical of increasing governmental powers. But I do believe that this resolution will have a positive impact on public safety and will advance our criminal law towards a fairer system of pretrial detention, a system based on risk. That's what this is about. Now, you heard, and I heard Representative Wu talk about this isn't a DNR issue. I'm going to read some quotes from Harris County elected officials, Democrat elected officials. Sheriff Ed Gonzalez, it's inexcusable cutting loose dangerous repeat offenders on bond. Mayor Sylvester Turner, the late Mayor Sylvester Turner, former state representative and congressman, at a press conference. It needs to stop. We should not count on ankle monitors to track violent criminals.
let me acknowledge that any person who is out, for example, on 7 felony bonds is unacceptable. And there's no real justification for anybody to be out on 5, 6, 7 felony bonds. So let me just say it needs to come to a stop. We're all in this together. This was Mayor Turner discussing the murder of a 24-year-old mother and the shooting of her 1-year-old son by a habitual repeat violent offender on 7 felony bonds who was also wanted for bond forfeiture. I'll continue on with some more. You just heard last month from Senator Royce West. Basically, he stated right here, this is not a Republican bill. It's not a Democrat bill. It's a common sense bill. And his words ring true. And it's time that we have common sense, and it's time that you as a body allow Texas voters to simply decide whether this is a good bill or a bad bill. And that's all we're asking. I have documented, as part of Crime Stoppers, over 200 victims that have been murdered by defendants released on multiple felony bonds or PR bonds. Think about that. Multiple felony bonds or PR bonds. We've had police officers killed in the line of duty by defendants out on multiple bonds. There were 162 defendants that we documented in Harris County that defendants have been released on more than one bond at the time of the offense of murder. And I'm just going to tell you just a few right here. One defendant was out on bond for capital murder and was charged with another capital murder. That's never happened before. We've never had a defendant released on a bond for capital murder of a police officer. That just happened last month. It's time to change this, and it's time to put victims' rights and the rights of the public. And this bill will simply let Texas voters decide. Do not suppress Texas voters in deciding whether this is a good bill or a bad bill. And I could sit here all day and tell you cases. We do a weekly segment on local Fox News called Breaking Bond. We've been doing that segment for over 4.5 years. And that is unheard of in TV news, to be doing a segment every week on the same subject on different stories. But we never run out of stories. So with that, again, I will implore you, let Texas voters decide. And as far as, I think Representative Moody, I just want to go back to one thing. We were talking about victims' rights in a lot of this stuff. Keep in mind, defendants' rights, and rightfully so, are protected and codified in the United States Constitution. Still to this day, victims' rights are a mere courtesy. Think about that. Defendants' rights, rightfully so, but victims' rights. So if a defendant doesn't give his Miranda warnings, we all know what happens to the case, right? It's thrown out. But if you're a crime victim and you're not told of your rights, as we've heard, you know what happens? You might get a shrug of the shoulders. You might get an I'm sorry. That's the difference. Crime victims are the only unwilling participants in the criminal justice system. Everyone else chose their role. Law enforcement, defendants, prosecutors, defense attorneys, judges, victim advocates, but no one ever said, pick me, pick me. I want to be a victim of a crime. And it's the least we can do to make sure that their rights, their well-being, their due process is looked after. Thank you for your time.
Members, are any questions? Thank you very much.
Thank you.
Next up is Kristen Budwine. Hi, Ms. Budwine. I have you as representing the Texas Civil Rights Project, and you're testifying against the XJR.
Yes, sir, that's correct.
Please proceed.
It's been a long day. Thank y'all so much for giving me the opportunity to speak today. I want to first say that we have visited with Chairman Smithy's office on all of the bail bills that I will be opposing today, and they have been open to discussing our concerns. So I want to thank his office for that. And before really getting into like the nitpicky piece of my testimony, I want to say that unfortunately, this conversation about public safety has been highly politicized.
I'm sorry. I was just told I screwed up. Could you say your name, your full name for the record?
Kirsten Budwine.
Thank you.
Yes, sir. So unfortunately, this conversation around public safety has been highly politicized. The binary that you're either on the side of the victim or the side of the accused is false and unnecessarily divisive. TCRP is a proponent of community safety, but we strongly believe that HJR 15 and the other bail bills that I will be opposing today do not promote that. Now into the nitpicky piece. Last session, and what you have in front of you is a packet that Nick from the ACLU put together, beautiful packet. And it shows that last session, a version of this joint resolution, at that time it was SJR 44, was filed. The House Committee substitute by Representative Moody included substantial changes that would have mitigated the harms of the legislation if passed. Some of those changes included a guaranteed access to counsel where bail denial is considered, and a requirement that a judge imposes the least restrictive conditions when bail is set. HJR 15 brings us back to a version that is stripped of these procedural safeguards that would mitigate the harms that an expansion of pretrial detention would cause. Additionally, as currently drafted, HJR 15 contemplates preventative detention for people who are accused of committing a violent offense as defined by the Texas Constitution, which includes some offenses that do not necessarily implicate public safety. For instance, second-degree aggravated assault does not require an actual showing of physical harm caused to a person. This is a commonly charged offense, and only 14.1% of these cases in Texas result in a conviction, meaning that people might spend months or years in detention for cases that are unlikely to result in a conviction. The U.S. Supreme Court has made it clear and declared that in our society, liberty is the norm and detention prior to trial is the carefully limited exception. The Texas pretrial system is far from being aligned with this, and HJR 15 only pushes us further away. Thank you.
Thank you very much. Members, do you have any questions? Thank you very much for your time.
Thank you.
Next is Amy Castillo. Hi, Ms. Castillo. I have you as testifying for yourself, and you are for the HJR. Is that correct?
Yes, sir. Hello, my name is Amy Castillo. I am the sister of a homicide victim. I support this resolution. I come here today because my brother matters forever. His name is Joshua Sandoval. He is my little baby brother. Growing up, we doted on him. He was the most precious child. As we became adults, life pulled us in different directions, but I knew in my heart we'd come back together. I told myself, he's only 28, let him have fun in his 20s, and then he'll come around. And when he told his mom he met the one he wanted to spend the rest of his life with, I was happy. But then came May 27th, 2021, the day that happiness was stolen from us. On that day, a man already out on 2 felony bonds decided my brother wouldn't get to live out his life when he shot Josh in the heart. And as if losing Josh wasn't enough, we were forced to endure even more injustice. This man, charged with a capital murder while out on a felony bond, was offered another bond. How is this possible? How is this justice? There is something deeply, tragically wrong with the system that gives repeat violent felony offenders chance after chance, while families like mine are given a life sentence of grief. And when we learned his parents wanted to bond him out to bring him home for their holiday, another hole was torn through my heart. The first when he shattered Josh's. HJR 15 should already be a law. This should not be up for debate. Why in our great state are we allowing victims' families to suffer again and again? Why do more people have to die before this resolution is passed? I cannot bring my brother back. As much as I want to, as if I beg to see him again, I can't. But what I can do is use every ounce of what's left in my heart to fight. To fight for Josh, to fight for what is right. Joshua did not deserve to die like this. No one does. So I come to you today for your vote, not just for my family, but for yours, because this could happen to anyone. Thank you.
Members, are there any questions with this witness? Thank you so much for your time. Don't forget your... Next is Nancy Boya. If I said that right. And you're testifying, sorry, could you, did I say your name correctly?
Bola.
Bolo. Nancy, you're Nancy Bolo.
Yes.
You're testifying for yourself and you're for the HJR, is that correct?
Correct. My name is Nancy Bola, a citizen and a grieving mother, and I support HJR 15. I lost my beautiful daughter, Indigo Garza, to a man who should have never been free. Her murderer, John Marcus Arnavia, had a long history of violent crime. In less than 2 years, his misdemeanors escalated to violent crime, felonies. He was charged with aggravated assault with a deadly weapon, unlawful carry of a weapon, and deadly conduct, before ever being charged with murder. Yet every time he was arrested, he was let right back out. Twice he was released on PR bonds, allowing him to continue his violent pattern without consequences. This system didn't just fail, it encouraged his crimes to continue, and in the end, my daughter lost her life. If HJR 15 had been in place, repeat violent offenders like him wouldn't have been given endless chances. He would have been behind bars, not out in the world, taking an innocent life. Nobody else should know what it feels like to bury their child because the system kept letting a violent criminal walk free. You were elected to protect Texans. Please do not let another family suffer this excruciating pain. Please fix the system, stop enabling repeat offenders, and protect innocent lives. Thank you so much for letting me be Indigo's voice.
Members, do you have any questions for this witness? Thank you so much for your time. Next is Marnie Conrad. And did I see your name correctly?
Yes.
Okay.
Yes.
And you're representing yourself and you're for the HJR, is that correct?
That's correct, yes.
Thank you very much. Please proceed.
Hi. My name is Marnie Conrad, and I am the proud mother of 3 beautiful sons. I'm testifying today in support.
Could you get up close to the mic, please? I'm sorry.
Sorry.
It's not that.
This is my first time.
You can move the mic.
Can you move it?
Towards you. Yeah, there you
Is that
go. And tilt it down.
And-
Like point it to you.
Okay. Sorry, where was I? I'm supporting HJR 15, and I'm here as an individual and as a parent of my murdered son. And I want to tell you about the last hours of my 16-year-old's life, my Matthias.
On Thursday, August 22nd, 2019, my boys and I were getting ready for the start of the school season. Matthias was going into his sophomore year, and my youngest was a freshman. Around noon, Matthias got a message from an acquaintance from school. She seemed distressed and wanted him to meet her. He was a trusted friend, and he showed up for people. But he was conflicted. He decided to go when an Uber driver turned up at our door. We thought it must be something serious. "I'll be right back," was the last thing he said to me, and I believed him. The Uber driver delivered Matthias to a playground in a community near our home. There, while Matthias was waiting for his school friend, he was accosted by a violent felon, brandishing a gun and wearing an ankle monitor. The felon shot Matthias in the face at close range, and then as he was sauntering off leaving the park, shot him in his torso, punctured his lung, left him for dead. He recorded the entire event on his phone. He went home, told his dad what he did, put the gun up, changed his clothes, and took to social media to brag about it. He was very proud of what he did. Then he cut off his ankle monitor so that he could return to the scene that he created. And this was the only time his ankle monitor was an obstacle. Matthias actually survived this attack and was cognizant enough for a time to describe his attacker. But he died, never knowing who shot him or why. Hours later, and thanks to our community, Fort Bend County Sheriff's Office, and Crime Stoppers, the felon was arrested at his home and taken to Fort Bend County Juvenile Detention Center. This violent repeat felony offender was 16 years old. He made his criminal debut at the age of 12 when he was arrested for possession of a controlled substance. From there, his referrals became more frequent and violent. He knew what he wanted to be about. His violence was brash and cruel, and he splashed it all over social media for the world to see. And everybody did see, except his SISP, probation officers. His consequences were little more than inconvenient and often abandoned by the state. But he should have been detained the first, second, and third time he violated the terms of his SISP probation. Had he been, Matthias would be here, graduating from college this year. Instead, more effort went into protecting the optics and covering up errors that were made by the unchecked juvenile justice department in our county. All three of my boys died that day. They failed Matthias, they failed my family, and they continue to fail the communities that they're sworn to serve. Please see this HJR 15 through and let Texas decide. Thank you for your time.
Members, are there any questions? Thank you very much for your time. Sorry for your loss. Next up is Lakeisha Garcia. Will show that she registered against the bill but is not here to testify. Next up is David Gonzalez. David, I have you showing that you're representing the Texas Criminal Defense Lawyers Association and yourself. Is that correct?
Yes, sir.
And you're testifying against HJR.
Yes, sir.
Please proceed.
Practitioners look to you not just for the public policy, but for the rules on how to implement the policy. And that is explicitly in one sentence of the bill that we have some observations on, relating to what is clear and convincing evidence. And I know as criminal lawyers, we don't deal with it a lot as family lawyers do, but I know it's a lot. And I know it seems to be a significant amount of evidence to terminate parental rights. And so there's a line in the bill that just says this section may not be construed to require any testimonial evidence before a judge or a magistrate in a bail decision. And the reason we just have an observation is the Texas rules of evidence don't apply in every situation for some pretrial hearings, but on some they do. And on the first thing that we read is Rule 1.101, in proceedings to deny bail are governed by the Texas rules of evidence. So what we anticipate at some point is someone will file a motion to deny bail, and if there's no witness on a he said, she said, because it's just hearsay, a lawyer objects and says, I object to the hearsay. And then I don't know what happens, because I think that's part of the implementation, because now at some point, how much is clear and convincing evidence if there's no testimony? And it may be that in some situations you don't need testimony because there's a video, there's a confession, there may be other things too. But in others, there may not be. And so I know we're not going through all the implementation yet in this draft, but it's that one sentence that I think we just say can at least raise some concerns that we would continue to work with your office on. Thank you very much.
Members, are there any questions? Rep. Little.
Thank you, Chairman. Mr. Gonzalez, we have a really robust set of case law in the state of Texas concerning what clear and convincing evidence is, and really in all areas of practice. It's the amount of evidence necessary to demonstrate something is highly likely to be true.
Yes, sir.
It's not like we don't know what it is.
No, you're right. I'm sorry. It's not a standard in criminal cases that we use as much as in civil and family law cases, I should say. You're right.
You've got, typically you're operating from an evidentiary standard beyond a reasonable doubt, right?
Or probable cause. Yes,
Yeah,
sir.
or probable cause, which is, and clear and convincing is somewhere between those two standards.
I think it's higher than preponderance.
Yeah.
So yes, between those two.
Right. So what is the nature of the opposition of TCDLA to the bill? Is it just to the uncertainty of the evidentiary standard or the fact that it's too high?
No, quite the contrary. It's just that when it says that it may not require testimonial evidence in this, the fact that there's a hearing, the fact that there's clear and convincing to deny bail, we stand down on those because there should be hearings. The question then is, go ahead.
No, I'm listening. I'm thinking. Keep talking.
Well, it's just when it says that there's nothing that may require, it's not a shall. The question is, what does the implementation look like? Because I can imagine in some situations there may be required testimony for things like future dangerousness or flight risks, those predictive kind of things. And I just use federal court detention hearings as an example. Typically a case agent is testifying or proffering, or a pretrial service officer is testifying. Someone is providing some testimony as to flight risk. Those kind of, go ahead.
And so your question is, or the concern is, the statement in the joint resolution that says section may not be construed to require any testimonial?
Yes, sir, that's it. If that's struck, go ahead.
When I was reading that, I was thinking this is to ensure that it doesn't implicate the Fifth Amendment protections that are due a defendant. Am I missing it?
I didn't read it that way, but that's another way of reading it. It's possible that a client wouldn't have to testify or a defendant.
Okay, thank you.
Representative Jones.
I've got a quick question for you. I'm a member of TCDLA, by the way. Glad to see you here. I would imagine, how do you prove something without requiring testimony? How would you meet any standard? So I'm confused about that. Do you have any idea how you can prove something without, because evidence comes from the witness stand, which means the witness has got to get there.
Well, sure, there's a few ways. So for example, let's say there's a video. The last witness talked about this horrific video. I think that's clear and convincing evidence. I think there's a confession. There can be lots of different things. There can be forensic evidence. I don't know if we'll have it that quickly, but no, I do think there's circumstances in which there is evidence that meets the clear and convincing standard. On other cases where it's a flight risk or some other issues on those things that might require testimony, it's just our issue of what do those hearings look like when you don't have that kind of certainty.
And because I was also thinking about cross-examination, but when I was thinking about testimony, I was thinking you can't just show a video, you've got to authenticate it, and and make sure it's not, business records, affidavit, whatever it is. So when I think testimony, that's what I mean.
Yes, ma'am. Yeah.
So that was my confusion.
Yeah, I understand.
And what do you think about clear and convincing being as for all intents and purposes, a new standard in criminal law when like normally in criminal law, there's an established beyond a reasonable doubt. Or again, for PC, where the cops had a right to stop the car in the first place, or probable cause. Probable cause, because there's not even preponderance really in criminal. So I was just wondering what you thought about that.
No, we don't have objections to the standard, the hearings, to the limited focus of what the bill is for, that it kind of looks at the same 11A factors of which it's just solely that issue, that one line, what do those hearings look like? And I know this resolution only just puts that on the ballot, but as the next steps are, what does that look like? And it was just something that we had raised. So.
Thank you.
Members, are there any other questions for this witness? Right. Representative Cook.
It seems to me like this is a timing issue. And I don't practice criminal law, and I know that you do, so maybe this is more of a question than a statement. But could this be as simple as when the prosecution brings it, prosecution or law enforcement brings in a warrant with all of the evidence that they have at that point in time, where if they're issuing, the judge is considering and issuing a warrant, at that time, could they make a determination on bail based on the available information on the affidavit?
And I think it's the question of what is the hearing? And I know that when elected DA Tharp talked about the 7-day turnaround, that's what's so difficult on some of those issues. I can imagine there needing to be some flexibility for that to not be 7 days, but 30 days or 45 days. Because if it's going to be a hearing, you're right, Representative Cook, there probably has to be more than just the officer's report or the hearsay to be able to deny bail altogether, especially if that denial of bail on a felony might last for a year or 2 years. That's why the resolution has a heightened standard for clear and convincing. But those are good questions that I don't know what's there when it just says it shall not require or it may not require testimonial evidence.
It seems like it leaves it to the discretion of the court. The court may say, "Hey, I need a lot more than what I have here, and I'm gonna set up an evidentiary hearing." But he also may have, evidence in the form of an affidavit or otherwise that would be sufficient in his mind. Like you said, if you brought in an affidavit with the video, that shows eyewitness video of what happened, that's going to be most likely going to be sufficient based on any of the type of situations that we've heard in the last couple hours. Where you're seeing someone shoot someone in the head or in the face or in the heart, things like that. Where if there is video evidence of that, I wouldn't need any more testimony in order to do that. I would just be able to look at that and say, I'm not letting this person out on bail.
I think one of the practitioners is the judge. So imagine the trial judge says, I've heard the state's case on a motion to deny bail, and I don't think the proof rises to the level of what's there because, for whatever reason. And the state says, well, we object, but just because we didn't call a witness doesn't mean that we didn't meet that burden. But for that judge, they say, but I'm missing something, and so the inclusion of that phrase shall not or may not require testimony. I just think the trial judge looks to you to say, okay, what am I supposed to look at? Tell me what to weigh. Because it says that you should weigh all the factors, but I think often it involves a hearing with a witness to do that.
Thank you.
Thank you.
Members, are there any other questions for this witness? You're fine. I assume not.
Okay, sorry.
Thank you very much for your time. The chair calls Nick Hudson. And Mr. Hudson, I have you as representing the American Civil Liberties Union of Texas, and you're against the XJR. Is that correct?
Yes, sir.
Thank you. Please proceed.
First, Chair and Vice Chair Wu and committee members, I just want to say we have been working really earnestly on this with many of you for several sessions. Mr. Smithy, Chair Smithy, we're really grateful to your staff for meeting with us and listening to some of our concerns. Our concerns are about things that are missing from the SJR. Specifically, this is a really big expansion of the ability to deny bail, which is one of the most severe deprivations of liberty in our society for people who are presumptively innocent. Before people have had a chance to defend themselves in court, before the government has had to put on evidence against them. Really, all there is often a probable cause affidavit in these hearings. We want to at least ensure that we have proper safeguards in place to guard against unnecessary pretrial detention. In just one specific case, someone who was here earlier today who intended to testify on this bill or another it was Edric Wilson, who there's a front page story in the Houston Chronicle today. He spent 18 years in pretrial detention in Harris County, and the evidence in his case eventually demonstrated that he was innocent of the crime he was accused of, and that he was held in detention for. He just got out 3 weeks ago. And I didn't even know that that was possible, to be held in pretrial detention for quite so long. So the types of protections we're looking for, and they're laid out in the document that Ms. Budwine provided, are things like ensuring there's access to counsel at these hearings. We also have concerns about the testimonial evidence part. Some of the specific concerns are laid out in the document. We agree with the Texas Public Policy Foundation Right on Crime that the least restrictive conditions when bail is set should be added back in. There's also too low a standard for detention. The risk of non-appearance in court is something we should all really care about, but that should not be, it's not high enough a risk on its own to justify detention. What we want to aim for is something more like willful non-appearance or flight from the jurisdiction. That would more narrowly target this in a way that respects people's rights. The last thing I want to say about the specific list of offenses, Chair Smithy, I heard you say that this JR dealt with injury and death, and I don't think that's quite right. There are some offenses that are covered by the SJR, including second-degree aggravated assault, that needn't necessarily involve actual physical harm. It can be brandishing a stick or something like that. So we're just trying to get to a more narrow and targeted approach.
Members, are there any questions for this witness? Thank you very much.
Yeah, Brent Money. Thank you. I'm new here.
Sorry,
it's been a
still
long
learning
day.
everyone's names.
Yeah, no, that's perfectly
Dude,
fine.
I mean-
That's perfectly fine. I'm like you, astonished someone can stay in pretrial detention for 18 years. I would have been shocked within 18 months or more. And so that is troubling and concerning. We've heard a lot of troubling and concerning stories tonight. A lot of them seem to have come from Harris County on both sides. So that's an issue that, I guess voters there need to sort out. The way I see this as being different than the previous one we talked about, though, is that this really just gives it gives the judge a tool by which he can determine to deny bail. So it's not a requirement to deny bail. It's just allows for a procedure whereby the judge could determine that he would deny bail, and so. And then he has to answer, presumably, to his voters about whether he has used that properly or improperly and go through that. So can you speak to that and how, I look at it as additional tools for law enforcement and a better opportunity, and not just law enforcement, but the justice process. Can you speak to that and why that is so concerning to you?
Yeah, you are right. This can be distinguished from the other one, and the other one mandates denial of bail in certain cases. This one allows denial of bail by judges in certain cases. What we are trying to get to if we're going to modify the denial of bail statute, which is again, this is a very serious power that we would extend to the government, and for many more cases in this particular version, is we want to make sure that we have people can only be detained for really good reasons after a really fair process. I think that's like that's the framework I would think about when I'm thinking about these types of things. And I think if I don't know if you've seen magistration hearings, if you haven't, I recommend going to some in your own jurisdictions. You heard from a previous witness, they often last a minute. These are not fair hearings where there's a meaningful individualized consideration a lot of the time. And what we just want to make sure we do is that before the government can take away someone's freedom, before they've had an opportunity to defend themselves, that there's a high standard for the government to do that. And I'll just also note, on the particular version that was voted out of this committee last session, we went neutral. We dropped our opposition to it because it got it was in such a better position than this particular version. So if y'all are thinking about what you need to do to pass this, I think that raising the standard for detention would be a helpful way to go about it.
Thank you.
Members, any other questions? All right, thank you for your testimony.
Thank you.
Chair, next call is David Gonzalez, or no, he's already testified. So, yeah, you were David, right? Yes, sir. Oh, all right, thank you. Joy Davis. Ms. Davis, as you're getting situated there, have you registered as Joy Davis with the Pure Justice Action Fund and also registered on behalf of yourself, and you're against the HJR 15, is that correct?
That's correct.
Okay, please proceed.
My name is Joy Davis, and I oppose this bill. The criminal justice system is not perfect. Depending on the nature of your charge can also trigger biases on whether or not a lawyer will represent you, or if a judge just wanted to deny your bail or make it difficult for you to post bail. If enacted, this could probably impact thousands of people across the state. With the denial of bail, the punishment is happening before the conviction for thousands. There are extremely high costs for maintaining jails and large prison systems, which burden taxpayers. Jail overcrowding impacts the safety of not only those who are incarcerated, but the staff and contractors who work there. County jails consume significant county budgets, diverting funds from potential essential services like victim services, education, work programs, community health care programs, infrastructure, housing, and more. Harris County had to spend over $50 million on diverting and incarcerating individuals in other cities and states to help alleviate the overcrowding of the Harris County Jail, which this bill would also cause. There has to be a way of reforming people, helping people, rehabbing people, because continuing to do the same thing over and over again is proving that it is not working. So people who have been charged with these crimes need to have access to services and programs to help this. And we also need to look at the root causes of why people commit these types of crimes anyway. Thank you.
Remember, any questions for Ms. Davis?
I have some questions.
Okay, Representative Little.
Ms. Davis, thank you for being here to testify today. I was not familiar with Pure Justice Action Fund, so I looked it up, and my understanding is it focuses on criminal justice reform and economic equity issues in Harris County and surrounding areas. Is that right?
That's right.
Okay. Almost every one of these stories that we've heard today from all these people who have lost family members to violent crime are from Harris County and the surrounding areas.
That's right, include myself. That's right.
Doesn't seem like it's going well.
It doesn't.
What's the answer? If this is not the answer, what's the answer?
The answer is we need to look at why it's happening in the first place. Because someone just stated that somebody had committed a crime against them, then a couple of weeks later the same thing happened again, months later. But we're not looking at the root causes of why people do the crimes in the first place.
What are the
what's
root
happening.
causes?
I would say poverty, lack of access to resources, having to make decisions that could impact someone's life. Like if you don't have the money to pay your rent, to buy your food, people are going to act out. People are going to do things that may cause them to act out of scarcity.
Ms. Davis, we got poor people in other parts of the state too.
That's right.
That are not shooting people in the face.
That's right.
Not killing random kids in cars on the freeway. So what might the other root causes be?
It could be mental health because you have rich people that are doing the same thing. So it could be mental health reasons that are causing that. But if you don't have access to mental health resources and these kind of services outside of the incarceral system, then I think we need to fund the programs beforehand, prevention programs.
What do you think we should do with someone for whom there is clear and convincing evidence that that person committed a murder? Do you think that we should grant those people bail?
I think people have, I believe, innocent until proven guilty. I truly believe that. And I believe, and if there is enough evidence to prove that this particular person did it, then they need to show that. And then not languish away in jail for years and no one gets justice like that.
Okay, if there's video of somebody in a convenience store shooting another guy in the face,
Okay.
is that sufficient to deny someone bail? What do you think?
I believe with the laws that we have already, if it's not capital, I believe it has to be capital in order for a bond to be denied, for there to be a denial of bail.
Let's assume it's not capital murder, just a regular old run-of-the-mill shooting a guy in the face at a convenience store. Do we deny that person bail or not?
It depends on the laws and the statutes of the state, and that would be up to the judge, that would be up to the DA, whether or not they want to deny that hearing. That's not up to me.
Do we think as a general rule we should deny that person bail?
I believe people are innocent until proven guilty. And so wherever statutes that are already there, there are procedures already put in place to determine whether or not somebody should be denied bail.
Okay, thank you.
Thank you.
Any other questions for Ms. Davis? Representative Riddell?
Yeah, I actually just wanted to answer your question real quick, Mitch, if I could. Can we get you here also? So anyways, there's a quote by Frederick Bastiat that I like a lot that I think actually answers what you were asking. And it just says, now since man is naturally inclined to avoid pain and since labor is pain in itself, it follows that men will resort to plunder. Whenever plunder is easier than work, history shows us quite clearly. We don't have the consequences. The punishment doesn't equal the crime right now, so people are taking the easier path than having to do work itself. So.
All right, next, Mr. Chair recognizes Representative Ramos.
Ms. Davis,
Yes.
thank you for coming and testifying today.
Thank you.
Do you know what the #1 cause of child deaths are in Texas?
It's from their parents, if I'm not mistaken.
It's from guns.
Guns.
And we've heard a lot of the testimony today, getting shot in the face and that. You know, what's the answer? I think there are many answers, but one of the answers is not the easy access to guns in our streets. And unfortunately, that is part of the problem. I mean, poverty, absolutely. Systemic racism, absolutely. Systemic injustices, absolutely. But guns, we cannot ignore. Pretty much everybody who testified today spoke to that, and children. And that's the #1 cause of deaths of children in Texas and probably the country. And we are the mass murder capital of the country here in Texas. So thank you for testifying. We don't expect you to have the answers. We obviously don't have the answers. In fact, we make things worse many times. But thank you so much for being here today.
Thank you so much. Okay.
Members, any other questions for Ms. Davis? All right, thank you for your testimony.
All right, thank y'all so much. Have a good night.
Thank you, you too. All right, Chair, next call is Travis Fife. I do not see Mr. Fife here. Is there anyone else that was intending to testify on HJR 15 that has not been called? All right, that concludes the testimony, and Chair recognizes Chairman Smithy to close on HJR 15.
Thank you, Mr. Chairman. Once again, because of the hour, I'll just go ahead and close it. We'll continue to work on this JR and hopefully get a good product out.
And I'll pass the gavel back to Vice Chair Wu at this time.
Chair call up House Bill 75.
Thank you, Mr. Chairman. House Bill 75 is probably the one that we've received the most input on, and it's one that we're working on trying to resolve some of the issues that people have brought to us. I think overall it's a very good concept, but it's designed to put some of the provisions in place that these constitutional amendments authorize. It makes several changes related to setting bail and releasing defendants, as well as to changes to reporting that's already required by charitable bail organizations. So Article 1517 of the Code of Criminal Procedure lays out the duties of an arresting officer and a magistrate with respect to an arrest under a warrant. These duties include taking the arrested person before a magistrate And within 48 hours of the arrest, there the magistrate must, among other things, inform the arrested person of his or her rights. This bill would amend 1517 such that the magistrate determines that no probable cause exists to believe that the person committed the offense for which he or she has been arrested. A determination of no probable cause must be promptly made on the record within 24 hours, along with oral or written findings of fact and conclusions of law to support the finding. The bill does several other things. One, it would prevent a criminal law hearing officer appointed under Chapter 54 of the Government Code, which would include masters, magistrates, referees, associate judges, from releasing a defendant on bail who's charged with committing an offense punishable as a felony if the defendant was on parole at the time of the offense, had been previously convicted of 2 or more similar offenses, or are subject to a U.S. ICE enforcement detainer or charged with certain violent or sexual offenses. We would also restrict, with some exceptions, the release of defendants on personal bond when that defendant is charged with certain violent offenses or violation of court orders or condition of bond related to family violence, child sexual and trafficking offenses, and unlawful possession of a firearm. We also, in House Bill 75, changed the reporting requirements for charitable bail organizations. These organizations now are required to send reports directly to the Office of Court Administration, but what the bill proposes, right now they send them to the sheriff or county of their county, but this would require that they be sent to the Office of Court Administration. If they fail to file the report or a violation is suspected, it could lead to suspension of their bail organization from paying bonds in that county. It also would prevent magistrates from modifying the amount or conditions of bonds set by the judge of a district court. It would also require a felony defendant to appear before a magistrate and for the magistrate to consider the defendant's public safety report before the magistrate can release the defendant on bail. And finally, the bill would allow the state to appeal an order that grants a bail considered insufficient by the prosecuting attorney in cases where a defendant is charged with the offense punishable as a felony and has previously been granted bail for a similar offense. In that case, the bill would require the defendant be held in custody during the appeal. And so that's just a flyby summary of what the bill's designed to do.
Thank you very much, Chair Smithy. Members, are there any questions for the chair? Hearing none, call up our first witness, Stephen Vicorito. Good evening, Judge. Would you please tell me, did I say your name correctly?
Vigorito. Yep, you said it fine.
And you're representing yourself?
I'm representing myself. I'm here in my personal capacity. I can tell you that I am.
And you're neutral on the bill, correct?
I am neutral on the bill. I am a judge for the city of Austin, and I'm actually the primary daytime weekday magistrate down at the Travis County Jail, a few blocks from here. I'm testifying as neutral on the bill because I think that, given my position, that I should just extend myself as a resource witness under these circumstances, given the kind of legislation that you're offering. So I am, but I'm not representing the city or the county. I'm simply expressing my opinions in my personal capacity. I do think that this bill has a lot of good provisions in it that builds on and tightens some things up that in terms of Senate Bill 6 and trying to make sure that magistrates have the kind of information that they need to make good decisions on bail. That stated, I do want to bring to your attention 3 issues in the bill that I do think deserve your attention and that might be of some concern. First of all, the provision at the beginning of House Bill 75, it's Section 3. It talks about Chapter 54 magistrates being limited in their ability to set bonds. And it indicates that magistrates appointed under Chapter 54 would not be allowed to set bonds on a certain number of violent offenses plus certain felonies where there's an immigration detainer or prior penitentiary trips and things of that sort. I think it may not be apparent to everyone that, and so I want to make clear that that if passed in this form, it will actually require counties to create 2 tracks of magistration. And I can tell you that in large urban areas like Dallas County and Tarrant County and Travis County and Harris County, where this is a very large operation with hundreds of people being arrested sometimes in a particular day, this creates a situation where we have to now have a separate bucket of people who are arrested who now cannot be magistrated by certain types of magistrates who have been appointed for this very reason, to get the system running efficiently. And now we have to find some other judges to do it. Now, who is that going to be? Well, it could be the district judge who takes a break from his felony trial to come on downstairs and spend a couple of hours dealing with this bucket of cases. It could be that we call in a JP or a municipal judge who is not a Chapter 54 magistrate, but who also does not have to be an attorney in Texas. The reason I'm expressing this is because there is a real logistical and fiscal impact to large counties if this goes into effect. And I do want to highlight something in terms of the language of the bill. Chairman Smithy, your bill uses the term criminal law hearing officer. That is actually a term of art that only refers to 2 particular counties in Chapter 54, Harris County and Cameron County. Now, Senator Huffman, when she passed Senate Bill 9 out of committee in the Senate, she changed that language from criminal law hearing officer to magistrate, and therefore, by that change, has it affect all counties in Texas. I just want to make sure that there is an understanding of the difference in that language. And so depending upon which language you use, if you use the magistrate rather than criminal law hearing officer, it's going to affect all counties in Texas. And I would just urge those of you who represent large counties that you may want to contact your judges to find out what kind of fiscal impact is this going to have. And when I say that, I will tell you, this means that you're going to have to find other judges on weekends, because when a person gets arrested, they have the law requires bail to be set within 48 hours of their arrest, which means someone who's arrested on Friday night, they need to have their bond set by Sunday, which means counties are going to now have to farm out some duties to some JP or municipal judge to come down there, because I'm pretty sure a felony district judge is not going to want to do it on Sunday. They're going to have to start contracting out for people to come down there on Saturdays and Sundays. I'll also note that if we're talking about that bucket of cases, including felony arrests involving immigration detainers, most of them are going to need an interpreter, which means now you have prolonged hearings. This is not, I'm simply expressing to you that this is not a small endeavor, and it's going to have some real fiscal and logistical impacts to counties. And so I would just express some concern that to make sure that this is really what you want to do, given the kind of impact it may have on your counties. So that's the first thing that I wanted to highlight, and glad to answer any questions on that. The second thing I did want to highlight, and that is, as you know, Senate Bill 6 in 2021, which many of you were here as part of those deliberations, it prohibited personal bonds on a laundry list of violent felonies. And in fact, Representative Moody went through that long list. It's quite an extensive list. And I could tell you reasonable minds disagree on this, but there is certainly a legitimate rationale for that type of policy. When you're dealing with an aggravated sexual assault and you're looking at potential exposure of 5 to 99 years in prison, the idea that you probably should have some skin in the game with cash or a bail bond company and therefore a bounty hunter coming after you if you don't show up, that makes sense. There is a rationale for that. Now, the reason I say that is because for the first time now, this bill is now adding a charge, terroristic threat, which is for 80 to 90% of terroristic threat charges, those are misdemeanors. And I do want to share with you that I do have some concern about that I do want to express. Because I could tell you that on most of these cases, terroristic threat, these are misdemeanors that in most instances are punishable up to 180 days in jail, sometimes up to a year in jail if it involves a family member or a public servant. These cases, if they don't get out of jail, but they claim innocence and they want their day in court, they will likely spend more time in jail waiting for their trial than they would have gotten if they got the maximum sentence from a jury or a judge. Because they're not going to get that trial in 2-3 months, not with the backlogs that we have. And they generally, in your sentencing in Texas, you're going to get 2 for 1. For every day in jail, you're going to get 2 days credit. So if you get a max of 180 days on a Class B misdemeanor, that's 3 months. Rarely are you going to get that trial in 3 months. So you have a situation where, in this situation, you could have a person that has never been arrested in their life. Never in their life. Highly contested allegations, highly conflicted and contested fact witnesses where they claim their innocence. And if they don't have money, they sit. And I can tell you that the studies have demonstrated by empirical evidence that a tremendous amount of people in those situations, the coercive element of the criminal justice system operates and they just plead guilty. They say, well, because the defense attorney says, well, look, you signed this paper, you'll have a conviction on your record for the rest of your life, but you're out today, you're back home with your family. Or you can have a trial, hopefully we'll get to that in a couple months. And I share this because as a magistrate judge, I'm very, very concerned about not only the rights of defendants and the due process concerns of people having their fair day in court. I'm also concerned about the safety of the community. Every single case is a factual determination to evaluate whether or not there's probable cause, what is an appropriate bond, and whether personal bond is appropriate. I can tell you that I have denied personal bond requests on terroristic threat many, many, many times. I can also tell you that I've granted personal bond in many instances. Every situation is different. And when you add this provision into the bill and take away the discretion of a magistrate to issue a personal bond in a misdemeanor case when appropriate, when it appears to the magistrate that there is not danger to the alleged victim, there's not a flight risk, maybe they've never been in trouble before. In some instances, I could tell you, we'll get the victim, the alleged victim, calling the jail saying they want them out of jail, and that this was a big understanding. Now, whether one believes that or not, there are situations in which that's not credible. There's situations where it is.
I'm going to pause right here and just admonish you to please stay on the topic of the bill.
Yes.
Just
absolutely. Well, what I'm referring to is the bill is prohibiting personal bonds on terroristic threat, and I'm stressing that taking away that discretion. You folks had a very spirited discussion earlier today on House Bill 799, which is talking about mandating personal bonds on a lot of misdemeanors. And I can understand a lot of the arguments there. I think it's a discussion worthy of having, but I can appreciate everyone's very legitimate concerns and passions about those things. This is different. This is saying, you know what? They may have never been arrested in their life. There may be highly conflicted factual situations, but you know what? Too bad. The judge can't give them a personal bond. And I can tell you in my experience as a magistrate judge now for 15 years, and I can tell you I teach. I am the primary trainer of all the municipal judges in Texas for bail and bonds. I am the primary teacher at the judges' CLE conferences on bail and bonds for the people that the municipal judges that get appointed in your district. I've been invested in this area for a long time, and I can tell you that the discretion that the magistrate has to issue a personal bond when appropriate is a crucial tool to make sure that the system functions fairly and that it's not a pay-to-play system where due process looks different depending upon your level of affluence. And so I would just urge you to move with caution on on prohibiting personal bonds on a misdemeanor. I will tell you that
That's not this bill.
House Bill 75 is not,
Personal bond on misdemeanor.
it's not prohibiting personal bonds on terroristic threat.
It has to be a felony, yeah.
What's that?
The way I read it is it has to be a felony, terroristic threat.
Well.
Well, we can work
We-
that
we can
out.
take a-
We've
yeah.
got a lot of people still to testify, and it's
Sure.
already almost 10 o'clock, so.
Well, listen, I can tell you that from my reading of the bill that applied to misdemeanors.
Okay.
But if it only applies to felony, I can tell you that my objections are much more tempered, okay?
Okay, all right.
I have a real concern
Well,
about that.
Let some other folks kind of.
Members, are there any questions for
I've
this
got some.
witness?
Representative Jones, please.
Representative Jones.
I just have one question. What is a Chapter 54 magistrate?
Chapter 54 is a part of the Texas Government Code that is a hodgepodge of tailor-made statutes for each particular county. In fact, there's about 50 or so counties in there, each who over the years has a particular statute that authorizes them to appoint magistrates. And so over the years, a particular county may say, hey, you know what? Rather than using a JP to set bonds or a municipal judge to set bonds, we want to go ahead and appoint our own magistrates to handle the bail setting process in that county. They also appoint them for other reasons, suppression hearings and other things dealing with just overflow from the trial courts. And so different counties have a different statute. And so the term criminal law hearing officer is specifically referring to Harris County and Cameron County. The word magistrate, though, is referring to all of them. So if that helps answer your question.
Thank you. Rep. Little. Thank you. Oh, I'm sorry. I'm sorry. I apologize. Rep. Jones. I thought you just wanted. Okay. Rep. Little.
Judge Vigorino, I'm glad that you're here, and this is no longer an academic exercise. You're the daytime MAG judge for Travis County, right?
I'm the primary. I'm not there all the time, but I would say about 80% of the time I am the weekday morning judge down at the central booking a few blocks away.
Last year, 2024, how many people did you release on bail who were subject to an ICE detainer? Just estimate.
Sure. Subject to an ICE detainer, not that many. I could tell you that I generally only do it in certain cases on misdemeanors where the attorney comes in with a representation from an immigration attorney, not just them, that they have retained an immigration attorney who has demonstrated that there is clear relief when they're transferred to Pearsall. That, for instance, let's say that they have that either they may not have a green card, but that there is clear relief that they are actually not going to be deported. From my perspective, if there's any risk that they're going to be deported, it makes no sense for me to do a personal bond and transfer them down to San Antonio. They should just stay in Travis County and deal with the case. I hope that answers your question.
I'm not talking about personal bonds.
Okay.
So, page 1 of this bill.
Yeah.
Representative Smithy's bill. A criminal law hearing officer may not release on bail a defendant who is, and then there's a subset of categories that are
Right.
identified there.
So you're not referring to personal bond, you're certainly
No.
just setting bail.
How many
Right.
people have you, over the last year, as the MAG judge in Travis County, released on bail who are subject to an ICE detainer?
I would tell you that I have set bail because they're all entitled to bail. I'd say ICE detainers, I get probably at least one, maybe two a day, sometimes more. I would say that if you were to multiply that over a year's time, it's definitely in the hundreds of how many people that come in and get an immigration detainer. I have to set bail on their case, whether they have an immigration detainer or not. Now, it's up to them generally to hire a bail bondsman or come up with the cash.
So one a day for 2024, roughly?
No, I would say it may be higher. Now let me clarify. This is a 24-hour operation down at Travis County Jail. I just work for 8 hours. I would say from 6 in the morning to 2 in the afternoon, I'd say I get maybe two. It'd probably be a more accurate average.
So on a 24-hour period, we're talking about maybe 6 people on an ICE detainer a day who are released on bail, right?
Possibly, that'd be accurate. Yeah.
So 6 times 365 days, I'm not,
Yeah.
my math is
Might
not
be close to
amazing. Let's
1,000.
call it a couple thousand people a year
Close to 1,000, I would say, yeah.
who are being released on bail who are subject to an ICE detainer. Is that accurate?
You know, I think that might be. I don't know the exact figures.
And if this bill passes, you won't be able to do that anymore, right?
If this bill passes, I would still be able to do that. I'm not a Chapter 54 magistrate. I'm a municipal judge. Now, if the bill passes, if the constitutional amendment passes that prohibits setting bail on ICE detainers, then if they're, the whole issue of whether they're legally here, then that would prohibit me from setting bonds. I can tell you that the current legal rubric requires me to set bond whether there's an ICE detainer or not. Now, obviously, if there's an ICE detainer, it's harder for them to obtain release from jail on that bail. I hope that answers your question.
And in your opening statement, you said that there's going to be a fiscal impact as a result of this bill. Could you just detail that for us a little bit?
Yeah, I don't know what the impact would be. What I could tell you is that...
What's the point of origin for it?
Point of origin?
Meaning, what will we be paying for, even if we don't know what the cost is?
Sure. So if you're dealing with a county, like, for instance, I believe Denton County, Tarrant County, Harris County, Travis County, probably a number of other counties that use Chapter 54 magistrates, Travis County is moving towards that, and they will, and I'm not one of them. But once they move towards that, if you pass this bill on capital murder, aggravated assault, aggravated kidnapping, aggravated sexual assault, felons that are on probation or parole, felons that have an immigration detainer, and felons that have 2 prior pen trips, I can't tell you how many people that adds up to on a daily basis. I would suspect that it might add up to, I don't think it's going to be high. I think it'd be probably on a daily basis, maybe 10, maybe more if you got a really bad night, and it might be 15. So those 10 or 15 are going to have to be thrown in, and actually it could be higher. I take that back. It could be higher based upon the 2 prior penitentiary trips. That could get it into 25 or 30, to be honest with you. I see some long criminal records, to be honest. So that could get it up to 25 or 30. Now, those folks are going to have to be magistrated by somebody else.
In theory, it's going to be a district judge, right?
It could be.
But not a Chapter 54 officer.
Right. I could tell you that it will usually be either a felony district judge, or it will be a JP or a municipal judge that they bring in to do it, because they're not Chapter 54 magistrates, and so the county would probably contract with them, particularly on weekends, to do that. That's my speculation on it, and I'm just letting y'all know that this is a when you have 150 people arrested in a night, it is important to be efficient and to keep that thing moving so that people who get arrested on a DWI don't get their bonds set 2 days late. 2 days later, and they might lose their job. And so the point is when you create a system where now you have to have a separate track for a whole group of people, and you actually don't know who those people are when they first come in because you haven't run their criminal record yet. You may not know that there's an ICE hold yet. And so it may take some time to find out that they're a felon, that they're arrested for felony and they're on probation. You put them in this bucket, and now you have to find a way to get them magistrated by someone else. I'm just sharing that it is a logistical hoop that needs to be run through. I'm not saying, oh, this is a horrible idea. I'm sharing that I think that it's important that you be aware that this is not just a ho-hum thing that is not going to have an impact on the county in terms of how they do it.
Well, and
I want to be fair about that.
No, that makes good sense. And I find myself asking, where do I sign the check? Because you've got a group of people who are being magistrated out who I think the thrust of this bill is that we've decided that there is a handful of offenses and people who deserve a higher level of scrutiny with respect to bail decisions, primarily a district judge.
A district judge.
The one thing that bothered me that you said is somebody's going to go, oh, Chapter 54 officer can't do this. Where's the nearest muni judge I can pull over here to do the exact same thing? That troubles me. So how does that judge that muni judge or whoever's not a state district judge get, I'll use the word deputized, to carry on the functions of a Chapter
Sure.
54 officer?
I think that's a great question, and I brought this up because of the irony of it. And the reason I mentioned that is because of the irony of it, because I wanted you guys to be aware that by prohibiting Chapter 54 magistrates from setting bond does not necessarily mean that a felony district judge is going to do it. In most instances, particularly on weekends, they will try to contract with a justice of the peace or a municipal judge to come in and set the bonds because they're not Chapter 54 magistrates. I could be wrong, but I suspect that the felony judges in your county are not going to have to come down there on the weekends to set these bonds. Now, I could be wrong.
Maybe they won't. Maybe those people will sit in jail. I don't know. But the concern that I have is
Yeah.
that somebody's going to go, oh, well, Chapter 54 officer can't do it, so well, I'll just ask the local JP, who's my friend, to come down here and turn these same people loose on an ICE detainer. They're not a Chapter 54 officer. Am I wrong about that? Am I wrong to worry about that?
No, you're correct, and that's what I'm sharing with you exactly that you need to be aware that if you prohibit Chapter 54 magistrates from doing it, then the county is going to either use the district, likely to use the felony district judge or a JP or a municipal judge because they don't fall in that category. I'm agreeing with you. I'm telling you that may be an unintended consequence from the decision that you're making here by prohibiting particularly Chapter 54 magistrates from setting bonds on these cases. And I would stress that regardless of who sets the bond, the rules are going to be the same. If they have an immigration detainer, unless that constitutional amendment passes, they're still going to be entitled to a bond to be set. Now, whether they're actually going to be released on bond is another question. But I'm going to have to set some type of a bond. The law requires it. I'm not going to do a personal bond, except in very rare cases.
Yeah.
But I will have to set some type of a bond. What I'm saying is that's going to be true whether you say, hey, this particular type of judge can't touch those cases. Well, some judge is going to have the same rules that they have governing setting of the bail, and so the bail is going to be set by somebody. I don't want to dismiss, I want to be fair, I do not want to dismiss that there is a rationale behind saying we don't want Chapter 54 magistrates setting these bonds. The understanding I have from speaking with the staff in Senator Huffman's office directly is that they have said we feel that on these particular serious cases that the bail should be set by someone with a higher level of accountability than merely being appointed by the other judges. In other words, an elected official like a district judge or a JP, which is elected. Now, most municipal judges are actually appointed by the city council, but some are elected. But the rationale that has been communicated to me is what she is saying is we want, on this particular bucket of cases, we want an elected official who has a greater level of accountability to the public who's setting those bonds. I want to be fair. I want to fairly characterize that is. It appears, my understanding, that that's the position of Senator Huffman's office, and I don't think that that's without a rationality. I recognize that. I'm simply communicating to you that when you're going to pass legislation, you do want to be thinking, well, is this a prudent way to accomplish what we're accomplishing if we're actually putting the counties in a position where they now have to create 2 tracks of magistration on weekends with interpreters, and I wanted to suggest that you might not actually be getting the felony district judge doing it. It might be a JP or a municipal judge. I'm agreeing with you on that concern.
Thank you.
As a municipal judge, I don't mean to insult myself.
No, not at all. Members.
We really need to move on, yeah.
I'm sorry, any other questions for this witness?
I would just say one last thing, and that is my understanding from Senate Bill 9 that passed the Senate is terroristic threat is banning personal bonds on anything charged under terroristic threat, which includes 80 to 90% misdemeanors. Now, Chairman Smith,
we'll check on that.
I may be mistaken on that, but that's my understanding.
Okay. Rep. Lauterbach has a question.
Yes. Yes, sir.
You go to the Travis County Jail for magistration?
I do.
Is that where you go? There's any ICE people there?
Are there what?
Is ICE ERO there?
ICE?
Yeah.
Oh, yeah. Yeah, we have ICE detainers all the time.
They have an office there?
As I shared, I get a couple of them a day, maybe.
Do they have an office there? ICE
Do they
itself,
have an
ICE,
office
ICE
there?
ERO.
I'm not aware that they had their own office
Okay, thank you.
in the jail, if that's what you're asking. I'm not aware of it. I know they come to pick them up.
Members, are there any other questions? Rep. Jones?
Question for you. In the rural counties, I know sometimes they don't have like a designated judge, and they'll have a judge that'll go to court at a certain court on a certain day, or right? So they don't have them there all the time. Do you know what happens in that case when they literally don't have a judge there every
Sure.
day?
I would tell you that in my understanding, in rural jurisdictions, there's no point to have a judge there 24 hours a day, because they're just gonna be twiddling their thumbs a lot of time. What normally happens, in my understanding, in most jurisdictions, is either a justice of the peace or a municipal judge will be responsible to come to the jail in the morning and magistrate everybody who got arrested in the previous 24 hours. And if it's a JP or a municipal judge, the Chapter 54 prohibition will not affect them. If, on the other hand, it's a rural county that has appointed a Chapter 54 magistrate and given them the primary responsibility to do that, which means that's their morning duty, at least on weekdays, well, then it will be a situation they will have to farm it out to someone else, or they'll have to get the district judge or a county judge to come on down to the jail and handle that docket.
The second and last question is this. You say you understand that Senator Huffman's wants an elected official who's accountable.
That's right.
And so this doesn't have anything to do with, we want a judge that's actually a lawyer.
That's not my understanding, because my understanding is that the Chapter 54 magistrates, there are a lot of Chapter 54 statutes. I've not read them all, but almost all of them that I've ever read. I've never read one that says that you didn't have to be a lawyer to be a Chapter 54 magistrate. My understanding is all Chapter 54 magistrates are lawyers.
No, I know that. I'm talking about like JPs. So they're not
JPs
Chapter 54 magistrates, but
No.
JPs don't have to be
No. and
lawyers.
my understanding is the majority of JPs in Texas are not lawyers.
Okay, thank you.
That's right.
Quick question.
Representative Cook?
Were you aware that we had 28 witnesses left to testify tonight?
I apologize.
No, I was just curious.
Did I dominate the
No,
time?
no, you're good. Thank you.
Well, I guess I would just say.
That was more for my colleagues than you.
I have been here since for a long time, but I appreciate what you guys do. God bless you.
Members, are there any questions with this witness? Seeing none, thank you. Thank you for your time. Next up is Eric Martinez. Eric Martinez does not appear to be here. Let the record reflect that he is testifying against HB 75, but is not testifying. He's registered against HB 75, but is not testifying. Okay. Aaron Johnson. Why is that one? Mr. Johnson, I have you as the president of the Texas Association of Pretrial Services, and you're testifying against HB 75. Is that correct?
Correct.
Thank you. Please proceed.
This is a mirror of Senate Bill 9, which we also provided testimony on. The fundamental reason for the 1517 hearing is to determine the probable cause hearing. Judges have discretion in how that is completed, and probable cause is not found. It's not always based on fact and conclusion of law, so mandating that would require every scenario to be considered, make the process longer than necessary. There's also no data regarding how often this occurs, or making a change of this magnitude might actually be needed, or would be beneficial, and make such a finding could be interpreted as instructing the arresting officer on what they need to do versus the burden being upon the prosecutor when they decide if they're going to move forward with a case. Normally, the affidavit's already been reviewed by the district attorney, so the burden is on the state, not the judiciary. There was a provision in here where parole is singled out in the bill, but according to 17027, anybody that's on pretrial probation and parole, according to OCA, still has pending. The case is still pending before the court till fully disposed. So bail denial for Part 2 doesn't appear to be necessary, as they're already available for denial of bail under the Texas Constitution. Further restriction of personal bond is unnecessary, as none of the charges listed are eligible currently. I feel the biggest issue is 4401A, Part 7,
creates a paradox in the bill. The judicial branch of government operates independently from the executive branch. Prosecuting attorneys already have the ability to recommend a bail amount. The judge does not have to use that amount recommended, just as they don't have to find probable cause. If this bill focuses on to limit who can be released, why are we talking about who has final say on a bail amount? If you're a danger to the public and need to be denied release, everyone else should be released on personal bond or least restrictive conditions, as they are not a danger, not a threat, because we've already established who's going to be held. Those are the ones we're worried about. And if they are not a danger.
I'm gonna admonish you as well to please stay on this bill and not. Again, we're not allowed by our rules to talk about other bills that are not before the committee.
Did I misstate what's in this bill?
No, I'm sorry. I thought I heard you say something else. If that's not what you said, then
Oh, I'm sorry.
please continue.
All right. I think they're not a danger and likely to show up 90% of the time with just phone and text message reminders, and I believe that's what 799 was looking at. In our opinion, the executive branch should not have an immediate override of the judicial branch in the 1715 hearing. It's only a hearing to determine release and detention, and on its face appears to be a violation of Article 13 of the Texas Constitution, as well as making bail a tool of oppression, which is against 1715, number 2. In our opinion, money should not be a criminal justice stakeholder, especially when there is no data supporting the use of money as a pretrial alternative. And with that, I am done for the night. I'll answer any questions you may have.
Members, are there any questions for this witness? Thank you very much for your time.
Everybody get home safe.
Thank you so much. Next is Emily Taylor. She is, we're going to let the record reflect that she is registering against the bill but is not testifying. Ken Good. Mr. Good, I have you shown as you're representing the Professional Bondsman of Texas and yourself, and you are for HB 75. Is that correct?
Yes, sir.
Okay. Please
I
proceed.
just want to make 3 points. Number one, on the charitable bail section of the bill, it makes no substantive changes. SB 6 did not limit any bond that was posted by a charitable bail fund. The changes make no substantive changes to that. It's only, we're changing, they file their report with OCA, the Office of Court Administration, instead of the sheriff, and then they change some things that need to be in the report. But we don't make any changes into what they can post. On the list of, the second point I want to make is there's some changes on the list of offenses not eligible for a personal bond. There's 4 added. You've already had some discussion talking about terroristic threat. It's currently on the list on 1703. It's currently in B2, and the change just moved it from B2 to B3. So I just want to make that point. And then the third point I want to make, I'll be so glad to be done, is talking about the limiting the magistrate's ability to set bail. I just want to give you the perspective from the bail industry. So when someone goes to the magistrate and have bail set on one of these very serious offenses, they come to the bail industry and they post a bond. Then several days later or a week later, they go see the trial court judge, and the judge says that bond is too low. So we had this discussion about how this is going to cost a lot of money. It is already costing money for the system because things are having to be redone. And then the bond that was originally posted that was only there for a week is being held insufficient, and then they're having to come back and to seek a higher bond from the industry. That seems to be repetitive. It seems to be the cause of the problem. And that is all I have. Thank you very much.
Members, are there any questions for this witness? Seeing none, thank you very much. Thank you for your time. Next up is Krishnaveni Gundu. Let's let the record reflect that she is she is registered in opposition to the bill but is not testifying. And I need to refresh this because it's doing it again. Jennifer Szymanski. let's let the record reflect that she is registered for the bill but not testifying. Darren Yancey. Let the record reflect that Mr. Yancey is registered against the bill but is not testifying. Do we need to fix this? I mean, we can't fix it if we want. He's not here to fix it. Okay. Emma Stamen? Ms. Stamen, you're listed as being a representative of the Bail Project, and you're registered against the bill. Is that correct?
Correct.
Thank you.
Thank you again for the opportunity to speak with you. My name is Emma Stamen, and I am the policy strategist at the Bail Project. I am here today in opposition to HB 75, which will undermine safety, freedom, and fairness in Texas's pretrial system. Passage of this bill harms all Texans, not just those accused of a crime, and will do nothing to protect public safety. Cash bail undermines freedom and fairness, creating a two-tiered system of justice that treats people differently depending on how much money they have. People who cannot afford bail are trapped behind bars for weeks, months, or even years awaiting trial. Yet rather than working to mitigate these harms, HB 75 increases Texas's reliance on cash bail by restricting the use of personal bonds. This legislation would mandate judges to impose cash bail more often based on accusations alone, regardless of individualized circumstances. Even when they believe someone poses no risk to safety or of flight, judges will not be able to release people without cash bail. For legislation that is meant to protect safety, HB 75 contains no consideration of risk or danger, instead creating a one-size-fits-all approach that would allow those with money to go free, regardless of their threat to others, while those who may pose no risk remain in jail. Cash bail was established as an incentive to help people return to court, not to keep them locked up pre-trial, but that is exactly what it has become. Even bail amounts lower than $500 are out of reach for many people and often result in pretrial incarceration. Research shows that 4 out of 10 Americans do not have $400 for an emergency, and nearly half of defendants are unable to pay a bail amount of $5,000 or less. The impacts of cash bail on individuals and their families can be devastating. According to studies, 37% of people who are jailed for just 3 days or more experience issues with housing stability, while 59% lost or were forced to change jobs. Pretrial detention can also cause a 30% increase in convictions, largely due to plea deals, and can add an additional 18 months of incarceration to sentences. And lastly, just a few days in jail can increase a person's likelihood of being rearrested in the future. This bill will threaten the public safety it seeks to protect by doubling down on the failed system of wealth-based detention. I urge you to vote no on HB 75 unless these issues are addressed. Thank you for your time.
Members, are there any questions for this witness? Seeing none, thank you very much for your time. Edric Wilson. Let the record reflect that Mr. Wilson, I think that's Mr. Edric Wilson is registered against the bill but is not testifying. Charles Cook. Show Charles Cook as registered for the bill but not testifying. Denise Cabanella. Show that Denise Cabanella as against the bill but not testifying. How are you supposed to pronounce it? That's Denise? D-E? Man, I ain't got time for this. Selena Ray. Y'all play too much. And I have you as register as representing Pure Justice and yourself, and you're against the bill. Is that correct?
That is correct, except for the last time today, I'm going to ask that it's Pure Justice Action Fund.
May we
instead of
have your
Pure
permission to change it to the Pure Justice Action Fund?
Justice. Please.
Thank you. Please proceed.
Thank you. All. While I oppose HB 75, which truly seems to lock away and throw away the key for many people seemingly indefinitely, I truly understand the need to be free of those who've harmed you. As a survivor of sexual violence myself during my childhood and domestic violence in my pretty recent adulthood, something that has always prevented me from working within the system is the feeling that I wouldn't be able to get pure justice, no pun intended. Justice would likely mean locking someone away pre-trial without any options to meaningfully participate in facilitated mediation with the party that they harmed, like me, or access deep clinical care for wounds that might be generational, psychological, or communal before they can harm themselves, potentially themselves or others, potentially for the first time. For me, justice does not look like HB 75. It doesn't look like continuing the pain. It looks like stopping it for all who may be involved. Personally, at this point in my short life, thanks to therapy and God, I know that someone else's pain and suffering and trauma is not justice. Justice is justice. To me and for many others, and while I don't speak for all survivors, of course, I know I am not the only one for whom pure, real, true justice looks a lot more like, as we've said today, distributing resources to be able to empower survivors to safely leave dangerous situations, not placing hordes of people, many of whom are parents and survivors of violence themselves, into incredibly dangerous, overcrowded, and deadly environments like jails and prisons. These are environments that folks often leave and recreate dangerous behavior that they're exposed to for the first place there. Justice looks like trusted adults and law enforcement actors centering accurate safety assessments and meeting people where they are, not for cash. It's not embroiling people in our cash bail system unnecessarily when we know, as many have said before, that it doesn't ensure safety and it doesn't deter crime. It is indescribably difficult for a child, a 12-year-old, to know that it might be easier, cheaper, and unfortunately convenient to not tell anyone about continual sexual violence because she has an awareness, a knowing fear that the system and the options that are laid out are not available to her, do not work for her, are not possible in her community because of what she looks like or because even what her perpetrator looks like. Is this how public safety is supposed to feel? I ask you earnestly and truly respectfully, is this what it looks like? Does it look like policies with cavernous loopholes and things that we can kind of understand are amorphous and ultimately difficult to do pragmatically or logistically? Is that what public safety is? Leaving more people stuck with less options and seeing that there are and having them experience less hope for justice and more stuck people because we're relying on a key factor here right now, cash. At the end of the day, in a courtroom, on both sides of the bench, at each desk, every family member sitting, every bailiff standing, innocent or guilty, people are people. And we owe it to each other as people working here to facilitate justice in these long days, to protect judicial and magistrate discretion, to clarify the rules to make sure people don't slip through the cracks for 12 to 18 years, and that misaligned priorities don't take center stage. I urge you to strongly stand against this legislation that would promote and enable actively unjust situations like getting caught in appeal clog, as we've known can be possible with Articles 44 as is currently written, or having little to no options to fight for your freedom, or eventually having to go into debt to fight bail, to make bail for terroristic threat charges that will ultimately be dropped. I again want clarification about the terroristic threat, felony versus misdemeanor issue, because as the Vera Institute reports, 92% of terroristic threat charges from 22 to 2023 are either Class A or Class B misdemeanors, things that I'm sure we don't want to put our valuable taxpayer resources, our magistrate time, and our citizens behind bars for. Representatives, please oppose HB 75, and if you must support it, please adopt provisions that will limit its harm to communities, its massive scope of incarceration, and its enabling and perpetuation of injustice. And I thank you for your time today. Yeah.
Thank you so much. Members, are there any questions for this witness? Representative Rodriguez-Ramos.
It's not a question, it's a comment. You're so fascinating to watch, and I look forward to your future career in politics, maybe replacing some of our Republican colleagues up here. Anyway, it's just wonderful to hear you. Thank you.
Thank you, Representative Rodriguez-Ramos, and your staff is very awesome too, I have to say.
Members, are there any other questions for this witness? Thank you so much for your time and being here.
Thank you all kindly.
Andy Kahn. And you're representing Crime Stoppers, and you're registered for HB 75. Is that all correct?
Correct.
Thank you.
Are we
Please
doing
proceed.
Crime Stoppers of Houston again?
Would you like to?
Oh,
use
okay.
Good. Would you like to change it? May
Sure.
we have your permission to change it to Crime Stoppers of Houston?
Absolutely.
Thank you.
You bet. I'm Andy Kahn, Director of Victim Services for Crime Stoppers of Houston, and I'm here supporting HB 75. Dominique Menifee was on parole for aggravated robbery with a deadly weapon. He was charged with a felony, and a magistrate gave him a PR bond. 6 days later, he murdered a woman, a mother of 3. That's just one example. I can give you other examples of magistrates giving PR bonds and defendants. Matter of fact, I've got numbers here that I've not shared with anyone, so I'll go ahead and share them now. So we got numbers in Harris County for a 2-year period, 2022 to 2024. Magistrates gave 22,208 PR bonds for felons. Now I'll give you some of the categories of offenses that were given PR bonds. The second highest one was burglary and robbery. Then came a nonviolent offense. Then came evading arrest, felon in possession of a weapon, a firearm, a gun. Everyone's talking about gun violence, right? Yet we give PR bonds to defendants charged with felon in possession of a weapon. I'll take it a step further. We also have possession of prohibited weapon, which is a machine gun. Now, you would not think that anyone would want to give someone a PR bond with possession of a prohibited weapon, a machine gun. But you would be wrong, because that's happening in Harris County as well. And I'll be more than happy if you want to go ahead and take a look at the list of this as well. Summing up, Senate Bill 6, when that went into effect in late December of 2021, Crime Stoppers saw the number of defendants charged with murder while out on multiple felony bonds and PR bonds plummet. And I mean drastically, almost an 80% decrease after Senate Bill 6 went into effect. So I'd just like you to consider that I have and we have seen documentation showing the numbers plummeting after Senate Bill 6, particularly for those charged with murder. So I would encourage you particularly to pass this bill. The numbers on the magistrates giving felons PR bonds are astonishing when you look at that, and that's just in Harris County. I can't imagine what it would be statewide, but I would think that this committee would want to know how many PR bonds are given to defendants charged with a felony in the state of Texas. I would encourage you to find that out. I'll be happy to share with you what we know from Harris County. Thank you.
Members, are there any questions for this witness? Thank you very much. Next is Kirsten Budwine, not Kristen. And you're representing the Texas Civil Rights Project, and you're registered against the bill. Is that correct?
I'm back. My name is Kirsten. I'm a policy attorney with the Texas Civil Rights Project, here to testify in opposition of HB 75, specifically Section 4 of this bill. So Section 4 of this bill adds to the list of offenses where a judge is required requires the accused to pay an amount of money to be released, effectively expanding Texas's cash bail system. This personal bond restriction builds on those that were imposed by SB 6. I won't go into that too much because that's already been mentioned. But as a result of SB 6, counties across Texas saw a sharp uptick in jail populations. Across the state, the total jail population rose by 6.7%, with some counties seeing a bigger increase. HB 75 cast this net much wider, prohibiting personal bonds for people charged with any of the 4 new offenses listed, including some misdemeanors. Realistically, this would mean prohibiting personal bonds for individuals with no prior criminal history. We are especially concerned with the misdemeanor offense of terroristic threat being included in the new list of offenses, as this captures a wide range of conduct, including people experiencing a mental health crisis or even 2 teenagers yelling baseless threats at each other. As mentioned, over 90% of terroristic threat charges statewide were charged as either a Class A or B misdemeanor, according to the very Institute of Justice. Requiring people to pay for their liberty has nothing to do with flight or public safety risk, the two pivotal considerations when setting bail. HB 75 would not make us safer, but it will further punish people for being poor and destabilize the lives of thousands of Texans. And for all these reasons stated, TCRP strongly opposes HB 75.
Members, are there any questions for this witness? Thank you so much for your testimony. Next up is Laquita Garcia. We will show Laquita Garcia as registered against the bill but not testifying. Marie Navarro. We will show her as registered against the bill but not testifying. Jennifer Tharp. I have you registered as representing the Comal County Criminal District Attorney, and you're registered for the bill. Is that correct?
That's correct.
And
myself.
Are you
I'll say
representing
it for you.
yourself? Okay, as yourself as well. Thank you.
Jennifer Tharp, Criminal District Attorney, Comal County, testifying in support of HB 75, testifying on behalf of my office as well as myself. I'm going to be real fast. I'd like to just highlight a couple sections that haven't really been discussed as of yet. Section 1, which deals with, in my opinion, adding some additional transparency and accountability. Where a magistrate makes the finding that no probable cause is there present, it requires the magistrate to make findings of fact, conclusions of law. I think this is a good accountability piece for law enforcement. Should it really be a situation of no probable cause, I think law enforcement command staff would like to be able to see that, to drill down what the issue is. Or perhaps maybe there was probable cause by law enforcement, but it might be an accountability or a transparency issue on the part of the judge that's actually making said finding of no probable cause, which would be relevant and would be clear within the findings of fact, conclusions of law. Section 6, I have personally dealt with magistrates changing and modifying a bond amount and bond conditions that were ordered by an elected district judge. So I think Section 6 is appropriate and should be in place. If a judge has set conditions and has set a bond for a variety of reasons, a magistrate should not have the ability or the authority to alter that. And then finally, Section 8, I'm supportive of it, which provides an appellate right in limited circumstances for the state of Texas where the state believes that the bond that was set was inappropriate. It's not in all cases, it's only in limited cases. It's cases where the person was charged with a felony, and prior to the current felony charge, they had a prior felony in which they were granted bail and clearly have violated by picking up a subsequent felony offense. Again, I'm supportive of this, happy to answer any questions, but also want to be respectful of everyone's time.
Members, are there any questions for this witness? Representative Moody.
Just a couple. I was actually waiting to see if you testify on the appellate provision. What's the deadline that's built in here
So
for a bond hearing appeal?
I think the case law that stands for where a defense files an appeal on a bail issue would stay the same. And it's my understanding they're expedited. I've had to deal with some defense bail appeals.
Sorry, so what's the deadline that's in the case law?
It's late. I want to say instead of it being, I want to say it's expedited. I think it's similar to what you have to deal with on CPS cases, but I genuinely, my brain is tired. I couldn't
No,
tell you
that's
right
fine.
now.
I think we're all probably at that point. I just didn't see it here, and I wouldn't want to rely on case law.
No, sir. It's in the appellate rules of procedure.
Okay, I thought you said case law.
I probably did.
Okay, good.
I'm tired.
So I'll cross-reference.
I want to say it's chapter 44 of the Texas Appellate Rules of Procedure, but again.
But that's applying to a defendant's
Correct, and I would submit to you, I think with bail, you have to also do the expedited process. But I'm happy to follow up with you. I'll do some research on it.
Yeah, I just want to make sure that the deadline's clear because,
Sure.
I mean, in any case, if there is no, if this doesn't have like a hard and fast time, I know we're talking about a narrow set of cases, subset of cases, but one of the things that can happen here is the person stays in custody pending that appeal. So there's nothing that stops a prosecutor from just saying, I intend to appeal all of these.
It does. So for the state, for any state appeals, not only does it have to be filed within a certain time period, I actually sign as the elected for all of state's appeals, where the state is able to file that appeal. And generally speaking, I want to say it's 20 or 30 days after the date the judge has signed that order or anything that it is that I'm trying to challenge. So it is a very short time period.
No, and I just want to make, I do want to make that clear because we were talking about, this is different. This is different since it's coming from the state side
Yes,
and how this is done. So that's the only thing that I wanted to bring up to make sure that we're keeping
I'll follow up with you
timelines
then.
in place because I get it. It's a remedy that needs to be here if we're going to have this process. But I just want to make sure that we have all the pieces in place. So I thank you for your testimony.
Members, are any other questions for this witness? If not, thank you so much for your time. Next is David Gonzalez. Mr. Gonzalez, I have you as representing the Texas Criminal Defense Lawyers Association and yourself, and
Yes, sir.
you're registered against the bill. Is this correct?
Yes, sir, it is.
Thank you so much. Please proceed.
I'll pick up there. It's Rule 28.1 of the Texas Rules of Appellate Procedure. Under Rules 28.1 by statute, if this body indicates that the appeal has to be accelerated or expedited, that's the designation that I would ask that you include, and it's one of the first things that I want to discuss. Second, under Section 7, I read that language is a little bit loose, has previously been granted bail for a pending offense. I think it's designed to say currently being on bail for more than one offense. And I think that clarifies that language so it's not, well, I had a felony 10 years ago and I was granted bail. I don't think that's what the intent was. It was just something that I read that was a concern. Last two. In terms of the scope of one of the previous witnesses' conversations about aggravated assault, our testimony related to that is that if you look at the Office of Court Administration's numbers on the restrictions, on capital murder, there's 1,300 a year. On murder, there's 3,000 a year. The scope of how many cases this affects, aggravated assault is I think in one version, 78,722 a year. So it's a lot more cases than the narrow number where you'd have to pull someone else. The highest number are drug cases. OCA says it's 154,000 drug cases a year. So it just is a different number of magistrations occurring on ag assaults. And the only reason I could say is that aggravated assault, unlike murder, those are result-oriented offenses where something's occurred. Aggravated assault can be threats or things that are not actually resulting in serious bodily injury. The threats with a rock, the threats with a pencil in high school, those kind of things make a little bit of a difference. And last is related to the terroristic threat. There's 3 ways that are felonies, 3 are misdemeanors. So the statute right now just says 2207 in full, so that was the issue there. That's all I have.
Members, are there any questions for this witness? Thank you so much for your time. Nick Hudson. You're representing the American Civil Liberties Union of Texas, and you're registered against the bill. Is that correct?
That's correct.
Okay. Please
Thank you. And thank you, Vice Chair Wu. And thank you, Chair Smith. Your office has also listened to our concerns on this, so thank you to y'all. We are concerned primarily about 3 sections. The first is the Section 8. It allows the state, as you've heard, to appeal a bond that the state deems insufficient in certain cases. It is a certain limited set of cases. It's just an enormous amount of power to give to the prosecutor. I have my understanding is that in some counties, some prosecutors were protesting bond amounts or filing motions for insufficient bond, in about 90% of cases. So our concern is that this will just become a routine mechanism that keeps people in jail for an extended period of time. As drafted, we do not see any limits on the amount of time that people could be held during that appeal. Our preference would be to see that the requirement that people be held in jail during the pendency of the appeal at least be removed. The second part is Section 4 that expands, as you've heard, the list of offenses under 17.03b2 for which money bail would be required. For those without resources, this creates an absolute bar to release. It means that if somebody is poor, they will be treated differently and be able to and be required to stay in jail, whereas someone with money will be able to buy their release, and that's certainly not fair and has been found unlawful. And our understanding is also that it includes even a first-time charge for terroristic threat. As you heard, 90% of those are Class A or B misdemeanors. And third, I just want to talk about the restriction on judicial discretion in Section 3 for these Chapter 54 magistrates. I'm going to try to stick to the bill, but Chapter 54, as the bill as drafted, it applies only, as you've heard, to Cameron County and Harris County. If it is expanded to all Chapter 54 magistrates, I just looked this up. It would expand it to these restrictions on your judges in Tarrant County, Representative Cook, Dallas County, Representatives Rodriguez, Ramos, and Bowers, El Paso County, Kirk County, Representative Verdell, and Denton County, Representative Little. Our state already sets money bail in the vast majority of cases. In about 83% of cases, you have monetary bails assigned. Our concern is that this deepens our reliance on a two-tiered system of justice where your release depends on how much money you have in your pocket, and we just think that's unfair. Thank you.
Members, are there any questions for this witness? None. Thank you so much for your time.
Thank you.
Brett Ligon. Show the witness registered for the bill but not testifying. Joy Davis. Ms. Davis, I have you registered as representing Pure Justice Action Fund and yourself, and you're registered against the bill, is that correct?
That's correct.
Please proceed.
Good evening. My name is Joy Davis. I'm with the Pure Justice Action Fund, and I'm here this evening opposing House Bill number 75. This bill will not only lead to mass incarceration, this will further the court backlog as an overextension of government power, infringing on personal freedoms and leading to excessive government control, and will cost taxpayers even more money. This bill takes the control out of the district courts in order to adjust the bail or bond amounts. In some circumstances, if the prosecuting attorney felt that the bond was deemed insufficient, an appeal would mean that the person incarcerated would have to wait in jail, such as Section 2, in which event the defendant shall be held in custody during the pendency of the appeal. And something that was brought up is like, how long do these appeals normally take? And that was not listed off in the bill. And we don't want that to be used as a form of punishment and, just delaying it just so people could continue to sit there incarcerated. And I'm not going to take up any more of your time. Any questions?
Are there any questions for this witness? Seeing none, thank you so much for your time.
All right. Y'all have
Appreciate
a wonderful evening.
Travis Fife. Mr. Fife, I have you registered as representing the Texas Civil Rights Project, and you're registered against this bill. Is that correct?
Yes, sir.
Thank you. Please proceed.
Evening, y'all. Like I said last time I was up here, my name's Travis Fife, and I just want to make one very simple submission to you all tonight, which is that HB 75, particularly Sections 4 and Sections 8, is a solution in search of a problem. The only people who are going to be held pre-trial because of this bill are low-risk offenders, which I've heard just about everyone on this panel say that we don't want our sheriffs keeping them in custody because it's a waste of taxpayer dollars. On Section 4, which expands the offenses that are required to be held on secured bond, I know we heard from the gentleman from Crime Stoppers who said 2,800 people from 2022 to 2024 had been released on personal bonds and felonies. Well, council members or committee members, that is out of 144,000 total felony cases filed across that same time period. Some back of the napkin math tells me that's about 1.9%. That is an infinitesimal percentage of the number of bodies and people and individuals that go through the Harris County criminal justice system. And across the state, we see that too. Folks arrested for unlawfully possessing a weapon, violation of protective orders, those people are being held on secured bail. The only time those people are released is when they're low risk, they have a medical emergency, or they're being transitioned to a diversion program. And so the only thing you're doing is keeping low risk folks behind bars when a judge and a lot of times the prosecutor has agreed to let them out for compelling reasons. Next, on Section 8, we had, I thought, pretty robust discussion about the timeline issues. I share those concerns in terms of a timeline. Ordinarily, when the defendant contests a bail amount, that's through state law habeas, which has statutory timelines and expedited amount or time limits imposed on it. I think in this case, where a neutral decision maker has individualized, considered that person's circumstances and made a bail determination, I would push for even more expedited timeline to ensure that if we're going to allow an appeal at all, that at least that person is not being held on the equivalent of no bond, just waiting out their appeal. I thank you all so much for your time, and especially this young lady who's sitting here taking notes and doing all that stuff, Lord's work. So thank you all. Am I really?
Members, are there any questions? Rev Money.
All right.
Where the money is.
Mr. Fife, I know you're opposed to this bill. Do you agree that there is that the current bail system has created or has some lapses and some problems?
Yes, although I imagine the problems I have in mind might be different than.
Okay, let's focus then specifically. I would assume, yes, there are situations where some people are given a bail that's too high or given conditions that are too strenuous and unfair. But listening to the testimony of the people here who are here tonight, where it seems that our criminal justice system has failed these victims by allowing people that should not have been freed to be free. Would you agree?
I think in what happened in those particular circumstances were horrific.
Okay. So just to follow up, sometimes horrific things happen, and that needs to be handled locally. Sometimes the horrific things happen and that needs to be handled by the state. Sometimes horrific things happen and there's nothing that can be done. What is the category that you see here? Is there a role for us as a state legislature to look at these horrific things that are happening and address that from a policy-making standpoint?
So at a broad level, and I'd like the chances, because it's a big question and I'd like to unpack it. So at a broad level, yes, I agree with you that the role of the legislature is to protect victims of crime as well as the accused. But I think where we probably disagree is on using blunt instruments such as a mandatory secured bond to do that, when in reality, people charged with these offenses, outside of some of the terroristic threat runs, which, as we've talked about, just are wildly different. Folks aren't being released pre-trial or on personal bonds. They're forking over cash if they're lucky enough to afford it. The other thing that I just want to, I feel like we've had this weird dichotomy today between victims on one side and defendants on the other. And I will tell you right now, over the last 4 years, I've represented pretrial detainees, I've represented victims of crime, I've represented post-conviction folks, I've represented 14-year-old kids about this tall in the state juvenile system. And I can tell you that while some of those people have done things that need accountability, they're also victims of crime. And so I think when we think about this dichotomy, it just, in the real world, it doesn't exist. And so when you ask me, how do we take care of victims? Does the state legislature need to do that? I say absolutely, but not through this.
Okay, so you don't think that our current bail system?
Can we pause here?
Yes.
Like, can we? And it's getting very late, and if we're gonna have like deep philosophical questions about like the 20,000-foot view, could we do
Okay.
that off? Not
Fair.
here. Can we please stick to the bill itself?
Yeah,
I'd be
that's
happy
fair.
to give you a card and keep the
yes,
discussion going.
I'm happy to have a conversation. I'm really not trying to be combative.
No,
I'm trying to figure out though, is there some, could this bill be reformed to a point that you would like it, or we're just you just don't think we need to fix it?
I think on Section 8, like I said, I think the timeline issues would be amazing. And to massively expedite that, I think where I have trouble coming up with an alternative on Section 4 is just the particular offenses that are listed. Just like if there was data that just huge swaths of people were being released on personal bonds for these offenses and then committing heinous acts, I think we'd be having a conversation. But I have studied in depth the Harris County data. I've worked in rural places like Refugio County, and I just haven't seen it. And so for these offenses that are listed under Section 4, I don't see, it's not fixing a problem that's there, in my view.
All right, thank you.
Yeah.
Members, are there any other questions? Thank you for your time.
Thank you all.
Adam Haynes. Adam, I'm sorry, Mr. Haynes, I have you registered as representing the Conference of Urban Counties. You're registered as neutral on the bill. Is that correct?
Yes, sir.
Thank you. Please proceed.
Thank you, Mr. Chairman, members. Starting off with my testimony, first thing I want to say is the fact that y'all been here for 10 and a half, going on 10 and a half hours, and there are 11 of y'all here. It is to be commended, and y'all's commitment to criminal justice is outstanding. So thank you for your, absolutely, thank y'all. Thank you, Sheriff. Don't get to testify here much. I usually do boring things over in Ways and Means and other things like that. But I'm here tonight to testify. We are neutral on the bill. As you all know, counties are your partners, and the number one thing we partner on, criminal justice. Every one of my members, I represent the 35 most populous counties in the state. Every one of my members, their number one expense is criminal justice. Whether that is, as Sheriff Louderback knows, in the sheriff's office or through the court system, that's what we do. We are your partners, and we institute the policies that you make. And I want to thank Chairman Smithy and his staff. They have met with us a number of times. We've given them 4 ideas, and I'll outline those real quick. But we will institute the policies that y'all implement here. But I just want to tell you that this policy that you're contemplating, this policy that's wrapped into 75, is going to be expensive. And what we would ask is that if the state is going to implement a policy where we hold folks in our jails, we will do that. But if you're going to do that, then the state should commit 100% of the monies that it cost us to hold folks in the county jails to reimburse the counties. if that's expensive, and as I was meeting with folks, I got kind of a, nah, that's probably not going to work. We understand that. We're your partners. How about a 50-50 split? Seems fair. And if that's not okay, because we know there's not much of a rider, there is a rider for OCA to implement data and things like that for this bill, but there's none to reimburse counties, so we understand that. At least don't penalize us. And what I would ask for is right now, counties have a criminal justice mandate under Chapter 20 of the tax code, Chapter 2644 of the tax code, that allows us to write off our criminal justice expenses under the no new revenue rate. If we're going to implement your policies and we're going to hold largely state prisoners, or future state prisoners, because they're not state prisoners yet, future state prisoners, then at least allow us to take those costs off of the no new revenue rate. And then finally, it's always referred to as kind of the Nelson Amendment that says if the states can implement a policy but doesn't appropriate the monies, then it is up to the discretion of the entities that are required to implement that policy to either choose or not to choose to apply. With those, and I've given Chairman Smithy those amendments. His staff has been gracious, and he has been gracious with their time. With that, I'll answer any questions.
Members, are there any questions for this witness? Thank you
Mr.
so much
Chairman.
for waiting here all day. Appreciate it. Next is, that's it?
Mr. Chairman, could I be
Representative Moody.
I don't have a deep philosophical question to go into right now, but this is usually the time at night that I call my boys and I read to them, and so wasn't able to do that, but I did have them tune in real quick. So I wanted to say goodnight to William and Preston. I love you. Thank y'all. Their mother agrees with you.
I did mine a few hours ago. I should have thought of that. We should have my boys watch it.
They were just toddlers when this hearing started.
Chair recognizes Chair Smithy to close.
Okay, well, in light of the hour, I'll close and just pray there are no questions.
I'm sorry. Are there any other? I'm sorry. Are there? Strike that. Are there any other witnesses to testify on for or against this bill? Hearing none, Chair recognizes Chair Smithy.
And members, it could be worse. This could be public education. So, anyway, I'll close it. This is a bill that we know we're going to need to do a little work on, and so that's why I've kind of left some of this kind of hanging, because we're taking input from really all these. I think most everybody that testified here has been by to see us, and we're taking all those seriously and continue to work with you all and with the Senate to try to come up with a resolution. So with that, Mr. Chairman, I would leave the bill pending.
Thank you. You close.
I close.
Mr. Chairman. Mr. Chairman.
Moody.
Sorry, and I appreciate all those conversations that you're having. Just as we sat here, earlier we heard Mr. Castro come and testify about some of the issues he was having, getting information on bond violations and rearrests. We went ahead and looked into the Code of Criminal Procedure Victims' Rights section. They're correct that is a gap in the law. That is something that they're not entitled to that information under the law as it's written now. I think it's easily amendable into this bill to make that the law going forward. So we're going to get y'all some language on that. Just want to update everybody. There is a gap there. It's not something they're entitled to under the code right now.
Rep. Jones.
Yes, Chairman Smithy. So I'm tired. I don't want to ask you any questions either, but I do want to tell you a quick concern, right? So if this passed, it's going to be more people arrested and locked up. Right now, we're already overcrowded. Like, for example, in Harris County, we're shipping people off to other states. And I can envision, right now I've got clients upset with me because they can only have so many people in the jail, like in a holdover at a time in court. Resets are longer, like maybe, 30 days, 45 days from one court date to the next. I anticipate it's going to take forever. Like it's just going to slow down the administration of justice, which I was hoping to somehow speed up, the administration of justice, so that, I just see that, so I don't know what.
Well, that's a consideration we can't ignore, you know, is what we're gonna do with our jails, and so.
There's no more space.
Yeah.
I would just say at the rate we're throwing money around, let's just throw another couple $2 billion into jails. Just joking. Sorry.
I mean, you get on a probes and you make that motion.
Yeah.
We're happy. We'll take it. I mean, I just spent a bunch of time trying to get Harris County Jail more money, so.
Yep. So I'm closed.
Okay. Thank you. With that, HB 75 will be left pending, and Chair recognizes, or Chair will bring up HB 76 and recognize Chair Smithy.
Yeah, and this is the last one, members, and I think the more simple of the bunch. And what this bill does is it just prohibits political subdivision from using taxpayer funds, taxpayer money, to give that money to charitable bail organizations that use those donations to pay a court for a defendant's bond. And there's a dispute, I'm aware, that whether this is actually occurring because of the way that some counties keep their books and make entries. There's a discussion going on whether this is being done right now, but there's certainly evidence that it is. And I'm not saying it's conclusive, but it's a real concern if taxpayer money is being used to bond out people who've been accused of committing some fairly serious offenses. We have a lot of charitable organizations that do that, but certainly that's not we could use some of that taxpayer money to, if it is being spent that way, to use the jails. So you get back to this situation, a lot of the counties that have been accused of this say, no, that's not really where it's going. So if it's not happening, you could argue that passing the bill is not necessary, but on the other hand, passing the bill will prevent it from happening in the future. And I don't think any of us could really argue that it should be happening. So that's as concise as I can explain the bill. And I don't think we have near as many witnesses on this one.
Members, are there any questions for Chair Smithy before we move to witnesses? See none, call up Aaron Johnson. Let's show Aaron Johnson as registered neutral on the bill, but not testifying. I heard, okay. Next up is Emma Stamen. Ms. Stamen, I have you registered to testify on behalf of the Bail Project, and you're registered against HB 76. Is that correct?
That's correct.
Thank you. Please proceed.
Thank you. My name is Emma Stamen, and I am the policy strategist at the Bail Project. I'm here today in opposition to HB 76. The Bail Project is a national nonprofit that provides free bail assistance and court return support like transportation and court reminders to low-income people across the country. Between 2018 and 2023, we assisted almost 1,400 Texans who returned to over 90% of their court dates. Our work shows that the pretrial system is broken, and we cannot agree more that we need to focus on safety, but this bill does not accomplish that. The rhetoric around this bill is that charitable bail organizations are taking taxpayer dollars to pay bail, but that is simply not true. I am here to assure this committee that the Bail Project does not and has never accepted public funds or taxpayer dollars in Texas. The services that we provide are funded by private donations. The auditing documents discussed in the Senate Criminal Justice Committee hearing on HB 76 reflect our own privately donated money coming back to us when our clients' cases close, which is the standard practice for cash bail returns. The Harris County Auditor's Office has since edited its website to provide clarity and confirmed that the payments listed are refunds of cash bonds paid by the Bail Project and not expenditures of taxpayer money. Materials with further information on this have been circulated to each of your offices. As written, HB 76 may unintentionally prevent church groups and nonprofits from providing other non-bail services to the public. These groups often offer court return services like transportation, court notifications, and referrals to community-based services for defendants. HB 76 would permanently ban local governments from paying for these particular services to better support their court systems. We recommend refining this language to solely restrict the use of government funds for the purpose of paying bail, a better reflection of legislative intent. Charitable bail organizations provide a vital service to Texans. Not only do we help ensure that bail is not the only thing keeping people behind bars, we also provide resources that improve pretrial outcomes and return to court rates. In fact, our work actually saves taxpayer money that would otherwise be spent on pretrial incarceration. I urge the committee to refrain from passing legislation that addresses no real issue and that could have harmful unintended consequences, and to instead focus on creating a pretrial system that protects the rights and safety of all Texans. Thank you.
Members, are there any questions for this witness?
Just
Representative Moody.
I appreciate it, and I know that Chairman Smithy mentioned the same thing. If there's, the way I understand the situation in Harris County is generally confusion about how those funds were being remitted back to the bail project. But in House Bill 76, we have a private cause of action that can be brought if someone in the jurisdiction thinks this is being violated. Is that correct?
That is correct.
Okay, and so just like there was confusion about this in January, while public funds might not be being used for this purpose, someone could be confused and think so, and they now have an avenue to, while would be fruitless, start a civil cause of action, and you still have to process that, you still have to deal with it, you still gonna have to, there's gonna be some cost to taxpayers to have to ferret that out. Is that how you, would you read that the same way?
Yes, that's correct, and that
So
is
so I think that's probably the broader, risk, because I don't think there's any statute that permits the counties to make bail payments for private individuals. I don't think they're permitted to do that under the law now. So I just, because there was confusion in this case, I would hate for there to be confusion out there, and then it leads to lawsuits that don't really go anywhere, but we still have to handle them. So I appreciate your testimony. Thank you.
Thank you.
Members, are there any other questions? Thank you very much for your time.
Thank you.
Calling up April Aguirre. I think she's left. Okay. We'll show the record reflect that she was testifying for the bill, but is not. She's for the bill, registered for the bill, but is not going to testify. Okay. Kristen Budwine. I'm sorry. Look, I'm ESL. What's your excuse? Kirsten Budwine.
Kirsten Budwine.
Kirsten
I
Budwine
appreciate
with the
it,
Texas
though.
Civil Rights Project. You're testifying against the bill. Is that correct?
Yes, sir.
Thank you
The
very
last
much.
time you'll have to say it today. So Emma already covered 90% of my testimony. So I'm just gonna briefly say that the reason for this bill has been debunked by not only the Harris County Auditor, but it was also debunked on the Senate floor during discussions. It's a waste of valuable legislative time and energy to entertain purposeless legislation. Further, the legislature should reject laws that are based on misinformation. Instead, our energy should be spent fixing Texas's broken pretrial system. And with that, I close and am open for any questions.
Thank you. Members, are there any questions for this witness? Seeing none, thank you so much.
Thank you.
Thank you for your time. Please have a good night. Last witness was Aaron Johnson. Okay, that's it. Are there any other witnesses testifying on, for, or against HB 76? Hearing none, we'll call Representative Smithy, Chair Smithy, to close.
Okay, and with that, members, I would close.
Thank you very much. And at this time, House Bill 76 will be left pending. And I'll hand the gavel back over to Chair Smithy.
Okay. And is there any other business, members, that we need to consider?
Sleep.
Okay, thank you all for staying around and being here, and sorry that we took so long with that. But thanks to all the witnesses that are still here. We really do appreciate your hanging around. So with that, the committee will stand adjourned pending further call.